Hey, what's up, guys? Skipping the intro today because this fucking thing's already on.
The third week of
So here we go.
These are your witnesses. I presume that you are prepared in whatever way that is.
How can I be prepared for? I'm not. So the witness is just supposed to get up there and just. I'm just like,
I'm
yeah.
not
can't even
gonna
hear
have
it
this
yet.
commentary. Okay, I'm done. The jury's
I'll
coming
probably
out.
have to bring the court up.
So that's a rush to judgment.
That is not a rush to judgment.
It is a rush to
Again, I'm done.
judgment.
The jury's
It's clearly
coming
a
in.
rush to judgment if I'm telling you that I don't have the
No,
file.
in
How
my
am I
opinion,
supposed?
you're attempting to delay. So
No,
let's
I'm not.
keep
I'm not
going.
attempting to delay nothing. You want to come check the boxes yourself?
Yes.
You always trying to pull some fast maneuvers.
Mr.
Fast
Brooks,
maneuvers.
Miss Judge, Your Honor.
Mr. Brooks, the jury's coming in.
Yeah,
Show
and
respect to
they
the
deserve
jury.
to know this too. It's still issues that need to get addressed. We didn't even address everything.
Mr. Brooks, I addressed all of the issues.
No, I
You
still
know
had another one that didn't have nothing to do with nothing we just talked about.
All
There
right.
was a whole nother issue that needed to be addressed that I needed to
And we'll
bring on
address
the
it
record to
later.
your attention.
We'll address it later.
It needs to get addressed now before we go any further because it's an important matter.
What is it?
Just like the subject matter jurisdiction is important. That hasn't been proven on the record.
Ladies and gentlemen of the jury,
Just
this
like
is
the
not
rush to
the
judgment.
time for evidence to be presented or arguments to be made by the
I
parties.
can't
The
even
jury
present
will
any evidence. You won't let me even put
disregard
any evidence in the record.
all of these
Which
statements
is a
made
rush to
by
judgment.
Mr. Brooks
That's
at this
unfair.
time. All right.
That's unfair what
The
you're
court
doing.
will address legal matters outside the
Then we
presence.
need to
Everyone
address
can
the
be
legal
seated.
matter that I was trying to get to before
And
you
you
rush
may call your
everything
next
out.
witness, sir.
I'm not calling any witness until I get an answer, Your Honor. You're a public servant. You're
Mr. Brooks,
supposed to be able to
This-
answer simple questions.
Mr. Brooks,
If
This
I'm
guy is
saying
doing
I have
himself
to bring
all
call
the
it
your
to your
favors.
next witness,
attention,
please. That's the stage
I
that
have
we
to
are
bring
at.
it to your attention, Your Honor.
Mr.
I'm
Brooks,
merely seeking
please
to
stop.
bring an issue to your
I'm
attention.
telling you to please, I'm asking you to please
And I'm
stop
asking you,
because
can
we
we
have the
address?
jury present
I'm asking
and
you.
we need to continue with the evidentiary phase of this trial. Call your next
I'm
witness.
asking you to address a legal matter, as you said that those have to be taken up outside of the jury.
I will
There
do
was
that
a
at the
legal
next
matter.
break.
There was a legal matter that needed to be addressed beforehand,
I
so
will
we
do
don't
it.
have to take up time,
I will do
valuable
it at the
time
next break.
afterwards to address something that needs to be addressed now. That way,
Mr.
the
Brooks,
court and you
For the
yourself
third
are on
time,
notice.
I will address it at the next break. Call your next witness, please.
Are you asking me,
I'm directing you to call your next witness.
Your Honor? We're not going to move past this, seeing as how you took an oath to protect the Constitution. I have your oath. I have a copy of your oath right here. The oath that you took, Your Honor.
Mr. Brooks, I'd like to continue with testimony.
Sir.
We have witnesses waiting for you. Please call your next witness.
The oath that you swore to protect the Constitution, which you are now not doing.
Mr. Brooks,
So you're
call
going
your
against
next
Not protecting the
your
witness,
sworn
Constitution
oath.
because
You're going
I
against
don't
your
like it.
sworn oath.
please. Mr. Brooks, call your next witness.
As you notify the jury every time when there's legal matters, we take them outside of their presence.
And we're going
I
to take
didn't-
testimony right now. Call your next
I merely
witness.
seek to put you on notice on the record for
Yeah.
something that needs
On
to
notice,
be brought
on
to
the
your
record.
attention
And
and
I
to the
will-
court's attention.
And I will address it at
That's
the
what
next
I'm
break.
merely seeking to do.
You
It's
know, on the
something
record
that shouldn't
counter.
have to wait because it'll take up valuable time later. At least if I notify you right from the onset, you'll already know what we're looking at, and we can nip it in the bud before everything starts to roll. And
Mr.
then
Brooks,
it gets
I will
overlooked.
address it at the next break. If you want to write something down, that's fine, and give it to my clerk. I have nothing in writing. I know there's witnesses available and ready to go. Call your next witness.
Your Honor, Your Honor, you have to answer this question. You're
Mr.
making a
Brooks,
judicial determination.
Call your
rush
next
me to
witness,
judge you.
please.
To rush
You're
me to
rushing
judge
me,
it.
Your Honor.
There's no rush to judgment.
There is a
here,
rush
sir.
to
3
judgment.
weeks,
If you
3
won't
weeks.
address a legal issue that I informed you that I had some legal issues that needed to be addressed before you just run right past that, Your Honor. You're a public
Mr.
servant.
Brooks,
Are you not a
it is
public servant?
9:37. Call
It is
your,
8:37.
sorry, 8:37. You're right. Call your next witness.
Your Honor, you're rushing me to judgment.
There's no rush to judgment. Call your next
We
witness,
had
please.
a legal matter that needed to be addressed, and I'm merely trying to
And I'm
notify the court.
Telling you
at
I'm
the
denying the
onset-
request to address it at this moment.
This is
Call
a
your next
problem of the
witness.
judge
what?
not
I'm
actually
denying your
controlling him.
request to address it at this moment. Please
How
call.
can you deny
please-
something that we're supposed to do before
Mr.
the jury
Brooks.
even comes out?
He's been running this trial.
Call your witness.
I'm not seeking to be disruptive. I'm just seeking to understand Why? We do this
Everyone
every day.
is in the courtroom waiting for you. Please call your
Your
next
Honor,
witness.
we do this every single day. We've done it every single day. So I'm simply trying to make sure that the court is notified of
Put it
things
in
that need to
writing,
be
hand it to the
discussed.
bailiff, and if I deem it important enough to interrupt the witness, I will, but call your next witness.
How can I call a witness and write something down and do
You can
both?
take a minute
This
to
is
write
How can you
down
write
what it is.
something
I'm not
down and
asking
call a
you-
witness at the same time? Oh my God.
Mr. Brooks,
That way
the
it
jury
doesn't
is
become an
remaining in
issue.
this courtroom. Call your next witness, please.
Your Honor, you're rushing me to judgment.
There's no rush to judgment, sir.
Are you not a public servant, Your Honor?
He does
Mr.
not.
Do I not have your oath of office?
Under 90611, this court has the authority, as you know.
Do I not have?
Call-
Is this not a copy, or I asked for certified copies that you said on record that
Tase
you
him.
would not provide for no good reason? That these are three
Sir,
of your
you are
oaths.
doing this.
What's her
and I've
option?
repeatedly told you, you can see the jury's here.
You're
You're
doing-
doing this.
Listen,
We need to go
I'm
forward.
not attempting to delay the proceedings. I'm not attempting to be disruptive. I'm merely trying to
Literally both.
notify
You dumb
Your Honor
motherfucker.
in the court for the record beforehand. That way, everyone's at least on notice of the issues that need to be taken up, instead of waiting until a break or a lunch and things of that nature, which
In
kills
my
valuable
discretion,
time.
it's my authority. It's the courtroom that I'm
Your Honor,
presiding over. I'm not going to address
is
that
this-
at this
Is
moment.
this not your
And
oath?
I'm not going to answer
Did you not
questions.
swear as a public servant that you would protect the
Mr.
United
Brooks,
States Constitution?
Call
Did you not do that?
your
3
witness.
times. I have all of it here. Your oath, Your Honor, as a public servant. And
Mr.
now you're
Brooks,
rushing me to judgment
there's no
when
rush
I'm
to
doing
judgment.
things lawfully by trying to notify you and notify the court of issues that need to be addressed
Mr. Brooks,
beforehand.
We are in
These
the
were issues-
evidentiary phase of this trial.
Your Honor, you're
Call
rushing
your
me to
next
judgment.
witness.
You're rushing me to judgment, Your Honor. And I object
You
to
don't
that.
have a
There are three
judgment
witnesses
to
right
make.
here.
I object
Call
to
one
that.
of them, please.
Your Honor, I object to that.
Your objection's noted.
And
for the
I
record.
want a legal reconsideration of your ruling. If not,
Denied.
I reject that ruling and take exception to that ruling.
I understand.
I request a legal or factual basis for your ruling, a written judicial finding of fact and conclusion of law for your ruling. And if not that, an interlocutory, declaratory appeal for this matter. And if not, these need to be stayed until
You're asking the
this
wrong
matter
court,
is
you
before
dumbass.
a adjudicated court of competent jurisdiction, because we have not proven jurisdiction in this court as of yet. Subject matter jurisdiction has not even been proven on the record, Your Honor.
Yes,
I
it
don't
has.
even know the true nature and cause of the
Mr.
charges
Brooks,
against me. I don't even understand that part
I
of it.
understand
I haven't
your
been
request.
provided a complaint. I haven't, Your Honor, there's so many issues.
Mr.
and
Brooks, we will take,
I'm not attempting to
Mr.
to be
Brooks,
disrespectful in any way.
we
I'm
need
not
to
attempting
continue.
to delay the
Your
proceedings in any
requests
way.
are denied.
Your Honor, I
And I'm going to
respectfully
instruct the
object
jury
that.
at this point to
I
disregard
respectfully
and not
object to
consider
that, Your
any
Honor.
of what has just happened since you walked in. It should not be held against Mr. Brooks in any way. These are legal issues that this court may or may not need to address, but they do not bear in any way on ultimately the issues that you as jurors will have to decide. And I'm instructing you to disregard what you have just heard and seen.
Just ignore
Your Honor,
this
with everything that I
retardation.
just said, be made part of the record.
It's on the record. I'm telling the jury that it shouldn't affect anything that they're doing in any way.
Your Honor, it's
With that,
it's a rush to judgment
Mr. Brooks,
because, Your Honor, I
Your
just
Honor,
showed your oath that you swore
I
to.
showed you your oath
You swore.
You
did,
swore, Your Honor,
please call your next witness.
to do what
You
I
took the
say
oath of office.
in this
You did,
courtroom.
Your Honor, 3 of them,
I understand my
which
oath,
is
sir,
very,
very
very
well.
commendable that that you decided to be a public servant in these type of matters, Your Honor. I respect it to the fullest, but also you have to uphold these oaths. That
All
you
right,
take-
I'm going to have to
Your Honor.
excuse the jury since Mr.
See, he
Brooks,
wins. He just
have to-
I'm
wins.
calling his witness.
You
We'll
have to-
hopefully
you have
bring
to-
you back out shortly.
He
You have
wins.
All right.
honor these oath of offices. You have to, as a public servant, Your Honor. I respect you being a public servant.
He just got his way.
This is not to take a shot at you in any way, but these
She's
things
gonna-
that I have,
Stop.
She's
they
gonna.
need to be addressed.
She's gonna rail
They
him.
need
I'm
to be.
excusing the jury. Can you please
It's not gonna help though. Not gonna do
Your
anything.
Honor,
You
this
can't
is a
do
rush
anything to
judgment.
him.
This
The
is
man's
clear-
invincible.
clear bias.
Mr. Brooks, you are to stop talking.
Are you asking me?
I'm advising you, or you will forfeit your right to be present in this
So you're holding
courtroom
me
for
in
the
contempt.
questioning of your first witness.
Because you're holding me in contempt.
I'm not holding you in contempt.
Then how can you remove me from the courtroom when I haven't given consent?
Mr. Brooks, I'm
How can you
advising
do
you
that?
at this moment to call your next witness, or you will forfeit the right to call these witnesses.
You can't.
Yes,
take my
Under
you
consent,
can.
90611,
right?
you
You
are
cannot-
refusing to
you
call a
I
witness.
didn't refuse anything, Your Honor. You can't deny me my Sixth Amendment right.
Do it,
which
Judge.
is
Mr.
to
Brooks,
call
do you want
witnesses,
to be present in
which
this
is to subpoena
courtroom
witnesses.
while you question your first witness? Because it is now 8:44 and you've consistently talked in front of the jury who's no longer in this courtroom on issues that you have been advised and are fully aware are not relevant to their determination, despite what you
This-
believe the
This
law
didn't have anything
is.
to do with the jury,
Subject
Your Honor.
matter that is what you referenced in front of the
I
jury, and then you
that
referenced
after I
my
had
oath.
raised the issues that I was trying
Subject
to
matter
raise.
jurisdiction, as you know, is not
As I
something
don't
the
know.
state has to be. The
It
state
has
must
to be
prove.
proven. It has to be. And
You
if
are
it
No.
doesn't,
frankly
show me
confusing
lawful law.
civil
Show me lawful
jurisdiction
law,
in
Your Honor.
federal cases
Show me lawful
with
law.
criminal court jurisdiction in the state of
You
Wisconsin.
don't have criminal.
That
you
has
don't
been
even
made
have.
abundantly
You don't
clear.
have subject matter jurisdiction or personal jurisdiction
Mr. Brooks,
or personnel jurisdiction. You don't. You haven't proven.
you have not.
Got
a
I
new fly
excuse
on
the
the
jury.
record.
Fucking
I'll
mad.
give you the opportunity to raise whatever issue it was, but
He
you need to
wins.
do it now or we're moving
He
forward.
wins.
That's what I want to do. That's what I was
So,
attempting
He
to
just
do.
wins.
And if you interrupt me one more time, you're going to go do it from the other courtroom
And
because
so
you're
holding
being
me in contempt.
all right. He can go to the other courtroom and we will address these issues because
holding
you
me in
are
contempt?
not being respectful. You are disruptive. You are interrupting. I will give you one more opportunity.
I've
Just
seen this movie before.
15
Interrupt me
more.
again. Don't roll your eyes at me. Don't sigh at me. You have delayed these proceedings now by 15 minutes.
What did he do now?
Your
Oh, he's just,
nonstop
he won.
commentary. I'm going to sit
Oh,
down
okay.
and I'm going to listen to you.
He wanted to her to hear these matters
What
before
issue do
witnesses
you
were
want to
called.
raise,
She
sir?
said no, and then he just
So
sat
are you
there.
letting me,
and
make an offer of
filibustered.
proof of my appeal?
No, because that's not what's relevant at this time, sir. If you don't need to make an offer of proof. Tell me what the issue is. You said
Okay.
you have a legal issue you want to
He
raise
just
before
won.
we get going. What is that issue?
She needs to just kick his
Okay.
fucking ass out of the
legal
courtroom.
issue is this.
Period.
Detective Casey yesterday testified for the second time under oath in reference to exhibits 13 and 14 that show the backyard of my mother's home.
Admitted
which
on the
he
record.
stated that he had been to the home, had seen the backyard, all this stuff, when he did not, in fact, even speak with my mother.
Uh-oh.
It was brought to my attention that my mother, in fact, never spoke to any law enforcement from Waukesha.
Would you like to add her to your witness list to call her?
Yes, I would.
All right, that's
Because
fine.
she's
That's how
willing,
we'll
she's
address
willing
that.
to come.
But that's not something we needed to address this
It needs
right
to
away,
be addressed
sir.
because of the issue of the subpoena. That's the reason why it needed to be addressed. That's the reason
This could have been
why I was
addressed
trying to attempt
at
to
the
It
bring
next
could have
it
been
to
done
break.
on a break. All right, so
Will I be?
you're
because I
putting
have-
you're asking me to add Dawn Woods to the witness list for you.
Yes, but I also have a question about the subpoena
The subpoena.
This
for
is a
whom?
terrible move for him.
for my mother. But I would
Wow.
also like to subpoena the phone records so it can be made part of the record of the conversation, since the prosecution listens to all the phone calls. They should be able to have heard that phone call as well. So they should be on notice of what was said.
You want to
I don't know
subpoena
what phone call
all
you're
the
referring
jailhouse
to.
phone
You're referring
calls?
to a
A phone
jail
call
phone
from-
call.
I'm referring
Then-
to a jail phone call that was made last night, October 20th, between 7:54 p.m. and 8:10 p.m.
Why does it sound like he's onto something here?
The prosecution has heard by now. And that also brings
He
up
made a
the
phone
issue
call and
of
his mom
perjured
said, I never
testimony.
talked to that detective or
Sir,
something.
the
Mm.
way that you will address the issues that you're talking about are to call witnesses to challenge that or to present the evidence in support of your position. If you're telling me you need to add Dawn Woods to the witness list, I approve of that. You can fill out a subpoena and I'll direct the state to serve that upon her. And at the appropriate time, we'll have her brought, we'll indicate when in the order of folks she can be brought in. So I'll grant that request.
Will I be
In
able-
terms of the jail records, you'll have to subpoena the appropriate custodian or a witness who can testify to that.
That's what I was trying to gain knowledge of. 'Cause
Well,
don't-
I
You
can't
don't-
give you advice on
You
that.
got to
I'm trying
figure
to
out who that is
ask
on your
for
own,
advice.
buddy.
I was is
I think we call that a fishing expedition.
I can't direct how you do that. I can't tell you how to do that. You are acting as your own attorney and you will need to figure that out. So you have the subpoena forms. You can research the issues. You have access to legal research materials and other things.
Good luck
And that's
figuring
how
out
you
who you have
have
to
to
subpoena for a
address-
jailhouse phone
value in
call.
return for value this document.
Was that a subpoena form? Thank you. Is there any other witnesses you're asking to add to your, and you can also call Detective Casey if you want, just so you know.
So that make 3 times he's able to testify.
Yes.
If you believe he has information that he hasn't testified to, I will give you permission to call him as well.
No, I don't think it'd be necessary. He know what he did.
He know what he did,
In
but
any
there's a
event.
jury,
He
you
know what he didn't
dumbass.
do.
We're gonna bring the jury back out. And then I.
Oh, so the jury's already been here and then went back out, huh?
He
Because I was trying to get
Stalled
been 10
for
minutes.
15 minutes just
because I
blabbing.
don't have the I don't have any paperwork for Kohler. I don't know. how to
Douglas
pronounce
Kohler, Stephen Guth, and Erica Patterson. Of those
It's always the
three,
Colliard people, isn't
I
it?
expect you to call one of those. witnesses.
Wolfen73 says, can
I
she
set
just
the value
end his
on time
defense
for
if he
values.
continues? Kinda,
it.
yeah.
Document.
If he refuses to mount a defense and does not cooperate with the court can, at some point, end it. If you're not going to call another
Claiming he
witness,
does not have it.
Since
You will
I
rest.
know that I don't have it. So let's make that record correct.
correct.
You don't have it with you in the courtroom, is what you're saying.
I can't find it anywhere.
You've had it previously.
Yes, I had it at one point.
All right.
The dog ate the homework.
How you doing this
Are you
morning,
ready
buddy?
to proceed forward,
I'm
Mr.
doing very, very well. Sleep
Morning for
deprived
me.
giddiness.
I cannot. I mean, he just. This judge has pissed me off today, because he just won. She let him talk his way and bitch his way into this issue in front of the jury.
Oh no.
She should have just removed him from the courtroom. Said, we're 5 minutes into this. If you don't shut your fucking mouth right now, you're going to the other courtroom, and then done it. Just do it. Just move him over there.
It's almost like she's scared of him at this point. I mean, like
She-
scared of a mistrial or something going horribly wrong right at the last minute.
What's those power dynamics, man? You let the other person. She's let him control this courtroom, and she has not controlled the courtroom, and he knows it.
It's male pheromones.
Keep making the bailiffs remove him. Every time they do, he'll get more and more belligerent, and eventually, maybe he'll swing at one.
Give Tackleberry something to do back there.
Bizit.
Wow.
Oh my God. Sadie
That made
Girl's
me-
mom says this is the result of her being too lenient with him all along. I 100% agree. 100% agree. What's to stop him from doing this the moment the jury comes back? Whenever he wants.
Wow.
Mr. Brooks, just to make sure, don't block any of the microphones with anything. Both of those microphones should be on. You want to make sure that.
Housefer says, I want his mom to say what his name is. Yeah, I mean, if he calls his mom on
Go
cross,
ahead, call your next witness.
or when the state gets her on
Defense
cross,
calls Douglas J. Kohler.
All right.
Well, I've got the dogs in here, so if you're snorting, breathing, one tell, just let me know and I'll kick them out.
oh no, I can't hear him.
Yet. They haven't started
Holy
to sleep
shit.
yet.
Housefer says every 30 minutes he wastes, he should lose a witness. Ethan Flash says, hey, Lorax Robotnik, how goes the battle against Sonic? Oh, damn.
Good
I
morning,
speak
sir.
for the hedgehogs.
The witness stand, which is up toward me, up one riser. and to my right. When you get there, please remain standing. Raise your right hand. My clerk, Teresa, who's on my left, will swear you in.
Do you solemnly swear that the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth, so help you God?
Thank you, sir. Have a seat. First thing I will ask you to do is to state your first and last names for the record and then spell each.
Douglas Kolar.
Okay, I gotta send
G-L-A-S.
Steve Gosney a link. He's available today.
Thank you. Go ahead, your witness.
I'm just waiting for someone to say my name is Doug Smith, EACH.
Kolar. Good morning, Mr. Kolar. I want to direct your attention to November 21st of 2021. Do you recall that evening pretty well?
Fairly well, yes.
Well, let me back up for a minute. First of all, what do you do for a living?
I'm an IT director for a law firm.
Been doing that for a long time?
I've been in IT for over 20 years.
Yeah, that is a long time.
Yeah, it is a long time. Why would you? No, the jury makes that
Direct your attention
determination.
Back to night of November, evening of November 21st, 2021. What did you do that day?
Well, that day.
Oh, you know what? I need to turn up the
was
court
preparing
just
my
a
daughter
tiny bit.
to march in the parade with her dance troupe. Watched football earlier in the day and got her dressed, and we had to change our plans last minute because my son was not feeling well. So it was just my daughter and I that went to the parade.
And do you recall what time you arrived at the parade?
It was at least an hour before the start time of the parade.
And do you recall where you were positioned at in the parade?
I moved with the dance troupe. So I
Kind of going with the flow.
correct.
This is the first witness he's called that doesn't look like he wants to kill him.
And at some point you
I
observed
bet he does,
something
though.
happening. That'd be fair to say.
Yes.
At some point, you observe
Do you
something
recall what that
happening.
was?
Well, after my daughter had finished and I was walking back to our vehicle to go home, I noticed as we were approaching White Rock, which is what we were parked off of, I noticed a vehicle coming through where the parade participants were going. It was a red vehicle. It was honking its horn. It passed a few parade entries on the right-hand side, and then it passed between two of the groups. It veered to the left and went around the next group on the left-hand side.
Ooh, it veered.
At which point, a police officer
Mm.
attempted to approach the vehicle. That police officer had reached for the door handle, and at the time of that approach, the vehicle started to speed off.
I just want to back up just a little bit.
What's up, Steve?
Can you hear me?
Yep.
You
Morning,
stated
sir.
you heard the vehicle honking its horn.
Got an echo, I think.
While it was on White Rock Avenue, it was honking its horn.
In your opinion, did the vehicle appear to try to avoid hitting people?
At that point, yes.
And you made reference to it coming in, the vehicle coming in contact with an officer. Did you see where the vehicle went after that interaction with the officer?
There was no contact between the officer and the vehicle. The vehicle attempted to make contact. The officer attempted to make contact. that after that attempt, the vehicle sped southward. You know, I know those streets don't run straight north-south on Main Street.
Did you notice the vehicle strike anyone at that time?
I did not.
And what did you do after you saw the vehicle? Once it was out of your view.
Once it was out of my view, I grabbed my daughter and walked as fast as I could to my car.
And to the best of your recollection, how would you describe the vehicle as far as make and model? To the best of your recollection.
To the best of my recollection today, I only remember a red SUV.
At some point, did you report to law enforcement officers what you had observed that evening?
On the Tuesday morning following the parade, I sent an initial statement to the police.
Would that have been the Waukesha Police Department?
Yes, it was to the Waukesha Police Department.
Did you said you sent a statement. Did you initially speak with anyone verbally?
Initially, no, I did not.
At some point, did you speak with someone verbally?
Yes.
And
At some point, did you speak with someone verbally?
was that sometime
Once or
after
twice.
Tuesday
Well, I have an echo too.
statement that you initially gave?
Yes, approximately 2 weeks after I made my statement, I was contacted by someone with the Waukesha Police.
Let's fucking fly. What? I'm alone
Do
again.
you recall if the vehicle had any tinted windows?
I believe the rear windows were tinted like most SUVs are.
I'm back. No echo. I'm so glad you paused him for me.
Yeah.
Am I echoing?
No.
I don't hear an echo. StreamYard's been weird lately when I've been adding people, though, like an echo will just randomly pop in out of
Right.
nowhere.
I've seen that. My hair's messed up.
After you had verbally speaking with law enforcement, did you do any follow-up on the reports after that?
Yes.
Like that he's not wearing a mask
The
anymore.
officer that I
Dramatic
spoke to had
mask
Yeah.
reveal.
advised to add to my statement the items that we had talked about.
Actually, the law enforcement officer asked you to add certain things to your report?
He had asked me some questions, and the questions that we talked about on the phone, he asked me to add to what I had initially submitted.
And after that conversation, did you have any further conversations after that point?
I had no further conversation after that point.
Had you yourself been contacted by any further law enforcement after that point?
No.
So it'd be fair to say that you were subpoenaed to testify at some point. That'd be fair to say.
Yes,
Do you recall when you received that subpoena?
I received my subpoena last Tuesday.
and the 18th.
whatever day last Tuesday was.
Do you recall whom you received that subpoena from?
The Waukesha County Sheriff. Or
Do you
one
recall-
of the sheriffs,
I'm sorry.
Plaintiff.
or one of the sheriffs.
Do you recall who the plaintiff was in this matter?
Shh, don't give him ideas.
No, that's when he's done with the witness. I
know.
want him to get there immediately.
I like it because it means he's almost done.
Let's do
Did you
closing
do any
arguments
follow-up
today.
Information once you received the subpoena, like for example, sorry, for example, calling the district attorney's office.
I did not call the district attorney's office. I did reach out to the clerk's office to see if there was any further information.
Were you or your daughter injured in any way during this incident?
No, we were not.
There's no victim, Your Honor, on the record.
On the record. The thing is that everything that's being said in this courtroom is being recorded by a court reporter. So everything that's being said is automatically part of the record. So you don't need to say it's on the record, for the record, any of that stuff. It's all recorded by the court reporter.
That's some Inception level thinking there. It's like
I wonder if
25D chess.
they actually use a physical court reporter in this courtroom,
No
or
further
if
questions
they
at this
use the recording.
No further questions, baby. Boy, that was quick.
What the hell was that about?
Morning.
Thank you for being here.
Just to say somebody wasn't injured?
Clear, sir, the subpoena you received was issued on behalf of the defendant, Darrell Brooks, correct?
I don't know. That information was not filled out on the subpoena.
Okay. You did provide a typed statement to the
Well, good
Waukesha
job
Police Department,
testifying,
correct?
prosecutor.
Objection, Lee.
Overruled. If there's an objection, let me rule on it first before you answer. Overruled.
It's going to object
Go
to
ahead.
every question is
And
leading.
his answer, I believe he answered it, but if not. Did you answer it?
I'll ask again.
Thank you.
You did provide a written statement to the police department, correct, sir?
Objection, leading.
Overruled. It's cross
Here we go again.
11 sub 2.
Yes, I provided a written statement.
And in that statement, you described the SUV as driving erratically down White Rock Avenue, correct?
I don't know why she's doing this.
Testify to that.
Um,
That was asked and answered.
What?
What?
If you didn't testify, but was
The
asked and
answer.
answered?
And
Dummy says grounds.
sub 2, by the way. Go ahead.
Yes, just the event of driving past some participants on the right and then veering to pass the next group on the left.
Okay. You said at that point, when the vehicle was on White Rock, it was honking its horn, correct?
Correct.
There was no objection. You can answer.
So one question that didn't have an objection.
And you saw an officer run up and try and open the door to the vehicle, correct?
I don't know that he was trying to open the door, just trying to, I don't
Kill
know what
people.
he was trying to do. He ran and his arm had gone towards the door handle.
Okay. And that was at the intersection of White Rock and Main Street, correct, sir?
Yes,
And you got a look at the driver of the car, correct, sir?
Objection, speculative.
Overruled. The witness may answer.
yes, I did.
And you described the driver in your written statement as a black male with dark dreadlocks and visible tattoos. Is that correct, sir?
And redirect.
Objection, leading.
Do you see any
The
dreadlocks?
witness may answer.
Yes,
Is that consistent with your memory, sir?
Objection, speculative.
Overruled.
Oh
It's
boy.
consistent with my memory.
Just word salad.
Once the vehicle went past the officer, you indicated that you saw it accelerate or speed off. Is that correct, sir?
Objection, leading.
Overruled. 906-11 sub 3.
Yes, at that point, it sped away.
Thank you, sir. I don't have any other questions.
Any redirect?
Briefly,
Go ahead.
Oh dear.
Hate that word. It's never true.
According to the written statement that was just testified to the best of your recollection, do you recall stating that the SUV was a older model red Chevy Blazer?
I do recall putting that down at the time, but that was at that addition that I added 2 weeks later.
So at that time, during the evening of the incident, to the best of your knowledge, that would have been your opinion of the vehicle that you saw?
At the time of that, the day of the parade, I just remembered the red SUV.
To the best of your recollection, what assumption will lead you to describe the vehicle as a Chevy Blazer?
I believe in my assumption, it was just to say it was a older boxy style SUV, and in my mind, that relates closely to a Chevy Blazer.
No
It was-
further questions.
It was the other red SUV plowing through the parade that he saw.
Gotcha, bitch.
And you also are excused. Thank you for being here. Call your next witness.
We might get through the 4 or 5 today.
1 second.
This is my actual hope about him representing himself, is that he's not going
I
to
may
have
just
a
a quick
cognizable plan for his direct examinations.
Well, he didn't have one when he questioned the first guy for an hour and a half.
It's true.
I
I
think
didn't
we-
watch
it's-
all that. I
I
wanted
think
to.
it's safe to say that he doesn't have any good witnesses. Is that a fair statement?
What
Well,
witness
his
could he
mother's
have?
coming.
Well,
Didn't his mom say he's guilty?
Something
boy,
like
that's
that.
going to be tough. If he puts mom on the stand and she throws him under the bus.
He's mentally incompetent, shouldn't be defending himself. I'm so sorry for what he did to everybody.
Stephen Guth.
Stephen Guth? I think this guy's like a detective.
I believe
that
one
he's
of my
calling.
assistants went to retrieve Detective Guth, Your Honor.
Yeah.
Thank you.
So unless he comes in with like crazy hair and a binder and he's like, he's the one guy who's been trying to find the real killer the whole time. Like, actually, no one's listening to me. Let me pull up my pegboard. Like, unless it's that guy, this isn't
It was
gonna help you at
aliens.
all.
So you're rooting for that for entertainment value. That would be great, wouldn't it? He got fired because he thought that the conspiracy theory, the aliens did it, right?
The hieroglyphs on the pyramids of Egypt predicted all of this.
They bring him in on this straitjacket. I used to be a detective.
This is why I have made a delicious whiskey sour to help me begin the day.
I just found out I have 70 plus hours of leave time that I have to take before the end of the year, or I lose it.
Hmm.
Nice.
That shows you how very little I take vacations. So I'm trying to take as much time off. So I said, thank you for letting me on again.
Oh, absolutely. Love having you on here. Yeah, the mom just did a news interview like yesterday.
Oh,
And everything she said, I mean, I don't know that you want to call her.
I just saw the one she did when she was saying he shouldn't be allowed to act as his own lawyer because he's seriously mentally ill, and she's sorry for what he did.
Right. Good morning, Detective Guth, if you would, as you are.
There's an issue there about eliciting testimony that is self-serving statements by yourself. So if he puts her on a stand, she could be waiving his Fifth Amendment, although she'll never enforce that. This judge is way too lenient with him. But if you call somebody to say, what did I say to you? That's a waiver of Fifth Amendment right.
Or names, I should say.
Stephen Guth, STEVENGUTH.
Go ahead, sir, you're witness.
Dude, the hair, stop.
Sorry, I'm trying to.
No, no. Yeah,
over 20 years.
No matter how messy your hair is, Steven, there's always one person on the screen that's messier than yours.
Just over 7 years.
Oh yeah. It's kind of cool though. I like it. It's kind of rough and tumble.
Your attention to the evening of
His hair looks like the other detective that just had white hair that looked the
I
same.
do.
It's like thinning and then just.
And were you on duty that evening?
It's a conspiracy.
Not initially.
For more clarification, what do you mean by not initially?
It was a regular
Not-
off day for me, but I received notification to respond to the police department for the mass casualty incident in the downtown area of Waukesha.
So at that point, I'm assuming you were dispatched to that location?
I was not dispatched. I received a Signal message. We use Signal. It's an app that's used that we can share
Send nudes and they'll
information
go away.
for investigations. I received a Signal message that this tragedy just happened.
And so what did you do from that point?
I immediately dropped my wife and kids off and responded to the parade.
And when you got to the parade, what did you do at that point?
I went to the downtown area to assess and see what I could help with.
At some point during your investigation, did you make contact with the woman by the name of Erica Patterson?
Yes,
And what was the nature of that part of your investigation?
I wanted to speak with Erica Patterson because by that point, when I made contact with our command center, they had learned the name of Darrell Brooks and had learned that Erica Patterson was the estranged girlfriend of the suspect of this investigation.
Some long ass shadows on that hair.
You made reference to a strange girlfriend. What do you mean?
Means you ran her over with a car and she didn't love you anymore.
I think the question was pertaining to the word estranged, but we'll move on.
The jury will disregard that last question, that it's been withdrawn. And the statement made by Detective Guth following that.
I'm assuming at some point you took a statement from Ms. Patterson.
I did.
Do you recall if it was recorded, written, you writing it? What was the nature of how the report was taken?
Well, her words were spoken and they were recorded, and then I prepared a report.
Did you prepare the report that same evening?
No.
When did you prepare the report?
Sometime after the 22nd of November,
Why'd you take so long though?
Why not the same evening?
because after I spoke with her, I wanted to go back and speak with her again.
See, I speak idiot, so I knew that question was coming.
Did you obtain any statements from any other people that may have been involved with Ms. Patterson?
I did not.
Do you know, to your recollection, if any other officers have taken statements from parties that may have been involved with Ms. Patterson?
Well, the night of November 21st, 2021, I did have a partner with me, another detective.
Do you recall him talking to any other parties that may have been involved with Ms. Patterson?
Well, the detective that was with me was a female, Detective Barron.
The question was, do you know if your partner had any interactions with parties that may have been involved with Ms. Patterson?
I don't believe so.
Hold on,
but
are
I
you
can't-
specifically referring to a date certain or just in general?
I think it was clear.
I need it clear for the record
The
though.
date would be
On the
November
21st?
21st
Okay.
of 2021.
Thank you.
My partner was the state of Wisconsin.
No, so,
Why ain't he here though?
Did you learn at any point that there may have been other parties involved with Ms. Patterson?
in which incident?
I'm referring again to November 21st of 2021.
Yes.
Do you recall who those parties were?
Corey Runkle and Nicholas Kirby.
Did you yourself speak with either of those parties, Nicholas Kirby or Corey Runkle?
No, I did not.
Do you recall if your partner spoke with any of those parties?
Which partner?
I'm guessing the female partner that you
I'm
made
guessing.
reference to.
No, she did not.
And in that recorded interview with Ms. Patterson, what did you learn about the evening of November 21st, 2021?
Which recording?
Are there multiple recordings?
Yes.
What did you learn about the evening of November 21st, 2021 from both recordings with Ms. Patterson?
Your Honor, I'm going to object at this point as this testimony covers ground that was very clearly covered during the state's case in chief.
So
I'll give Mr. Brooks some leeway. You are asking for hearsay, though. You understand that.
I asked him, what did he learn?
Fair enough.
that's true.
Go ahead. You may answer.
Didn't ask what she said.
I learned several things. Initially, I think is what you were getting at. Ms. Brooks wanted to report that she was injured by Darrell Brooks on November 20th, which would have been Saturday. She stated that she met with Mr. Brooks at Frame Park, and they were arguing over the fact that she did not give him money. And he injured her by slapping her in the mouth and punching her in the eye. The next day,
What a charmer.
I went back and talked to her again, and she clarified that that actually did not happen on the 20th. It happened on the 21st, and that she got in a motor vehicle with him over the same argument. He was mad that she did not provide him with money. He proceeded to try to take her phone because he thought she was talking to other guys. Slapped her in the mouth,
This is
punched
helping
her in
him.
the eye. She jumped out of the motor vehicle, she feared for her safety, and made her way back towards Frame Park. While walking back towards Frame Park, she was calling her friends, Corey Runkle and Nicholas Kirby, to come help her. When she arrived back near Frame Park in front of White Rock School, there was a confrontation in front of White Rock School with Mr. Brooks, Erica Patterson, Corey Runkle, and Nicholas Kirby,
A lot.
where there was some kind of shoving match. And that's when Mr. Brooks got back into the motor vehicle and took off down White Rock towards Main Street. Erica Patterson then made her way back towards Women's Center.
He needed gas money.
Made reference to
Imagine buying gas just to
being
then drive
told,
through a parade.
about an incident from Saturday, November 20th. And then stating that in the second interview, Ms. Patterson stated that didn't happen. Is that correct?
She didn't state that it didn't happen. She just stated that she didn't drive around with him on Saturday, November 20th. But she also met with him and was slapped in the mouth that day too.
Dude, I don't know what you think this is
If
helping.
it pleases the court, I have a document here I would like to show the witness.
All right, if the bailiff could have it to the state first to look at it. We may use the
Why do they
document
get to look
camera
at it, Your Honor?
if that's hooked up. Otherwise, the bailiff can take it to the witness.
Before we go through that process, I'm gonna object. It's, well. maybe
Let
we
me
should
see the
talk about
document.
this. Yeah.
All right, and give that back to Mr. Brooks, given the content of that document. I'll sustain the objection, or what that document is, I should say.
Sustain on what grounds?
It's not relevant. Yep, to this witness's testimony.
How is it not relevant?
It's not relevant.
You made
Let me
reference
count
to
the
November
ways.
20th. That's what this document is talking about.
It's not relevant to the charges at issue. We can take it up later, and if need be, I'll let you recall the witness, but I'm directing you to move on to a new topic.
Your Honor, I'm gonna respectfully object to that and ask for
A judicial
finding
determination,
of fact.
a finding of fact.
The objection's noted, it's sustained. Well, their objection's sustained, yours is overruled. Please continue.
He almost had her.
Is that noted for the record? I would like a written finding of fact.
The request is denied. Keep going, please.
Denied on what grounds, on what lawful law?
Keep going, sir. It's not relevant.
Lawful law.
So, Steve, are you familiar with lawful law?
You don't have to answer that question.
That's opposed to the illegal law.
I've ruled on the
I
objection.
thought it was a delicious Mediterranean food.
Going.
Once again, information that needs to be known is being hidden.
It's not relevant, sir. Please continue.
Very relevant. He just opened the door on that by saying November 20th.
What? No.
Objection.
You don't-
Move
you-
to strike all of the comments made by Mr. Brooks in the last 20 seconds or so, especially with regard to the implication that he hasn't had all of the discovery material.
Objection, I never made any mention of not having any discovery material.
You also can't open your own door.
As I've told the jury repeatedly, comments made or statements made by the parties, whether they be lawyers or the parties themselves, are not evidence, and you're to disregard them and not consider them in any way. And if the statement suggested facts that are not in evidence, you should not make that, do not consider that in any way either. All right, go ahead. Your next question, please.
So is it fair to say that in your report, you referenced 2 incident reports?
Objection. This
Grounds.
witness wrote,
I'm going to overrule the objection and let the witness answer it. I think it might just be semantics at this point, but go ahead and ask your
You
question.
mean semantics?
What, Judge?
I think you were referring to that he had 2.
That's it. That's what his report says. He makes reference to two reports, 2 incidents.
2 incidents,
Yes.
not 2 incident reports. Reports would be separate documents. That's what I'm talking about. With that understanding that you're referring to. I
She
think
should
you're
just
referring
let
to
the witness
incidents with
answer
Ms.
that.
Patterson, correct?
Yes.
Go ahead. Ask your question. I think that clarifies so that the witness can answer.
In your, let me back up. You wrote your own report. Would that be fair to say?
Yes.
And in your report, you referred to 2 incidents. That'd be fair to say?
Just to clarify, which report are you speaking about? I wrote several reports.
The one written November 22nd of 2021.
I do reference 2 reports and 1.
God, I'm so jealous of you, Jeff.
What was the last
Going
one?
for the Isla tonight.
Yes.
What
only
do you mean
9:30
cab
here.
call?
A cab.
Cat.
It's always happy. So it's always happy time somewhere, isn't it?
You mean cat call? What?
That's a call for service that does not generate a police report.
And what was that cat call?
That was a call for service near Frame Park for a fight involving potentially a domestic related incident.
Do you recall any other details about that CAD call?
There wasn't much in it because the officer had to leave to go to the parade.
Do you recall mention of a knife during that CAD call?
Yes,
To the best of your recollection, do you recall anyone recovering a
like
knife
that,
or you yourself recovering a knife?
He
there
was
was
gone.
no knife involved in that incident through my investigation of the report that you have.
But it is fair to say that that's how the CAD call went out, that there was potentially a knife fight.
That's how it was initially, I believe, reported or communicated through dispatch to the officers that responded.
You made reference, and I'm referring to the second interview with Ms. Patterson. You made reference in your report that in the previous interview that Ms. Patterson was not completely forthright. What exactly do you mean by not completely forthright?
She did not give me all the details of the incidents to me initially.
Do you recall why?
I don't know why she didn't.
The CAD report is a report that's generated for the police, and it's sort of a listing that's a public document that goes through all the calls.
So it'd be fair to say that Ms. Patterson had been untruthful with you in the first interview.
Objection. That
No,
calls.
she was extremely afraid of you.
Oh, that's better than the objection.
Yeah, Rick, Steve.
You just stated that you didn't know why she was not forthright.
I can't read her mind, but that's what she told me.
You don't say.
Wolfen73 says, this is exactly the result of the lack of control she has presented here. He has realized he can openly disparage her and flout the court's rules and nothing will happen.
No, that's correct. That's my biggest criticism of the whole trial absent him. He's doing everything wrong, but she could be a lot stronger. I understand what she's doing, and I guess it's her call. She's the judge. But
at any time during your investigation in regards to
Today was
the
painful.
incidents
You were watching this morning, right?
with Ms. Patterson, did you at any time see interviews that were conducted with Nicholas Kirby and Corey Runkle?
What do you mean by see them?
Had you seen any statements made by those two parties?
No.
What time is it in Korea?
Would it be fair to say, assuming that
It's 11:33 p.m.
Okay.
for the incident on the evening of November 21st of 2021, would it be fair to say that at some point they were interviewed by law enforcement officers, to your recollection?
Yes,
And you've never seen any of those interviews?
they weren't video recorded.
Had you seen any written statements from them or report from law enforcement?
I received a summary of what they stated verbally from another detective. Yes,
So it'd be fair to say you did have knowledge of what they said transpired on November 21st of 2021.
I acknowledge what they said. I didn't see anything. Correct.
Oh God. Ooh, I'm gonna definitely get a fucking sitting standing desk soon. I can't just.
I feel you.
Where?
My ass hurts.
You feel me and
Oh,
your ass hurts? Okay.
It's all your
To
fault.
the best of your recollection.
A lot of
Seeing
that
what
going
those
around.
two parties had said, what do you recall?
Get that butt.
You know,
Evidence, you didn't see what they said, and also calls for hearsay.
Sustained.
what did you read
Objection.
from those statements given by those two parties?
Objection. Calls for hearsay.
Grounds
Sustained.
for the sustained.
Calls for hearsay.
I'm trying here, Your Honor. I'm trying.
One second.
You think he might be trying to set up thing like he was threatened or somehow forced to run, and this is so there's a duress
Do
defense.
you recall what officer took those statements from?
Well, one of his stories was that there may have been another passenger in the car with a knife
in
threatening
relation
him.
to the
But the guy
incident
with the
of
knife
November 21st
said
of
no.
2021?
It was an
Yes.
altercation before.
Yes.
What do you know?
And
Yeah.
what law
No, you don't,
enforcement
because the window
officer
was tinted.
Detective Van Els.
And I do not believe duress is a defense to first-degree murder, by the way.
No, it's not a defense to first degree murder. Well, I think the only thing you could do is eliminate the intent element and drop it to a second degree. Right? Maybe.
Well, I don't think so. I think the one crime that you cannot say, like if somebody puts a gun to your head and says, kill this other person, I don't believe that's a defense. I don't think you can. I think you have to take the bullet. I'm not 100% sure on that, but I haven't had a case on that. But I believe that duress is not available as a defense to first degree murder. So, and the fact is if he's in control of this car, he's accelerating and running down grannies. I don't, if somebody's got a knife, you run into a pole, you
After that,
stop the car.
report that you wrote on November 22nd of 2021. Was that the end of your investigation into the incident of November 21st of 2021?
No.
And what was the extent of your investigation after November 22nd of 2021?
Judge, I'm gonna object. Well, on the defendant's behalf, I believe here, based on previous rulings the court has made.
Sustained.
They're protecting him from his own record.
Yeah. Oh, quite a bit.
Yeah, that's a good question for Bronca.
The as far as the murder, I almost wonder if you could raise it as an imperfect, like similar to an imperfect self-defense, where
It would be a mitigator in sentencing, perhaps.
yeah.
Yeah. He's taking his time, isn't he?
The reason, by the way, someone said stop helping him, but the reason they're helping him is because protecting
you
him
speak
from
with Ms. Patterson
really
again after
obvious mistakes,
following your report?
especially on a motion in limine
In
that
reference to
was
the incident
previously ruled on,
on
is
November
what the
21st,
court should do here.
2021?
What's up, Drop Bear?
G'day.
I don't understand your question.
Did you speak with Ms. Patterson after you filed your report in relation to the incident from November 21st of 2021?
No.
I'm so glad I have a lot of whiskey.
I take it I've missed some downright
In
fuckery.
relation to the alleged incident on November 20th of 2021. Do you know if that alleged incident ever took place?
Objection.
Grounds.
Calls for hearsay, lack of personal knowledge.
Well, you reported it.
It also goes to one of the ultimate issues that the jury will need to determine, so it's sustained.
We need to talk about the motion in limine and how that plays and opening the door, so we can do that at the break or at the next opportunity.
That's what happened with his rap video yesterday. Was I believe that was excluded in pretrial motions until he opened the door to the identity.
What would be required generally in that type of thing is the state would ask the court for a ruling that the door has been opened, but that would involve excusing the jury. So, Your Honor, we have a
No
motion.
further questions right now at this time.
So what they do is they say, we'd like to excuse the jury. Then you discuss, you say, we believe the statements open the door.
Sir, you may step down.
And then the court would pre-rule before you introduce the evidence. You don't just blurt out the evidence. The proper way to do that is to get the judge to make a ruling.
For that particular witness.
All right, I'll first you'll raise that on an appropriate break. The next witness, please.
I don't think these witnesses are helping him as much as he thinks they are.
I think he thinks that if people are confused about a detail, that is reasonable doubt. That is not reasonable.
Yes. For that, yes, for that time. Yes. I
No
believe.
one else is here?
No, it's not 10:30 yet.
Yeah, so the way that would work is if he takes the stand, they could say,
Who's supposed to come in 10:30, right?
Call your next
Oh,
witness,
God.
please. I don't have that list right at my fingertips.
Yo,
So what
mama.
happened?
I don't have that list right at my fingertips, but I know there's a witness available, so please call your next witness.
Can I be provided that 10:30 list?
No, call the next witness who's available.
Does the state have that? You could pass it over. I don't have that at my fingertips.
Sure, let me jot it. I have it, but I'll write it up for Mr. Brooks to review. Your Honor.
these prosecutors are. Hating on him so
Other than
bad.
that, the jurors want to stand for a minute, go ahead, or anyone else in the courtroom.
It's got 45 minutes of time until your 10:30 witness comes in.
So what they do is they have a certified judgment of his prior sentence, which I think he's a prior sex offender, right? Felony. So he's a felony sex offender. And you confront that witness on the stand. So if he takes the stand, I would expect them to say, "Are you Darrell Brooks?" And he's going to say no. "Do you have a prior felony conviction?" He's going to say no. And then the jury's actually going to be able to see, at least this is the way it would work in Florida, see his prior conviction. Now,
Yep.
if he doesn't take the stand, they can't do that. But he could open the door through these other witnesses. And that's what he's doing. He's kicking that door open so they could bring in his prior conviction because he's opening that subject. But they don't want to do that because that's like you're sort of a side issue. It's not about the trial. It's about impeaching him. So whether he opened the door or not would be an appellate issue. So they don't want to create an issue when they don't need to.
This paperwork.
Thank you for everyone. Have a seat then. Please call your next witness.
And who determined this order?
Mr. Brooks, I'll take up that issue outside the presence of the jury later. If there's a witness available, please call the witness.
That's not the witness that was intended to be called at this time.
Too
I
fucking
understand
bad.
that, sir. Under 906.11, I have the authority and the discretion on that. So please call the witness who's available.
So I'm being rushed to judgment.
No, sir, I'm trying to have an effective and efficient use of all of our time. So please call the witness.
Which is respected, but at the same time, being is that this is my
Right,
time to
I'm going to
present my
excuse the
defense.
jury for right now. I'll rise for the jury, please.
Well, this is a good time, I guess, to mention the, just in case anybody's curious, the best chat on the internet is the Locals live chat, rekietalaw.locals.com. Get your little booties in there. It's a wild place, man. It's full of jokes and memes and commentary about this case
Thank
and
you.
whatever
Be
else is
seated.
going on throughout the day.
Mr. Brooks, under
And
906,
Loraxes,
I do have the
apparently.
authority and just my inherent authority over this case to require you to call the next available witness.
He's the next available
Um,
witness,
you-
I'm guessing.
In my opinion, we're not entirely cooperative yesterday with the process. And so I told you that 3 witnesses would come in at 8:30, 2 would come in at 10:30, 2 would come in at 1:30, 2 would come in at 3:30. And then if there were any left, I wasn't sure if there were or not, would come in at 4.
You also didn't provide me with that list.
You were advised on the record,
But
sir.
It's your list, you
You
dick.
provided to me.
Sir, you chose not to write down. So that's on you, not me.
Nah, that's
So,
no. You
here's
can't.
the
That's
thing.
a rush to
Erica
judgment.
Patterson is here, so I'm advising you that she will be the next witness that you call
Oh.
if you so choose. If you choose not to call her right now, then I'm releasing her from the subpoena because
Oh.
we have almost 45 minutes until 10:30,
Whoa.
just slightly under that. And
I'm a little surprised that this
there's
kind
no
of
reason for you not to.
atomic level thing. So witnesses,
On
I've
your
had
list
witnesses
to
sit
the
out for
bottom,
hours.
The listing, as I understand it, the groupings of 3.
But I think her point is that
Tuesday
she's the
morning,
only
Tuesday
witness that's
afternoon,
there.
Did you
Wednesday
receive it?
morning, Wednesday afternoon, and so on and so forth. That's the order. I told you very specifically, I'm not going to have everyone come in at one time because that's not efficient, that's not effective, and it's not courteous to them. People have families, people have jobs and other responsibilities, and we're trying to be mindful of all of that as well while having the state assist you in getting these people here. So I'm advising you that if you don't call her right now, you will forfeit your right to call her.
Is that lawful law?
Yes.
Sir, I believe I have the authority to do that. She's here.
Rob law, laws, law blog.
I'm just
She's
asking the
your
question.
witness.
I'm just asking the question. Is that lawful law?
Yes.
I
Yes.
have the authority under 90611 and other rules and the inherent authority of this court to control.
If he's
the
smart, he'll
order,
filibuster
mode
her
of
for the next
interrogation.
45 minutes.
Your
Get her
Honor,
all
Why is
why
flustered,
is it
hot,
always
make
so
her go back
hard
to
to just
chambers.
say yes or no?
Yes,
Is it lawful
I have
law?
the authority, sir.
I'm not disputing that.
You just
I'm not
disputed
disputing.
that.
No, I asked the question. Is it lawful law?
Sir, I've told you what I believe.
Ask the appellate court.
Okay,
You told
don't
me
want
what
to
you-
recognize it, that's
told
fine.
me
You
your
want to object
authority.
and note it,
You
that's
told me
fine.
your
Your
authority.
objection
I'm
is
not
noted
debating
on the
your
record.
authority. I'm not.
So I will address one other issue with you because you said you had an issue regarding the last witness.
She
which is
can't
fine.
just say yes.
Quickly, and then I'm going to have the jury brought in, and that will be your opportunity to call
That's a
Ms.
misdirect.
Patterson.
That's a misdirect. What issue did I said I had with the
You
last?
said you wanted to raise an
said-
issue with about
What I
Detective
said
Guzman's
was I
testimony.
might have more questions for that witness. I didn't say it was an issue.
Well, I didn't hear that, sir. You had your opportunity to ask the witness questions. He's been released.
Your Honor, if I mumble something under my breath, somehow that's audible, but when I talk clearly, somehow
I may have
nobody hears
missed
me.
it, but I heard what
Been a
I
long 45
interpreted
minutes.
was when you said I may have an
She's got him on it. Why is
issue
she
with the
answering his
I didn't
questions?
understand. I guess I didn't take that as you were going to reserve your right to recall him.
The love
What
boat.
so
Is that the-
are you telling me you'd like to reserve your right to recall Detective Guth?
Yes.
All right.
There you
And that
go.
will be noted. and
You
we'll
didn't
keep him
answer
under
clearly when she
the subpoena.
mentioned it specifically. That's your problem. You so
Now,
busy about the record.
That should address that. I'll have the jury.
I do
brought
want her to
back
say
in.
just one
You
time,
should
just
be
every
prepared if
fucking thing you say in court is
choose to
on the
call Ms.
record.
Patterson, this is your opportunity.
It's
to
being
do it.
recorded. All of
At
it.
the same time, though, that's still a rush to judgment, Your Honor.
There's a bunch of jackass lawyers watching you as we
I
speak.
should be forced to call people in the order that I'm being told to when these are my witnesses. My subpoenas.
You did
And
not
it's her
want to
fucking
provide us with
court.
the order, and I respected
But
that, Mr. Brooks.
But I said that
And
from the
so then
beginning.
I asked
Your
you
Honor,
to put
with
him
all
in
respect,
flux.
did I not inform Your Honor in the court that I would not give a specific order? I stated that numerous times.
And Mr. Brooks, I
Numerous
have
times.
authority to tell you otherwise. You
I
may not
did-
like it, you
I
may
did.
disagree with
It's
it.
not
You
about
have
that.
been-
It's about the rush
You
to
have not been
judgment, Your Honor.
cooperating with this process. The
There's
state has
nothing to cooperate
graciously
with.
agreed to.
They're gonna have
assist you
angry
given your
sex soon.
Custodial status.
Okay, I never asked them to
frankly,
do
any
that.
attorney in this
I never asked
situation
them to do that, Your Honor.
would
If
give
they
us
didn't
the
do that, you
order.
wouldn't have any
Did
witnesses.
I not? Did I ask them to do that? I did not ask them to do that. They
No,
volunteered.
They offered.
So at the end of
but-
the day,
but we expect
if
your
they didn't want to do
cooperation
it,
in that.
yeah, but that wasn't one of the stipulations when they offered to do it, Your Honor.
If he's smart,
Let's be.
he's gonna
No,
drag this
common
to
courtesy is the
10:15.
stipulation,
Okay,
sir.
but it
And-
wasn't
and here's the
stipulated
thing.
to, so I didn't have.
You are well advised of how this process was going to go.
No, I was not.
It is
because
normal
if you-
in a trial.
You can't
to
put
call
the people.
witnesses
You can't
out
put the
of
people
order
in a
based on
specific
their
spot for me,
availability.
Your Honor. Come on now.
That it is.
That's a rush to judgment.
There's no rush to judgment here. You
Did the
keep
state?
saying
Did the
that,
state
sir,
have to
but
put
that's
their
not the
witnesses?
case.
Wake
Your Honor,
me up when
with all-
something
with all due
happens.
respect, did the state have to put their witnesses in order and tell me?
It's irrelevant what the state did. in
Did
that
they have to
regard.
do that?
They didn't need your assistance to do that.
Did they have to do it?
No, they did
I
not
didn't have to be
do it.
provided with. We're going to call this witness at this time.
But they're
and this
able
witness at this
to
time.
contact
They
their
didn't have to do that,
witnesses
so why should I have
and
to do that?
accommodate their schedule.
Couch,
It's not about
couch.
the state. It's not about the state. It's about the witnesses.
It's about what's
Chambers,
fair.
now-
It's about what's fair.
No, frankly,
Tired of
sir, it's
this.
about you trying to control what's happening in this.
How
courtroom.
am I controlling what's happening? I'm the one shackled to the table with
So
a.
here's the
with a shock
situation.
device
It is
on my, ankles.
9:52.
I swear
So how's
Tackleberry
I'm
just
trying to
said, "Let me
control
tase him."
anything?
I'm
Let me
He
tase
I
him.
just want
He
this to
did.
be fair, and it hasn't been fair.
Mr. Brooks, it's fair.
No, it's not. If I have to do something that they don't,
Come
have
on,
to do,
Judge.
how's
Just
that
have
fair?
some fucking balls. I'm getting sick of this.
Explain to me
Because
how that's
the
fair.
process that has been set up to frankly help you. get
No,
the
it's not
witnesses
helping me by.
to
It's helping.
court.
It's helping the state
And no,
by being able to say,
fuck
if
off.
we know the time and we know
You
the
did
person
not-
and
I
we know this,
asked you-
then we can be prepared. So we'll
She's
already
fucking
be
lost
ready.
the plot.
That was
I
the
asked
whole
you
aim of that.
yesterday, and I would have had her come in later. You didn't want to answer that question.
There was no
And
question. There was no question to answer.
This
I
is
did-
an abusive relationship.
You said yes, you did.
That's why I said they're
You
gonna have
did
angry
actually
sex here any minute now.
Give them my witness
Mr.
list.
Brooks,
I gave them my witness list.
yesterday,
It's not my fault.
I very
It's not my fault they
expressly-
weren't
Not
gonna
my
be
fault.
prepared to
Mr.
do
Brooks,
their
here's the
to
deal.
do
The
their
jury's
cross.
coming out, and I'm gonna stand my ground on this.
I'm gonna
Okay,
stand my
it
ground,
is-
too, but
if
I'm
you
not gonna
don't call
be disrespectful or disruptive.
If you
I'm just
don't
stating I
call
wanted to be
her
fair.
When the jury comes back out, I'm releasing her from the subpoena.
You can't do that.
For
Law,
your
where's
lack
the
of
lawful law?
cooperation.
Where's the lawful law? I have the right to
You have to
witnesses,
cooperate with this process.
but I
sir.
also have the Sixth Amendment
Well,
right.
We have a witness available for you to call. I can require
It's
you
not
to
the
call
witness
her
that
right
should have
now.
been called at this time, Your Honor.
It is based on the list that you provided and
That
in
didn't
the
have a
orders.
time. That didn't have a time or
I'm not going to
or an
play
order.
this game with you,
It's
sir.
not no game.
It
That's what
was-
you don't
it
seem
is
to
a game
understand.
you. I believe that fully.
I don't care what you believe fully.
All right.
It's not a game.
He-
I don't take
I
this
have-
as a game. That's what
Let me explain
nobody.
this to you
That's what
once
nobody.
again.
You don't got to explain nothing to me.
She needs to remove him
That's what
immediately.
you don't understand.
Yeah.
You think
You
that
want
this
to
is a
answer
whole
me?
game to me?
He's gonna
This is
win.
not a game to me, Your Honor.
He's got 20 minutes to go.
Nothing about this is a joke.
I never
That's
said
what
it
y'all
was a
don't
joke,
understand.
but there's
And it's
some things in the
unfair.
ship
It's
that's going on.
unfair and it's disrespectful to me that you think I would come in here purposely and
Sit your
treat this
ass
like a
down
joke
here.
of a game.
Oh. Get him, Tackleberry.
What
Get
type-
him.
What type of statement is that?
Sasquatch in
Your
the back
life
a little
is
bit
not on the
upset too
line.
now.
Mine is. And you
That's
think
Chris
that I
Pratt.
think this is funny?
I don't think it's
I think it's funny.
whatsoever.
So,
And I-
Chris
so
Pratt
I
from
think, Your
Parks and
Honor, with all due
Recreation.
respect, I think you
So
should show
we're
some
gonna take
respect.
a 5-minute break, and when we come back, the jury's
Oh,
coming out,
boo.
and you need to call your
Oh,
next witness.
so much for standing your ground.
No, you're not rushing me to judgment. I don't care what you're talking about.
Light his fucking ass up.
That was the bailiff's opportunity right there. But see, she
had
she
it.
is so weak right now. I got to say, really
He's
weak.
winning.
He's
winning
winning.
today.
He's-
He's
and
running
she's
the
gonna say-
courtroom.
Gonna come back and say, "Sorry, baby. I'm gonna make up with you, baby."
I know it won't be like the last time, the next time. I know it won't be like the last time,
That's
the
right.
next
I
time.
promise to be better. Just give
You're
me
like-
some love.
Now listen, girl. I told you once. I tells you again. What's up? What's up, Hayden? How you doing, buddy?
Yeah, good. Glad to be here. I wasn't sure if I'd make it. We had a massive electrical storm that took out the power. So
Yeah.
An electrical
was,
storm? Like lightning?
yeah, like 3,500 kilometers down, like right from Queensland right down to the bottom of Australia.
That's
it
like
was
8 miles.
An enormous storm.
Fuck, I got a Mike Pence flight. Oh, God
Oh, I
damn
actually
it.
saw it fly past your head. It went zoom.
Dude, it I don't know what happened. Actually, I do know what happened. Fucking fly. I hate it. I hate it. I hate it. I hate it. Anyway, I think they come in through my air conditioner pipe or something because it's cold out. Anyway, yeah, no, this judge has lost control of the courtroom. So they're gonna take a 5-minute break. They're gonna come back at 10. It's probably gonna be 10:05. I think it'll be closer to 10 minutes. It'll be about 7 minutes, I'm guessing. And then what? It's 25 minutes until the 10:30 witnesses show up. He won't have to call this chick that he's for some reason avoiding calling her. Not sure why. Like, she's there, but he doesn't want to call her now
because he is trying to control the court.
Yeah,
You know,
and
now
she's letting him.
I'm a little surprised that they're getting so atomic with this witnesses here at 10:30 and time. I mean, and maybe it's just maybe I was an abusive prosecutor, but I would call cops and I'd say you need to be here on Tuesday and Wednesday, or Wednesday, Thursday, Friday, and they just be sitting out in the hall cooling their heels, probably hating on me. But I mean, you know, the block of time that they're trying to say you need to have 10:30 to 11 to this, that's too atomic level control. And I think the subpoenas are broader than that. They could wait out there for the day. It's not going to kill him. And this time discipline, she's going to lose on that. And he's forcing her to lose on that.
Yeah. It'll be interesting if she excuses the witness from the subpoena, though.
That's a tough remedy, but she has not been strong the whole way. So her threats have become idle. Yeah, it's tough. I mean, I understand what she's doing and I wouldn't want to be in her shoes, but he's letting her control she is letting him control the courtroom.
Okay, so I had a question for you, Steve. Now so binding and gagging is a remedy that's recognized in what was it, Illinois v. Allen. However, given that this judge has demonstrated that she can merely remove him to another courtroom and mute him, which is an effective binding and gagging. If she bound and gagged him in front of the jury, would you make an argument as an appellate lawyer that it was that was an impermissible prejudice before the jury?
Whether you have an argument and whether it's going to be successful are two different things. Okay. So you might be able to make that argument. I think the Allen case is clear that binding and gagging is one such remedy.
And wasn't that 1973 or something?
Right. In uncivil law, I actually watched most of his analysis. Uncivil law did an analysis of the Allen case, and it's a really good analysis. He's a smart guy, and he did it very carefully and methodically. So if people are interested in the remedies and why this is an issue about the remedy, because it only lists 3 remedies. One is contempt, and the other is binding and gagging. See, now in this case, for example, the jury is out of the courtroom. He's getting out of control. He's talking over her. He could have that bailiff put a matter and say, okay, you're going to listen to me, and I'm going to bind and gag you right now, so you have to listen to me, and then ungag him before the jury comes in. No harm, no foul. The problem is the binding and gagging in front of the jury. So she can control him in that way. That's one option she has that she's not going to do. But I'm just saying that these are amongst the many remedies.
Yeah. It's an interesting idea of because I'm trying to figure out. I mean, she needs to take control of the courtroom. What she needs to do is just remove him to the other place and mute him until it's his time to speak. But I think what'll happen is he'll just stand up and do the same shit while muted, and then eventually she'll just have to rule that he loses his privilege to call a witness.
Well, and there's a lot of things she could go with this. Another one is that, and I was thinking about this a little bit about making case law. Like the appellate courts are not going to entertain any of his garbage that he's done so far. He's made himself completely appeal proof, right? Just by being an idiot. But, what they could do, he could write a pro se or pro per appeal on his own behalf. So the public defender's office gets it. It's an Anders brief. They say there's no issues. Here's a factual summary. Write your own brief. And then he writes his own brief, right? And all the times that he's been injusted. But you know what the appellate court could do? And I was thinking about this after watching Uncivil Law. The appellate court could come back and say, we agree with the judge that there are other options beyond Allen. For example, you could appoint him a new attorney. You could remove his right to an attorney. You could remove him from the courtroom, even if he's represented. They could add to that list by appellate ruling against him. Now, this is exactly how we as citizens lose rights, because of some idiot like this and bad facts that all of a sudden are now the court's going to say, we've got to give her options. So now the court has more options to control the courtroom. And then that gets applied to good citizens who are trying to do the right thing. Does that make sense? This is how the arc of the law tends to go towards the state, because of people like this who are going to make bad law. I'm just saying the appellate court could do that. He could write his pro per appellate brief, and the court could come back and say, we're going to say she was absolutely right and she should have done these extra things. Here's a bunch of remedies that we're saying are legal, and now there's case law that she can point to do extra remedies.
We have an off-topic issue to deal with. Lady Racket sent me a screenshot of her analytics on her most recent video, and it has the YouTube search terms that are most frequently associated with, or that return this video the most. So the first one makes sense, real lady rackets. Second one makes sense, lady rackets. Okay. The third one is Danger Witch. And the fourth one is McJuggernuggets. And I don't know how to feel about that. I'm not sure how to feel about the fact that when my wife does a YouTube video, YouTube categorizes it under McJuggernuggets as a search term.
What is that? I mean, who comes up with
flattered.
That? First of all, who searches for McJuggernuggets? Second of all, why does her video show up? Oh, Jesus. Okay.
Hilarious. I mean, seriously, I was watching you stream with Drex last night, and how the hell do they get away with naked yoga? on YouTube. I'm sorry. How does
It's
that not breach
educational.
the terms of service?
You bigot. It's educational.
It's
Especially-
horrifying.
Especially if the
When you
camera's
said
going
that-
down the anus.
The rabbit hole, so to speak, that sent me down when you said that in my office. I ended up at full-on Brazilian waxing videos. How is that even there?
Yep. Brazilian waxing, educational content,
There ain't nothing educational
vaginoplasties.
about that.
I got your educational content right here.
Or I shouldn't say vaginoplasty, labiaplasties. I believe they have those on YouTube as well. It's wild.
I have
YouTube's
nothing
a
to
weird
add.
place.
It's not my area.
John Moes says, "What is a lawful law?" It's a term made up by an idiot.
Is that
It's-
lawful?
She could
Lawful
just
law.
say,
Just keep adding laws to it and keep asking. Is that a
Blah,
lawful?
blah, blah,
lawful,
blah,
lawful?
Oh, okay.
she
So
could easily just say it's law of the. She could just easily say that it's part of the court rules. It's part of her judicial discretion. I don't get why she can't just say
did.
yes.
She did,
Well,
but he doesn't listen.
She said it that way, which I think is the proper way. But I think she's worried about saying, "Oh wait, hey, speaking of an incorrect statement of law." What's up, Andrea? How's it
What's
going?
up?
Hey, what's up, Andrea?
Hey,
How
it's
you?
bright
I haven't-
and early here, so nothing like a dumpster fire to really get the day going.
Oh, dude, it has been a mess today.
Hey,
Have
I-
you been following along with this trial?
I
She said it that way. What?
He's got an echo. She's got.
Yeah.
oh shit, do I have the echo?
Yeah, you do.
I think
Oh,
she's playing
I
it
think
on
your
the video.
YouTube video's playing.
Oh
Or
my
the
god.
Rumble video or something.
I haven't met the new one.
Because it's on a delay.
Are things sane now?
Yeah.
Okay.
Introduce the pretty lady now that you've got to clean up your act and not be so nasty.
Oh, so you
Well,
don't
man.
you don't know Andrea. Clearly.
Yeah, hi, nice to meet you. We haven't met.
Yeah. Andrea, this is Steve Gosney way across the way here. He's a Florida public defender.
Hi, Steve. I'm a Washington public defender.
All right, brothers.
And
Or
she likes sovereign
siblings.
citizens, so this is her bailiwick. She loves the soft sets.
Oh yeah, we all had a good one. No, I didn't realize until yesterday that this was just going to be a boring old DV abuser case where the whole reason we're having this trial is because it was her fault that all this happened.
Yeah. Well,
Now
I mean,
I know.
it's true, though.
He honked his horn and 72 people didn't get the hell out of the way.
Yeah. Well, if she hadn't made him do all that in the first place, we wouldn't have had this tragedy that we had to cry over.
Women.
If they would just stop ruining everything, it'd be really nice, just for a few days. No, so we were asked a question about, he keeps saying lawful law. Is this lawful law? And the judge is hesitant to say yes. Maybe you guys think differently. I think she's really hesitant to make a definitive statement of law.
But she's a judge. That's her job.
Yeah, but it's like this extra point. I mean, I don't know.
Did I tell you
think
I
she's
read-
hesitant. I don't think that she needs to be.
I read
Yeah.
through the whole sovereign citizen guidebook that you had sent me.
You realize
read-
your entire life's work is a lie?
Yes, no. Well, it was fascinating. I love the fact that your chatters and users and Rumble people all went and asked about the whether the sovereign citizen guy, whether they defend this guy. And really, it's a guidebook on how to be the most difficult jerk possible in a human being in the world. The self-centered, narcissistic jerk. So here's how to do it. Don't agree to everything, object to everything, come up with stupid law and then keep asking questions, never consent to anything. I mean, that's kind of the basics of it, is just wear everybody out, which is exactly what he's doing. And it's a really, I've never seen the actual guidebook, but I found it now. And I did, because they all run from the same playbook, but it's basically how to be difficult. And so he's playing that book, and you got to be on your game in order to deal with this jerk. And I think the female judge here is being too nice to him. She needs to put the hammer down. I mean, there's only so much you can take. He is showing such disrespect for the court, and it's a bad example for the world. Anybody who's watching this who think, oh, he's getting something on her. She could put she could be a lot more aggressive in her control of the courtroom.
How many times do you think they should tase him today?
10 at least.
Should.
Just a battery check at least.
Was
I
that
mean, look, there was
tasing on the record?
I have honest to
Like,
God
there was-
never seen anything like that last 10 minutes.
Well, that's
in
just
my
it. Someone
life,
in chat said, "Would any of us get away with any of that?" And the
We'd
answer to that
be
is
in
absolutely
jail.
fucking not. Yeah,
But you can't
We
put
would-
him in
we
jail.
would be
He's
reviewing
already
it at the
there.
expert board. Yeah.
There's
We'd- we'd
nothing
be-
like
we'd
the
be in front
freedom
of the
of being a
ethics
man
board.
with
It's
nothing to
ridiculous.
lose.
With nothing to lose. And and that's like the one thing that's kind of the upside about him being pro se is that when I was a lawyer representing like, oh, the guy who's already in on life on a 3 strikes and he picks up, some prison assault or something like that. And he's got nothing better to do, to entertain himself than maybe try to shank me with a pencil, so.
That's why they give those jobs to those guys.
At the table, but I presume she'll be back shortly.
Grounds for
God.
tasing.
Dee Dee Hine
Advising
says,
the
Di-
clerk to have the
Dine?
jurors brought out.
I watched you and Drex show from last night. You have great chemistry together. You need to do that more
Who's here to
often.
call
Today's my
the defense
birthday.
next
Thanks for the
witness?
coverage, entertainment today.
Matter
Oh, you're
jurisdiction,
welcome.
it still has to be proven for the record.
I decline to do. Your objection is noted for
Is
the
the
record.
audio on?
No.
Of course it is.
Your objection is noted for the record.
Is the audio on?
Yes, it's on, sir. It's on.
She
She
didn't
is
cool
still
down at all.
exasperated.
Address subject
Nope.
jurisdiction.
That was not 7 minutes well spent. She's still very tightly wound.
She was just on the phone to her therapist.
And
Proven it
here's
for
it
the
written.
record.
And your objection's noted for the record.
Proven subject matter jurisdiction for the record. Proven it.
I was going to
I
make a
don't
joke
know.
about something else that could have been done, but there's a lady present.
There's
You
only
really-
one way to solve this problem.
You really want to know what he would accept as proof of subject matter
That's
jurisdiction.
judicial determination that you don't have to answer.
The
that.
state of Wisconsin saying,
Yeah.
I'll take it.
Here's the information.
I didn't hear what you asked. The jury's coming in.
You heard
Because
what
I mean,
asked.
I actually
she
did
wrote
not.
a ruling on it, gave it to him. He ripped it up.
Come on now. Come on now.
Did he rip it up?
Yeah.
Oh, Jesus.
I cut that out.
This guy is such a control freak.
Subject matter jurisdiction. You know that.
What gave you the
You know
first
that.
hint? Was it running over a bunch of people, or was it beating his girlfriend?
I'm just spitballing. I'm just thinking, like horrible.
That's why he's the judge and you're the law talking guy.
Has Andrea or Andrea,
Everyone, please be seated.
have you represented pro se clients? Or I mean,
Call its next witness.
sovereign citizens?
I've only had a couple,
Paperwork.
fortunately.
Judgment.
But we've agreed that I would be on retainer for all maritime law related questions.
Well, so my only time I ran into somebody with maritime law was actually a prospective juror that during voir dire was raising all kinds of, peculiar questions about maritime law. So could have used you as a consult on that one. I can't tell. Should I pick this guy or not pick this guy? I don't know.
So Canuck says there's no proof. It's a trick question. He thinks the court only has jurisdiction over the legal fiction, all caps name, not him. So he knows she can never put that proof subject matter jurisdiction. But that's not subject matter jurisdiction.
Yeah.
That's in personam jurisdiction, which
But
is a
there's
different
some-
question.
There's something in
Yeah.
the federal. They're leveraging the federal. Having read their book, they're leveraging something in the federal constitution about the jurisdiction of federal courts and having maritime jurisdiction. And if you don't have some sort of special proven jurisdiction, you're a maritime court. It's a complete misreading of the law. But that's what they're doing. Am I echoing again?
Somebody's echoing. I don't know who. Andrea is echoing. Hold on. I'll bring you right back, Andrea. StreamYard's been stupid lately. That might fix it.
I was hoping my headphones would fix it.
Defense calls Erica Patterson.
He's calling the girlfriend.
Since I'm being rushed to
Oof,
judgment.
yeah, this is the ex-girlfriend that he ran over.
This is the one he's expected to really spend a lot of time with, I think.
Yeah.
Yeah. It'd be more than 35 minutes.
I'm gonna pull all of you guys out and bring you all back in because StreamYard's been doing this lately. I don't know what's up. Got rid of all them. That was easy.
I'm first.
Okay, hopefully that'll
Check
fix
one.
it.
Can you hear me?
Yeah.
Good morning, Ms.
Testing. Nick's a dick. Yep, we got it.
The witness,
That's
one
true.
which is on my right. You may recall it's upper riser. When you get there, please remain standing. Raise your right hand and my cousin Teresa, who's across from you and on my left, will swear you in.
Do you solemnly swear that the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth, so help you God?
Why would you call her?
Thank you. Please be seated.
To pick on her.
First thing I will ask you to do is to
That's the only reason I can think.
first and last name.
Is he's going to spend the next hour and a half
Erica
just.
Patterson. Thank you. Go ahead.
Wasn't
You're
she
witness.
15 when he got her pregnant? Is this that chick?
Mm-hmm.
Yeah.
Yeah, that's the one. And she still looks 15. I'm not going to lie. This is not going to go well.
Yeah.
By the way, guys, we have 17,000 people watching on Rumble. Make sure you hit that Rumble plus and that thumbs up. Push it up the page.
ErikaPatterson.
Just 1 second, Your Honor. I'm trying to find some relevant paperwork here.
What paperwork do you need to see?
Whatever allows him to delay doing what he needs to do here.
Well, he's got this thing where doing police reports often differ from the testimony in for small ways. So he's seeing every little microscopic inconsistency and thinking those inconsistencies are reasonable doubt. That's a common mistake of this type of narcissistic delusional person.
Yeah.
They think that that's reasonable doubt. Reasonable doubt goes to the overall elements. You have a set of witnesses and a set of bits of evidence that taken together prove, say, identity. Whether there's little inconsistencies throughout, that's just memory and human nature.
I want to do another super chat, but I just am nervous that he's going to start talking immediately.
Sorry about that. 1 second. I'm trying to find this.
Do the short ones.
Genkin says the judge's body language standing there is almost like an assault victim. I think she's honestly scared of him.
When you're ready.
I think she is being abused.
Mm.
There is an abuse dynamic going on here. And he's a perfect abuser. This is a textbook abuser right here.
Angry Medic 5 says this witness, previous one, is the definition of fuck games. You ask dumb questions and I give you dumb answers. Surveyor 8587 says, do you think the judge will unload on Darrell at hard at the sentencing? That'll be interesting at the sentencing. She could bind him and gag him at the sentencing because there'll be no more prejudice left to have.
Did you print that off for me? Did you email?
Well, actually, at the sentencing is also a hearing in which he's entitled to be represented. He could ask for the public defender to represent him at sentencing, by the way. He would have a new opportunity to get a public defender in. But if he becomes he's not, no.
Seeming to find paperwork that I just had on the table.
Oh.
For some reason. Odd reason.
Some odd reason. The bailiff must have stolen your paperwork. Oh, this
The facial expressions. Jeez.
This locals chat, I'm telling you.
Please, for the love of God, just unleash Officer Tackleberry on him once.
Yep.
Well, good morning, Miss Patterson.
Good morning.
So what do you do for a living?
Oh,
I have my CNA certificate.
I'm going to direct your attention to the evening of November 21st, 2021. Do you recall what you were doing that evening?
I was hanging out with my friend Corey at Frame Park. I had spoken to you, Mr. Darrell Brooks. You came out there at Frame Park and met me after Miss Corey separated from me with her friend. Me and you got into an argument.
Whoa.
God.
Pursuant to
That's
the
not an
question.
objection.
I am answering your question.
I was referring to the judge.
I was hanging out
I
with
think
Miss
I kind of
Corey.
got a little ahead of.
Oh. I'll let you interrupt the answer and you can ask a follow-up. I apologize. I was instructing the clerk to turn up the volume. So go
Pump
ahead.
up the volume.
Ask your question.
Same question.
Sure.
Yes.
What were you doing the evening of November 21st, 2021, before linking up with the alleged defendant?
Linking up.
Me with my roommate at the time at Frame
Don't talk
Park.
about that.
And what were you and your roommate doing?
I'll object. We covered this ground during her testimony previously.
Objection and grounds. So I object to that.
Wait, did he just
Grounds
object
for
to a dejection?
objection.
Yeah.
Mr. Brooks, we did cover many of these topics previously. So if there's new topics.
With her?
Please
Was
go
she
through
the witness
those. I'll give you
previously?
a little bit of leeway
Okay.
to lay some foundation.
I think I missed that
Go
day.
ahead, ask your question.
that's
The
with the-
objection is from the state is overruled. Do you remember the question?
You asked me what we were doing at the park with Corey? Is that your question?
Yes.
We were drinking. I was drinking Mike's hard beverage.
Oh, wait, no, I did see this. She had like one Mike's. The other chick had a half
Do
pint
you
of
recall,
vodka.
around
What's
what
wrong
time
with that?
It was when you and your
Yeah.
roommate arrived at the park.
Or it's
I only had
Friday
one
in
glass,
Korea.
remember?
You
With
can't
legal
judge
license.
me.
Do you
I
recall?
only had one glass. I just never said how big it was.
Do you recall having any phone interactions during that time when you and your roommate were at the park?
Phone interaction,
1-900.
yes.
Phone interactions.
Do you recall who they were with?
Sounds sexy.
What do you mean by
Sounds
you?
less sexy.
Darrell Brooks.
$1.99 per minute. Not available in Utah, Wyoming, or Idaho.
I don't consent to be called a name.
Wonder if she's gonna pull.
Yeah,
one.
how's he gonna evade that one?
The alleged defendant?
No.
Oh, she doesn't usually refer to him by that name. Here you go. There's new. There. It's maybe it's not him.
Jackass, motherfucker, and all sorts. That's what she refers to him.
Maybe he makes her call him Math Boy
Would it
Fly.
be fair to say that during
Baby daddy.
those phone interactions, there was a talk of you guys meeting up? Would that be fair to say?
Yes.
Do you recall, to the best of your recollection, what time that would have been at?
No. I don't remember. It was throughout the day.
I'm sorry, are you making references to the phone conversations being throughout the day?
Yes.
And so at some point, would it be fair to say that you did meet up with the alleged defendant?
Yes.
Do you recall what time that was?
I just told you no.
Do you recall if you were still at the park during that time or had you moved locations?
Still at the park.
And was your roommate still present with you at that time?
No, she left. We went separate ways. I stayed at the park and she went her other way with her friend,
Do you recall who that friend was?
Nick.
It's me. Actually, no, that was the sex offender.
Yeah, I was gonna say that's the
I'm not sure
that's
you
the
wanna
essay,
take that
Nick.
one.
There's
Yeah.
gonna be a meme now with Nick's head on some witness. There he is. He's in the witness.
T Cool says, sounds like someone read a forum post about Rush to Judgment last night. Also, what are the odds the DA just asked, ma'am, how old are you and how old is your child?
Or let me back that up. Would it be fair to say
back
that
it
at
up.
some point during the meetup with the alleged defendant, things got a little chaotic. That'd be fair to say.
Would that be fair?
It's one way to characterize it, I suppose.
And do you recall if at that point you were still at the park?
When we met up,
Yes.
well, we were at the park for a second, then we drove around.
Where did you drive to?
Around, then me and you, Mr. Brooks, were arguing in the car. We went up this, it's a street, it's like a hill. Went up there, and then me and you got into an altercation. I got out of the car, walked back towards Frame Park.
Oh, wait, again.
Hold on, she's answering your question.
Um,
You asked her where you drove from. Go ahead.
What?
Finish.
yes, ma'am. And then I was walking down the street, and I left your car. And that's when you followed me, and I walked back towards Frame Park. And you were following me.
Made reference to walk back to Frame Park.
I don't know the exact street name. It was the walk back down the hill. I don't know the exact street name.
Did you at any time, sorry, did you at any time during your travels back to Frame Park, did you at any time notice that there was something going on in the area?
No. When I got to Frame, I was too worried about walking back to Frame Park. When I got to Frame Park after I left it, that's when I realized there's nothing going on.
So he didn't know there was a parade? Is that his defense?
You know, he's
It's
not laid out a
fluid.
cognizable theory of defense. He had the chance during his opening to like at least say, but I didn't try to do it though. And he didn't even get
He
there.
didn't even do that.
Yeah.
It took him 15 minutes to deliver 4 minutes of statement. It was
Yeah.
bad.
To be fair, there was like 8 minutes of blubbering, so you know.
Yeah.
But
I did see the opening. It was unimpressive.
Mm.
It's a historical. We got to look at the pain and the
And what did you do when
history.
you arrived
and
back?
Sorry, and the history and. Ugh.
I called my friend.
There's
Nobody
two
cries
sides,
for
and only one's been
themselves like a
pointed out there,
narcissist.
Mr.
Don't
Brooks
cry
called
for
me.
me, Argentina.
I went back to the SUV, the car, and you argued with me some more. I walked back across the street, and by that time, Miss Corey had walked towards us to meet up with me.
You made reference to you calling your friends.
Mhm.
Do you recall? Well, let me back up a little bit. Did you call your friend Corey or the friend that she had left you to hang out with?
Corey's phone, I kept calling her phone. Her phone kept going to voicemail, and I called Nick's phone. He put Corey on the phone. I said, Darrell Brooks had just hit me.
That'll do it.
I hate how whenever he does this, I have to wonder if the video is buffering or not.
Well, it's either the video buffering or it's his brain buffering. Either way, there's some buffering.
Yeah,
going
it
on.
is his
Yeah.
brain buffering.
Insert Jeopardy theme here.
I'm going to back up a little bit, if I may,
I need to add that to the soundboard.
to the day prior, November 20th of 2021. Do you recall what you were doing that day?
Well, where I was staying at the shelter at first, I was arguing still with Mr. Brooks all throughout the day. Me and Corey had left, and Corey and I stepped away, and I went back to Frame Park. On the Frame Park, that's where I met you at. Me and you also got into argument that day, but we didn't drive around. We're at the Frame Park.
It's pretty accurate from locals chat.
So you're saying that you and the alleged defendant
You are the defendant, not alleged.
Yeah.
were together the day of November 20th, 2021?
Yes.
Do you recall around what time that was?
I do not remember.
So something I've missed, are these people from Waukesha or how did they end up there?
I think they're from Milwaukee. I think she ended up in Waukesha because she's at a shelter or something.
They were at the wrong parade at the wrong time.
And you
Yeah.
said you were briefly with your friend Corey that day?
Yeah, but she went a whole different direction. She didn't come to Frame Park.
What if that was
you know,
his
they're-
defense? He was trying to run
She
over
turned
a
around
different
the street right
parade.
before Frame Park.
And he just happened to get hemmed in by some plastic barricades.
Is there a SOV-sit defense to transferred intent? I'm not sure.
Mm.
Maybe that's the jurisdictional grounds. I was trying to run over a parade in Chicago, Your Honor. And so
Give
this
him
should be
ideas.
federal court. Cross state lines.
Do you recall at any time on November 21st of 2021
I can hear the Wisconsin come through his
being
voice from time
interviewed
to
by
time.
a Detective Guth?
Yep.
A little bit. Not her so much. But someone
It's
said
less
she's from
pronounced.
Atlanta.
Do you recall
It's less pronounced when he's rapping.
giving a recorded report at that time?
I don't remember.
Do you recall if you had given Detective Goof all the details of the alleged incident on November 20th of 2021?
I didn't give him all the details, but I did the next day when I seen him.
I wonder who the prison's going to assign as his roommate. I do not consent to being on the bottom bunk. Just she say, like, how long will this debate go on? She has to listen to him, but his bunk mate-
bottom. Is that
That's
lawful law? It's law of the cell.
the law
You're
of
going to
the
respect my authority.
sub-
Surely he's not a stranger to prison. Do we know his record?
Oh yeah, he is also on a register.
Were you aware?
He is
That-
not a stranger to the dark. That's from The Greatest Showman.
Dumbass almost-
Bigots.
Yeah.
It was reported there was in fact no incident on November 20th.
Dumbass almost got his rap sheet entered
That's not
when he was
true.
talking with the other sex offender. God,
We've seen his rap video, just not his rap sheet.
Yeah.
That of itself is a crime.
Sustained. I'll strike the question and the answer. The reason stated, sir, rephrase, or
So can I
No.
show the witness the same paperwork that I attempted to show?
no.
And why not?
Not
Because we said
relevant.
so.
How's it not relevant when that was just testified to?
Oh, damn.
Would that be opening the door?
No. Next question.
you can't open the door on your own witness, just as a
Yeah.
matter of law here. But
Open the door for yourself.
this is such an example of what not to do.
Well, you can
Any
open the
reason
door
why?
for the other side on your
Yes.
own witness.
Yeah.
Yes.
This is the example of what not to do.
No,
The
this
example?
guy, the prosecutors.
It happened on November 20th of 2021? Grounds.
Since facts not in evidence. Sustained.
Grounds for the sustain.
Facts not in evidence.
The records.
I ask you to sustain.
If he's trying to impeach her with his prior statement,
So,
there's a way to
I'm
do
speaking
that.
to Detective Goof.
What are
during
the
first
Vegas
interview,
odds on he knows how to do that?
Do you
Yeah.
recall why you were not forthright with information?
Oh, lovely.
It wasn't-
Locals
that
chat.
was
At least
That
plus
was an
800
objection.
on his Vegas odds.
Why not?
I don't know, Mr. Brooks.
Ooh. That pose.
when speaking with a law enforcement officer, would it be fair to say that you should be truthful and honest?
I was very truthful. I wasn't telling everything at once. Told him the
Not
next
at
day,
all.
Mr. Brooks.
And in the alleged incident on November 20th of 2021, were you injured?
No. Well, you did hit me a little, both like little.
Were you injured?
It hit
I
me a
have
little.
marks on me. Is that what you're asking?
So where were you injured?
By my lip?
Objection. This states the evidence.
Grounds.
I believe the witness understood the question. She answered it. It may stand.
If I didn't hit, you must have quit.
Did your roommate observe any injuries from the alleged incident on November 20th, 2021?
She knew about it, but there's nothing visible on my face.
Just want to say thank you to the locals chat that
Do
posted the
you know
article
if
about
your
his history.
roommate? Do
That
you
is a
know
hell of a
if
rap
your
sheet.
roommate had spoken with law enforcement about these alleged incidents
I
from
don't know.
November 20th of 2021 and November 21st of 2021?
I don't know.
Did she ever tell you yourself that she was interviewed by any law enforcement?
I don't remember.
Oh, come on now.
You're gonna use that instead of the crickets now, aren't you?
Gamer635 says, "Isn't this the one who he has his prior conviction on? You know, when he was 23 and she was
So
15."
what time did you meet
Yeah,
up with the
also,
alleged defendant on November 20th, 2021?
he was out on bail after
I
hitting her with
remember.
a car when he did the parade thing.
Morning time, evening
Afternoon.
time?
So he has a prior with striking
Afternoon.
somebody with a car?
Striking her with a car, yeah.
Wow.
He was on bail.
He was
When he
out
did
on
this.
$1,000 cash bail for second-degree recklessly endangering safety, felony bail jumping, battery, obstructing an officer, and disorderly conduct.
Yep.
So he's on bail for striking somebody. See, that's relevant. Boy, I would bring that in. If I was the prosecutor and he wants to testify on his own behalf, I would definitely bring all those.
They've been really hesitant.
404B. 404B.
That was
What were you
that was
doing
actually his
prior
best objection.
to the
Yeah.
alleged
Earlier, he
meeting
got
up with the alleged
he got an
defendant?
entire video
Objection.
struck
Grounds.
because she
Asked
mentioned
and answered.
briefly that incident.
Grounds for staying.
Asked and answered.
When?
Next question, please.
When was it answered?
There's a very slight possibility. Well, very slight. There's a real possibility I may have to end the stream early because our nanny may not be showing up today. But that would be around an hour from now. I'm trying to get final information from Lady Rackets on that. But just as a warning, I'll try and give people lead time if we need to fire up another stream somewhere. I'm hoping not, but
Me too.
So to the
Reality
best
is
of your
real.
recollection, you can't recall why an alleged incident on November 20th of 2021 was reported to never happen.
Objection.
Grounds.
Same reasons as the previous objections.
Since facts not in evidence, it characterizes her prior testimony and irrelevant.
I object to that respectfully and
Next
ask for a
question.
legal finding of fact and a legal reconsideration of that ruling, Your Honor.
Denied. Noted for the record. Next question, please.
I'm trying to figure out how something got pulled out of thin air.
you're trying to figure out a lot of stuff.
Interesting.
Interesting. Interesting.
I wish like 6 people hadn't
Well,
died
fair to
and
say that
66
you
people
have-
hadn't been run over. It'd be more funnier.
Mm.
A child in common with the alleged defendant. Would that be fair to say?
Yes,
Is that the only child in common?
yes.
You have any other
The
children?
age difference.
Objection.
Has
Grounds.
nothing to do with the case. Sorry.
Hold on, there's been an objection, not
She wants
relevant.
to get out how many baby daddies she has.
Grounds for the sustain.
He got her pregnant when she was 15
Yeah.
What was the record?
and then ran over her.
Not
Yeah, but
relevant.
how many men's been in there
I was
since?
not relevant.
Next question, please.
I was not relevant.
Just don't engage him.
Who has the higher body count, her or him?
Oh.
Oh,
Oh.
shit.
Sorry.
Oh my God.
Damn.
The child that you're having in common with the alleged defendant. How old is that child?
15,
Uh-oh.
Do you keep regular contact with that child?
off and on.
Describe what you mean by off and on.
I'll object.
Grounds.
This is not relevant.
Not relevant, sustained.
They're saving
Not
you from
relevant,
this
sir.
one, buddy.
Horrific.
She
Yeah.
answered it.
She answered it.
Next question, please.
Bro, the prosecution, that door is swinging wide open. State your age for the record, ma'am.
She already did that, and now we got the age of the child, and that he's the daddy. So the jury's paying attention.
Child
They'll
in
be able
common
to
that
do
you
so.
have with the alleged defendant. Does that child live with you?
No.
Objection.
Grounds.
Relevant.
Grounds.
Sustained, not relevant. You don't have to answer that.
Do any of your children live with you?
Objection.
Grounds.
Relevant.
Sustained.
Damn. He's just brought her in to abuse her.
Grounds for the sustain.
Yeah.
Not relevant.
It does not go to credibility.
Grounds are not relevant.
The objection has been sustained.
For relevancy. I object to that and would like to inform you that I intend to appeal that decision unless you want to give a legal reconsideration of that ruling.
Noted for the record, I direct your attention to 906.16. And the basis for the objection being sustained is it does not fall within the categories listed. Next question.
Now, theoretically,
That
if this was a real case,
Next question, please, sir.
the way that you preserve
lawful law.
the way that you preserve that is
Statute 906.16.
the way you preserve this is to proffer it. So you make a note of the questions she's not letting you answer, and then you go back outside the presence of the jury, proffer the witness testimony outside the presence of the jury, create a record of appeal why it's harmful to your case. You think, what's the chances he's going to do that?
Well, 0. He thinks he's making his appeals to this judge. I mean,
But that's how you properly. If you've got this issue, a lot of trial attorneys don't do that, and they make
No, they never do, and it ends up getting held out for the writ.
Where did you meet the alleged defendant?
Reno, Nevada.
How long have you known the alleged defendant?
16 years.
You made reference to meeting in Nevada. Do you recall where you met at in Nevada?
No. I don't remember.
Whiskey Actual says at my middle school. Jesus. Wait, Vices, where'd you go? What happened to you?
That was a
In relation to the alleged incident on November 21st of 2021, would it be fair to say that there's been no contact between you and the alleged defendant?
Not since then, no.
That last answer was kind of low. Did you say no?
I said no, not since then.
So that would mean, assuming that would mean no contact at all via phone or anything like that.
No.
So my question would be, I don't know if you can see them from here, but do you recognize these pictures?
Oh, come on.
We need to show those to the state. The bailiff will take them.
Look at the look on her face.
I'm leaving. Please let me back in.
I'm gonna object to those being shown as a witness. They have
Hi.
no relevance
Oh,
whatsoever.
damn it.
Yes, they do. And
Sustained.
I'm getting to
What's
how
wrong?
they
You having
have
echo
relevance.
issues
It's
again?
also never been disclosed to the state.
Am I?
at this moment.
You got
Sustained,
both mics on again?
And why?
not relevant.
They are relevant. It creates foundation,
To make your offer of proof.
and I can prove that.
I'll take up the issue outside the presence of the jury at the conclusion of this witness, and if need be, bring the witness back in. But next question, please.
And these need to be offered into evidence as well. You
Let me
stated
reset the
that
panel
there's
again.
been no contact.
I hate StreamYard.
How would
Check,
the
check,
alleged
check.
defendant be?
Check.
We'll see.
How
my
would the
fault.
alleged defendant obtain photographs from you if there's been no contact?
Objection.
Grounds.
Suspect, yeah.
Grounds.
Sustained. Assumes facts not in evidence, not relevant.
How's it not relevant? Photos just don't pop up out of the blue.
Mr. Brooks assumes facts not in evidence,
No,
and
it's
at
facts.
this
I
point,
got the pictures right
conduct
here.
after
Facts.
the alleged date of violation here, it's not relevant.
Alleged violation.
You're
For the record.
correct. After the date charged, that the dates that are charged for these allegations, you are absolutely correct.
Thank you.
Schooling the judge.
Wait, what was he correct on?
Alleged violation.
Oh, okay. I was like,
The dates of the alleged
Since
violation.
the evening of November 21st of 2021,
have
have
you thought about
attempted
me?
to contact the
Objection.
grounds?
Relevance.
Grounds.
I'm gonna excuse the jury.
Uh-oh.
Yeah.
I'll rise for the
Yeah,
jury.
Look at these photographs.
Every time I do, they make me laugh.
My
She was
angel
just
is
a
the
minor
centerfold.
then.
Blood runs cold. My memory has just been sold. My angel is
In the centerfold. Yeah, that's good. Who's
Oh,
singing?
there you go.
That was me, Jay Gal's band.
I'll tell you, you must be my generation.
Absolutely.
Xers.
Wait
right?
a minute. Wait a minute. How dare you, gentlemen,
Yeah, it's
exclude
got nothing to
me
do with
from
generational.
Centerfold?
Thank you,
Don't you do
Stephen.
that to me.
Awful funny.
Oh, they used to play that song at church dances.
Hold
And
on.
everybody would freak out once they started paying attention. Then like that false
Mr.
ending
Miller,
would come in.
we
They
can
go, oh,
always
thank God
prove
it's
as to
over.
why you
And then
believe
it would start
in
again and they'd
photographs
panic.
And the questioning about contact after the alleged incident is relevant.
It's relevant because these were sent by the witness.
So, okay. So why is it relevant?
It assumes a fact, not an evidence.
Impeachment? Is that what he's
What is
saying?
letter
Hold
two?
on, hold on. Tell me the basis you believe There's been
Your
communication, and why you believe it's relevant to
It's
her testimony.
relevant because it was testified to her first time testifying, and then also by was the last guy, Guth, that he was told that the witness was supposed to be so deeply afraid of me and all this type of stuff. So if you're so deeply afraid and worried about somebody and this and that, why would you sneak
Did
and have
you want
contact
to
with
open up the door to the other act's evidence of
That's
you
not
using-
opening.
No.
That's not
Hear me
opening the
out.
door.
Hear me out. Oh, yes, it does.
No, it doesn't.
These witnesses have been incredibly careful to abide by my rulings. Sometimes in a court of law, when there are pretrial rulings, the testimony of a witness needs to be said in such a way not to run afoul of that. This witness, Detective Guth, I believe Detective Casey and others, Corey Runkle, and even Nicholas Kirby yesterday, this court has all had to stop them so that they didn't run afoul, or they stopped themselves so that they didn't run afoul of the court's pretrial ruling on other acts evidence between you and this witness. And I've been very, very careful to make sure that doesn't come in. But if you keep
Way overly
questioning
careful.
her about whether she's afraid or not, or
I
why
didn't
she wouldn't
question
have
her about that.
contact or
I
not,
didn't
you are
question her about
opening
that.
the door to that testimony. All of
How
my
does-
rulings have
how
been
does-
made to prevent
how
what
does
could be
pictures
seen
work?
as prejudicial evidence. The standard's not prejudicial. The standard's whether it's unfairly prejudicial.
It's
But you
unfairly
can
prejudicial.
open the door
Your
to
Honor,
that,
It's
sir.
unfairly prejudicial that I have a document stating that November 20th never even happened, but yet and still the witness
Then
can get
have
on
you
the
turned
stand
that
and lie on the
document
stand.
over to the state?
Come on, man. Y'all know that's not right.
What?
Y'all know that's
It's
not right.
required.
Then you need to immediately turn it over to the state right now. It may become relevant, but no one has seen it. When
So-
did you receive the
so that- so
document?
what-
Hold on. When did you?
Wait.
I'm having you make an offer. But when did you receive the
Okay,
document?
but that I just want to state for the record, Your Honor, that's kind of biased because the state did the same thing yesterday with creating an exhibit right on the fly that didn't even exist that I didn't have. But
That's
then,
not true. That's a
no,
misstatement of the
that is
evidence.
true.
No,
She said it herself.
no. Marking an exhibit is not creating an
No,
exhibit.
not marking the exhibit. She said
We're
that
not going to go
essentially-
down a tangent, sir.
All right,
I'm going
I'm
to
not gonna
focus
argue
on
with
this,
you,
and I'm
but
going to
it's
give
not
you the
fair.
opportunity
It's not
to make
fair.
a record.
It's not
All right.
fair. It's not fair.
When did
He already made a rap record.
receive this document that you claim was sent by this witness?
It's not claimed. It's for a fact.
Sir, it hasn't been established yet. I need to make a
So
record.
do y'all want
I
the
wanna
letter?
see
Y'all want
the
the
letter.
envelope? What?
I want to see the letter.
Okay, so I gotta.
And I wanna
so
know
I gotta
when you
bring that in.
received
So
it.
I gotta bring that in. Every time this what I don't get. Every time I'm presenting something that needs to be made for the record and placed in the evidence, it's a problem. But the state can do it, no problem.
It's not.
Yeah, because they know how to do it.
I want you to
That
make
was the
a
proper
record. If
procedure.
I don't
Discovery,
don't make a
dipshit. All this
record,
should
So
already
what?
been
I need to
emptied.
make a ruling.
It threw people off the loop. They weren't ready for it. They
Fucking
scared of it. That's what it is. Oh man,
Mr.
I
Brooks,
feel like I'm watching an abusive
you are-
relationship
you
here.
are-
stop it.
letting
You're a
me
public
ask the
servant, Your Honor.
questions.
I respect your courtroom. I
You
respect you. You're a public
Shit,
servant,
you
though.
do.
Your job is to be the referee. Is it or is it not?
Your
You say so yourself on record that your
Nut
job
up,
is
Judge.
being the umpire.
Your Honor, can I ask?
We're not playing the same game, Mr. Brooks.
My apologies too, but it needs to be some truth,
Truth.
especially when we're talking about stuff that didn't even happen, but they're allowed to get on the stand and say that it happened when they know it didn't happen.
So let me make. I'm going to make a record about what
This
he's
is
referring
ridiculous,
to
man.
in count 77. Okay. The
And what happened to that paper? Because it was on the table. Then when I
Mr.
come
Brooks,
back in,
I
it's
need to
nowhere
make a
be found.
record of a variety of
So who
things.
took my paper?
And you keep interrupting me repeatedly today. I have shown an abundance of patience this morning. I've warned you repeatedly about being removed from the courtroom. And then every time I try
Just
to get into it,
Jesus.
you, meaning an explanation and make a record, you
Yeah.
interrupt
This defensive engaging is annoying.
from what is
Mhm.
being done this very second.
I didn't attempt to do anything.
Yes, you do it repeatedly,
Okay,
sir.
whatever.
So you're doing it.
Bickering. It's like a bickering, abused.
Yeah.
And she's past the point of being able to put her foot down at this point. Just
The
gone on.
document-
He's turned the trial into Calvin Ball, and she's playing along.
So, Detective Guth and this witness was a letter sent from the state of Wisconsin to the court regarding count 77. The state sought to dismiss that count, and they have prosecutorial discretion. And I granted the request that the charge be dismissed.
Why was the charge dismissed?
And that's
Because they asked
I
for
can't
it
answer. I
to
was
be.
dismissed because the request was made, sir. They don't need a reason. There's an abundance of case law about prosecutorial discretion. And
Wait, did he
They
seriously
chose
just ask
not-
why did they drop a charge against me?
to pursue that, my
Your Honor-
guess
Your
is
Honor,
maybe
with all
to
respect-
simplify things and to keep this tidy. I don't know. You know what? I'll
Oh
indulge.
yeah, getting rid of
the effort.
count 77 really made things a lot tidier.
The state
Because
Oh.
78 would be
of
ridiculous.
that charge prior to the
Mhm.
start of this trial.
Yes, Your Honor, because as Ms. Patterson just testified a short while ago, she did not have any visible marks or injuries from that event. And we did have the photographs of her injuries. We did not want to confuse the record as to whether or not there was a battery that occurred on November 20th.
Freeze frame.
Your Honor, I object to that.
Internet
This-
freeze
this is the
frame.
letter read.
You have the letter. You showed it to me,
I
sir.
tried, yeah, and I've been trying to find it ever since I came back in, and now all of a sudden I can't.
And now
find it.
you're impugning, though, like somehow you're impugning the integrity of this court,
No,
of
I'm
the
not.
bailiffs of this state. You're accusing, frankly, everyone
Did I
of
point
moving
the
your
finger?
papers.
Did I point the finger at anyone? Did I say anyone did anything?
Not directly, but indirectly you did,
So
sir.
how can you make
You
the assumption
made-
that I'm saying?
Can
that
I
I'm
please
pointing to
make the
someone?
record?
What are you saying
without
then?
Yes, yes,
interrupting
you may.
me?
Yes, you may.
This is not a court.
I appreciate that. Thank you.
No.
This is a bickering of
But you
between
made
That
an abused
Right there,
couple.
when the judge says, "May I please make a point?"
I can't
Yeah.
find my
Game over.
documents,
She
I don't know
lost.
What happened?
Yeah.
Things of that nature. When you came back out, you took multiple minutes before you even asked your first question of Miss Patterson. And if I need to,
The
I'll
judge
have the
asks
bailiff
this
put on the record
defendant
that
if she
no
can
one
ask a
touched your
question.
table.
Yeah, bad.
Did I say anything?
Bad look. But she's been doing that for a while
You
from what I've
implied
seen.
it, sir.
But did I
Asked
say
him
that?
for permission.
I
You
never
stated
said.
it implicitly.
I never
Look,
asked.
there's a time for
the bailiff,
manners
say,
and there's a time for sticking a boot up someone's
my
ass.
table.
And she
Yeah.
has long
Said that
past
to
it.
them. I just said I can't find my paper, which is the truth.
And the
I'm
way
looking
that
down.
you said it, like,
I didn't point anyone
Without-
out. though.
And like,
I
well,
don't
that's
think that
kind
that's
of
fair.
interesting.
I don't
I don't
think that
have a
that's fair to
document that was
assume.
just on my table. That is what you said.
That's
Words
what
to
I
that
said.
effect.
But I did not.
so
point.
terrible.
I can
You
see
have
if
the
I
letter.
came in, Your Honor. With
You've
all
been
respect,
given,
I can see if I came in and said, "Hey, one of you moved something off my table," or if I would have directed that towards the state, or if I directed that towards the clerk.
If only there were cameras that
He's
could
being
identify
such a
when that
cunt
was
right
That would be
now.
more of what you're saying.
you need to continue with the record, sir.
Yeah. So whiskey
It's
actual.
very apparent to me, sir, that
Hold
every
on.
time, I can't say every time because that would be an absolute, but many times throughout this trial, and especially the last 2 days, when the court makes a ruling that you disagree with, or I want to make a record about some behavior of yours, or a further record about a ruling that you that was not in your favor, that you start peppering me with questions or comments, statements. You question me
Why
about
is she
law.
like
You ask,
this?
is it verified law? It is, from my perspective, a clear
Stop
attempt
saying from my
to-
perspective.
to kind of turn us in a direction away from what we're doing, perhaps even to stall and to delay.
I'm sorry.
That's
you
my
feel that way.
perspective.
Perhaps.
I'm making a rule. You're doing it again.
I mean, because it has no validity.
And you're sounding whiny and
So-
not
This
like a
is just
judge.
bickering. This is just bickering.
I am trying
Yeah.
to make a record
Judge, you
outside the
don't need
presence
to.
of the jury.
It's already on the
about-
record.
Exactly.
Line of questioning you want to ask Ms. Patterson. Now, I've reviewed repeatedly up on the bench 90608 and 90616, which are two of the primary ways you can attack credibility. I've referenced one of those previously. 90608 is evidence of character and conduct of a witness. I'm not going to read through it all, but it's limited to character for truthfulness or untruthfulness. It's not specific instances of conduct. It's character evidence, which frankly wouldn't even come from the witness who's testifying. All right. Then there's the statute on bias, 90616. All right. And none of the questions, as I heard them, went to a permissible topic under bias of witnesses. You generally said credibility. You did not give me any further explanation as to why you believed it was relevant to credibility. Now we have you claiming that there's some document that was sent by the witness after the charges were filed that apparently contained photographs. I think, and you can clarify the record momentarily when I'm done, that you believe goes to the credibility of this witness. So I need to ask a few questions about that, sir, to determine whether
You do
it's
not.
relevant to those issues. Number one, when did you receive this letter?
I received this multiple letters actually over a period of time. It wasn't. I referred
Okay, so
to
give her
this
a date
one
range,
because
dumbass.
one had the pictures. But
When?
And why do you
the
believe
one
it was from
to
Ms.
answer your
Patterson?
question, to answer your question with clarity,
Thank you. Does it have a date on it? The letter?
no, I didn't bring the letter. I brought the pictures because I thought
Best evidence rule.
my interpretation. I thought showing the pictures would be okay. How did I get these? So my mind was saying, show the pictures. They didn't come out of thin air.
Yeah, it did.
The witness
We need
knows
the
that they
letter.
sent me the pictures. They know that.
Well, again, it assumes facts that aren't here. You're assuming this witness sent it. I don't know. But even if she did, what relevance does it have to her credibility before this jury?
It goes to the credibility because she's put on this facade of being so afraid of someone, but yet still, you know that we're not supposed to have contact, but you still sneaking behind and saying, "Oh, I wonder how you're doing," and oh, this and this and that.
I
Oh,
don't think
you know, I
she's
still
ever
love
said
you.
she was
Oh,
afraid. I
ooh,
think that was the officers who may have stated that, but I don't believe she
But-
ever said that. She specifically said today when you asked her why did you, it was either why did you go back or why did you have, I'll look at my notes, and she
it was
said,
why
I don't know.
it was why weren't you forthright with all the details?
This is so
That
pointless.
was the question.
I would hate to be the
Okay, I'm
appellate
gonna
lawyer
ask
having to read
even
this
if
bickering.
This letter's from her, these pictures are from her. How does it
Your
relate to
Honor.
her?
Did they have a live court reporter in here?
Yes, that's Nick Rekieta.
Yeah, it's me and Drag.
I'm going to ask you point blank. Did you get a letter that's signed from her?
I got. What do you mean sign? No
How
one
do you
signs
know?
letters.
What's your belief? Why do you have a belief
What?
from
I
her?
have multiple
Judge, what are
letters
you
from
You're
her.
not
doing?
answering my question.
It's just,
Why do you believe the letters are from Erica Patterson?
this is so bad.
Because they were sent from Erica Patterson. Why else would I?
Were they signed by her?
What do you mean
For
signed?
Did
fuck's
she
sake.
write her name? on
What
it?
do you mean signed?
Was
This
it-
is like a
Yeah.
courtroom train wreck.
Like when you put it on the contract where you assent to the jurisdiction of
Is it wrong that I'm on his side in this argument?
Your Honor, I'm gonna go out on the limb
and
here.
I'm asking you why you hold that opinion.
I'm gonna go out on the limb here and assume, which I know is true, you've never been in my position. You've never been in jail.
Yeah, she's never
you've never
murdered 6
received a
people and
letter.
mowed down 66
Just
others.
explain that the
someone
letter
writing
was
someone in
addressed
jail.
to you from her.
From
That's
her.
she's
No
just
one's gonna
begging you to
sign-
make the fucking record.
When you
That's
You're
say
all.
not
to me-
answering my
when you
question,
say to me,
sir. What's
did-
the basis why you believe they're from Miss Patterson?
Judge, help him out. Did this come from her email address? Ask that question.
That only she would know.
Jesus.
Did she sign the letters? Is it penmanship that you recognize? Why do you believe they're from her as opposed to somebody else sending you information? Could be your mom.
Why-
Could be. I'm just saying.
Why
Could
was
be anybody
somebody?
else.
This is,
You got to
Oh,
answer
just
my
answer the
question.
goddamn
Yeah,
question.
but you still got to understand why this is mind-boggling to me. Like how
To
I
us
got a
too.
child with this woman. Why would I not know her?
finally
name?
we agree on
You
something.
have to
Why would
have
I
a
not know?
foundation for these letters, sir. That might be
This
through
is
your own
ridiculous.
testimony. So that I'm
Say
trying
because
to
it's her handwriting.
figure out why you believe they're from her, not all this other stuff
Are
about
you
I'm in jail
serious?
and I have a child. I'm trying to. I need to
He's
know
such an abusive guy. He is such an
Are you
abuser.
what do you believe? Why do you believe they're from her? I am serious. I need you to
Because
answer.
they're from her.
But you're assuming.
Like how
You need
else
to
am I
establish
supposed to answer that?
Will she just tell him, please? Like,
I've
just
given
tell
you
him.
a few reasons why
Yeah.
it would lend to that opinion.
So it has to be put in a legal
The
term.
bottom
or
line is I
something?
need the letter. So if you're gonna question her,
Is it
on this,
verified?
absolutely has a right to see the letter. So you need to provide that letter. The bottom line is I'm not going to allow any questioning without having that letter.
So
The
what
state
about-
has the ability to question you about that. Or question
How about
your
putting her on the
statement
stand and
because
saying,
they're
"Did you write this letter?"
asking what your claims are here.
Well, because it's his offer of proof. All he has
Yeah.
to
He
do is
doesn't
say
have the letter.
it's addressed from her. The
When we-
envelope was given to me
I
with
may
the
take
letter
an
in the
early
jail.
lunch.
It's addressed
Her
from her.
address is
That's in
on
your
it.
cell,
Yeah.
then you can go get it and bring it. But without that letter, I'm not allowing this line of questioning.
Now she's staring at the ceiling like a child.
Do you have the letter with
So-
you in court?
I just said no. How many
Okay.
times I got to say the same thing on record?
You know, sometimes, sir, I don't hear what you say because you interrupt me so much
Oh
or you answer
man.
quietly. And I'm taking notes and I'm focused on probably.
And now the
dozen
judge is
things
just
at the
admitting
same
to not paying
But
attention.
if I say something under my breath, everybody seems to hear it. Everybody seems to hear it. It's
Quiet
fine.
courtroom?
Everybody
You usually
assumes-
talk under your breath while everyone else is
everybody
quiet,
assumes
dumbass.
that it has to be disparaging.
Once
or-
again, you're doing this tactic. where you
because
try to
it's not a
go
tactic,
off
it's
of what we're
facts.
talking
It's
about
facts.
to some other reason.
It's facts. Because
some
I
other
find it
thing.
hard to believe that
I'm going to
all
let
of
the
a sudden
state.
nobody hears what I say.
I'm going to let the
Come on,
state
man,
make a
stop.
record of why they
Stop.
believe it's objectionable because I haven't let them do that. I've given you multiple opportunities to tell me why you
So
believe
I
it's.
didn't get these pictures from nobody else. Why was
The
somebody
record will
else
reflect you have 2 pictures that you believe were from this witness.
that I know is from?
No, that you believe.
That I know.
All right, I'll ask
Okay,
the state.
so
their
explain
position
how
on
you
all
know.
of this.
My
All you gotta
position,
do.
Your Honor, is that these pictures, first of all, should not be admissible. 1, because of a discovery violation. We've never seen them before. 2, because we have reason to believe that he did not get them from Erica Patterson. He is on a jail phone call talking to his mother, Dawn Woods, about Dawn Woods sending these photographs to him. Now,
That's a lie. I object to
Let the
that.
state make their argument without interruption, sir.
That's a lie, though.
3, I believe that these photographs are designed to make a suggestion to the jury that Erica Patterson is a bad mom. I think that that's what the defendant is trying to do. And if we're going to go down that road, then we would be forced to counter that claim. First of all, it doesn't make her an incredible witness, if it's even true. And second of all,
She's an
if we go down that
incredible
road, we
witness.
would be forced to counter that claim by pointing out that not only does the defendant not live with the child in question, he doesn't live with any of the other children that he has. He
Oh, Jesus.
impregnated Erica Patterson when she was a minor in Nevada. And for doing so, he was convicted of statutory sexual seduction, pled guilty in March of 2007 for
Ooh.
that felony offense, and is a sex
Statutory
offender
seduction.
on the registry as a result. So if there's any
So what I thought
causation
when I
that would
read
lead
that, I was
to
like,
Erica
"Ooh."
Patterson being a bad mom, Mr. Brooks has a direct role in that causation.
And that's
Furthermore,
I object to that
I'm not
because
done.
that's a
This is
lie.
per
Let him
se
At the end of the
seduction.
day,
Let
if
him
we- If
finish,
we're gonna open the door
Mr.
on that, no,
Brooks.
since he want to make a record and not be accurate,
You're
so let's be
automatically
accurate
into
on the record since you think you know so much.
Taser.
Oh,
So we
And
can
Mr.
open the
Brooks
door
was
on.
being
We can open the door on how old she told me she was when we met.
interrupting.
We can ask
He's-
that
he
question
is
too. Then
over the
Did you
top
ask that?
animated
Do you
right
know
now.
that?
Mr. Brooks,
You know that?
I'm
Tase him.
ordering you to sit down and to let the state.
No,
finish.
Just
no,
kick
I'm
him
not
out.
gonna let somebody be
Tase him.
inaccurate on the record and lie on the
Jury's
record.
not in there.
Under
Tase the
Illinois
shit out
versus
of him.
Allen, I've warned him repeatedly. He's being removed
Ain't
from
nobody
the
got time
courtroom.
for that.
And you know what?
Finally.
Let me dial that back. We're just going to take
We
an
need to
early
cut
lunch
to black.
for an hour.
No,
You
come on.
wuss.
Seriously.
Wow.
He brings that letter and
Don't
he can
sit
show
there and try
it
to
is
think you know what's
inadmissible.
going
She will
on.
not be questioned. And under 90611, I will
You gonna
declare
talk
the
about what my
cross-examination.
kids do. You don't know where.
closed.
You don't know where. What
Thank
happened.
you. We're in
at the
recess.
time.
Boom.
Hour.
Get your facts
Over.
straight.
Get your facts
So
right.
let's open the door on all of it then, so we can get all of it on the record. Since you think you know so much,
What I unbelievable. This is
Wow.
did you
so
know she said she was 18 when I met her? Did you know
Doesn't
that?
matter. It's not a defense, homie.
Doesn't matter.
Statutory for a reason, dipshit.
Strict liability on that one.
Every,
We can have a-
every man over 18 knows that rule.
We can have a long discussion on the propriety of that, but that is the law. That is how it goes. And many a men. What was the judge who said like shop in the adult section?
why is this entertaining though? For some reason, it's like watching a train wreck going, and it's like you can't stop watching, even though it's horrific.
Because
It's
we have
morbid, yeah,
never
but it's-
seen anything like this in our lives. That's why.
Yeah.
Mm.
This is
Yeah.
so far away from like real courtroom and real law. This is a judge who's lost control to this defendant. She doesn't have the ability. She's so used to dealing with professionals and lawyers who are careful and respectful, and she doesn't know how to deal with this guy who is doing everything he can, and he's got a playbook on how to be difficult and disagreeable. And she
Clearly,
doesn't
Binger's
have the
never been their
tools.
courtroom.
What's that?
So clearly, Binger's never been
No,
their
Binger.
courtroom.
Yeah, Binger.
To be fair, I think he'd be just as much of a prick if he didn't have that playbook, though. I really do.
Oh, I
Oh,
agree
yeah.
100%.
Well, that's the bottom line. What does he really have to lose by being the biggest jackass in history? Nothing.
Yeah, he's got to know he's going away. I mean, there theoretically is a question of if he'd ever get out, but at this point, I mean, what evidence do you have?
Just go full Nero. Play your violin while Rome burns, man.
Do you? So maybe you say, well, I didn't try to kill the first people I ran over, but then you plowed into more people. It's like, I was trying to avoid them. Well, why didn't you just stop? Like, why
I was
didn't that
swerving
happen?
all over the road and they wouldn't get out of my way?
Because
And,
she was a bad mom. How do you not see that? I mean,
that's
it's clear.
true. Do her kids even live with her though?
What's that have to do with the murder of 6 or 7 people and 60 people getting run over? How is
It's
that
all-
relevant?
Look,
It's
you
all
gonna-
her fault. It's
you wanna
all
put this
her
on the record?
fault.
She was a bad baby mama, so I ran over a bunch of people in Waukesha, Wisconsin. Yeah, that makes sense.
Now you're starting to
Yeah.
get it.
But Steve, I'm glad you're finally coming around to the truth and the facts that are
Yes.
present in this case.
Just
And
want the truth to be out there. That's all.
let me read a couple of these chats here while we have a break. We have a long break. We have an hour. That's
Oh
that'll
my
be
God,
fun.
is it lunch already?
She called early lunch. That was
I couldn't hear over the screaming exactly what was being said.
instead of throwing him out of the courtroom and proceeding with the trial for the next, I don't know, 40 minutes after that, she called an early lunch. She's losing every one of these encounters with him
It's
She
3-0.
says like last chance, and then she gives in.
every time.
Yeah,
Every
that's
time.
bad. You follow through. When you make a statement, you follow through on it.
Yeah.
It's like when I'm laying in bed and my kids are being annoying. I'm like, don't make me come out there. Like, I'm gonna, unless you stop now, though.
I mean, now.
1, 2, 2.5, 2 3/4.
Like, I'm serious. Like, if I have to get up, I'm taking your iPad. Please go to bed. Dude, it's terrible. It's terrible. She will just not stick by what she says. He knows it. He smells it. And this is an abuser, right? He's an abuser. And I know you guys, I know at least Andrea and Steve have dealt with very, very abusive people. And when you deal with an abuser, the interesting thing is it becomes a character trait of the abuser. They abuse everybody they can until they are stopped by some sort of thing. Some sort of authority has to cut the abuse off for that particular person, and they will abuse forever. This judge should know this. She should have dealt with plenty of people who have abusive personalities in her life, in her courtroom, and she should know that if she doesn't get out in front of him, he will walk all over her forever, and there will be no stopping it. Abusive people they're pathologically abusive. It's not like some guy got drunk and hit his girlfriend once. This is an abusive monster.
Well, I'd like to hear Andrea's position on this, but if she was my judge and I was in her courtroom, I'll bet you she'd be a joy to work with because she's patient, she listens to arguments, she makes clear rulings, right? But this is a different game. She's dealing with this pathological person, and she's got to know her fundamentals. And I don't know that she's really confident in her authority. She's so afraid of the appellate court. And let me tell you, I'm not afraid of the appellate court. I do appeals. And she should not be this afraid of the appellate court. She has so much more authority than what she's exerting. I mean, what's your perspective, Andrea?
Yeah, 100%. And I don't know her professional background. My, general perception is that most judges do not come from a criminal defense background, so they don't have a lot of experience in dealing with these types of people. And I think this kind of shows where that can be, a pretty big shortcoming. I don't want to, Monday morning quarterback her too much because she's obviously got a very difficult job. But she needs a lot more gray rock in her handling of this guy. Once he is successful in being able to poke her and get her defensive and get her making all these explanations and engaging with him in this bickering back and forth, that is fuel. I mean, that is the purpose of why he's doing what he's doing is to get under her skin. And so that's just basic rule number one for dealing with a pathological person is you can't give them that reaction. So it just indicates to me that she is probably a little bit out of her depth here with this type of personality.
And she's also set the groundwork for this because she should have early on, when he starts going off, been hard as rocks and said, "I'm sorry, that's beyond the scope. You didn't listen to me. One warning, you're out." And disciplined him through that if it's possible. Now, some people have no bottom. See, this is the thing. I mean, you're talking about abusers and until they get disciplined, but some people don't have a bottom. This is one such guy. I think he has no bottom to his depth of depravity and depth of narcissism. And so the court system has to be able to deal with this. And it does have the tools, but she's afraid of it because I think she's obviously she comes in with this mindset that she doesn't want the appeal, doesn't want to kick him out. But there's just no way that an appellate court is going to overturn this type of case.
No, and she could, I think, like you pointed out, she could be much harsher than she has been. From my perspective, she has been bending over backwards to be beyond fair to him.
Or forwards.
Yeah, give him every possible opportunity to, try to do what he wants to do, try to give explanations for him, try to feed him what he would need, let him stay in the courtroom when he is clearly behaving in a way that would support, her exercising her authority to have him removed. So, I mean, I tend to agree with your initial read here that, yeah, if you're one of the people who is, playing the game, according to the rules, she probably is great because she does come across as very fair and even-handed and not trying to, tilt the scales one way or the other. But that can be a mistake with this type of person. You can't be fair to somebody, who is just going to see that as an opportunity for manipulation. It's what he's doing.
Yeah, and that's an interesting point, and I may want to mildly, I don't want to counter because you're right, but
pushback.
No, it's going off the same vein. I think it's the thing is there's a desire to be fair from the judge, but what she's forgetting is that fairness implies equal terms on both sides and the referee being fair to those equal terms. But he is not following any rule and he's required to. He is not observing any decorum and he's required to. So like she's being so deferential to fairness, ignoring the fact that these are not level playing fields. She's not being by attempting to treat both sides equally, she would not be being fair already. And she's being overly deferential to him. So she's actually giving him so much power and control in the courtroom that if the state could be prejudiced, and by the way, fuck the state, if the state could be prejudiced in any way, they would have absolutely been prejudiced throughout this entire trial. But they can eat shit for all I care, generally speaking. But I mean, if this were a civil matter and she treated these two parties in the same way, and one was a represented party and the other was an unrepresented party, and she gave this much deference to the pro se party, it would be categorically unfair. That's what I'm trying to get to.
Yeah, she's using this view of fairness that's more of like the equity view of fairness, than the equal rules that applies to everybody regardless of your starting point. So yeah, I agree. She's kind of giving him this boost to put him on a par with the state when that really isn't appropriate.
And what do you think about? I mean, I think the best group in this has acquitted themselves is the prosecution. I think they're so clean and so fair, bending over backwards, but presenting a very efficient case, except for his delay tactics. I think the prosecutor's office, this is the way a case should be tried, absent this idiot. But they're very clean in the way they're. What do you think about that, Andre?
It's hard for me to have a judgment on that since I've just been very piecemeal in what I've been able to see of this case. So far from what I've seen, yeah, I would tend to agree. It looks pretty clean to me. So
Has anybody seen any problems with what the prosecution's done?
Only very, very minor quibbles with an offhanded statement or something that like they just didn't need to do from time to time. Mainly in any other case would be like no big deal at all. But in this case, it's like you just don't need any help.
Like redirecting. They don't really, some of the redirects, it's like, we don't really need to redirect after his.
There's some redirects. And then there's just been a couple little like flippant comments or statements that they have made throughout where it's like, you just didn't need to go there because the facts in this case are so thoroughly stacked against Darrell Brooks that you don't need any help. You don't need to undermine.
Tough sitting there in that courtroom with that guy.
Oh yeah.
And listening to this show, right? Sitting there, and there's something that I've really learned, and I've had to discipline myself as doing trials. When I was doing trials, mostly, is to have a stone face in the face of this kind of stuff.
Yeah.
So being able to sit there coolly and not show emotion is a skill, and it takes patience on the part of everybody when you're a defense attorney or a prosecutor. So, oops. Oh. Yeah, that's right.
No. You're absolutely right. It's again holding the state, as we all should, to the highest possible standards of behavior, and then going back from there. I think the state is doing a fantastic job in this case. But just like that's why I said I have very minor quibbles. But yeah, humanity is the fact that you have to sit in a room with this fucking moron blathering on like an idiot. The law, he's supposed to be representing himself under the law, and he's completely just throwing it out. This is your life's it's your life's work. It's your career.
I did have
completely disrespecting every aspect of it.
Oh, they're dying for him to testify. They're dying for him. That will redeem this everything for them if they get that opportunity.
I did have a client similar to this guy. It wasn't near as bad. I mean, this is really pathologically extreme. But I did have somebody like this that was very self-centered narcissist who would take individual notes and because of this little missing word, and they said it was light when it was actually dusk, and they'd want every little inconsistency questioned, and they'd keep, there's something about this atomization detail that gets that short circuits their brain. And then when it's all about them, I mean, like we're living in Darrell Brooks's world, and everybody else that's there playing in his big stage play of his own mind, and everybody's playing along. So he's having the time of his life. He's in center stage, and the tragedy of injustice and all, woe is me, and all the injustice inflicted on me. Nobody else has any injustice here. He doesn't inflict any, right? It's really pathological.
Well, it is, and it's a big tell. You can see the denial in the strategies that he's using to try to defend himself. It's something I mentioned not long ago in a video I was making was about Scott Adams and his description of cognitive dissonance. And the tell for cognitive dissonance is when you have 100,000 explanations for something. When there's a million reasons for something, it's not because that's justifying you. It's because that's your process of rationalizing and reinforcing the position that you already want to reach. And that's what happens when people go through this granular type of, identification of these minor inconsistencies. That's their reason over and over and over again. It's not because that proves anything. to somebody who isn't in that kind of state of denial trying to justify it. It's really very self-referential for him. He is showing you this is my process. This is how I'm not accepting the reality of the situation because there are minor inconsistencies. It's just a justification.
No, absolutely. And the amazing the benefit of this trial, as painful as this trial really is to watch, because it's hard. And I feel really bad for Jeff and Aussie because half the time they're watching this stuff like 4 a.m. There's 12 drinks deep. They're like,
Yeah, but they get to drink. It's too early for us to drink.
What are you
Yeah.
talking about, Steve?
I calculated
It's 3:30 in
since
the morning,
Monday.
Trust me, I'm on coffee.
Yeah. I calculated since Monday morning,
Excellent.
I've had about
Energy drink.
8.5 hours sleep.
Yeah.
Yeah, it's
Yeah.
fair.
And lots of coffee and nicotine.
Yeah,
Yeah,
I'm getting
cheers.
just a couple hours a night to do it, but that's the nature of streaming trials and streaming at night for me, and for you, it's the nature of living in a fucking weird country.
Yeah.
You strange man.
But
But
the grift is real.
and Aussie's over there just pretending it's the middle of the night because we know that he certainly doesn't live in the middle of the blank ocean that we pretend Australia exists in. So he's just somewhere in like Ohio.
I have you guys keep going on about how Australia is imaginary, all that sort of stuff. I have exactly the same amount of evidence that America exists. As far as I'm concerned, you're all just virtual reality people in the middle of nowhere. So
Isn't Australia populated by people like this that we sent over there just to get rid of them? And now you're the progeny of the
Steve,
Brookses of the world.
You're making the
Aiden, do
case.
me a favor. Hold up your beverage. CGI. Fake.
That's
Look
awesome.
at this.
Fake, yes,
Look at this
yes,
fed. Steve, think about this. So we, the British, though, took a bunch of prisoners and shipped them to an island that is as far away from anywhere on Earth as anywhere can be. That like there's nowhere farther away from everything than Australia. And
where
then
literally every creature is designed to kill you.
yes, the
exactly
entire
survival of the fittest. That's exactly why we
and
have
the
hottest
climate is
chicks.
terrible. And the climate is terrible. It goes from desert to just murderously cold. And then not only that, they somehow form civilization after this. A bunch of criminals show up with nothing and they're like, well, we'll make these boomerangs and then we'll form civilization. It'll be fine.
We'll
And they
build a
they
fucking
do
opera
it.
house.
They do it until the fucking emus revolt, and then they lose to the birds twice.
They've also lost to frogs, mice, and rabbits.
And then they still have a bunch of hot women there. None of this makes sense. I don't get it. I don't get it. Well, we built an opera house. Why do you have an opera? Why do you even do that?
So they
I,
can
don't get
I
it.
do not defend the opera house. I think it was a complete waste of money. Okay, but just
But where else would you show Hamilton, though?
the theater would be fine. We don't need an opera house.
But as you would, fair dinkum, as you would say, Busan, Korea has just commissioned a pretty much exact replica of the Sydney Opera House just down the road from my house.
Oh wow.
Are you serious?
Yeah.
The,
Copyright, but B, why would you bother?
but,
Because culture.
That's not culture.
we take it from somewhere else. No, so what I
Nick,
was getting to.
Where's our grifting titles? Don't we? Where's our little?
Oh yeah, I
Yeah.
turned them off last night for a different reason. There we go.
There we go. See there, look.
Yay. Subscribe to me now.
Yes,
But
I want to find Andrea. Where are you posting, Andrea?
I'm on
Usually on
Twitter at
Twitter.
Apricot Law, and I have a YouTube channel.
And everyone should check out both of them, by the way.
And this is the legendary Andrea Burkhart who organized the crowdfunding to release all of the Amber Heard documents that were released.
Really?
The unsealing.
Hey,
Andrea had the
unsealing.
most encyclopedic knowledge of the Johnny Depp, I don't want to just call it a trial, situation of anybody I met by
The cultural moment.
miles. I'd bring her on and she'd be like, well, don't you know about this? I'm like, Jesus Christ, no, I have no idea. But you know everything about it. It's amazing.
Yeah, I don't know if that's a good thing that I should have out there, but yes, I was following that trial for years, and so when it finally,
Wow.
oh yeah, I watched the UK, I watched the lead up to the UK. I had been involved with it for quite some time, so yeah.
And you said you're a public defender out in
I am.
Really? Excellent. See, I gotta watch, see what you're doing, because I'm just a lowly public defender, which is my real job. But I was telling Nick, I have 70 hours of vacation time I've got to burn before the end of the year or I lose it.
Oh, wow.
So I've been taking off a lot and doing stuff like writing a book.
And he chooses this. He chooses
Yeah, right.
to be here watching this. Oh,
Degenerate.
so what I was getting to before I got tangented by Australia existing, is though it is painful to watch this trial, it's really difficult. We get this insight into a person's mind that you will not hopefully encounter in your entire life. Like this is an abuser, for one. And I've dealt with a couple abusers on the channel, but I have a resistance to abuse personality because I just don't care and I laugh at them. But you see it, and they'll like beat up against a barn wall over and over and over again. Except in the case where someone basically asserts dominance over them. That's not the play I tend to do because I find it funnier to let them just keep going. So, but you don't usually deal with an abuser who's also a mass murderer, who is also a sovereign citizen, and who is also functionally retarded.
No, I don't.
And given the world stage,
I don't think that he's stupid or incompetent or
I
insane.
didn't say either of those things.
Well, you used the bad R word, but I would just say that I don't
functionally.
I'm just trying to throw some, it's a pathological personality disorder and an attitude problem. Attitude, and Andrea, again, public defender's world, attitude gets people in trouble. People that are, we do have people that are illiterate, that are overrepresented. We have people with poverty, but the number one thing is the bad attitude. In fact, it's like people line up and they're like, you want to go to prison. You want to go, you're volunteering because they're so this like this. And then they just keep going and keep going and keep going until they end up being in trial and going to prison. The people with the good attitudes, that we work it out, I think it's so much smoother and they don't get the full hammer of the law. Generally, attitude is such a factor in criminal law.
Absolutely. And that's kind of one of the, was I thinking about this in this case or a different case? I don't remember. Just in general, the factors of, and maybe Steve and Andrea, since you guys deal with this more and more, I think that's been kind of on display. It's on display a little bit here, but it's also on display in the attitude that sovereign citizens have and other people have when they approach the law, is that sovereign citizens have a completely skewed version of what the law actually is. But the principle that they apply to that is very similar to people who do understand the law at a basic level. And they think that the law is this mechanical algorithm and that, you have this and this and this. Most often, this is demonstrated in conversations on Twitter about legal issues, in my opinion. People say, this is how the law works. Bam, 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 bam. These are the factors. These factors are filled, obviously. But once you get into a courtroom, that all changes. And the analysis is completely different of how a trial will go versus what the factual and legal arguments are, because some facts aren't going to come in. Some facts are going to come in from someone who can't be trusted, for example. Some witness or defendant, or hell, the state may act in a way that makes the evidence uncredible for some reason. So I didn't know if you guys wanted to talk about that or if you saw anything about that in this trial or any other big trials that are going on. Also, are you watching any other big trials? Anybody on the panel?
We have
a business.
We have a death case going on right now in my real job. So I've been sort of backgrounding that. But like I said, I work even when I'm off. It's sad. I shouldn't do that.
It's a bad habit to be in.
No.
Okay. What's up, Aussie?
I was just going to say I've been following the Bruce Lerman trial here in Australia. The parliamentary staffer who allegedly raped one of the other staffers right in the Parliament House. That's officially in deliberations as of yesterday, your time. So we'll be very interested to see exactly where that goes. But yeah, that wasn't so good. I mean, there's a whole heap of issues there. She was drunk as a skunk. whether or not she was able to consent to anything, obviously, and whether or not anything actually took place. There's some allegations as to whether or not the security guards actually fulfilled their duties. Basically just left her half naked laying there when they walked in at 4 a.m.
This was only half.
It was the lower half.
Oh, damn. Not a good look, fam.
No,
Jeez.
exactly. So,
what do you
what do I think the verdict do? Sorry.
Yeah, what do you think the verdict will be?
I will be very surprised if they don't come back with a guilty verdict on him. I really will be. There's been a lot of back and forth with it. But given our, if nothing else, the political issues that have come out of it, and now that we've got positive consent laws and all that sort of thing, I think the jury will come back against him. I really do.
Gotcha. So to everybody on the panel, in particular from the defense side, sorry, Vice isn't Aussie, but I have 2 public defenders and I like criminal law a lot. And this is an interesting topic that you just brought up. The idea of is there, okay, so there's a philosophical question, but I'm talking about the legal question. Can you voluntarily forfeit the ability to consent with consumption of illegal substances? Or not illegal, not necessarily, with intoxicants. So the idea out there is once a person gets to a certain level of intoxication, they cannot consent anymore, and therefore another person who might be involved with them would be held liable for what happened in the aftermath, even if that person expresses consent to them, but they shouldn't have been able to. Does that make sense? Like, that's kind of a topic that's hanging beneath the surface of American sexual misconduct law right now.
Yeah.
What do you guys think?
It comes, I mean, legally, yes, you're correct. It comes down to a question of capacity. And in my state, there are issues that come up. There are specific charges that can be levied. It's usually where I am, it's like a lower degree of offense. You'd have, rape 1, rape 2, rape 3, or whatever. So rape of somebody who is incapable of consent for, whatever reason. I think the way my statute is written is it has to do with physical incapacity, developmental disability, things along those lines. Yeah. So they basically put extreme intoxication from a factual standpoint. That's the question for the jury. Is this basically equivalent to, having dementia or, having an IQ of 60 or whatever?
Dumb people can't have sex. That's not fair.
That's basically, I mean, that's
well, thank God that's
if
not
you
illegal.
Get down into the technical part of the rules, that's kind of the conclusion that you inevitably reach, is that, yeah, there would be consent problems at a certain point. People in the nursing home, who have dementia, they probably can't consent either.
Jeff, don't hate.
Don't you start going?
Ageist?
Don't you start going?
No, I'm
to
just-
Jeff. I mean,
I'm actually-
there's a reason that STIs are on the rise in aged care. Okay.
Mm-hmm.
Oh no, this
Don't judge Nick.
For me, this question became really interesting during the Stanford swimmer case, right? Because Brock Turner, because there were fact questions around consent. And ultimately, I think the jury came to the conclusion that the female was not able to consent. She didn't have the capacity at the time. But then,
there's a flip side to that, and I want to address that, because in Florida we have a voluntary intoxication defense, and I will read you. I just pulled up the jury instruction, which is 3.69 and 3.
Look at this guy.
3.6D and 3.6E1, and the state legislature passed these laws to say voluntary intoxication from the use of alcohol is not a defense to crime. So the interesting thing is, what if both parties are drunk?
Well, that was the thing with the Brock Turner case. If I remember right, he tested at like a 0.16 blood alcohol content, or maybe even higher. And so it's like, okay, so at what point do both parties lack capacity?
Mm-hmm.
But it's
can
amazing
one party
because
be held liable? Because
Yes.
couldn't the rape
That's
go
the
both
problem.
ways? As
That's the problem.
it's a weird situation.
It's a big problem, because it's basically Andrea, correct me if I'm wrong, but it targets men.
Yes, it does target men. I don't see how that's even debatable. Of course it targets men. Women
Yeah,
have no sexual agency. It's 2022.
Right. You have two people get drunk and they have sex, and then both of them regret it, but the man gets charged.
Yeah.
Because he's the perpetrator, he's the aggressor, he's the non-victim class, and of course women are always the victims. So that's what we do. And under Florida law, the man cannot raise the fact that he was intoxicated as a defense.
Wow.
It's a
So here's a question.
Yeah.
Someone in chat just raised 2 drunk lesbians. Benefit of the doubt.
Well, which one is the upper
Title
and which
9
one
is not equipped to deal with 2 drunk lesbians.
Well, thank God. I need Drex to come on and consult. He'll just tell us the truth that lesbians
not
don't
real.
exist. They'll be fine. No, that's it's such an interesting it's such an interesting thing because if someone is voluntary consumption of an intoxicant is not a defense, but also like their voluntary consumption of an intoxicant can remove their ability to consent, yet they can still manifest outwardly consent to you. And that's such a weird thing. Now, if the person's knocked out unconscious and you're like, hey girl, you into it, and she just moans, like that's one thing, right? But if she's like Brock Turner's testimony, whether people believed it or not might have been the issue, but his testimony was like, we were making out. I was going back with her to her apartment, or she was going to his apartment voluntarily. Like all of this stuff was going on, and she passed out in the middle of the encounter. And so it's like, okay, well, like at what point where does consent like stop and start? I think becomes a really start and stop. And how is the other person supposed to know? Like these become interesting legal questions.
Well, I would just throw in out one little, I know this is going to be very politically incorrect.
That's my favorite thing.
Obtuse. But, this is an argument for no sex before marriage.
Oh, what are you talking about? These traditional values, Steve?
It's
How
crazy.
dare you?
I'm talking crazy here. But I mean, all of these problems are generated by the same society that is creating these kind of problems, right? I mean, it's like we're breaking up the traditional family type idea of traditional sex and traditional Christian ideals, and we're breaking that open and saying everybody's free to do whatever. And now we've created this situation where all of a sudden these things get into the milieu. So I would encourage men and women to not put themselves in situations like that. I mean, that's the answer to the problem. Now, once you get into the problem, then you've got to kind of clean up. There's no going back and restarting time. Once things happen, you got to live with the results. But the
buddy.
What? Share?
Nothing. Yeah.
I miss these
if
references.
I could turn back time, that's it.
Right. Okay.
I could turn back.
You know what?
time.
Never mind, Steve.
It's not Iron Maiden. I don't know it.
It's true. It's true. Okay, let me read some. Brief update to the stream. The stream will go on. Lady Rackets, who is a saint, has figured out how to organize everything, so I do not have to leave, even though we still do not have a nanny today. So it was she made it work for us, just for you, chat. So you have a duty and an obligation to go subscribe to The Real Lady Rackets on YouTube and watch all of her little videos. They're great. She's got like 4 of them up now. So go check that out. And as a big thank you to her, I'd really appreciate that, because she did all that just so the stream could keep going. There was no other reason. I told her, if I need to go, just let me know, and I will. And she's like, nope, we got it. We got it. So D. Hirsch says, Rackets, no one grifts better on the misfortunes of others like you. Well, someone has to.
That's all lawyers do is that. I mean, come on, we're dealing with the states and people fighting over the states, so we're preying on the suffering of others, or people. The lead for lawyers is because people have screwed something up and they're trying to get out of it. So everything we do is preying on the sins of humanity.
That's what I always say. The worst thing that can happen for a lawyer is everybody's happy.
That's right. Yeah.
It's Lionel Hutz things. Imagine a world where there's no lawyers and everyone's dancing around singing Kumbaya.
Yeah.
I'm just a guy with the snow shovel who has to clean up the charnel house. That's my job, and that's what I do.
That's Iron
Surveyor
Maiden lyrics, right?
Surveyor 8587 says, is there any point in time where they can deny him the privilege of calling witnesses since he has brought nothing of substance or relevance? And what do you think is running through Tackleberry's mind? Okay, in reverse order, Tackleberry's mind is on that taser button. That's what he's
absolutely.
thinking.
He just wants to, he's just like, oh, whoops, my finger slipped.
I think every
that's all
time
we'll
Darrell
say.
Brooks gets up, Officer Tackleberry gets up too, just a little bit. I think that's what's going on.
A semi, yeah.
But the other question, yeah, I think there is a time when, and the judge came close to doing it. If he refuses to participate in the courtroom, if he refuses to call a witness, she can just decide that his case is over at some point. If there's enough of a record to show that he's just not going to do it, I think she has that authority. Because otherwise you could just filibuster forever. And he's been effectively filibustering the whole time. But yeah, I think that could come up. I don't know if there's any conflicting opinion on that on the panel.
No, I mean, pretty much all of your trial rights you can forfeit by conduct. So it's like you said, it's just a question of making an adequate record. She's clearly erring on the side of caution, which is probably appropriate. You don't want to have to try this case again.
Yeah.
But yeah, I think she could be doing a lot more than she is.
Over on Odyssey, Ocean Redux says, Nick, you're a late piece of shit. You know that? Lol, by the way, I hate Law and Crime Network. They timed me out the moment I said anything remotely offensive. Well, why did you say mean words, you bigot? Kirix just sent a Pepe emoji.
Don't offend the delicate sensibilities.
And then Kirix also just sent okay. So thanks for that. ZRWJ, the judge is treating Brooks like she's disciplining one of her sons. I kind of hate to say it, but I think a male judge would have been preferred in this case. I don't know if it's male versus female, but someone who is willing to control the courtroom, and she's been too deferential. I would love to see Judge Borowski on this case. That guy, he just didn't take any shit. So I'd be really interested to see how he would deal with a defendant like this.
Well, let me make one more. I've been thinking about this too, and let me make a contrary opinion on the judge also to give her a break because she's got a tough job. And that is that the fact is that this trial is unfolding. The witnesses are getting presented. He is represented. He is in the court. Things are moving forward like that freight train. And all this talk, it's time. But in the end, he ends up back there and he's calling his witness. And so she is manipulating in him so enough to get him to avoid the appellate issue, which we've talked about, right? So although it's painful to watch and it's time wasting, she is getting the result that she wants, which is moving the trial forward. So it's easy for us to second guess and Monday morning quarterback, but she is accomplishing her goal over his intent. Just a little side.
I don't know if I fully agree. I mean, the trial's moving, but it's moving
slow
at a languid pace, at probably too languid of a pace. But I don't know. It is hard to figure out where the balance would be. And I think most judges, most people would never have to deal, like you go your entire judgeship and never have to deal with this type of case, this type of person. And so she's writing the book as she goes, and that's a tough job too.
Public defenders have to deal with these all the time. There is also a criminal, this respect thing. That's a very much a street thing, and it's like, and I've have no problems. I deal with a lot of hardened criminals. And as long as you're honest and upfront and direct and tell them the truth and you give them the respect, you don't have any problems at all. It's so part of this, it's a bicker. The bicker is not, they're seeing weakness and they're trying to control the court through that weakness. See, so public defenders that have trouble with clients like this are ones that want to be nice. And then they think that they can control the court system through their attorney. So you can't, I'm not saying you don't be nice, but you got to be direct. You're like, look, you're the one facing life in prison. I'm just trying to help you. You're going to say that? That's a stupid argument. What's your other argument? And just talk to him directly. You just respect him and say, look, you're the one that needs the help, not me. I can go home at night. We're trying to keep you from going to prison for life. So you got to be direct but respectful, because that street thing, they think the way they play is I control these people and I'm controlling, and that's how I survive. So he's exhibiting a lot of that kind of street criminal mentality in this courtroom.
Bald Eagle 1787, with Brooks's logic, he's innocent because he's innocent. I hate this judge. I hate Brooks. If I was the DA, I would go off again on both of them. This is completely improper from Brooks and the judge. Gamer 635 says, if this had been in Borowski's court, he would have had the death penalty reinstated day one. Look, we're going to do this case. It's going to go quickly. If it doesn't result in the death penalty, I'll bring in my gun and we'll get it done here. This is over. Adjourned. Freighter J, fuck Australia and everyone that lives in Australia.
Fuck you too.
Damn. Vinny D95, we were told in the Army, if both parties were drunk, whoever reports it first would be the victim. Also, chat, you asses, check out my Give, Send, Go, which is givesendgo.com/TRDWTS. That's a guy who is he's a trucker, but he's looking to do some CNC training. He's trying to change careers and he's looking for a little help along the way. So if you feel any inclination to help out with that, please do so. But by the way, if you feel any inclination at all, it should be towards going to the website birchgold.com/knows. The sponsors of today's stream, the Birch Gold Group. Look at this. They made a webpage just for you, the Rekieta Law listeners. So you can get information on protecting your IRA or your 401k through a loophole, which is a silly buzzword in the IRS code. Obviously, there is no loophole in the IRS code. There is just the IRS code, and then there is what is not in the IRS code. But what is allowed is holding physical assets like gold and silver in your IRA. Some people may not know about that. Birch Gold Group specializes in that and would love to tell everyone about it. So if you have an IRA or a 401k, or if you want to buy gold and silver outside of that, go to birchgold.com/knows, click this green button, and they'll get back to you probably while you're still watching the stream and give you all the information you need. You can decide if it's right for you at that point. I'm not a gold merchant. I'm a green button merchant. I don't know anything about actually selling the gold, but they can tell you everything you want to know about it. Look, I can sit here and blab on about how they have an A+ rating from the Better Business Bureau, and they have a bunch of like definitely not bought positive reviews on social media. But the reality is they came to me, they said, we want to work with you. Here's what we do. I'm like, yeah, I've heard of that. That's a pretty cool idea. And they said, so what do we need to do? And I said, well, what can I say and what can't I say? And they said, no, say whatever you want. I was like, really? Okay. So you're not gonna police my speech. You're not gonna tell me how to do my show. And they said, no, we just want you to tell people about the link. So I've done my part. I've told you guys about the link. They're very gracious in sponsoring the show and saying to just be me. And they have never, ever said anything other than that. So check them out if that's the thing that you might be interested in. I'd really appreciate it. The link is in the description if you're too lazy to type birchgold.com/knows. You just click on it yourself. There we go. I think that was 60 seconds. Was that 60 seconds? I think so. Contractually obligated 60 seconds is done. Okay. Sorry about that. I have a job to do after all. RX Jones, anyone going to watch the Lucy Letby trial?
Which one's that?
I'm thinking about it. She's the nurse in the UK that supposedly murdered a number of infants in the maternity unit over a period. She's an absolute piece of work.
Wow.
Oh.
What about
multiple attempts on multiple kids at different times, injecting them with insulin to watch them die, air into the veins, and all sorts of things. So,
Black Widow type thing, huh?
Yeah.
Basically, yeah.
What was the motives? Do you know?
We don't know.
Psychopathy, it sounds like.
Yeah, it doesn't sound.
She seems to be that nuts.
Those babies pissed her off.
Oh yeah, absolutely. They were little shits.
Self-defense.
Day dot.
Self-defense.
There's actually a guy throwing the babies at her, and she was just lethally injecting them as they flew by.
See, I wonder if she's a law self-defense member and she can get free advice from Branca for his for self-defense advising. No, I'm just
yeah, self-defense of tennis racket. Oh my God.
What
was
about that?
awful.
There's that somebody had emailed me. One of your chatters emailed me about the guy with the
chess case?
the chess case with the probe.
Yeah, I've gotten several people that have suggested that I take a look at that case. So I
At
haven't
least-
looked at it closely yet, but
At least it's
yes, I
not like
will.
this kind of horror show that we're seeing here. I mean, at least the
Yeah.
subject matter is relatively low. You know, it's nobody really got slammed and murdered. It's defamation, and it's the act and the allegations are quite entertaining.
Well, what about the real case? You guys we're all ignoring the real case that's coming up. The one that's definitely valid and certainly not a grift. George Floyd's family suing Kanye West for defaming George Floyd's dead body.
Really?
Yeah.
I didn't hear about that.
$250 million they're suing Kanye West for. Here you go, chat. Watch this. George Floyd died of a fentanyl overdose while fantasizing about sexually violating children. You can't defame the dead. It's not real. You can't do it. They don't have a reputation to protect. It's gone. Their property interest and the reputation is gone. It's impossible. You can say whatever you want about any dead person ever. Always, always, always.
Anyone else feel like Jeff knew this was coming and decided to bow out early?
No, anybody who watched my coverage of the George Floyd case knows that that's not actually my opinion, but the point of the speech is that you can't defame the dead. You can't do it. So Kanye saying that George Floyd died from a fentanyl overdose is, first of all, even if you could defame the dead, we'd be in really questionable territory over whether or not that's defamatory. There's significant evidence that fentanyl would have played a significant role in any death that took place. That doesn't necessarily absolve the police of their guilt, because it really depends on what is the actual cause, not what is a possible cause. And the jury decided the actual cause was Derek Chauvin. So that's that thing. But someone could easily form a reasonable opinion that the fentanyl was the actual cause of George Floyd's death. There's sufficient evidence for anyone to come to that conclusion, and for the purposes of a defamation case. So that's one problem.
The comments that I've seen that just blow my mind are these comments that no, it went to a trial. There's been a verdict. People are entitled to disagree with jury verdicts. Hello, O.J. Simpson. You are not defaming O.J. Simpson by calling him a murderer, even though, a criminal jury said that he was not. The actual malice bar on that one is going to be very challenging to clear.
Yeah, the other theory that they have, and I think it's a similarly failing theory, but for different reasons, is intentional infliction of emotional distress, which, I mean, what you have to do for IIED is you have to go beyond all bounds of decency.
Yeah,
and Kanye just rehashing a major narrative about George Floyd is not going beyond all bounds of decency.
But we do seem to live in an era where people are willing to entertain the idea that voicing an opinion is extreme and outrageous conduct. That's what's, a little troubling to me about this case, because it's just inviting, that type of response to grow.
Yes, absolutely. And as someone who's voiced opinion got him in trouble not too long ago, I fully agree with your assessment, and it is wise and wonderful. Booster Engine Cutoff says that face when Darrell Brooks has more trial experience than law Twitter. Oh, come on, don't do that. That's mean. That's mean. Suz Day says, hey, Nick and not dumb LawTube folks, any chance you can take a look at Michigan's Prop 3? It's an insane constitutional amendment proposal. This guy argued and won at SCOTUS. www.noprop3.com. I'm supposed to take a look at that. Shit.
Don't conflate issues.
Yeah. Megan Fox has been looking at that. I haven't paid close attention to it yet, but I did see that she's mentioned that.
Yeah. That's why I'm supposed to look at it. I need to do that. But no, I haven't looked at it yet. But I will be taking a look when I get a minute to do that. Okay, over on the locals chat, Red Rum's Taken Says fact of the matter is that anyone who's attended public school can tell you this is behavior is pure N-word shit. The fact that she can't recognize that he's going to reciprocate her attempts to be respectful tells me she's a white lib. Many such cases. I mean, maybe. I don't know. I would find I'd find it hard to believe that a judge in the suburbs of Milwaukee would have not run into the whole like respect thing going on, like the street behavior that we're seeing in court. But yeah, but maybe not. I mean, it depends. Some people are able to avoid when they live in a city, even avoid stuff depending on their, where they are raised, what kind of schooling they go through, and I don't know anything about this judge.
And they avoid it.
I'm reading that Megan Fox is covering that issue that you were mentioning earlier, and I just found out that she's the PJ Media writer. I read PJ Media and Powerline and Legal Insurrection and Instapundit. Those are my favorite websites. And it's funny because I never put it together until she was on your show. And then I read one of her articles. I'm like, because every time I'd read one of her articles on PJ Media, I'm like, boy, that's good. And then I look at the byline, like, because I like to look at who's writing, And I always think whenever I see one of her articles, I read it. And then she shows up in your show, and I'm like, oh, that's cool. And so I put the two and two together. I'm just like,
every time you read one of her articles, you're like, man, I really liked her in Transformers.
Yeah. yeah, right. Exactly. That's why it kind of rings in the head, and I remembered it because of the other Megan Fox, right?
No, she's great. I love talking to her. She's hilarious.
So does Instapundit still exist?
Oh yeah, it's great.
Oh wow, I see, that was for some reason it slipped off the radar for about 15 years until you just said that right now.
No, he hasn't gone the way of Drudge. He's still rocking, old Glenn.
Well, not only that, he's got a whole team of people that support him. So it's like it's not just Glenn Reynolds. Glenn Reynolds is University of Tennessee law professor, which I'm a big fan of. That Instapundit is great. I must check that site twice a day, and also Powerline blog. If anybody needs to also watch, actually, I don't know if you know Steve Hayward. He's actually written a. I can drift my book. See, there's a connection. He actually wrote one of the dialogues, like the promotional things on the back of my book, with Stephen Hayward, who's part of Powerline blog. He's an academic. He's the resident conservative professor at UC Berkeley. How's that for a
token?
No, well, maybe a token, but there's a couple others out there. But he goes in there and he's got this great attitude, Saturday cartoons on Powerline that he does. And he's got a great jolly sense of humor. And he's very, very smart academically and knows all kinds. And he's a very conservative guy. So I highly recommend Steve Hayward, who's also in my book that you can buy at crimelaw.net. In fact, I got a problem here, Nick. I'm almost out of my second run.
What?
Well, you just got your second run like a couple of days ago.
I know. And I haven't even begun signing them. I'm going to have so many books to sign. It's going to be overwhelming. But I've only got 22 books left. And one of your listeners is so nice. Pam Smith, I think she's a designer, and she volunteered to redo my cover because I did everything. I did the cover, the layout, everything in the book. And she did such a good job that now she wants me to like redo the cover, but then I have to pay for a new ISBN. So I have to reorder. It's going to cost me. So
it's going to cost you, Steve.
It's going to cost me, but the cover looks so much better. She's got, so the second edition. So if you want one of the original collectible covers, you got to go now and buy it. Otherwise, when they run out, I'm going to do the new cover.
Nick, I have a proposal. We
need
to have a Gosney Branca book grift off.
But mine aren't free.
I was hoping for a ring, you bastard. Yeah, you got to get on that level. The free book somehow making you money. That's the trick right there.
Well, Emily Branca has been advising me on a lot of stuff on how to get the books and everything. And so I'm telling her, like, I'm buying 100 books. I had to reorder 100 books. And she's like, oh, because I'm paying a lot because it's a short run, for each book. And she's like, well, we buy them by the truckload, right? I was like, that's a whole different level. I'm not at the Branca level. I'm just a poor public defender. This is a little sideline. But thank you for everybody that buys it. It's going to be back. It's going to be here next Wednesday And once the next 23 go, they're going to have the collectible Ghazni cover, and it's going to probably get redone with a beautiful professional looking cover. And
Well, why would I buy one of the current ones when the new one's coming out with a better cover, Steve?
Because it's collectible.
There you go. Oh my goodness. Okay, so we've got, I don't know when court is coming back. I am monitoring it, by the way. It's just sitting there.
Oh, the nightmare. I was having so much fun, and then you brought that face up. It's like, I'm traumatized.
It's the face only offender could love.
Yeah.
Is that inappropriate? That might have been.
Yeah.
I missed a message a long time ago for Andrea from one of the lovely ladies of the Rekieta Law Locals chat. She said, Maiden Iron. She says, "You look wonderful." So,
thank you.
Oh, and I got another grift too. My Rumble channel. I took your suggestion.
Oh yeah, you do, and you have a video up, right? You playing bass?
Right. Well, everybody thinks that this is a prop here. Okay. So first of all, you said that everybody would love to watch me playing guitar. And you said, oh, that's your first 30 videos or whatever, right? So I've kind of done all my summary of my book and all my book promo. So, and somebody was like, what am I going to do with my channel? So I took your suggestion, and there's, the other thing, Rumble does not have a lot of like how to play music videos. You have to go to the other thing, the other channel.
Or you have to just already know, like a true Chad.
Well, but on Rumble, there's going to like how to play music and how to play guitar and how to play bass. So I'm going to start. I'm the first one on Rumble to do how to play bass, and it's Iron Maiden Flight of Icarus, Up the Irons.
Nice.
There you go, guys. I posted it in the in all of the chats. You guys can go check out Steve's Rumble channel. Check out that video. Obviously, everybody on this panel is some type of creator. Steve and Andrea are out here creating chaos in the streets by getting all sorts of bad people off of their criminal acts. I'm just kidding.
It's a calling. No. It's a calling.
And it really is. And what's interesting about that is when you talk to public defenders and they talk about the public defense, that's a really common refrain because it's a different type of law than anybody else will practice. And I'm going to say this in the rude way, but it's not intended to be. You have to get accustomed to losing because the overwhelming majority of your clients are losers. So you have to reframe what victory means. And victory means, well, maybe you guys can say, what is victory in public defense? Why should I pontificate? You guys are the ones doing it. Andrea, would you like to start?
I mean, it's relative to the client, victory in public defense a lot of times is just not getting a bar complaint, but so much of what we end up doing our work on is not this black and white world of, is this person guilty of, X or not? Did they do it or not? I mean, the dirty secret is that, yeah, probably 99% of the time they did something wrong. I mean, there's not going to be a good way to get around that. That can be proven. There is evidence of it. It's just an issue of, are they charged with the right thing? Are they charged appropriately? Was the process that, was gone through to lead to this point fair? And is the punishment going to be proportionate and ultimately in the interests of society as a whole? So those are more the areas that we tend to navigate in as defense attorneys than the sort of, pipe dream of, oh, you're getting innocent people out of the clutches of, the oppressive state. It's not that doesn't happen, but it's very much the exception to the day-to-day practice that you're doing.
Andre, perfect. Exactly. And I just emphasize that a lot of the debates and a lot of the things that we do is that the punishments for some of the acts that our people doing are so outrageously harsh that it's just injustice in the sentence. Like people, and a lot of what we deal with, like homeless people who are trespassing. And it's like, what's that, a year in jail? I mean, so you have a lot of it's like, that's ridiculous. And some of there's a lot of kind of close cases. So a lot of what we do is mitigation on and trying to bring the humanity, because a lot of the prosecutors see our clients as a file, and a crime that they committed. When we deal with them face to face and we have to look them in the eye, and we understand that there's a whole baggage of human flaws that come into it, and here's their worst day. So we're trying to mitigate and show the court who they are as a human being. And misdemeanor court's a lot more fun because the crimes are usually entertaining. The people are more common. When you get to felony, it gets a lot more serious. The crime, the punishment gets harsher, and it gets a lot more like life-changing events for our clients. So, winning, like you said, winning for a public defender doesn't mean like not guilty or even any of that. It's sometimes, well, we got a 2-year sentence or a 3-year sentence and they were facing 25, right?
Right.
100%.
Hold on one second. Oh yeah, wait, Aussie, this is for you. My locals chat has found the proof that Australia is fake.
Oh,
did you know this? There's actual proof of this. Are you familiar with Rule 34?
Oh, fuck.
Literally.
Yep. Nailed it. If it exists, there is porn of it. No images were found to match the search criteria. You're done. You're done.
I'm curious what would happen if you typed in America in that as well.
Ooh, no, you don't want to know.
The gauntlet is thrown down.
Here we go. Okay, I've sent Kurt the link as well. He's available to pop in, so that'll be cool. And we really should be getting back to court really soon here. I might start going through some of the other chats as well. Whiskey Actual says, panel, give us the lay fags on the breakdown of what that was all about. Was she trying to keep this dirtbag passed out of the trial? I'm not 100% sure of exactly when that came in, but yes, the long and short answer is yes. Hey, what's up, Kurt?
How you guys doing?
Hey, Kurt.
What's up, Kurt?
Sounded like you guys were having some fun over here. So I thought I'd join your crew.
Such as it is.
Yeah.
Such as it is.
But don't worry, the trial will resume soon.
Yeah.
Hey, I watched your breakdown of the Allen case, and that was excellent. If you want to, yeah, and I'd recommend you do Cotton. I commented on the Rumble channel, but I'd love to hear what you have to say about that because that's one that Sovereign Citizens cite too. But your analysis of Allen was exactly right and very thorough. So thanks for that posting on Rumble, not on YouTube.
Well, I'll do Cotton maybe on Wednesday.
1 to Henry David, how thorough was it?
It was it was front to back, soup to nuts.
Mr. Brooks in the other courtroom so that I could make an adequate record without interruption. We are on day 15 of the trial, and today has been a rough morning to say the least. We are in the stage of this trial where Mr. Brooks has the right to present relevant and probative evidence and to call witnesses. And I have done my very best to honor his rights in that regard. Part of this morning dealt with his, from my perspective,
hold on, I got to reset the panel real quick because
disagreement with how
today.
I yesterday and in the days preceding that set up what I thought was a very reasonable way for witnesses to be called into this courtroom on his behalf. Going back to when the state offered to, excuse me, serve subpoenas on his behalf and talk with or coordinate with these witnesses to come into court. And yesterday, I wanted to narrow things down a bit, as is my not only right, but frankly, my obligation under 906.11 to make sure that there is an effective presentation of evidence and exercise reasonable control over the mode and order of interrogating witnesses and presenting evidence so as to do all of the following. And let me just back up a moment because I think it's worth putting into the record once again the full language of 906.11, which is entitled Mode and Order of Interrogation and Presentation. Number 1, control by judge. The judge shall exercise reasonable control over the mode and order of interrogating witnesses and presenting evidence so as to do all of the following. Make the interrogation and presentation effective for the ascertainment of truth. Avoid needless consumption of time. Protect witnesses from harassment or undue embarrassment. The next section, a witness may be cross-examined on any matter relevant to any issue in the case, including credibility. In the interest of justice, the judge may limit cross-examination with respect to matters not testified to on direct examination. The next section, leading questions. Leading questions should not be used on the direct examination of a witness except as may be necessary to develop the witness's testimony. Ordinarily, leading questions should be permitted on cross-examination. And then the next part talks about civil cases would not be applicable in a criminal case. So that is a statute that guides what I do, not just in this case, but in every case that comes before me for trial.
I'm gonna see if I
even a
can
motion hearing.
hear what they're hearing.
And in my almost 11 years on the bench, I've presided over dozens and dozens of cases that have gone to trial. To say that this has been the most challenging of my career would be an understatement. I've done my best, I believe, to be fair, to be unbiased, to protect the rights of not only Mr. Brooks as it relates to this trial, but those of witnesses, those of the victims, and of course, last but not least, the jurors. Prior to
I'm not sure where that echo's coming from.
taking an early lunch this morning, a couple of things happened that I think are worth making a further record about. Going to the beginning of this morning, where it is true, I did not do my usual practice of asking if there were any preliminary issues that the parties wanted to address. In my mind, I wanted to get to the witnesses. We are at that stage. I knew there were a number of witnesses.
I think everybody has
called,
headphones in,
and
right?
I wanted to ensure that it was done effectively for all of the reasons that are stated in 906.11. And I thought it was reasonable at the time to simply take up issues dealing with legal matters at a break. That's why I brought the jury in. During the jury coming in, Mr. Brooks continued to talk, make statements. The record speaks for itself. I'm not going to, frankly, I couldn't tell you everything that was said at that time. At this point, I think it's important to note, though, it's the tone, the demeanor, the decorum, or frankly, the lack thereof for many days on end throughout this trial. It has become apparent that when the jury comes into this courtroom and leaves this courtroom, that Mr. Brooks makes disparaging remarks about the integrity of this court, of these proceedings, and of other parties in the courtroom. He repeatedly references things such as subject matter jurisdiction, which there is a written decision that I have filed in this case. It is very clear this court has subject matter jurisdiction over this case. This is not a civil case. This is not a case in federal court, for example, where subject matter jurisdiction sometimes becomes an issue for things like whether there's a federal question that's involved. Every now and again in a criminal case, subject matter jurisdiction is a type of issue that comes up, but not under the circumstances here. I'm not going to rehash everything that's in my decision. I stand by that decision. The record has been made abundantly clear that Mr. Brooks does not believe this court has jurisdiction. His objections have been noted, well documented by the record that's being taken down. I know from my experience, not only as a judge, but as a litigator, that once that objection is made, it's preserved. I even stated at one point, I think there's a standing objection. I will note that for the record. Mr. Brooks continues, in my opinion, to bring this issue up in front of the jury to distract.
Yeah, the echoes from the stream
delay,
itself, guys.
and to call into question the integrity of these proceedings.
Probably
Frankly,
picking up
maybe
Darrell's
to
mic.
create an issue on appeal if he is convicted. I brought him, I should state it this way. He is not in this courtroom presently because on day 15 of this trial, and specifically this morning, right, we have a history of disruptions, delay, interruptions, disrespectful behavior, the common courtesy, I think that just as a human being, we all would expect have not been followed. It's evidently made, let me restate that. It is evident to this court that when there is a ruling that Mr. Brooks disagrees with, whether it be an evidentiary ruling, whether it be on subject matter jurisdiction, whatever it may be, that he has a pattern now of directly confronting the court, asking for, is that verified law? Can you prove that? Is that an actual law? He starts debating the topic once again, or he will even try to further turn us away from that by bringing up another topic. For example, just today, when the issue came up about this letter that he claims was sent to him by Erica Patterson, and I asked repeatedly for an offer of proof rather than answer the question directly, Mr. Brooks instead started talking about an exhibit the state offered into evidence yesterday. And from my perspective, he doesn't address the merits of the issues that are before this court and then tries to divert things down a different path, whether that's to delay, to disrupt,
The hell was
or
that?
just simply be discourteous.
Vices is disrupting.
All of those words would be an accurate description.
Thanks for putting that in the record.
We are still echoing, by the way.
That was one piece of one objection or series of objections that I actually went off the record. Not off the record. I actually dismissed the jury in order to try.
Sorry, dropped my hat.
To get an
He's
offer
reading
of
about
proof,
salvation right
from
now
Mr. Brooks.
because he
And
knows he's
as
fucked.
that exchange went on, it got, from my perspective, he got louder. He got more disrespectful. I think it's fair to say his behavior was volatile, and it's because of that that I called an early lunch.
Just
And it's
make
because of
findings.
all of those things.
Stop.
Even when I attempt
Whoa,
to
go by
give
some-
no, no,
assurance
no.
that he will be removed upon further behavior, he immediately interrupts and says, "Are you
So
holding me
echoes
in
are fucking
contempt?"
back. Hold
A
on.
very clear indication to this court that he is
Chat, let me know if this
attempting
fixes
and
the echo.
trying and actually disrupting the proceedings so that I can't make an accurate record.
Check.
Like I said, it's challenging.
Echo.
That
Hold
is
on.
why he is in the other courtroom muted so that I can make the record. And I will confirm with my clerk and the bailiffs. I should have done this at the
Fucking
beginning, but I
Christ.
believe, thank you, my clerk did confirm that they can see, they can hear, we can see as well.
How about now? Is there an echo now? Somebody tell me if there's an echo with just me.
It is this court's opinion that Mr.
I'll bring
Brooks
everybody
is
back in a
blatantly
second.
pushing the limits of what I have tried to establish in terms of when to call witnesses, how to call witnesses. He pushes the limits on asking
One at a
questions that
time.
are not probative, that are not relevant, or that
Check.
directly contravene
Check.
a prior
Check.
ruling by this court related to
Check,
other
check, check,
acts
check.
evidence.
Check,
That
check, check,
ruling
check.
That I made
Check, check, check,
was
check.
to the benefit
Ah,
of Darrell
Check, check,
Brooks,
check, check.
not the state, Darrell Brooks, the defendant. There have been multiple witnesses who have themselves stopped,
Echo on Steve.
basically looked at me and
Yeah.
Check.
can I
Yes.
answer that question basically. Is there nonverbal communication to me? Or some have actually said, I don't think I can answer that. There have been other witnesses where I've stopped them
I'm
from
good.
answering so as
Testing on
not
Steve.
to bring in the other acts evidence. The most recent of which occurred this morning with Erica Patterson and the repeated questions to her related to either information she did or didn't give the detective when the detective spoke to her.
So it's on
two
my end,
separate
apparently, but
occasions.
there's
been
nothing
other
that should be
questions throughout the
echoing.
trial
So
to,
give me a
I
second.
believe, to Detective Guth directly and other witnesses who had information about why that may have been the case. But this witness, I think, has been very, very careful to not run afoul of the court's prior ruling. That leads to the evidence
Check 1, 2.
claimed by Mr. Brooks that he has related to a letter and photographs. As I indicated before the break, I've looked at both 906.16 and 906.08. Those are generally two of the statutes dealing with character
I
evidence.
love when
that
we
would be 906.08,
suddenly have an audio issue.
906.16 deals with
Nothing has
bias.
changed.
From
I'm
my
not
perspective,
playing
the
with settings.
questions that were actually asked and answered about do we have a child together?
You're not echoing, but I think we all are.
I'm summarizing, but regarding their common child,
I hear an echo.
whether
I hear
they
myself
leave the
echo.
child on or off, where they met, things of that nature, are solely to attack her character, as a mother, which is wholly improper. The only character evidence that would remotely be allowed under, at least for a witness under these circumstances, would be character for truthfulness, which would not even be from this witness.
Check.
Typically another witness comes in and testifies to that, and only about opinion evidence, their opinion of the person's character for truthfulness. Under bias, 906.16, I didn't see where it also related to her credibility. It says, for the purpose of attacking the credibility of a witness, evidence of bias, prejudice, or interest of the witness for or against any party to the case.
Can I have
is
you guys?
admissible. Again,
I was
simply
muted. Can I have you guys
attacking
pop
her
out like completely
on
and
her
come back in?
motherhood.
I'll bring everybody
That's my
back.
perspective. I did not receive the answer to the repeated questions I asked.
Here, I'll bring the judge right
this-
back too. I'm gonna redo that.
Than the photos. The issue as it relates to this witness
You win, you get to be on top.
is a single charge in the case. It is a battery charge with a date
Check Stephen.
violation that is alleged to be November 21 of 2021. To allow Mr. Brooks to ask the witness about contact after that point in time is not relevant. He has not given me any reason as to why it's relevant. The state also, I think, rightly points out that if those questions were to be answered by Erica Patterson and other questions along those lines that were questions that were objected to by the state and that I sustained, Mr. Brooks would open the door to what only could be described as very damaging evidence against him related to the other acts evidence, related to whether he has a relationship with the children or not. And frankly, a topic I am not going to open the door to. I'm not going to allow. It's a side issue. It is not relevant. It is not probative.
I'll look into the audio issue when the judge is done yakking. Everyone is on headphones, guys.
But certainly one could argue, based upon the questions, topics that the door could be opened to. It is my duty as the judge assigned to this case to ensure that the trial is fair, that relevant and probative evidence comes in, and that it is done so in a way that's effective and efficient for the presentation of evidence, including the testimony of witnesses. And so I'm not going to allow questions related to the children in common or child in common, at least any further between Mr. Brooks and Ms. Patterson, when they met, how they met, the nature of their relationship now, whether there's been any contact between them since he was arrested and going forward. Because nothing that I've been presented with would suggest it relates not only to relevant and probative information, but even to her credibility as a witness. I will give Mr. Brooks a final opportunity to make an offer of proof as to why he believes my decision is wrong.
Good luck.
That needs to include an offer of proof as to why he believes this letter is from Erica Patterson and why it's relevant to the issues in this case.
Also, where's the letter?
I don't have it,
He
Kurt.
came in to the courtroom this afternoon.
He's taken from his table.
And
I
is not
told you.
in here, but in an adjacent courtroom. I want to make some additional findings as well and kind of just tie up a few loose ends for the record. As the Supreme Court in Illinois versus Allen stated, it is essential to the proper administration of criminal justice that dignity, order, and decorum be the hallmarks of all court proceedings in our country. The flagrant disregard in the courtroom of elementary standards of proper conduct should not and cannot be tolerated. Trial judges confronted with disruptive, contemptuous, stubbornly defiant defendants must be given sufficient discretion to meet the circumstances of each case. No one formula for maintaining the appropriate courtroom atmosphere will be best in all situations. This court has utilized an adjacent courtroom with superior audio and video capabilities
Echo?
that I believe are the functional
I'm not echoing.
equivalent
We're good.
of being
No, I think the echo's gone.
in this.
Echo check.
Mr. Brooks's behavior today
She wrote a lot
alone
in an hour.
was disruptive.
Yeah.
I would absolutely characterize it as stubbornly
Who
defiant.
got to be in the back feeding her oatmeal while she did it?
It was interruptive,
Like I have weird court
certainly-
fantasy, okay? Leave me alone.
aggravates the proper administration of the
The thing that's so
Court fantasy.
counterintuitive
This
about this
trial,
is that
there's
it's
nothing
very
dignifying
easy
about it.
for a
There's
judge
nothing
to talk
orderly about
themselves
it.
into error. Keep it minimal. This
Exactly.
is
Yeah.
strategically
Yeah.
very ill-advised.
Right.
I think she's doing
SCR
fine though.
62, which are the
Oh, you
basic
would, Mr. Contrarian.
expectations, courtesy and decorum in the courts in the state of Wisconsin. I'd remind him of the golden rule. Do
Stop.
unto others as you would have them do unto you.
Stop.
A little late for that.
Be respectful.
You got to be proud. That's a problem because we
Give these
can't.
proceedings
Ugh.
the due respect that they deserve for himself. I do not believe he even shows respect for that. I'm not looking for any further input on the issue of removal or any further record. I wanted to make that record without interruption, which is why Mr. Brooks was in the other courtroom. When we come back to this courtroom, I will ask Mr. Brooks for an offer of proof. He will be brought in.
Why don't you do that now
We'll go off the
before he comes
record for
back?
that momentarily.
Do it while he's there.
An offer of proof if he wishes to do that related to the letter and further questioning. I also want an offer of proof.
Nighthawk says
as
we
to
should
what
observe the
probative
golden
and
rule.
relevant
Someone run him over with a
information
red SUV.
Ms. Patterson will be testifying to
That's the Mosaic
his
law,
direct
not the golden rule.
examination. This is a witness who was called by the state initially. This is a witness where Mr. Brooks had a full and fair opportunity to cross-examine her on
Opportunity.
a prior date. He was allowed to call her himself. The vast majority of the testimony today has been a rehashing and a representation of her testimony from the other day. I'd have to look at my notes for the date. October what? October 7th, I believe she was the third witness. We did not
That's the court.
Ooh.
anything
Yeah.
new, probative, or relevant through the course of the questioning today. Because he's had a full and fair opportunity to already cross-examine her, because he's had a significant amount of time this morning to question her, I will require that offer of proof, and then I will make a decision whether any more questions will be asked of the witness. At this point in time, does the state anticipate any cross of Ms. Patterson? But I'm going to ask that when we come back, when everyone is here. With that, I am going to take a very short recess to have Mr. Brooks brought back into
You gonna
this
play
courtroom
kickball?
so that we can continue with testimony and evidence. Thank you.
Okay, I think we got the audios fixed, the audio issue fixed. Random 11 in the locals chat had a suggestion that may have been what actually ended up fixing it, because the timing kind of worked out. But I'm actually going to leave this up because I think taking things in and out causes problems and teen pregnancy. But no, he said to go in and adjust everybody's echo cancellation, turn it off, and then turn it back on. And after I did that, it seems like that's when the issues were fixed. So Random 11X, thank you for that suggestion. StreamYard, man, I need to learn the new Streamlabs thing, but you can only have 4 people on as with guests on Streamlabs, so it's a little bit different. But and
trust me, from experience, it's a pain in the ass. You can't share video very easily either.
No, they have a new thing where you can.
Why is Aussie upside
the
down?
Collab cam.
Yeah, they
Because he's
an
an Australian.
Yeah, he's on the bottom side of the disc. No, they have Streamlabs has just implemented a new feature which allows guests and screen sharing with the guests, apparently.
Yeah, I've been trying to use it. I can share video with people. Audio is a pain in the ass to try and share.
Ah, I gotcha. So, yeah, it seems like somebody could just get this right. I really need to try out Riverside. I really need to try out Riverside FM. But anyway, Surveyor 8587, did she go to break and watch this stream? I feel like she's about to end this shit show. No, she was just making a very voluminous record. And Andrea, can you expand a little bit on what you were saying about the risks of this thing?
Yeah, it's just the problem with going on and on like this is that the more she says, the more likely she's going to say something that will end up being problematic, that will be unsubstantiated by the record that preceded it. You know, it'll be a finding without sufficient evidence. It will be something that will be able to be characterized as unfair bias. I mean, there's just a million ways that it can go wrong when the judge starts explaining like this. And so the prudent thing to do, in my opinion, is just make your findings that you need to make to justify your ruling that you will now deliver, and leave it at that. Let the parties on appeal go through the argument about what you perceived or didn't see or how fair they thought you were about it. Don't be trying to expand the record in this way. It's just not a good judicial strategy from my perspective.
I agree. And she's done this several times where she's like, I just need to make a clear record. And it's like, Judge, everything in your courtroom that has happened is clearly on the record. You don't need to make another record, because the only person who's not clear here is Darrell Brooks. Everybody else watching, everybody in the courtroom, every attorney present, all of us watching at home, we're very clear on what happened on the record. It's very obvious. And to suggest that you need to come in and rehash it and then say a bunch of extraneous stuff is really pointless. And it's bloating the record. And it's and like you said, anytime a judge does that, they risk saying something that could be an appeal point and should not be entertained. And the golden rule is not the rule of defense, by the way. I just want to point that out.
Well, see, that's a biblical reference, and I know that we've had cases reversed.
It's not necessarily a biblical reference. It goes older than that.
Really? Well, how far back does that go?
I'd have to double check, but I know it has older origins than that.
Oh, and if people are interested in the real appellate issue here, that's the one that she's bending over so much to avoid. Uncivil Law did a like a 2-hour or hour and a half video on this Allen case, which is the one that they're all referencing and that she's hyper afraid of. She really shouldn't be, because I think the likelihood now, Uncivil wasn't on when I said this, but if he appeals this pro se, the appellate court may just come back and said, no, not only do we rely on Allen and she was proper, but here's a bunch of other things we can do given modern technology to expand her scope. And so they'll write to expand the judge's authority in these type of situations. What do you think?
I haven't really had any problem with what the judge is doing. The judge seems to me to be bending over backwards to extend every possible deference and courtesy to the defense, which if you're going to err, you want to err on the side of the defense. So I don't really have any problem with what she's doing. I haven't heard her say anything that creates any questions in my mind.
Back on the record, I've been advised that Mr. Brooks does not want to come over to the main.
I don't even want to come back.
Oh, great. That's great.
I'm advising you, you are invited back to this courtroom. It is my sincere hope that you want to come back here.
No, it should
I
be
see
your hope
you're
that he wants
reading
to stay
something,
away, because then there's no
but
appellate
it's-
issue.
We are at the point in this trial where you have a witness still on the stand, obviously figuratively at the moment, not literally. I'm going to ask you if you are ready to answer my questions from previously and also to let me know whether you are asking to stay.
He's going to stonewall now
courtroom.
like a child.
Yeah.
Yeah, here we go.
Yeah.
Yep, forfeiture by conduct. Here we have it.
Hear and see. Mr. Brooks, we
Please
are
just
on the
speed things up.
record.
Hey.
Uh-huh.
And I'll go through the topics one by one. You are in the other courtroom.
When
You
one
are
of my
invited
daughters
back
was
here.
about
Would you
5
like
or
to come
6
back
years
here?
old,
Yes or no?
we would have to drive down to Texas or Florida. She would stop. She would.
Yes, we're back on the record.
The audio is on. Would you like to come back to this courtroom, sir?
You're unmuted. So I'm finally unmuted.
You've been unmuted for a while since I came back on. My understanding, sir, is you'd like to be in that other courtroom. Is that true?
This guy. So anyway, my daughter would demand a
Oh,
bathroom
Lord.
break like every 20 to 40 minutes. And this is how children take control of situations when they don't have it. They'll do whatever they can to exert the smallest amount of control.
Mr. Brooks, I'm inviting you back to the courtroom. My understanding from a relay of information from the bailiffs is that you don't want to come back here.
I ain't saying nothing.
All right, are you ready to come back then?
Not if I'm just gonna get held in contempt again.
I didn't hold you in contempt
Then why am I even over here?
so that I could make a
Illinois
ruling
versus Allen, we covered it
without an interruption
on my channel. Check it out.
pursuant to my authority in Illinois versus Allen.
So did you make your record?
I did.
Am I ever gonna get a chance to make the record without being interrupted?
You do constantly.
Mr. Brooks, I'm asking you, the first question is, do you want to come back into this courtroom?
Not if you're gonna hold me in contempt.
You're not.
Sir, I
I
need
don't
to
wanna
continue with the trial.
I don't
So
wanna
if you
keep being
don't
held in
answer yes or
contempt.
no, then I will presume you want to be in that courtroom and you'll, by your conduct, waive your right to be in this courtroom.
Do it.
By what conduct? I didn't consent to
By
being held in
failing
contempt.
to answer my question, sir. So I'll ask you again.
Are you gonna hold me in contempt? I don't want to be held in contempt.
You've never
I
been
will
held
ask
in
you again,
contempt.
sir, would you like to come back to this courtroom?
I'm supposed to be in there anyway.
So twice now I've asked him, he has not answered a yes or no. Mr. Brooks, I'll ask you a third time. Would you like to
No.
come back into this?
No. Yes, if you're not gonna hold me in contempt.
Well, if you don't do contemptuous things, we have a deal. Come on back. Come on, Judge.
For the love of God, dickhead, just go back so that we don't get the echo. Come on.
You have conditions, I have them too.
And for the record, I do not consent to being called that name.
No one fucking cares.
No one cares.
Ugh.
Oh, it's endless. Jeez.
I care.
Why did she ask him 3 times? Take the answer and move.
Yeah,
Oh,
well,
look, you can hear he's still fumbling.
Oh shit. Here we go again.
except we can't actually hear that audio. It's weird that the Law and Crime feed is was transcribing it, but we couldn't actually hear him say it.
You can hear it.
Yeah, I could hear it a little bit.
Just
Oh.
hear it. Yeah.
Okay, I could not. So I guess
We're hanging on every word.
yeah.
She should say, okay, so I'm taking by his actions. He doesn't want me in the courtroom. Call your next witness. And if he doesn't answer that question, say, okay, then you're done today. Then we're done with your questioning of your witnesses. I'm going to cut your defense off. Threaten once and then act, and then rule. She had the standard here on appeals is abuse of discretion. And can anybody say that she's abusing her discretion?
Not even close.
Would any
Not even
reason?
close.
Not even close.
Not
And
even
in
close to close.
And
Yeah,
you can-
because
go ahead.
any other attorney or any other defendant who acted anywhere close to this would you can find videos of what happens to them. They're usually funny compilations on YouTube of people getting thrown out of court for any number of reasons. None of that has happened to this guy. So her being this patient and eventually just exercising that discretion would certainly not be abusive. Because she could have done it several times. I mean, she could have held him in contempt. She probably could have already forfeited his right to question these witnesses at all at this point.
Yes.
Yeah.
But damn. John M. Mo says, to be honest, I'm not entirely sure there's a coherent strategy regarding his interruptions. Surgically enhanced Judge Mommy might be giving him too much credit.
There is a coherent strategy, and that's in that sovereign citizen document. And the purpose of it is to disrupt and be as difficult and obstinate as humanly possible in every possible way and challenge everything that comes along. It's all laid out in that document, and he's following that playbook but to a T. So the thing, what it does is it requires the court to justify everything that's being done from the ground up. And most judges have never had to do that. That's why she's running into problems here.
Well, it's really nice that she again is giving him control over the courtroom by letting him bounce back and forth between these. She should, in my opinion, if she's going to remove him from the courtroom, it should be until the next break of court. And then she should let him not create a new break every single time he goes back and forth. But we just had lunch. Nothing substantive has happened since lunch. We had the break for the witness. I guess that issue and then the heated moment, but nothing substantive happened after that. And now we have another break. It's like, no, you should just wait until 3:00 or whenever the court's going to take its next break and do it then. Let him stay in the other room until then. Again, these are things she should be doing to control her courtroom. And I don't know if this is from a judge's handbook, but it's definitely from a freaking parenting handbook. Like if your kid determines the length of time of their timeout, then you're doing it wrong.
Yeah, you're done. You're done.
Ugh. Gosh,
You are ruled by a tiny tyrant.
Yep. Oh my goodness.
It's like rule 3 in the parenting handbook. If you're going to give in, you give in straight away. You don't fight because then you just lose the power. It's just ridiculous.
Incelsior. Some of these names says he's finally successfully gotten under her skin. What an absolute nightmare. Chalky Adams says, important question. Is it acceptable to use a mid-shelf whiskey, black label equivalent for whiskey sours, or do I need to be admonished? No, if
you're absolutely fine.
Use bottom shelf whiskey for a sour.
If you're gonna,
I just made one with an Elijah Craig earlier today. So
if you're gonna mix something in your whiskey, it doesn't matter what the whiskey is, as long as it's not the Johnny Walker Game of Thrones editions, because those are the worst whiskeys on the planet.
Winter is coming.
The White Walker, Johnny Walker, was God, it was so bad.
Winter is
that's
coming, and
bad.
so is the puke.
No,
Cassie,
it's a pure gimmick bottle. That's it.
when
Rock
the
that in
whiskey
again.
tells you to put it in the freezer, like that's when you know it's
Yeah.
gonna be bad.
And if you put it in the freezer for like 30 minutes, like winter is coming appears on the side of the glass, on the side of the bottle.
Yeah, because if you don't know, frozen or very cold whiskey you don't get the flavors of the whiskey at all. And so if you have shit whiskey, just put it in the freezer, and then you can just get drunk. But that's the branding on that stuff. God, it was awful. Cassie Marin says, Nick, I like that shirt. You look great today. Hey, thank you. I like this shirt too. It's brand new. Spatula Guy says, when Jerry Springer coming out? That's a good question.
Yeah.
So should the judge and Darrell be? Oh, you have it there. Nice. God, here, hold on. Let me hold that up again.
Oh, wow.
Look at that.
And then if you put it in the freezer right here, like winter is coming appears down the side.
God, it was
it's just
so bad.
Absolute shit. Oh, right here on the back it says freeze for an unexpected icy reveal.
Yeah,
that's kind of
Need
an
to
expected
license
reveal.
that.
There's some language on there, if I remember right, where it says it has an interesting transition as it comes up to room temperature, and it's like, oh, just like a corpse. Jay Hudler says, Rekieta Law.
12:48.
Oh, we're back. Yeah.
All right, let's take up the issue of
Let's take up all
the
the
letter
issues,
and the
Judge.
photographs and your.
Do you
offer.
have the letter? How about that as a starting question?
I don't need no offer.
Featuring notes of caramelized sugar and vanilla
the
with
second
Fred
time,
Resch
yeah,
berries with a touch of orchard fruit. The whiskey develops in complexity as it warms to room temperature.
Too much of an issue, too much of a problem.
Mr. Brooks, I'm going to ask you for a third time. Do you have an offer of proof
I
related
just said
to
no.
the route?
I just said no.
You said no.
I
He
just
said no.
I
He
said
did
no.
say no.
Thank you. Then based upon there being no offer of proof, then my decision stands. As to the continuation of the examination of
How do I make
Ms.
myself feel better?
Patterson, I would like an offer of proof as to what you believe her probative and relevant testimony will be from this point forward.
I mean, I don't know how she's going to answer the rest of the questions. There's not that many questions left. I was almost done.
And yet she was the one you're supposed to spend so much time on.
Generally, were you going to question her about?
Remember, this is the
finishing
witness
my
that he
leg
had to
killed
call before the 10:30 a.m. witnesses, though.
Mhm.
That's how disruptive he has
I
been.
guess I'll have to look in here because so much that happened since
You just
over
said
the
you were
past
almost
hour
done.
and a half or so.
Yeah.
So you're gonna have to look in the file for all the
I tell you
questions
one
you don't
thing,
have.
I don't intend to.
But what's
I
Nate
don't
doing
intend
back
to
there in the
have too many
background?
More questions. I tell you that. I was almost finished.
I need an offer of proof as to what you believe her testimony would be, meaning what topics? And are they topics that have not already been covered either through her direct examination from the state, your cross-examination, or already covered by your direct?
I don't remember her. What do you mean by related to her direct? Is that from the last time she testified?
From the first date that she testified and from today?
I don't
What
remember.
new topics
I
will
don't
you be?
remember everything she testified to the first time. It was 2 weeks ago.
Well,
Take notes.
Mr. Brooks, this is your opportunity to prevent relevant and probative evidence. But under 906.11, she's already been questioned now twice by you. So what new topics do you intend to question her about when she comes back on the witness stand?
What do you mean by new topics?
Well, I'm not sure how ambiguous that question is, Darrell.
Already covered.
What, pursuant to the police report or something? Is that what you asking? I don't understand.
It's your strategy, dude.
This is your case right
Once
now,
again,
buddy.
so give me an offer of proof as to what you believe your questioning will be as to Ms. Patterson going forward.
And you said related to topics, right?
Yeah,
You
that'd be
can just
helpful.
give me the topics. I think that's fair.
I wanted to ask questions about the police reports. That was the last few questions. That's why I'm saying it was only.
Is it a statement that she wrote?
No.
No.
I don't know if it's a statement that she wrote in
I
here.
do.
Possibly is.
Do you see a written statement with her signature
I will
on it?
have to go through all the paperwork.
Is there a written statement from Ms. Patterson? It's my understanding Detective Booth spoke to her on both occasions. Is that right?
Yes, with Detective Barron with him on the first occasion. Detective Barron wrote that first report. Both interviews were also recorded.
Previously provided with discovery?
Absolutely.
What about the police report, sir? Do you want to question her about, so I know with specificity?
Oh, I'm looking at it now.
Do you think he's done any prep, or was he just planning on making this all up as he went?
Yes.
Option
that
2.
one.
Yeah.
Mm.
He's just been spending his evenings with his tablet researching sovereign citizen quotes.
If I'm
How many
If I'm with the
officers- how
tablet in
many
the jail
officers
room,
gave
I'm
reports?
going to
'Cause it
Rule
seemed like it's
34.
more than just 2. At least from this paperwork, is more than 2.
Be worried about Bubba and the next soul using his imagination.
Oh, damn. This is amazing.
Show me what Mr. Brooks is referring to. I can maybe
Fucking
help him try and
chat.
explain, but
Sure.
I don't know what he's talking about.
Look at that.
That's great.
Wow.
That's a good one, Nick.
Baby got back.
So I've got pages 2 and 3 out of 6 from Detective Barron's report under Waukesha Police Department incident number 21-047523. This is one of the 2.
I'm going to post that image on my community tab. It's a good one.
Regarding the statements that Ms. Patterson gave to detectives on November 21st and then on November 22nd. This is the first statement.
Is that the officer you just said?
Yes.
What about that report do you want to question this witness about?
The report is not in order, so again, as I stated before, I would have to read it.
Mr. Brooks, I trust that you're prepared. These are your witnesses. So what about that report do you want to question Ms. Patterson on?
Your Honor, I just stated 3 times, I would have to read a little bit of this to form the questions.
Boom, out.
Then, and given that this witness was initially called by the state, there was a full and fair opportunity for cross-examination by Mr. Brooks at that time, and they had ample time this morning to question her. I will declare that his questioning of her to be closed. I will bring the witness out on the witness stand and then we'll bring the jury out, and then I will simply ask the state if there are any questions, and then we'll move on from there.
Just so I understand what you mean by closed.
I'm not allowing you to
You're not
ask
asking any more questions,
additional
dumbass.
questions, given your full and fair opportunity that you had previously when she was called by the state, and given the opportunity you had this morning and your failure to identify for this court any probative and relevant information that she would testify to about what's in that report.
How do I, first
Basically-
of all, the report isn't even in order. So I would have to.
Basically, you didn't do your homework, so she's slapping you over the knuckles for it.
To even ask a
Mr. Brooks,
question.
this is your witness. I expect that you will be prepared and you will not cause delay by any lack thereof. So I'm bringing the witness out. The jury will come out, and you will not have another opportunity to ask any additional questions unless the state asks questions on cross-examination.
So what is we bringing the witness out for?
I
then
have
if
to do
can't-
that in front of the jury.
Has to do it, dude.
I object to that ruling too. Can you give me a lawful law why?
Your objection is noted for the record. If you start interrupting me when the jury comes out or make any commentary, you will be removed to the other courtroom, and that's.
So I'm being held in contempt again?
It's
No,
not contempt.
Contempt, sir.
It's different than
literally
contempt.
not.
Illinois versus
It's
Allen.
basically
Warning that
contempt,
you will
though.
forfeit your
So I
right
might
to
as
be
well just, I might as
present.
well have just
No
stayed
such
over there.
contempt finding.
I find this
That's why I just
contemptible.
stayed over there then if I was
Mr.
gonna get held in
Brooks,
contempt.
that decision is for you and you alone to make, and it is based on your conduct If you're going to
Just take me over
continue,
there. Just take me over there because I'm not finna get held in contempt for nothing.
I have not held you in contempt.
You
But
did.
you should take him up on that offer right there.
That's what that is.
Please take him up on
No,
it.
Missy,
He's
no,
volunteering.
you're
Don't argue.
gone.
Just do it. Take yes for
Why
an
am I
answer.
being held in contempt?
I'm going to keep you in here because
that's the whole
you're
reason
going
I
to need
didn't
to
want to
call the
come.
next witness, and I'm going to need
Your
to
Honor.
bring you over in any event.
That's the whole reason why I didn't want to come over here because you was gonna find a reason to hold
Then why
me in
didn't you
contempt.
just say you
I'm
would
finding a
stay over
reason, and
there?
It's not contempt, but I'd find a reason to remove you based upon your disruptive.
Well, then
outbursts
remove me if
and
that's
your-
what you want to do. Remove me then.
I don't want to.
tase his fucking ass.
Courtroom.
Obviously, you do. You brought it up before we can even get to.
All right. Mr. Brooks has forfeited his right to be present in this
Tase
courtroom
him.
for the remainder
Come
of
on.
this witness.
So
Even though
did
it will be
I
short,
actually forfeit that
Give us a
right?
reason.
you have forfeited your right to be present.
And how did I forfeit that right, Your Honor?
All right.
Goodbye.
We're going off the record so
So,
that
yeah.
he can be removed
Bailiff.
from the courtroom and he can call his
Please be
next
physical with
witness
bailiff. Please be
after
physical with bailiff.
Ms. Patterson and giving the state an opportunity from the neighboring courtroom. And once you can promise to this court that you will abide by the rules of decorum and civility.
Make him call the witness from the other courtroom. That'd be good. You've got real-time audio and video.
Yeah, just conduct
Exactly.
the trial from the other courtroom.
Exactly.
Why am I being held in contempt now?
I'm not
What,
holding
It's not
you in
contempt.
what did I do?
All right,
Tell
I'm going
him-
to step off. You've
You
interrupted
asked to be
me.
removed. How about that?
I
What'd
think
you do? You
this,
asked. That's a start.
see, she does this.
one around here gives a shit about the rules.
Yes,
I
Walter.
feel that. I feel
Uh,
that one.
She keeps
Yeah.
doing this thing where she is
We are all
stepping
Walter.
she is stepping off of her dais to get away from Darrell Brooks's meaniness. But it's like every time she does that, she's conceding the control to him. She should stand there while the bailiffs remove him. Stand there and stare at him. Fuck him. Like seriously, that's not prejudicial. The jury's gone. She does not need to remove herself. She's doing it because she's actually intimidated by his presence and can't bear to see this thing play out. No, remove him. Stand there and stare at him as he goes. Oh God, just it's pissing me off. Like, have you never had to deal with a difficult person in your entire life? Work at a gas station or something.
Well, she's treating a guy that killed 6 people and and injured 66 others with kid gloves.
Yeah.
Yeah.
Oh Jesus, it's driving me nuts.
She's so
The only
scared
thing
of
that gives me
appellate
any
that
pleasure
it's
in this
just-
world is the thought that his jailers will not be so kind.
Well, they definitely, not that they would be anything like particularly untoward towards him, but I mean, they will certainly not be as kind as her. There's no, you don't get deference in prison with the
No.
attitude that he has. My father-in-law was a prison guard for over 20 years, and he talked to him many times about how basically this works. He's like, if the prisoners are respectful, if they're, they'll be very cool and very friendly with the prison guards, and that's fine. But the prison guards know, one, there's a lot less of them than the prisoners. And two, the environment that they're in, if the prisoners step out of line, that goes out the window immediately. They will be cordial back to the prisoners, but they will immediately match the level of respect that is given to them because they have to in that environment. If Darrell Brooks acts like this in prison, he's going to be in a very sad state pretty quickly, if not from a guard, then from another prisoner.
Well,
The prisoners are going to be, yeah.
He has
Well,
to be
he's
in
got
protective
that.
custody for the rest of his life.
Well, he's going to have the prisoner blowback, and also I've toured multiple prisons and gone and been in the inside. When I was a prosecutor, I used to do that, and they have something people don't understand. There's the general population, and then there's the whole. The whole is an isolated room with basically very little window or just a toilet and a sink, and that's it. And you are
As an
alone and
incel,
isolated.
I know what that is.
Well, anyway, but the general population is a lot better, but he might be a lot safer in the hole because, like you said, when he's pulling that attitude on some of these guys in that prison, he's going to get the short end of a shank.
He cannot be in Gen Pop. I mean, where
absolutely not.
He's killed a bunch of old ladies and babies.
A kid.
He
killed a
gone.
kid. He is gone.
He's gonna be in
His
protective
attitude's
custody
going to
the
get
rest
him
of
in
his
trouble in prison because he
I
is
won't-
not.
Oh, go ahead.
Well, he's not the toughest guy. I mean, everybody is a sheep and a wolf, and that is not a fun place. The people that he's going to be around, he rolls those eyes wrong way, and he's going to get shanked. I mean, this attitude will not last him long in prison.
Well, the problem is that prison power is very group dependent, right? It's who you have that has your back that keeps you safe in prison, and this is not a guy who seems very capable of making, developing those kinds of loyalties with people. He's going to be on his own. That makes him a soft target.
I think the Aryan Nation would take him in.
He's going to mouth off to some dude that has been doing nothing but doing push-ups and bench presses for the last 20 years.
I was going to say that.
End him.
This dude he's not big. He's not a big, imposing guy. He's big towards small women, like his baby mama, who was 15 or whatever when he got her pregnant, who he's been slapping around. But this dude, I don't even know how big he is. He doesn't look like he's 6 feet tall. And trust me, in prison, there is someone much bigger than 6 feet tall and much wider than 6 feet wide. And they will kick the shit out of you if you they don't care. They're already there and they're not leaving. Where he's going. That's the important part. That he's 5'8". Yeah. And he's not like overly bulky. And he's going to life prison, not like the middle tier prison. So he's
Maximum
going with
security,
people who will never leave.
Andrew could take him with that much problem.
Yeah, I believe it.
Easy work.
That was it was a great video interview I had, plugging my own shit, with Gary Nerdrotic. Because when Gary was young, he caught some drug and theft charges, went to prison. But he was in like a tier 2 prison, or supposed to be, but the prison got remodeled. So they put all those guys in with the lifers at Folsom. So Gary's roommate was like a lifer in prison. And he said, yeah, those guys don't care because they're never getting out. So the whole environment it's a different environment. People who are getting out have to worry about getting in fights. They have to worry about stabbing someone because that can transfer you to the never getting out phase. The people who are already in there for life, they'll kick the shit out of you. And you're lucky if you get to live through it because they're already done. Yeah, you just don't want this kind of attitude. But John Moes says rackets and legal vices, top 5 whiskeys. Do you know him?
My desert island whiskey. If I could drink one whiskey for the rest of my life, it would be Glenmorangie Signet. On top of that, I would say Ardbeg Corey Vrecken, Lagavulin 16, Bruichladdich Black Art. I think that's 5. Is that 4? I don't know. Anyway,
I don't know. Hey, have you ever seen one of these?
And a good bourbon.
Have you ever seen one of these? Just a second here. This Duncan Taylor.
I've seen them. I've never had it.
14-year from Bruichladdich.
Yeah, I think I saw it because you sent me a picture, I think.
Oh, yeah. That's right.
Yeah.
Sorry.
That's where I've seen
I forgot I did that. Damn it. I was hoping anybody had seen this. I've got to wait until Attorney Tom grows tall enough to get on my stream again. It was a gift from him.
You're never going to drink it.
Oh, I will. Okay, my top 5. Number 1, Kentucky Owl Last Batch Rye. Batch number 4 is my favorite whiskey that I've ever had by a mile. Next, Boss Hog Samurai Scientist was really good. I like the Magellanic, but the Samurai Scientist is better. Next, I go with, right now, I'm just jiving on this, I think. Yeah, Joseph Magnus Cigar Blend is number 3. Number 4, I'll go with Lagavulin 12. And then number 5, I'll go with Bowmore 15 Darkest. Those are my top 5 whiskeys.
Nice.
So there
I'm
we
being
go.
a basic bitch and just having a Lemmy Killmeister now.
Oh,
Straight up Jack
Decon28
Coke.
said had actually said the Bowmore before I did. God, that's such a that 15-year the Darkest is so good. Gamer 635.
I'd like to submit Redbreast as a for one of my list.
Redbreast 12 cask strength is impeccably good.
You are unmuted, sir. The jury is on its way in. Well, will be shortly.
I'm an alcoholic.
I'm going to mute you if you do that, sir.
Oh, Christ.
I'm not gonna do it when the jury. That's why I asked now before the jury came in.
I addressed that in my opening type remarks and record when we came back on the record today. I already addressed that.
So will it be proven for the record?
Don't even answer him.
Why at least be told why I'm held in contempt?
You're not held in contempt.
No, for fuck's sake.
I wish you would tell
That's
him
a
what being held in
misstatement of what I
contempt
did, sir.
is.
Yeah.
The sovereign
Well,
citizen
well,
playbook tries to
Jury's
get the
coming
judge
in.
to hold
Please
you in
be
contempt.
quiet. You're going to be muted, sir.
You gonna mute me anyway?
What?
You're quiet.
What?
I gotta be quiet. Like
Not
you.
if you're quiet.
Mute him.
Like I
Just mute
said,
him.
sir.
I have to be quiet like a kid.
Respectful. You have to be respectful of the proceedings.
I like the irony of that. I'm not going to mute you if you're
That's a
quiet.
mischaracterization as well.
So can I say for the record that
Push the mute button.
is making
Just get yourself a stream deck.
on my head and I'm
Just push the button.
screen and made me feel uncomfortable.
You can say it on the
Jury's
record.
coming in. Please rise for the jury.
So that's not gonna be addressed.
Mr. Brooks, I'm muting you.
You said it on the record, Brooks. He
okay.
does not seem to understand. Well, I mean, intentionally not understanding that he is on the record every time he speaks.
Okay.
Gamer635 says Stacy Kuhn is somewhere watching this trial wishing he was the bailiff. I don't get the reference. Probably a good thing. I had to guess.
For a second.
And Maggie Rose 1521 says perhaps this judge is afraid of her house getting razed to the
Thank
ground.
you, everyone. Please be seated.
Possibly. I don't think there's a ton of community sympathy for Darrell Brooks now. I think there was at the time of the incident, but I think as time has gone on that. Oh, well, there was a GoFundMe from Black Lives Matter for his bail and stuff, but like
Just
I
for
think
the
that's
record,
even
Mr. Brooks is
gone out.
appearing from another courtroom. That should not affect your deliberation or verdicts in any way. At this time, does the state have any questions for this witness? All right. Thank you, ma'am. You may step down. Thank you for being here. All right, the defense may call its next witness, please.
Mute him.
He's faking it.
Just tell him if you don't call anyone, we'll take your case as submitted and go to closing arguments.
Yeah, for real.
Go ahead, sir. You can call your next witness.
I don't even want to.
I thought I was muted.
No.
You're not muted.
I'm not? I'm not muted?
Call your
How
witness.
long am I supposed to stay here now?
Call your witness.
I'm going to excuse the jury.
Oh, God.
No. Until the next break. Until the next break
All
is
right,
the
for the jury,
answer.
please.
There's not enough Jack Coke in the world for this shit.
She's going to do this again. She's going to excuse the jury. She's going to have an argument with him, invite him back. He's going to be disruptive because this is how he controls the courtroom.
He's going to win.
Hopefully, she is going to give him the advisement that if he doesn't call his witness, she is going to treat the case as submitted.
Yes, and then follow through and then do it.
Yes.
That's the
Yes.
trick.
That's the problem.
You have
And
to.
then I, as the Court of Appeals, watch me not care.
Exactly.
In the
Exactly, Kurt.
in the foster parenting classes that
All right,
my
the
wife and I
jury
took
is no longer
to
in
become foster
the
parents,
courtroom.
it was set the expectation and then follow through. Let them make the decision
Brooks,
for the
I-
discipline.
Had the jury leave the courtroom because it appeared to me you wanted to perhaps either ask to come back into the courtroom or make another record of something. Do you want to come back into this courtroom as you call your next witness?
Not if you're going to send
Oh,
me
he's got
back
his
in with
mask
him.
back on.
Don't do it.
You're not
Make him
muted.
call him first.
You're unmuted.
Make him call the witness first.
Exactly.
Oh my God.
Just put your fucking
What's
headphones on
going
when you get
now?
there.
Why am I being held in contempt yet again?
You're not being held
You're
in
not.
contempt.
That pursuant to Illinois versus Allen, Mr. Brooks was not held in contempt, although that is one of the possible ways for a trial judge to handle a
The mask is back on.
defendant who is stubbornly defiant, disruptive, and contemptuous.
He wears
That
it
is
when he's
not the
being a
only
bitch.
way in which
Yeah.
a judge can address a defendant that is being discourteous, disrespectful, and disruptive. So pursuant to the authority in Illinois versus Allen, I found that you forfeited your right to be present based upon your conduct. I'd also direct the parties to some persuasive authority from other jurisdictions that are more recent, including People versus Cone from the state of Colorado, 160 P. 3rd 366. It's a Colorado Court of Appeals from 2007. And then from the state of Washington, from their Supreme Court, State versus Davis, 461 P. 3rd 1204. That's from 2020. And then I'd remind the parties of the district court decision that was later affirmed from Pennsylvania, U.S. versus Jennings, 855 F. Sup. 1427 from 1994. The finding was, sir, that you forfeited your right to be present based upon your conduct.
Okay.
That's
So don't bother
her
asking
law
him
clerk.
back.
Case
Law
laws
clerks
to be
have been
cited
working.
are pursuant to that.
Sir, I will ask you, would you like to come back into this courtroom as you complete the calling of witnesses and your next witness?
I thought you was using Illinois versus Allen.
You are welcome to come back into this courtroom, sir.
So why was I removed in the first place then?
Because you're a fuckwit.
You're being a child.
You're being a
And I will
cunt.
ask you one last time.
D, all of the above.
Come back into this courtroom as you call your next witness.
You're not finna hold me in contempt no more.
You're not in
Not
You haven't
contempt.
been held in
Brooks is
contempt.
not answering my question directly. So based upon that, I'll advise him that if I will ask one more time and he fails
Don't
to
ask
answer
one
with
more
yes
time. She
or
keeps
no,
saying that.
I will take that as a no that he wants to stay in that
You
courtroom.
You can't
So,
answer
Mr.
for me.
Brooks?
You can't do that. You can't do that.
Yes, you
Mr. Brooks, I'm
can.
advising
Actually,
you that I will.
you're
He's
answering by your own
interrupting me
conduct.
once again. From
Okay,
the
you
other
talking.
courtroom.
You the one talking right now. So don't do that.
I'm going to
Don't.
mute him because he's
Brenda
not.
closes case.
Yes,
Do it.
she's the one
Spouting.
talking
Do
right
it.
now. That's how you're
Brenda
interrupting
closes
her.
case. Please, for the love of God.
Directly. He has not reclaimed his right to come back into the courtroom because number one, he has not requested it. Number two, he hasn't answered my question about whether he wants to come back in. And number three, he hasn't stated or demonstrated a willingness to conduct himself consistently with the decorum and respect inherent in the concepts of courts and judicial proceedings. I will give him one more opportunity.
No, you already said that.
So
You
that
have
it-
no authority. You keep saying one more and then you don't pull the trigger.
I will unmute him. Sir, would you like to come back into this courtroom as you call your
No.
next witness?
Don't try to seem like you're trying to honor my rights now because you haven't.
Okay,
been doing
he
it before.
is, again, not
Don't-
answering the
don't-
question
don't try to
directly.
put on no. Don't.
I'm going to mute him again, as I did before. This is
Nice.
a method now that Mr. Brooks is employing, that when I have done something that he disagrees with, that he just continues to argue with me and does not answer questions directly. So based upon his continued disruptive behavior, the fact that he will not answer my questions directly, I'll find that he's continuing to forfeit his right to be present in this courtroom. Clearly, the audio and visual technology are working. He's been responding, although not appropriately. He is in that other courtroom. We can see him. He does have the headphones on, and I confirmed that he can see and hear as well based upon the court personnel that are in the other courtroom. So I'll make another finding that his appearance from the other courtroom is the functional equivalent of him being present in this courtroom. Mr. Brooks, before I unmute you, I am going to
Pop-Tarts
advise you, I
across the
will
room.
ask you
I'm weak.
to call your next witness. And if I don't get a direct response out of you, I may ask it again. And if you fail to give me a direct response, then you will forfeit your
I'll
right
ask you again.
to call any other witnesses.
There's the
I'm going
threat.
to unmute
Now
you.
follow through.
Yes.
Actually, I need to
Be a
bring the
big
jury
girl.
back
It's
out.
big girl time. I believe in you. You can
Before
do
I
it.
that, I will
You can
unmute
do
the
it.
person, ask you which witness you intend to call, so we can at least have that person ready to go and outside the courtroom. Who will be your next witness?
I'm not calling no witness if I got to be in this other courtroom.
Would you like to come back into this courtroom, sir?
Why was I ever removed? You never answered.
I've
I
made
gotta
a record
answer
of that,
everything.
sir.
I have to answer everything though. Everything you ask me, you expect me to answer. But then when I ask you questions, you never
That's right. That's correct.
That's how it works.
I just
You
put on
are
the
not
record
in an
that
equal
two of your neighbors
power
just
position.
made gestures. When I'm looking at them off the reflection of the screen, they're making gestures behind my head that make me feel uncomfortable. I just brought that up on the record. You didn't even address that.
Who?
Mr. Brooks,
People.
The
I
bailiff?
didn't address it because frankly, you keep interrupting me and then I
As
have to
Lionel
deal with
Hutz
the
said,
interruptions
you're
and make
the
a record
judge and I'm
regarding
the
that.
law talking
So I just
guy.
saw the captain walk over. I will let security personnel, Captain Dussault, look into that. And if appropriate, he can bring that
No.
conduct to my attention.
We are the knights who say
I'd
me.
also remind the defendant that at any time you can also ask to be brought over to the bailiffs who are in that
Close the
courtroom.
case. Close the
So to
case.
be abundantly fair to
We
you,
can
I will
have closing
at one
arguments.
time,
We
would
can
you
give
like
it to the
come
jury.
back
We can be done by dinner, man.
Exactly.
I should have
Right
never.
It's at times like this. The
That's
best
not
thing you
answering
can
my
ever
question,
hear
sir.
is,
You haven't answered my question.
The court's not going to answer questions directed at the court by the defendant because they're not relevant or probative at this time, and they're a delay and disruptive tactic.
They're
Mr.
not a delay
Brooks,
and disruptive tactic. Is that a judicial decision determination? A judicial
Yes.
determination that
Just
you're
stick
making.
with
I'm going to
who's
mute
your
you
next
because
witness.
we're going off on
Who's
the
your next
judicial
witness? One
determination.
time.
Every decision I make, sir,
Your
is
case
by
is
definition
closed.
a judicial
Thank you.
determination. It is on the record. If there is a conviction, you can raise whatever issues you want on appeal if you are convicted.
If.
But we don't need to have this back and forth every time to further make the record when the record speaks for itself. You were given plenty of opportunities throughout this trial to make offers of proof, to state your legal reasoning for either an objection or for a question that's being asked or for a whole host of other things. But right now, you're not doing anything legally relevant. You're being disruptive. I would like you to be present.
No,
That is always
I wouldn't.
what I want
Pull the
in
trigger.
this case. It certainly, I think, is important, but you can forfeit your right to be present by your conduct, which you have done repeatedly throughout this case. I will advise you that if you are in that courtroom, because I have put you there and you have not reclaimed the right to be present by number one, asking and then expressing a willingness to conduct yourself consistently with the decorum and respect inherent in the concepts of courts and judicial proceedings, you will remain over there.
What happened to
He took
if
his
you don't name your
headphones
next
off,
witness, I'm
so
going to
I
close
will-
your case? What happened to that threat?
Mhm. I know. Can we get back to that just for a sec?
I was so happy for
Mr.
a
Brooks,
moment.
I'm advising you that if you fail to call a witness, you will forfeit your right to present any additional witnesses.
Do it.
ooh,
Do it.
And I'm doing this
Drop the
outside
ban hammer,
presence of the jury
biatch.
right now for a reason. I need to know from you right now, you are unmuted. Who is your next witness?
unmuted.
Did he just say she's trying to say something to
He
me?
took his headphones off.
What you trying to say?
That son of a bitch.
That was very disrespectful, sir. You chose to take off your headphones.
Yeah,
You choose
because
to
I'm
read.
muted. I'm muted. So
I'm
why
muted.
am I gonna have my headphones
That
on
means
when
you
I'm
can't
muted?
speak.
Well, I would
Yeah, but
think
he's
your
muting her
headphones
back.
help you hear. The
They
muting
do.
is
Giving
so
him this
that I
power
don't
the whole
have to
time.
hear the disruption.
Yeah.
Okay, well then why should I need to hear what
So
you
let
saying?
me be clear, sir. And
You
you
don't
are
gotta
not
be clear nothing. I don't gotta listen to you.
Do
There
it.
you go.
I'll
Do
ask
it.
one last time, sir.
Yeah, no,
Do it.
Who
that's
is your
it.
next witness?
No, he took chop it.
Do it. Do
No
it.
Forfeit it.
witnesses.
Do it.
He's
Do it. Do it.
This
Do it.
We gotta keep doing this little childish stuff, dude.
you're the one doing the childish stuff.
Dude.
Forfeit it.
I gotta sit up here and I'm supposed to abide by every single rule.
What a
and
man-child.
nobody
Yes.
else gotta do that.
Everybody has to abide by
The
the
record
rules.
should
Judicial misconduct.
reflect that Mr. Brooks
Repeatedly.
is spouting off, making
I think
unsubstantiated
the record can hear me. I think
allegations
they can hear me.
against this court,
Unless I'm
directly
muted.
attacking the integrity of this court and these proceedings, while yet
This court ain't got no
refusing
integrity.
to answer.
This court don't have
simple
Why the
questions.
fuck is she putting up with
Mr.
this?
Brooks,
Mute.
you
That's
are
not my name. I told you I
She
don't
mutes him.
consent
He'll
to being
take off his
called that name.
headphones.
Sir,
Nobody cares if you
you are
consent.
hereby advised
Mr.
this
Brooks?
is the last time I will ask this question,
Do it.
or you will forfeit your right to present
it.
Can't do that.
any
Show me what-
additional
show me
witnesses
where that's law.
because
Show
you
me
are
where
not
that's law.
cooperating with this process.
You put show me where
Show me
that's
that is
law on
That's
your
all I'm
appeal.
asking. Show me that is law.
Exactly. And then we
Mr.
can,
Brooks,
How can I forfeit not being able to have a defense?
Because you're being a dick.
all I'm asking is that you conduct yourself
And by the way, chat, this is
with
not
dignity, with
a
decorum,
reasonably
and with
appealable error
respect.
for him
I
at
will
this
gladly
point.
bring you back into
If
this
she
courtroom.
ended this
so
case
you can
right now or
present
moved to
your
closing
additional
arguments, that's his
witnesses.
choice.
But you need to ask me to come back into this
as a
courtroom.
criminal appellate lawyer, I'll put my stamp on that one. I would say that the chances if she cut it off right now,
Gotta having this back.
there's no appellate issue.
Back and forth with you every day. It's not my.
There's not supposed to be any back and forth, you prick.
And have these interactions with you every day. It's not. Regardless to what you may think, regardless to how you may feel, that is not my intention. Okay? I simply do what I do because I do not have the understanding. So if I
So you
don't
shouldn't have been pro se, you dumb fuck.
ask a question, I apologize if it makes you feel that I'm intentionally trying to delay the proceedings. If
I'm intentionally trying to delay the proceedings?
No, if you
Makes you
feel that.
I'm trying to. He wasn't that quite that
I feel
stupid.
Misty, if you feel.
very, very, very disrespected every time the record is made, making it seem like that's what I'm attempting to do. So of course it's gonna frustrate. Of course it's gonna make me a little bit upset.
That echo, I think, is from the court feed, guys.
And I just want
Yes.
you to understand. That. It seems to me the way I'm interpreting what you're doing, which is it is your courtroom. That's not it. It's not a dispute. That's not up for debate.
Seems to be.
You control what's going on in there. That's not a dispute.
So he's conceding that she has the right to control her
interpreting
courtroom. So
What you're
that's
doing
nice
is
bonus.
that I'm being held in contempt. That's how I'm interpreting.
You're not.
Because one of the three things that's cited in the Illinois versus Allen, one of them is being gagged. I haven't been gagged. One of them is held in contempt. If
What's
I'm-
the
if
third,
I'm not
Mr.
under-
Brooks? What's the third?
Removed from the courtroom.
The third is removed from the courtroom while the trial continues, right? That's the third, right?
That's where we're at.
That's what's been done.
That sounds suspiciously
Okay.
like where we're at.
Now, where does it say after that? That having me on a headset or being able to see and hear and all this and this, how is that not prejudice my defense?
Sir, you can
I
raise
can't
that
even-
issue on
I can't-
appeal. You
This
can
is
raise
why I
that
say that.
issue on appeal
This
if you are
is why I say
convicted.
that. This is why I say that though, because I can't even see. The only thing I can see right now when I'm looking at the TV is you and the
You can
prosecutor.
raise that issue on appeal, but I'm going to laugh in your face.
Anything else?
Exactly.
I understand that, sir. I'm fully aware of that.
So I'm not fully aware of what's going on in the courtroom.
Just do it. Just do it.
Don't I
End
deserve
it.
that right to be able to see and hear everything that's going on?
Not when you forfeit it.
If you can conduct yourself consistently with the decorum and respect inherent in the concepts of courts and judicial proceedings,
Week
then
says I'm
yes.
more time, and she just
So I'm not going to
Just
have a
won't
debate
pull the
with
trigger.
you about the law.
He's clearly demonstrated his ability to do that.
Yeah. By the way, guys, the
I will
echo
ask
is
you
on specifically
again.
his microphone from
Would
Long
you like
Court's
to come
feed.
back into this courtroom?
The Long Crimes feed. It's not
Are
us.
you going to kick me out? Are you going to kick me out?
Sir,
You've been
I'm
kicked out.
asking the questions right now.
ask him who his next witness is. Don't
Would you
bring him
like to
back.
come back
Make
into-
him
Exactly.
call his next witness.
Yes or no?
Exactly.
Don't bring him back.
Yeah.
Make him call his next
Sir,
witness.
It's a yes or no question. Would you like to come back
my
into this?
answer, my answer was based on the reason why I'm answering like that is because the moment I say something, it's going to get me put out. I don't want to keep hauling this stuff back and forth and back and forth. And back and
Just
forth
end this
back and
case.
forth.
And
Call
don't
his
be a
next
dick.
In the case, I don't have
It
to do
makes-
this on
it
Monday
makes
because I
sense.
can't.
It wastes his time, really.
Well, Stephen, if
I'm well aware
if
of
she
that.
just said, "Okay, you're done,"
And it delays the
Yeah,
proceedings.
what would that do for the appeals?
But then
If it was raised on appeal, it would be judged by abuse of discretion.
I want to be over
You
here.
think she'd be abusing her
Sir,
discretion?
I don't know what you
No.
want or
No.
don't want at this time. I know that we need to complete this trial and that you have frustrated today more than ever before the ability of this court to do that.
People can be tried in absentia.
Yeah.
Nobody seems to take that into account. I'm just as frustrated as everybody.
I'm just an unfrozen
I
caveman lawyer.
suggest that you conform your conduct
I doubt that's true.
requirements of courtesy and decorum so that you don't run the risk of forfeiting.
That goes to
your right.
credibility, Kurt.
That falls on you and you alone, sir.
There is no conduct. I don't understand what you mean by that.
That's why you have a lawyer.
Mr. Brooks, you may not understand it. I don't think that's accurate. I think you know exactly what you're doing.
If that's what you think,
sovereign citizen
And
playbook.
you have demonstrated throughout this case that you pay attention to witnesses' testimony, that you make cogent and coherent objections. At times that you
Right now, she's
even
eliminating
had
the
evidence
argument that
suppressed in
she
this
should have
case
ruled him
or stricken.
incompetent and
That's
appointed
the word I used
counsel.
during this case.
Yeah.
Made an opening statement. You communicate with witnesses. So
Your
you
Honor,
clearly
it's
read,
not
write,
fair.
and understand
It's not
English. That's not an issue
not-
here, sir.
It's not fair
Are
to
you
say-
self-represented? Absolutely. Does that present difficulties and disadvantages? Absolutely. But that takes me back to when you waived your right to counsel. And you did so
warned you.
freely, voluntarily, and with a full understanding of the disadvantages and advantages of doing so, meaning advantages of having an attorney, the disadvantages of doing it on your own, and you made a deliberate decision to
Your Honor, that's
represent
not fair.
yourself,
Your Honor,
and
that's
that
not fair.
comes at a risk to you of, yes, at times not fully understanding the law,
Why is she having a debate
rules of
instead of
evidence,
pressing the
the
question?
rules of procedure, but you
That's
do
not
so
fair.
at your peril.
That's not fair to state, Your Honor, because
Press the question.
I'm going to do the following, since I'm not really getting anywhere. I'm going to mute you for the moment. I'm not getting anywhere with him. I would like him to be brought over.
Why?
No.
Because she's going to
And
end the case with him
he
there
has
in
a choice
person.
to make.
Hopefully she's going to end the
Come back
case.
over or he doesn't. Either way, he's going to be asked to call a witness in front of the jury. I will ask him 3 times if he fails.
No, why not ask
Yeah,
once?
Why would you
And
do
after the
that?
3rd time, I will make the appropriate finding, but I will do that outside the presence of the jury. But we are going to continue. So we'll go off the record and he will come back over here. Thank you. We are in recess until that happens.
God damn it.
This is ridiculous.
Yep.
This is a fundamental error with the pathological personality is this eternal naive optimism that you will ever be able to get them to see your perspective. You should just stop. Like it's not going to happen. You are not going to persuade him. You are not going to outreason him. Just give it up.
He is still going.
The only way this could have like worked out in the judge's favor is if early on she were somehow able to impose upon him a sense of respect for her authority, either through the bailiffs tasing him through the ankle cuff or whatever during one of his outbursts, or when he stands up in a very aggressive manner or something like that, to say, no, you actually have a limit. She has not given him a limit anywhere. And if she's not willing to give him a limit that does what he wants, which is delay the trial, then she's never going to win it. So you're right. I mean, at that point, you just have to say, this person will continue to act this way. They have demonstrated, I mean, he's demonstrated every day of trial, he's willing to be disruptive in the same manner. The past 2 or 3 days have been particularly bad. And that's when you just say, you know what? You're done. You're done. It's like, if you're not going to actually participate in the rules of the forum, then you forfeit your right to the forum. And that's your choice. You don't, you can choose to represent yourself by just not doing anything. That's an okay representation. And the jury can make its case based on what the state has presented.
It really does seem to me like this case should open up a broader conversation about the use of personality disorder in establishing competency. Because no, I'm serious. I'm serious. This is something that it's such a minority view. Like there are psychologists out there If I go in and get a client evaluated who will say, yes, this person is so, personality disordered that they cannot bring their behavior into conformity with what you need to do to have a meaningful relationship with your attorney, to be able to meaningfully participate in your defense and so forth. But it's such an extreme minority view. It doesn't, seem to have broad acceptance from the courts. But this is exactly the example of, what happens when you don't recognize that this is a problem. You're not going to fix this guy. It's not going to change. This is how he's going to behave. And it is not consistent with the ability to actually put on a legal defense in a courtroom.
Yeah, but assuming you did all that, then where are you at? Just knowingly indefinite civil confinement because this person is unfixable. They'll never be competent. So you just confine them indefinitely.
Oh, you have to have danger. You have to have proof of danger in order to confine somebody. You can't confine somebody just for being mentally ill. I am going to be the first one to say, yeah, there's risks of going down that road. I don't like getting people evaluated when I suspect that there might be a personality disorder issue, because one, the upside is unlikely to be there. The judge isn't going to buy that this is actually helpful to my defendant. And then when we get to the risk assessment part of the process, the state and the Department of Corrections and everybody is going to be pointing at that diagnosis to say, oh, he's, like you said, he's not fixable. He's going to continue to be a risk. So these things just end up not getting developed in the court process.
Well, I'd kind of go a different way with that. That's an interesting perspective, and you're right on the money on it. But I'd like, I was just thinking about it as we were talking, and I mentioned it. We were talking, which was trial in absentia, which I think that what we have here, trial in absentia is a thing, and how does that integrate with Illinois v. Allen?
Well, Illinois versus Allen itself cited a Supreme Court upholding trial in absentia. In that particular case, the person fled in the middle of the trial, and so they had the rest of the trial without him. And there's like what Supreme Court said, no problem. It's like, you're the one who's chosen not to be here, so waiver by conduct.
That's what it comes down to, is voluntary absence versus not. And so then it just becomes a question of when you engage in disruptive conduct, there's certainly cases in my state that say, yes, that can amount to you are voluntarily absenting yourself because you're choosing not to, follow the rules of the process.
Right. You can, there's the Randian fantasy. If anybody read, I think it was Fountainhead, when he gets hauled into court and he refuses to accept the authority of the court, and he ends up winning that way. Now here's the thing though, there's a trick to this. People who read that, like the sovereign citizen, look at the Randian fantasy of the Fountainhead court is, if I don't give them the authority over me, they don't have it. That's not the correct approach, because that court had a law that required you to give them, it required the court to give, or to have you accept the authority. That was the punishment. The punishment was you had to accept the authority of the court for the court to have the jurisdiction. And he was just the first guy to say no. So there's a distinction there. Our court system doesn't work that way. You're in the United States. They have jurisdiction and authority over you. That's part of the price you pay to literally be physically present here in this country, whether you're a citizen, whether you're a legal immigrant, an illegal immigrant, a visitor visa, it doesn't matter. You're here, you're under the jurisdiction. That court was a special court in the book that was created with the requirement that the court obtain permission for jurisdiction. He just said no. That was the point of that scene. But people misinterpret that a lot, and they think that, well, if I don't consent to the authority of the thing, then it can't have authority over me. No, lots of things have authority over you with or without your consent. Your consent is your existence in that place. You could just go somewhere else, I guess. Swim into the ocean. We don't care where you go. You don't stay here. And that seems to be this fundamental, I don't want to call it a misunderstanding, because I think it's more of a ploy, frankly, about the jurisdiction stuff.
This is all right out of that Sovereign Citizen Manual. I mean, I was reading it. I read the pretty much the whole thing. And this court survival guide, copyright, sovereignty, education, and defense ministry, litigation tool, 42-page document. Everything that he's doing is right out of that. So he's obviously got a copy of it. He's sticking to it. And this is, I'd take the state should introduce that into evidence as an exhibit for what he's doing, because it's evidence that he's following this playbook that's created. And if this is designed to try to break the system, that's what they're trying to do.
Right.
And, thank God we have a courts and fairness and this sort of thing. And Wisconsin's trying to do their best to give a fair trial. But if these sovereign citizen types win and break the system, then you result in tyranny. He's not going to have any court protection at all. You think the sovereign citizen version of the world is somehow better? It's delusional. But he's following this thing to a play. I'm reading through as he was talking this last time, and I was going through and picking out all the things he's saying, which are right out of the sovereign citizen playbook.
Yeah, and that's you got to wonder if they're like true believers, how they got deceived into it, or if he's just like, this is my only shot. That's what I got to do.
I think he's using it as a tool for abuse.
Yeah. I think
Yeah, this is the perspective that this is like planned or that this is strategic. I think just from my perspective is very off base. This is just who he is. He is always going to be like this in every context, in every sort of authority battle. This is who he is. He's just doing what he does.
Yeah, so you talked about personality disorders. Is this just oppositional defiant disorder? Is that what he has? Is he like me?
I have no idea what his diagnosis is, but he's obviously yes, he's got an issue with authority. He's got issues with just his own management and regulation.
I think he's got zero empathy. He's completely self-centered. He doesn't care about anybody but himself. And the only thing that matters is him and me. And he's got this chip on his shoulder, like the world is wronged him and he's the Pentagon of justice. I mean, it's a pathological personality that he's, maybe he's, children do not have empathy. You learn empathy over time. So he's come into adulthood with this complete selfish, childish lack of empathy. It's not stupidity.
Is it sociopathy though? I mean,
I'm not a psychiatrist. Does anybody have any psychological background?
I mean, just gut feeling. Is it just him being obstreperous, or is it?
I think he's never grown up. This is basically a 2-year-old.
Word of the fucking day over here.
Where else are you gonna go on the internet to find someone casually drop obstreperous?
No, but this is a 2-year-old who's never grown up and never learned compassion for anybody but himself, and he's going to kick and scream. And now he's got these tools that he can kick and scream with, and kick at the world and look at me. That's the same thing. He's driving his truck. Get out of my way! I'm the only person in the world. Run him down. And it only matters is me. I'm the only one that matters. Everybody else is just a tool. No compassion for anybody.
Someone said in the chat, let's see, who was that? I can't remember. They said he was diagnosed in pretrial with antisocial personality disorder.
Welcome to
which is that's the serial killer hallmark disorder. Antisocial personality disorder. You didn't not that you will automatically serial kill if you have antisocial personality disorder, but the amount of serial killers that do have it is it's extremely correlative.
Yeah, APD is not something you want to get back on your evaluation.
Yes, it is.
Yes.
Oh my God.
Well,
Okay.
I think the judges' clerks are doing some research in the background. See, she's got some out-of-state law, and they're setting it up to shut his arguments down. And they're going to cite this out-of-state law as not authority, but as persuasive thing that she has this discretion. They should have been doing this a long time ago. Yeah, she's obviously they're feeding her, but they should have done this. They should have been prepared for this. I mean, but it looks like she's doing it at the end. But she needs to pull the damn trigger.
Mm-hmm.
Yeah.
Yeah, she needs to stop. I mean, she's given him miles of road, and we see what he does with that. So she needs to stop with that.
Well, and she just keeps getting dragged closer and closer to the ditch as well. Like I hated during this last colloquy where she's making, findings, so to speak, about his mental state, his intentions. Like you don't need to do that. Just stick with his behavior and with what he's doing because, that's just muddying the waters of what is otherwise very clear. This gentleman is not behaving in a manner that allows him to remain. That's all you need. That's
Well,
all you
she's
should
making the
stick
remarks
with.
outside the presence of the jury, so it wouldn't
Well,
influence their
she is,
decision.
but she's just become so emotionally invested in it that it's a problem.
And Ty,
I
she
absolutely
has
agree with
is
that.
off, but he's still wearing a mask. And the jury will be brought out, and you'll be asked to call your next witness.
Being called that name.
So noted.
I'm sure.
He's just continuing. He's relentless.
Still need to address subject matter jurisdiction
Oh, Christ on the cross. Shut up.
before the jury's brought out.
I will not be doing that.
Will it be proven for the record?
Yes.
It already
It already has been.
So is that a tacit agreement that you don't have to answer that
What
question?
is it? What is a tacit agreement? Is that like a
Tacit.
tisket?
He's reading from the soft
read
sit
something.
literature and he
Well, that
doesn't know
means
how to
you
pronounce
answer the question.
tacit.
Great.
Will we be addressing subject matter
It's
jurisdiction
already been addressed.
on the record?
Every
and will it
fucking
be
day.
verified and proven?
At least twice a day.
Non-responsive answer is a tacit agreement, Your Honor.
Jury's
No, it's
coming
not.
out.
Silence does not accept as basic principles of law. You should know that one.
How the hell anyone can come up with an acceptance by omission is ridiculous.
Well, all I have to say is don't throw turtles on my knees.
Yes, exactly. Don't do it. Gamer635 says Stacy Kuhn was a CHP sergeant in the Rodney King beating. Oh,
Thank you, everyone. Please be seated.
Yeah, he did 2.5 years, causing a fractured skull, broken legs, and burn marks from a taser. So I can understand why they're
Since we
thinking
called
that he
next
might be
witness.
involved.
Who's here?
All of them. You've delayed that fucking long.
Bertram, Hayes, Aldrich, and Lescano are present and ready, Your Honor.
Thank you.
So he's got 3 to pick from.
What was the last two?
Aldrich and Lescano.
Lescanos don't exist.
He's actually going to call somebody. I'm so disappointed. I'm sad. We were so close. I could taste it.
We could have had. We
Yeah.
could have been there. Could have been a contender.
Even the bailiff looks disappointed.
It's like 8 days since last beating.
Let's go with
I still want to know what happened when
Deanna
they cut the
Aldridge.
camera and then they came back and he was bawling like a
Deanna
little
Aldridge? All right, very well.
We're so close. I mean, for better or worse, Darrell Brooks has figured out exactly where this judge's lines are. He knows how far he can push it.
Master manipulator.
Christ, wake me up when he calls a witness.
I can't decide if I need alcohol or coffee for this.
Yes.
You
Irish
pour the
That's
coffee
why-
in your eyes and you pour the alcohol in your mouth.
That's why God invented Irish coffee. Takes the decision right out of your hands.
That's not a bad idea. I'll be back.
Judge, I just want to know if there's a tacit agreement between me and the state of Wisconsin that they will show up. Did you see that, Andrea, yesterday? That was first witness he tried to call was the state of Wisconsin.
I did see that. Yeah, I did see that.
That was amazing.
Well, you can't call him because the subpoena was thrown out before.
Yeah, who'd you serve for that?
I'm holding my line. I just want someone to have the guts to go down to the courthouse and legally change their name to the state of Wisconsin.
I want him to look the judge in the eyes and say, "Will you serve my subpoenas?" That's what I want him to do. I want him to just do it. I feel like the sexual tension is too high between him and the judge. I think it needs to be cut like a knife or with a knife. Like that Bryan
Cuts like
Adams
a
song.
knife.
Yeah.
Yeah.
There we go. But it feels so right.
Oh,
I hate that song. I
It's
hate
the
it
bad
so
one.
much.
It's a terrible one.
Bryan Adams is a earworm all in and of himself.
But I mean, I'm okay with Summer of 69. I'm okay with Heaven, but I hate Cuts Like a Knife.
Summer of 69 for Summer of 69.
Touch the Riot says this judge is afraid of being called a racist. If she has kids, they walk all over her. The amount of time being wasted on the jurors should be appealable by the jurors. The jurors are getting a nice workout in, though.
It's all right. Thank you for letting us know.
Touch the Riot also says, ooh, I see now. The judge severely resembles his mom. Okay, now submit the case for closing argument. I don't think she resembles his mom. Zookster says it's like watching two people fight on Twitter, just in real life. That is an excellent description of what's been going on in this courtroom.
It's like a 72-hour Twitter argument.
Let's see. Senshi Roll says, hi, actually diagnosed with the serial killer trifecta, APD, psychopath, sociopathy here. Oh, and the key is being aware of it. It does scare some people, and oftentimes you aren't aware of the red flags you're giving off, and having a conversation partner that can inform you so you can learn, if you are willing to, of course, is amazing. So there you go. Dude, I bet you're an interesting fella or
How
lady.
many cat skeletons do you have in the basement?
Not enough.
There's never enough.
I've got a possum that's eating my cat food. I have not had to deal with like a small animal messing with my small animals for a while. And the last one did not go well for the small animal. That's all I'm going to say.
God damn it. Don't do that.
Why is it funny to have a possum eating your cat food?
It's like random possum blasts.
Every time I drive up to my house, like this possum sitting out there, like looking at the cat dish, like looking at me, then it skitters off. I'm like, I don't have my gun on me. I also don't want to shoot at my house.
How many total witnesses is called? Like 2?
Yeah, he's 3. He's done 3 witnesses.
Good afternoon, Ms. Aldrich. If you would please make your way
4
to the
technically, because he had the one out of order.
It is up by
That's
me.
right.
It's up
We got 8
Score
more to
1
go.
for marsupials.
Get all the way to the witness stand.
We
Please remain
technically had
standing, raise your
13,
right
but one was
hand,
the
and my
judge and
clerk,
one was the
Teresa,
state of
who's on my left
Wisconsin.
and will be across from you.
So
I gotta
7.
say, if your cats can't take the possum, then they don't deserve to eat.
They can. I just think they don't care. Assholes.
Can't take the possum, stay out of the kitchen.
They
It's
know
well
they know
fed.
that you're going to feed them again anyway. So they're like, let the possum eat. The human will fill the bowl again.
The first thing I will ask you to do is to state. your
Let it be known that
last
Starbucks
name
coffee
for-
and Basil Hayden is actually a nice blend.
There you go.
Deanna Aldrich.
That's what she has for breakfast too. I can tell.
A. Last name is ALDRICH.
Thank you. Go ahead, sir, your witness.
Good afternoon, Miss Aldrich.
Fuck off, Brooks.
Have all these people already testified? Are these all repeat witnesses?
What do you currently do for a living?
I'm retired.
I think she's new, isn't she?
I don't
Yeah.
recognize her.
That's always pretty good.
Squeaky clean, no wrinkles, brand new.
Director
I
of
see plenty of wrinkles.
the evening of November.
Look at that.
21
She
of
wants to kill
2021.
him.
Do you recall that evening pretty good?
Yes.
Where were you staying at the time?
I live on Maple Avenue.
And during that evening, did you hear anything unusual?
I did.
And do you recall what that was?
I heard a large thumping noise in my neighbor's yard. And when I came out to my porch, I saw a red SUV.
Chumbawamba tub thumping.
Back up a little bit to the thumping noise.
She's just tub thumping us.
Can you describe that thumping noise? Would it just be?
Did you get knocked down
Did
and
it
get
sound
up
like
again?
a crash or anything of that nature?
I believe it was like the engine dropping kind of noise.
Okay. And you stated you looked out your patio and saw a red SUV.
I did.
Do you recall how that SUV looked at that time?
It was smashed to smithereens.
God.
Seems like this is gonna go well for him.
Oh yeah.
All the witnesses
That
are
in
just
line with the
great.
rest of his witnesses.
The SUV was still running at the time that you observed it,
Yes.
and at some point did it cut off?
Yes.
And what did you see from that point?
Before I seen it shut off, I seen it go forward in the driveway and then back up like 3 feet. And then someone got out of the car and ran around the bushes to the front of my building.
And who's the someone that you are referring to?
At that time, I didn't have my glasses on, so I could not see clearly.
What do you recall?
As far as
Description
what?
wise, yeah.
Dark hair, possibly white or purple or whatever color shirt, and dark pants.
Do you recall a height?
I think he was probably anywhere between 5'6" and 6 foot. I really couldn't tell because of the angle.
So I'm assuming then your patio is kind of on a upward base type of angle that you would have kind of been looking
I was
sort of
looking
down.
down, yes.
Okay. And the individual you stated ran in what direction at the time that you were observing?
My porch is here, and he ran from the driveway here around to the front of my building.
Did you see where the individual went from that point, or could you not see because of where you were positioned on the patio?
He stopped to, if you were looking at the building, he stopped to the right of the building front.
And the building front, is that a street?
Yes. Not all the way to the street, though.
Okay.
He was in the front yard on the grass.
Did you at any time observe this individual jump over the hood?
I was running in and out of my house, so I did not see because I was trying to find my glasses as I was running in and out.
So is it fair to say you were trying to locate your glasses so you can get a better look at what you were observing?
Yes.
Do you recall if the SUV had any tinted windows?
I do not recall.
Do you recall what time of the evening you heard the loud thumping and then observed the SUV?
I do not recall.
And before that evening, had you ever noticed that SUV before that evening?
No.
How could you even be sure then that that SUV was different
Did you
than
speak
prior
with any
to
of your
that?
neighbors to inquire who the SUV?
Ooh, Jedi mind trick.
No, there was people coming outside from the building that the driveway was, and they were gonna walk up to the vehicle, but they did not because I yelled to them and said, "Don't touch it."
So that kind of would be fair to say that kind of startled them and stopped them in their tracks.
Yeah.
Do you recall how many people there were?
Maybe 10.
Guys, we have 22,000 people
Wow.
watching on Rumble. Hit the damn plus button, hit the thumbs up, make sure you like it. Let's show this fucking platform like what can happen.
And at some point, did law enforcement come
when a
to
beautiful
your,
audience of
to your
degenerates
home
gets a
and
hold of
interview
it.
you about what you observed that evening?
Yes.
And do you know if they
assuming they took a report. Would that be fair to say?
They came up to my apartment and asked me some questions.
Do you recall if they were writing it down or recording it?
Writing it down.
How upset do you reckon she is with herself for not having her glasses with her at the time?
If he did to my cousin Vinny, how many fingers am I holding up? Like
If you
I would
recall,
die.
Did you ever
laughing.
learn what the loud
Mhm.
noises were that you heard before seeing the SUV?
No.
And the street that you observed the individual running toward, do you recall what street that would have been based on the direction?
Arlington Avenue would be right directly in front of that building.
Damn it. I'll be right back.
You didn't see the individual run towards Maple Street?
He ran towards Maple Street and came around the bushes directly to the right of my patio, being up high.
But that general direction would have been, what street did you say?
Arlington.
Arlington. I apologize.
This is exciting.
Were you aware that there was a parade going on that evening?
Yes.
Did you attend?
What?
After you spoke with the law enforcement officers that evening, did any more law enforcement officers come back and interview you at any time after that evening?
They did not interview me that evening. They came early the next day on the 22nd.
Oh, I'm sorry. After the 22nd, did any other law enforcement come back out to interview?
No.
Boy, she wants to come over that podium.
Yeah.
A lot of us feel that way.
Mm-hmm.
Do you recall the name
Is
of
that
the
your Sling Blade impression?
No.
Mm-hmm.
Deep breath, honey. Deep breath. In through the nose, out through the mouth.
Poor thing.
That's my girl.
Good.
No further questions. Hey, baby.
Jesus Christ.
Wow. No
All
cross.
that for that.
Great. The end is foreseeable.
Defense may call its next witness.
God bless the state for not doing cross.
Yeah, they. That's.
Anything to speed this up at this point.
Thank you.
Yeah.
Exactly.
Plus, you've proved your case. Like,
What did I miss?
he finished his witness just now.
Yeah, he just said no questions.
After
Wait.
staring at his notes for about 4.5 minutes.
Yes,
The lady he was just doing?
yeah. Now
Okay.
he's gonna coming up with what was next witnesses.
Bertram.
All right, thank you.
She was a neighbor, saw the crushed car, heard it come in. That's it.
That probably helped, I guess.
Mr.
Did really well for him.
Assisting. Thank you.
Your Honor, my assistant.
I didn't want to assume.
I guess he was eliciting that she couldn't identify the driver. Was that the point of that?
It would
Yeah,
seem
he's going through all the police reports, and anybody who's like, I saw somebody, but I can't recognize. Reasonable
Yeah.
doubt.
Yeah.
Yeah, that's what he's thinking. I think.
Yeah.
The witness stand.
No.
Off to my right, it is up one riser. When you get there, please remain standing. Raise your right hand. And my clerk, Teresa, who's on my left and across from you, will swear you in.
Do you solemnly swear that the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Thank you. Have a seat, please.
Jury will take as long as it takes to fill out the forms.
First thing I will ask you to
That's my
Yeah,
do is
prediction.
state your first
I think
and
it'll be
last names
pretty
for the
quick,
record.
in all honesty.
Mm-hmm.
And my last name is
Well, this guy looks very sharp, a little preppy, but I like it.
A little preppy.
Well, he's not wearing an Argyle sweater.
No Izod, but close enough.
You will not have to lean in. Go ahead, sir, your witness.
He just.
Oh, I'm sorry.
Wow.
Go ahead, your witness.
He just needs a members only jacket and some parachute pants.
First of all, good afternoon. What do you currently do for a living?
I do electrical work.
No, you don't.
What he means by that is he puts gator clamps attached to a car battery on people's nipples.
All right,
Directly your attention
okay.
to,
Yeah, then he does do electric work.
November
Sorry.
21st, 2021. Do you recall that evening pretty well?
Not very.
Do you recall what you were doing that evening?
Yes.
And what were you doing that evening?
Taking my
Masturbating furiously.
to our mechanic friend.
Were you aware of a parade going on that evening?
No.
Around what time were you taking your mom's car to be inspected?
I don't recall.
Do you recall seeing anything that
I'm
caught your
fixing the
attention
court
that
volume. Just a
Yes.
second. StreamYard
you
keeps
say what that
adjusting shit in the
was?
background.
A smashed up red car.
evening? And do you recall where you saw that at?
I believe it is Prospect Court Street.
And at the time you observed this smashed up car, as you say, did you Did you see anyone driving it?
Yes.
And were you able to make a description? Sorry, description of who was driving it?
I believe so.
And what do you recall?
I don't recall what I said.
You don't recall what you said or saw?
I don't recall what I exactly said when I gave my statement.
Do you recall what you saw?
No.
Good
In
job, witness.
reference to giving the statement, I'm assuming that would be to law enforcement. Is that fair to say?
Yes.
And did they write down? Well, let me back up. How was that interview conducted? Was that an in-person interview over the phone or?
In person.
And do you recall if the law enforcement officer was writing down what you were telling them or recording?
I don't recall.
Oh, this is a great witness for him.
Yeah.
He's trying to impeach them with the police reports, which is not their sworn testimony.
Yeah.
No.
He doesn't remember. He doesn't remember. So, you know.
You can refresh him if you'd like.
But you can't
Yeah.
refresh
You
him
know
with
how
a
to do
police,
that.
but not with a police report.
Yeah,
If
you
he
can
did-
refresh him
not?
with anything.
Well, I
Yeah,
mean,
you can
You can
refresh him with
refresh
anything.
recollection, sure.
with a
Yeah.
police report,
Did
it
you
has to be
observe the
sworn
vehicle
testimony.
stop at any point in time?
No.
If it would help him remember what he said, yeah.
But you just saw it just kind of just rolling past.
Yes.
Did you notice if the vehicle had any tints?
Any what?
Tints,
Tits.
like tinted windows?
Tug's tint.
Do you recall in your interview with law enforcement? Well, let me back up a little bit. Was it
If you would have backed up, you wouldn't have hit
was
all
your
those
interview
people.
with law enforcement the same evening that you saw this vehicle or sometime after?
The same evening.
Do you recall stating during the interview that evening that you observed the driver as a black male with short hair and a short beard?
I don't recall exactly what I said.
Smart. He's good.
Do you recall
Is he
stating
good
that
enough?
during that interview that evening that you believe you saw the operator of the vehicle reach down and grab something as they were driving past?
Yes.
Did you ever see them? Did you ever see what you believe was being grabbed?
No.
And what did you think at that moment that you saw the operator of this vehicle reach down?
I was unsure.
The state's done a good job of telling these witnesses how to deal with this guy. Be direct, answer correctly, don't go beyond, don't
Do
engage.
you recall in your interview with law enforcement that evening stating that you thought it was possibly a gun?
Yes.
And where did you observe the vehicle go after it had passed you?
I turned away after it passed me.
Do you recall what the operator of the vehicle was wearing at the time that it passed you?
I do not remember.
Do you recall during your interview with law enforcement that evening stating that you thought the operator was wearing a black sweater or jacket as it drove past you?
If that is what is written.
Do you recall saying that?
No.
Don't do that. You don't recall.
And do you recall where your interview with law enforcement that evening took place?
Yes.
And where did it take place?
My house.
Short, sharp, to the point. He's doing well.
And was anyone present with you during your interview with law enforcement that evening?
Yes.
And who was that?
My mother.
Short. To the point.
And do you recall what agency your interview was conducted by?
Yes.
And would you state for the jury in the record?
The FBI.
Do you recall stating in your interview that evening with law enforcement that you heard a lot of gunshots?
Yes.
And do you recall I think that's a little bit unfair to say. If you had to estimate where do you think those gunshots were coming from, like vicinity wise?
It sounded from downtown.
And when you say a lot of shots, what would you describe as a lot of shots?
Like a full magazine.
William Mitchell School of Law and Crime says, I will give you 11 more chances to answer my question, Mr. Brooks. Do you love black people? Speaking of which, someone asked about his social media posts. I'm guessing those were taken care of by his public defense counsel and restricted on a motion in limine. He apparently has a very race-heavy social media.
The vehicle that you observed crash
that would not
into
get brought
anything?
up unless it was
No.
door was very clearly opened for that, and I don't think it has been.
There's been very little racial stuff in this trial, which is good, I think, but it's been kept out. Yeah, gunshots echo.
Do you recall stating in your interview with law enforcement that evening that the vehicle appeared to slow down while traveling down Prospect Court?
Yes.
At some time after observing this vehicle, did you call 911?
Yes.
Do you recall around what time you called 911?
No.
Do you recall shortly after seeing this vehicle texting anyone?
Yes.
Do you recall who that was?
My girlfriend.
And what did you tell her?
I don't remember.
Do you recall telling her there's a shooting?
Possibly.
Did you see anyone else in the vehicle?
No.
But you do recall seeing the operator wearing a black sweater.
I don't remember.
Did you observe at any time that evening seeing someone run from the vehicle?
No.
Do you recall why you would have gave a description that evening when initially interviewed by law enforcement?
Because I saw the person in the car.
And how did that person look?
I don't remember.
Grounds.
Grounds.
This answer may stand.
What was the answer?
He said, I don't recall, or I don't remember.
I wonder
No
what
further
was the
questions at this
objection.
time.
Thank you.
Asked and answered.
Thank you, sir.
Which it was, but
You are
But
excused.
yeah, let's slide.
boy, that was powerful testimony.
Is Jeff okay? I don't know.
I don't know. I think we killed him.
Is Jeff
He didn't make the
asleep?
5 minutes.
Your next witness?
I think so, yeah.
Lucky bastard.
When you get to the next break,
Here,
I
I'll
have,
I'll pull him out of the stream.
something to
If I see him
discuss
perk up,
outside
I'll bring him back.
of the jury. That pleases the court.
Do you want to after your next
We
witness?
can.
All right. I'll address a legal issue, and we'll bring the jury back in when we're ready. I'll rise for the jury, please.
If it please the court. Well,
This is the makeup session. After the bad fight they had, they got to make up now.
this is love bombing time.
We would feel terrible if Jeff was actually dead. A little bit bad for it. Feel bad for the dogs. Just kidding.
Given he's been meaning to get his affairs in order, I'll be a little bit concerned that he hasn't done it yet.
Go ahead, Mr. Burke.
Josh 316 says, "All hail the nose." Hey,
I'm
thank you.
curious. Some of these, judging by the reports, how are some of these answers allowed to pass when they're coming straight from reports made by the people on the stand? Very curious.
I don't understand your question. I'm not sure what you're asking me.
What I'm asking is,
Yes, what are you asking?
reading from the report that the people on the stand are giving, the report that they gave to law enforcement.
If you're asking me whether there's a mechanism in the rules of evidence and how to establish that before the jury, the answer to that is yes. If you're asking me how you do that, I'm not going to answer that.
I didn't ask how. I just to be blunt, which I've been since the beginning of this trial, obviously.
Bullshit.
I see the whole strategy here by the prosecution.
Oh,
you?
he's
I see right
so
through.
smart.
You see right through this whole
Don't have
presenting the evidence and
Yes.
Mainly because you've already
I look at the bones
School.
under the skin.
schooled the people getting on the stand on how to answer certain things.
Well,
Oh, there
that
you
is
go.
They're supposed to.
relative on your part without any
Obvious.
basis in law or
It's
fact.
obvious.
Sir, you could ask questions that establish that. You can ask them if they've met with anyone. You haven't done that. So for you to say that right now is without basis. If you want to,
It's clear.
if you are looking to elicit what they said in the report, there is a way under the rules of evidence based upon the way the witnesses have answered to clarify that. But that requires you to call certain witnesses. I'm not going to give you any more legal advice further than that.
I don't think I have to
So
call any other witnesses that's
if
not
you're
on the
asking me to
stand.
strike their testimony based on your
I didn't say
perceived, then
anything
that's,
about that.
all right, then I'm going to bring the jury back out and you're going to call your next witness. So I'm
So
not
is you-
hearing a request from you at this time. You said you wanted to raise a legal issue. What's the legal issue?
The legal issue is how is the state allowed to coach the
You're
people getting
assuming they
understanding?
spoke to them and coached them.
It's obvious. I'm not stupid.
Well,
not
I disagree
obvious.
with that, sir. Again, you could ask
All of a
questions to
sudden-
lay a
All of
foundation
a sudden, the
with
state
these
don't got.
witnesses.
All of a sudden, for the first time in trial, all of a sudden now they don't got no cross. That's clearly a rush to try to get through the case. Hurry up. We just gonna let these people
They,
go.
You're not
This is
required to.
argument.
Oh, man,
You
that's-
should like
This is
that they're not
argument on your
crossing.
part. It is pure
I
commentary
just
at
want
this
that on the
point.
record. I see.
And I'm pretty sure that you're right,
You are
though. The
seeing
state does
through
want to get
this.
through this.
Has
Yeah.
absolutely no basis.
Pretty sure they're like,
I know
we're
that's
good.
what's being done.
You could
Come on, man.
ask
I'm-
these questions. You could
Come on,
ask
man.
these
Got the right
witnesses
one.
certain questions, and you're
far,
not.
far from the idiot.
They're your witnesses, sir. If you believe
The record will stand on your idiocy, sir.
That they seem just to mysteriously now not have any cross for. Have they been coached to answer the way they answer? Because
well, you can't
I
ask
find-
that, but
I
you can
find it
ask them
very
if they've
funny.
met with anyone ahead of
I
their
find it
testimony
very
here
funny.
today,
I find
which
it
you've
very
done
funny.
with
Why
other.
is she coaching
I find
him?
it very
Yeah,
funny
I
that
know.
these are their
This is
reports,
not.
and now all of a sudden you can. Oh, I saw the person.
It doesn't matter. He's not hearing her,
but,
so it's fine.
I saw
It's
them
an
reach for
attempt by
something.
you
Oh,
to
I don't.
delay these
I don't recall what
proceedings.
they had on.
Mr. Brooks,
You can
there's
recall
no
seeing
purpose
somebody
for you
reach for
saying this
something
right
and
now.
don't know what they had on. I find that
All right,
very.
I'm having the jury brought
man.
out. I'm instructing you to
Come on,
avoid
man.
the commentary when the jury comes out, or you will
I didn't
forfeit
say-
your right to be
I didn't say
present.
nothing. You.
There's an issue that we do need to take up potential as to a witness by the name of Abel Lescano. He has prior criminal history.
Thank you.
So as long as the jury's out, we should probably discuss that. I would like to provide the defendant and the court with a copy.
So that had
of
to be said. So it's the defendant.
What?
She didn't like their tone of
That
voice.
was how I said. You want to run the record back?
Mr. Brooks,
So I'm the only one. I got one. I
Mr.
got one
Brooks.
ear that work, and I heard that.
this
Come on,
is to benefit
Come
on,
you
man.
so
No,
that
it's
you
not.
understand
Ain't none of this
your
to benefit me,
witness
so let's be
has a
clear about
prior
that.
record.
Your Honor, when I leave the table, I'm away from the courtroom and I have to elevate my voice. This is the
So she had to
alleged
elevate her
record of
voice
Abel
just for
Lescano.
that.
Stop talking.
Come on, man. Like, I don't know who y'all be thinking y'all fooling. I'll accept value in return for value.
Can we bring out the ball gag yet?
One more interruption and you're going to be removed to the next court.
No, don't threaten. Do. Oh my
Not what I
goodness.
want to do. Do not interrupt Attorney Opera.
Hey, Jeff, how's it
So
going?
Your Honor, I
Hi.
believe he has 7 prior
I'd kicked you
criminal
off for a bit.
convictions.
You were
Oh, did
sleeping.
you?
OWI
That was the nap.
1997, and OWI 3rd from 1997, and OWI 4th.
Yeah, I was going to check out like
2003,
a half hour ago.
criminal trespass to dwelling.
Anytime you need to go, buddy.
2006.
All right, I need
I'm
to-
going to do that right now.
Right now is
All right,
having
peace,
a
man.
stare
Catch you
down.
later.
Everybody have a good day and put up with this nonsense.
Pounded his fist, frankly,
Have a great time.
Look at
guys.
that mean mug he's doing.
and we're taking a break.
Look at that mean
All right,
mug.
take a
Taste
break.
the
Just
shit
let,
out of
let
him.
the state get through the record. Just let him
What
stare you
up?
down. At least he's not interrupting. Just ignore him.
Mm.
Yeah,
Yeah,
well,
the
and I
judge-
don't. Basically, a police report you cannot cross. You could refresh recollection, but if the
Yep.
person says this does not refresh recollection, you cannot impeach them with a police report. You could
That's
call.
correct.
You could call the police officer to impeach the witness to say they told me X, Y, and Z. Right,
Correct.
but you can't. But that's what the purpose of depositions are. So what you do is you depo all these witnesses, then you have sworn testimony, and you know what they're going to say. And when they get up there and they say, "I don't remember, I don't forget," then you impeach with the deposition. The statements
Right.
that they gave to law enforcement are not a deposition, not sworn testimony, unless they wrote out an actual thing and signed it. So, so this guy, he thinks that what's in the police report that the police took down what the guy said is somehow impeachable against this guy on the witness stand, and that's not the way it works. He is so over his head on law, and that's all needs to be said there.
You're absolutely correct about the difference between like in impeachment and refreshing recollection. Like you can refresh someone's recollection with anything. If a pizza box will help, you know, you can use a pizza box. But if you want to impeach them, that's a different can of worms.
Well, the problem here is that I don't remember is not really impeachable. It's the lack of recollection is not a prior inconsistent statement. You know,
Right.
It doesn't necessarily open the door to confront him with that prior statement. You can
That
ask him
too.
to adopt it. You could ask him to adopt it, and then you could elicit it from the law enforcement officer on the stand. You know, just get him to say, yes, when I made it, the state, whatever I said at the time was what I believed to be true and accurate at that time. Then go ahead, but you don't remember what it was. Would it refresh your recollection to see what the cop said it was? You can try that. If he doesn't, then you can just get it in from the cop.
Well, Andre, what do you think if he asks these witnesses on the stand, have you spoken to the state attorney's office?
Mhm.
And what did they tell you? What's he going to say? What are they going to say?
Good question. I mean, they seem to have been prepared. Yes. That's not inherently, problematic. But whether they've been prepared for that particular question, who knows?
We have there's a jury instruction in Florida that says that, and in fact, usually when that happens and that kind of question happens, the judge will then read the thing that it is not to be held against a party. Both lawyers can talk to the witnesses, and some usually the advice from the state attorney's office, and when we would talk to witnesses beforehand, answer truthfully, directly, and don't go outside the bounds of the question if there's interruption. So
Yes.
it's kind of a loaded question. So he says, "Have you talked to the state attorney's office?" You say, "Yes." Well, what did they tell you? They told me to tell the truth.
Yeah.
Right? That doesn't really help him.
Right.
Yeah. No, it's very true. It's very true. And the advice I'm sure that these witnesses have been given, like you've said, it's listen carefully to the question, answer only what you have been asked. We may have practiced this, I would do that with witnesses a lot. Just give you an example. If I ask you, did you have breakfast this morning? The answer is not, yes, I had pancakes. The answer is yes. And you just work through that, until they get it and move on.
Yeah. Just answer what's asked. You got it.
That
Right
is
on the
the
money.
Best advice that witnesses just will not follow. Just
Try
shut up and-
defendants. Have you ever tried telling a defendant that?
Oh, yeah, right.
Well, defendants are worse because they there's the psychological issue of if I just tell my story, especially if they believe they're innocent or justified. If I just tell my story, then everybody will get it. And they want it. That's why they talk to cops all the time. That's why they talk on the stand when they really shouldn't. It's like, no, we don't care about your story. We just care about you not being in prison forever.
And it's the clients that go, I just want my day in court. They're just the one, the ones that will just continually run their mouths and put their foots in it and cause you the most amount of trouble, honestly.
Yep. Okay, here we go. Surveyor 8587 says nobody is going to call this out. Darrell Brooks, I'm not stupid. Judge, I disagree with that, sir.
Yeah, I noticed that.
think
I
that's
noticed that. Unfortunate timing. That's not going to look good in the transcript.
There's his appeal. He just won.
Yeah.
Hagen says, Judge coffee cup text. Life is short. You kind of shouldn't be here. Okay, so that would be on the coffee cup. Life is short. You kind of shouldn't be here. Maybe. I don't know if I'm
No.
following it. I'm not following it personally.
Yeah, I'm not get. Yeah.
Let's see. God. How many more witnesses does he have? He's through 5 now.
Something like that.
These witnesses are useless.
But one of them stayed at the state of Wisconsin. So
Yeah, well, and one was the judge. God, I wish the judge would take the stand.
oh, no, it's not going to happen.
Isn't it true, Your Honor, that you did not prove jurisdiction on the record? Apocalypse Dan says, Rackets, is she provoking a possible appeal simply by her failure to control him and ensure a fair and speedy trial? No, the speedy trial requirement is not. It would be that the court and the state were causing undue delay, and typically it's a delay in starting the trial. Realistically, this trial has the potential to be even longer than it is. If he were mounting a competent defense, it very possibly could have been twice as long because the potential witness list for this thing is very, very big. And if the defense had really had time to, or if a competent defense team had wanted to, they could pull in a whole lot of witnesses. They could have hired experts to try and counteract the expert for the vehicle. and the brake lights and say, no, actually he was hitting the brake the entire time. This type of vehicle has a brake failure rate of whatever. After hitting the first people, it could have messed with the anti-lock brake unit. I mean, any number of things that they could try and get through. The only blessing is that since he's running his defense and has no idea what he's doing, that there just won't be that much fun.
Yeah, here's the Florida jury instruction on weighing the evidence 3.9. It says, it is entirely proper for a lawyer to talk to a witness about what testimony the witness would give if called to the courtroom. The witness should not be discredited by talking to a lawyer about his testimony. So whenever you get that kind of questioning, the judge will pull that instruction out. And then usually and then if it's a real court case and not this case, you might be asking like, well, what did they tell you? And then they come up with what they're going to say. And then the state would come back and say, well, did we ever tell you what to say? And the answer is no. So and then they sit down. So it's usually not an issue. It is something you could get into about coaching witnesses, but this case is not a good one to use as an example for really anything.
I was going to say, how would that instruction work if, say, the state actually did tell the witness what to say? Does that instruction not get given? Does the instruction, I mean, is there...
Well, it says, if you look at it, it says it's proper for them to talk to about what the testimony they give. So it's specific. So if we were asking, what are you going to testify to? And that, so again, that's why the instruction to the witness from the state position is tell the truth and answer directly, because that is, you're not coaching the witness, you're telling them to tell the truth. If you said, for example, they told me to say it was not the black shirt, that I misremembered that it was a red shirt, then that would be damn well impeachable, right? So that would be something that you could use that statement as a credibility problem, the state's coaching. Most state attorneys are not going to do that.
Sure.
The biggest problem that most times that comes up is in sex offenses, where you have child witnesses, and the child witnesses get coached by the state attorney's office. So that's, and nobody likes representing sex offenders, and they're all guilty and they're all evil, but that's where it really becomes a problem.
And it is a problem because if they are all guilty and all evil, then you do not want any sort of potential for impropriety from the state.
Right. Well, they shouldn't, but that is where it's the most tempting for the state, and they most often violate that. I don't know. What do you think? Andre is a public defender. You've dealt with those sex cases. What do you think?
I see that kind of interference more often from mom than from the state, in my experience. But who's neither here nor there?
So
yeah,
so
actually, go ahead.
I was just going to say, so an interesting and kind of like a different angle on this that I've covered was Nate DeBruin from the Kyle Rittenhouse, the guy colloquially and lovingly known as Photo Chad. When he came out with his statements about how the prosecutors, I think Krause in particular, had effectively brought him in, shown him video, gotten an answer from his statement, then shown him video, told him who was on the video, and asked him if he wanted to change the statement that he had made prior to seeing the video. That was a really, really kind of interesting thing. In the Rittenhouse case, it wasn't so important. The problem I had with it is, to me, it was like, this is potentially jeopardizing the Zeminski case, because that's who they were actually asking about. It just happened to come out during the Rittenhouse testimony. What do you guys think about that? Did you see that at all?
Well, what happens, another potential witness memory interference thing happens when police do photo lineups, because they'll say, this is a big problem. They'll say, do you recognize anybody on this sheet? Right. Or they'll show them a picture of the defendant in isolation, and then they'll show the lineup, and then they remember the sheet that they were shown, and then they pick that out of the lineup, putting those things together based on the way the memory works. So there's been a lot of work in Florida and around the country about being very disciplined about photo lineup pickups and how they should be done and how it should not be done. And it's an evolving thing, but a lot of times that's a problem. But these are not problems in this case. So we're just talking theoretically.
Yeah, we just had a case come out of the Washington Supreme Court earlier this year that was dealing with exactly that, the foundational requirements for the state to be able to present line up evidence basically. And it's this kind of common grievance that, I've had my entire career, because the bar to, introduce quote unquote scientific evidence in the courts is so low. And we've known about these problems, for years, if not decades, and little is done to make that a more credible process, to have some more integrity with it.
Are you a
So-
Dalbert state?
No, we're a Fry state.
Florida
We're a Fry
just
state.
moved to Dalbert. Fry is
So
a
whatever
little bit,
more than one expert will agree to say is scientific, you get to use it in Washington. We have
Nice.
some ability to argue under the evidentiary rules that pseudoscientific stuff is not going to be helpful to the jury. But you still have
Washington,
your
I thought they
burden of
lived off that.
establishing that it's pseudoscientific, when the state will just say, my expert says everyone agrees with him.
Yep.
Okay, the Dragon's Treasure. I didn't know how to follow that, so I'm gonna go because it's. I mean, the Dragon's Treasure says, "I can only rumble rant how awesome my teas are so often, so I'm gonna ask the chat to do it for me. Please rumble rant your favorite teas of mine. Let everyone else know. Grift for me. I expect no trolling." Siege says, "Could standby counsel get him to play the white bitches scene from He Got Game for the jury?" He doesn't have standby counsel. Just Gen T, always about the horn honking. It's not my fault they didn't move out of the way. Loose Cut
Good
says
song.
my favorite Dragon's Treasure teas come in wrinkled, hairy, thick sack. After I'm done teabagging my teapot, I put the hot, wet sack in my mouth and suck off the delicious dragon teabag juices. Disgusting. Danconia Copper, nice. You missed the testimony from the beta who let him in the back door, made him a sandwich, told him he loved him, and then gave him the jacket and let him use his phone. Literal movie stereotype. That's a weird artifact of this. Like, some guy shows up to your house. Here, have a phone. Here's a sandwich you can put in your pocket. Pest Base says,
I mean, isn't that like just in some level like the best of us? I mean, so compassionate and nice. I mean,
Yeah, but that's
I'm
how you
a
want
hater.
dead.
but he put the sandwich in his pocket, Kurt.
Yeah.
Pest Base says, "I love the closed captions. Scream Park. I mean, it certainly fits this case, doesn't it?" Let's see. Here we got Napplejacks says, "Not to mention that something like 70% of all prisoners have known personality disorders, antisocial being the most common." But yeah, yes, but here's the thing: there's two sides to this coin. One of the sides to the coin is it's a personality disorder, which necessarily means a difficulty in dealing with social mores, right? Like, so if we have law and rules and you have a personality disorder, it is likely that you will have some higher degree of difficulty conforming with those rules. So the likelihood of you becoming incarcerated is higher than for someone without a personality disorder. And the overwhelming majority of people follow the rules relatively well. I mean, for however much crime we do have in the United States, it's as a percentage of the population pretty low. And so when you think about it that way, I know there's a big push about, is it just to put people with personality disorders or some, like, what level of insanity is required to be or should not be incarcerated. But at the same time, like, that's kind of the system we built. If you don't follow the rules, and this makes you less likely or less able to follow the rules, then you're more likely to end up on the other side of them.
Well, have you seen have you heard Jordan Peterson talk about this and about disagreeableness is one of the big 5 personality traits, in that there's a bell curve, and men and women are different by about a 10% disagreement. So men tend to be more disagreeable than women. So, but what that affects is at the end, the tail end, the most disagreeable people are men, all men. That's why we have such a high overpopulation of men overrepresented in the prison system, because disagreeable people tend to get into the law enforcement problems, and I'm aware of this because I'm in the top 1% of disagreeable people.
I was too, according to my studies. So I worked out okay. Yeah.
Yeah. So, but I mean, some of us become defense lawyers, and I think it's a good asset when I'm trying to tell the judge that they're wrong and standing up and everybody hates me, but I've got to represent my client. sometimes it helps not to be affected by the being disagreeable and not being worried about the social pressures. If you're a defense attorney and you're worried about what everybody's thinking about you, you're not representing your client. So I find it to be helpful in a defense role.
Let's see. America Floats. I can't imagine how bad that room must smell after a day of him being in there speaking aloud. Okay. Manders 13, Your Holiness, do you still have Closer playing in your head? Excellent brain choice, sir. No, that was yesterday. That's always interesting when you get that song stuck in your head. Jimmy J009 says Rekieta is being a bitch. Wait, when? I mean, besides always. Oh shit. Bronca wants on. I'll send him an invite right now. Thank you, locals chat.
We'll tag out Andrew, buddy.
Here we go. Let's see if he's able to come in. Pest Base says, how badly do you think this judge cannot wait until he's found guilty and she can sentence him?
She's got a fantasy in her mind at this point.
I'm worried that she's
She's going to give him a middle of the range sentence so that it's basically unimpeachable.
Oh no.
But unless if he gets convicted on intentional murder, though, the middle of the range sentence, the only sentence is life without possibility of parole.
Mm-hmm.
Yeah.
I already sent Bronca the thing, guys. We're just waiting on him. Sorry. Go ahead. What were you saying, Andrea?
Oh, I just said, well, that makes it incredibly easy for her.
Yeah.
You can pick from your one option.
That's what's so frustrating about his lack of counsel is that there is one aspect that really should be, that should be everything they're hammering on is just
intent.
That intent. Has the state proven it? Right. He's
100%.
And he kind of has alluded to it lightly, but it's not been effectively done for sure. XSSFDIT says, since I'm getting here on day 12, how has he been doing? Pro se, just terrific.
Oh yes, hitting it out of the ballpark, just amazing.
Just amazing.
See, Mick 3B says, hey Pope, are you related to the court reporter that nose takes up half the screen? No, I have no known relations that are court reporters and no known relations in the state of Wisconsin on my genetic side of the family. So no. Kakalo Tuzaru says, hey, and Nick, I'll be supporting you here on Rumble from now on. Hey, awesome. Thank you. He also says, what are the odds that the judge secretly gets hot under the collar when Brooks is combative and that's why she lets him behave that way? Panel? I think it's funnier in theory than it is in practice. That's what I'll say. I think she's very flustered by him, but not sexually flustered by him. I think she's just not used to dealing with someone with such a domineering personality.
Can I just jump in quickly?
My impression.
Sorry, just so Henry's aware, I played Little League. I know baseball. Okay.
Right. Andrew, what were you saying?
Sorry. I was just saying that the thing that is standing out to me about this, my impression is I feel like she's very frustrated with herself and her inability to control the situation. That's kind of part of what's feeding I don't want to call them meltdowns that she's having. It's not that she's melting down, but she's just, keep saying she's being excessively defensive.
Yeah, and overly explanatory when she gets defensive. She should just shut it down, make a very brief record if she needs to, and then if she's going to remove him, I really think she needs to stop leaving the bench when he's being removed from the courtroom or when anything's happening. She just, because it looks like she's running away, and I think he sees that, and he seems to be someone who's an abuser who has a history of beating his girlfriend. Is probably going to see someone running away as an invitation to pursue. And that's, he can't pursue her physically, but he can certainly pursue the course of action he's on.
Well,
Joel,
let me flip the perspective just slightly on this as well and ask, what types of personality characteristics do you think it requires to become a judge, and particularly, at a young age, at a relatively early stage of your career? And I mean, when I see it, I have to wonder if the part of the problem here is a little bit of just battle over the control dynamics. We have two people who really want to be in control,
Right.
and and so the fact that she is losing it, that's what is triggering her.
Yeah, I think I'd agree with that. It's because yes, if you're going to be a judge, you have to have typically a level of assertion. She was appointed by Scott Walker, but she would then have to go on and win elections after that. So I mean, she's been in office for a while. If she was appointed by Walker, it takes a type of personality to say, I will control this courtroom. I will sit in judgment over people's lives and decisions. So yeah, that could be that's certainly an interesting prospect there.
And it might go into that agreeable dynamic, because she's trying to be agreeable and he's maximum disagreeable. And so her strategy of agreeing and being soft is not affecting his eyeball on the goal. So, and that's what that whole sovereign citizen thing is a way to pick apart somebody and push people around who may have some bit of agreeableness. So, I mean, that might be part of the thing that's played here, this personality conflict, and he's winning because she doesn't know how to deal with this maximally disagreeable person.
Yeah.
Let's see.
Where's Andrew?
He's coming. He said 5 minutes. Joel Reese says, can Wisconsin please reinstate the death penalty? Shank Uger's Sweaty Gun says, is it possible that I'm rooting for him to give them the hardest time possible because fuck the state, while just coming short of winning because fuck him too? No, that's fine. Viola Pride 14, betting he gets tasered when the jury comes back with the verdict. That might actually
We can only
be
hope.
a really interesting moment when the jury comes back with the verdict. How he reacts. Whew. That could be great. Just Gen T says,
great.
What was that?
I'm sure it'll go great. Really positive.
He might just finally fold under the defeat, right? Like sometimes that's people's reaction. Other times it's to be extremely combative. We'll see.
He's going to have been wronged in his justice, and he's going to he's going to mouth, and it's going to be all mouth.
Yeah, I think he'll mouth. I don't think he'll come over the table, at anybody, but I think he'll mouth.
Somebody said he was 140 pounds.
130, I think, according to his rap sheet.
Yeah, so he's
something like that. Yeah,
he's probably not a fisticuffs guy. He's a bully by his mouth, and
no,
he'll hit his.
He's a super bantamweight.
Yeah, he'll hit his girlfriend, but when it goes to fisticuffs with the big guy that was for his first witness, he's going to be backing up and getting in his car and running him down. Right? It's a position of weakness. He's weak, and so this is his control.
Just Gen T, she is an example as to why women are weaker so often in these roles. As a woman, I'm yelling at her to have some balls.
Balls.
Damn.
Surveyor 8587, even though his actions theoretically create a bias in the minds of the jury, could the constant removal of the jury by the judge assist in an argument at appeal for creating a bias? No. The judge removing him or removing the jury, even if it has to be done every minute, is only to his benefit.
And a lot of this craziness is happening outside the presence of the jury, this bickering and stuff. So it's not really reflective. It'd be interesting to hear when the jury gets, if any of them speak to the medium and talk about this. It'd be fascinating to hear what the jury perceived. I mean, obviously they're going to hate this guy up and down, but
Bucky Cat 60 says, Drunkita, we want Borowski. Everybody wants Borowski. The man's a fucking champion. Speaking of men who are champions,
the medium and talk
what's up, man?
It'd be fascinating to hear what the jury perceived. I mean, obviously they're going to hate this guy.
Do you have a video playing?
By
Andrew?
bringing the jury out.
Hold on.
Momentarily, Madam Clerk.
Bucky Cat 60
And
says,
how do you call your next witness? I trust that you're ready to do that, sir.
Yeah, right.
Welcome to the circus, Andrew.
You know, he's the
And-
dean.
We need to complete the task.
Now you're
Oh,
muted,
I
Andrew.
knew I would left something in.
Nothing but the highest levels of
I-
professionalism.
What is the state's request then as it relates to the prior record?
We believe the proper answer would be 7 prior convictions, Your Honor. And that would not obviously be counting the OWI first conviction from 1993, which is at the top because it's the age of that. And obviously that would not have been a crime, but everything from OWI second on down, we believe would be appropriate. There's also one that's noted, 06CM2039. It was a case, but all the charges were dismissed and read in, so we're not counting that file either.
Can you go run and get that for me, please? Thank you. Just gonna have that brought back out. I took it with and I left it on my desk. And then remind me the statute again on priors.
90609.
Thank you. And a copy of the record was provided to the defendant.
It was. It has not been discussed with Mr. Lozano.
That was going to be kind of my next topic once.
No, all those questions
I'll
can
look
wait
at
for
this
Saturday, you
again.
thirsty chat.
Oh, the comments don't work in StreamYard, huh? When you're on Rumble?
No, they don't, because StreamYard doesn't actually integrate with Rumble, because
All right,
Rumble and
Mr.
StreamYard are
Brooks,
racist
do you
against
have
each
a
other.
position on the prior convictions for this witness? The state is asking for a determination by this court that there are 7 prior convictions for purposes of questioning the witness, whether that's by you or by them if they so choose.
Judicial
looking for a
determination.
determination under 90609.
Oh, he's got the crazy eyes.
Yeah.
Oh, he was mean mugging the judge when they went into the break, just in there.
The Manson high beams.
I don't know what you're asking.
Mr. Brooks, you may recall at some point, I believe we had a discussion about prior convictions. I think maybe we only discussed that if you were to testify.
We talked about your priors.
No, there was one state's witness that had one prior that we discussed. And the
That's
court
right,
ruled.
we did. I recall now. So at that point, I directed your attention to 90609. And then I made a ruling based upon the factors that are enumerated in that statute. You've been provided with a listing of the record. I would direct your attention to, I'm not sure if I see that book out there,
Did
but
you pull that up, Nick?
Yeah, that's what he was. That's what he looked like.
to you.
The face of 100 disagreeableness.
90609 would be in there. But in any
Looks
event,
like me at every marriage
the
counseling.
state is asking that I make a determination about how many for purposes of the questioning of this witness. Do you have any comment, statement, or position on that?
I'll have to ask.
Looks like it's 9 on here.
Which is the one the state referenced that the charges are listed, but they were dismissed?
2000, well, it's recorded as 06 CM 2039, 2 times violate harassment / restraining order, and then it says DM / RI, which means dismissed and read in, 2X MBJ, which would be 2 times misdemeanor bail jumping, dismissed and read in. So no convictions from that file.
The proper number 7.
So why is it on the sheet?
This would be an accurate listing of the cases that you found when investigating the witness's background.
Yes, Your Honor.
And nothing since 2007.
That's correct.
A long time ago.
Right.
If
Any
especially
statement
for
you want to make,
DWI.
sir, on what the number of convictions this court should consider under 90609?
He doesn't need to agree. The record, they'll put that in, and it's a certified judgment copy. It's a pen pack.
It's read in.
It's like when you get a speeding ticket, you don't have to sign it.
No, it means it was
Still a ticket.
when there was a conviction for something else, the charge was dismissed and read in, and then the court considered it at the time of sentencing. So they are not convictions, but it was a case. So that's why, my understanding why it was listed.
The court survival guide says never agree to anything, express confusion, and ask questions.
Order and the MBJ.
Right, misdemeanor bail jumping. So 2 counts of violate harassment restraining order were dismissed and read in, along with 2 counts of misdemeanor bail jumping dismissed and read in.
Being helpful.
I'm guessing that the state can confirm that it either was read into 06 CM 1859 or 06 CM 3149.
Yes, I believe it was the 1859 case, Your Honor.
So at the time of the conviction for resisting obstructing, there was a misdemeanor bail jumping dismissed and read in, and then the other charges, all of which are listed under 06 CM 2039, dismissed and read in.
So then 8. Should be 8.
The OWI first would not be criminal, as I understand it, and so I believe that's why it's not, the state did not ask it that it be counted.
He's arguing for more than the state.
Because the statute requires conviction of a crime or an adjudication of delinquency.
So there's no crime for OWI.
An OWI first would not be a crime, it would be a forfeiture.
It's like a McDonald's cashier trying to figure out change.
Is that going to be one of those clips that they snip out? What are they called? Bronca Burns?
I still would say 8, just based on the fact that there's continued OWIs. All the way up to a 5th.
So I guess Wisconsin doesn't have this rule where you can't impeach your own witness.
Lapse of time since the conviction, or in this case, convictions, the rehabilitation or pardon of the person convicted, the gravity of the crime, the involvement of dishonesty or false statement in the crime, the frequency of the convictions, and any other relevant factors. So based on that, do you have any argument that
I would say yeah, they're all pretty stale.
Yeah.
Not crimes of violence. They're all
Over
pretty
a
stale.
decade, it's pretty old.
Is 7.
So they should all be excluded. That's what I'd say.
And I think it's also they're presenting it so that if he calls the witness, the state's going to impeach him with the prior felonies.
Yeah, I'd say exclude them all.
And that's not counting OWI first.
Correct.
Maybe
Because
this
it's
is
not a
my
crime, it
read,
can't be
but
counted
I see
under the
he's calling this witness
Should be
to
7.
play this game once again with the police report that,
7.
you know, what you said
Correct.
to the police is not
You wanna make
credible.
any
And
argument
by the way,
about whether
you
any
know,
should be
you're also
excluded
this
under the
generally
statute.
uncredible person. I could
It's
be wrong
not
about
that
that,
correct.
what I saw coming.
Well, you already made reference to one of them not being a crime. So that brings it to 8. I don't understand the whole.
Well, for example, the last conviction was in 2007. It's now 2022. So do you want to make an argument to the court that she's
Giving him this, feeding him.
rehabilitated?
That's what she's done the whole time, though.
Third person pronouns, that kind of trial.
He's a third
I
party
don't want to
intervener.
speculate on
Please stop being
the next
bigoted.
man's life. But if it's 7 on here,
She's giving it to you.
well, I guess
She's giving you the answer. Just say yes.
He can't. He has no agreeableness in him. None. That's what she should be doing strategically, is just feeding him softball after softball so that he can reject it and
2, 3, 4, and 5.
sink his own case.
He's like one of those guys who talks his way out of hooking up.
It's like 7
Yeah.
to me.
All right, then. Anything further from the state on this?
Yeah, we have 3 maximum disagreeable people at least on this panel.
Given the number of convictions, factually, although the first one's not a crime, the OWI first, Mr. Brooks is correct, is from 1993, and without that, you don't get the other criminal OWIs. But I would note the record is the criminal record is from 1997 through 2007. That spans about a 10-year time span. It's now 2022, but there's essentially an agreement by the parties that there are 7 convictions that are listed here. I've looked at the lapse of time since the convictions. I don't know about rehabilitation or pardon, other than it looks like he did complete the earned release program, which would have resulted in a reduction of initial confinement and then converted to extended supervision. I don't see violations of probation listed, meaning that he was revoked. I see some extensions, but that could be for a variety of reasons. But given that there was a pattern with the OWIs, that the last one was a felony, that goes to the gravity of the crime. And the other issues, I'll find that for purposes of his testimony, that this witness has 7 convictions. He may be asked, have you been convicted of a crime? His answer should be yes. And then the follow-up, how many times? The answer will be 7.
That will have to be told to Mr. Lozano before he testifies, Your Honor, I believe.
Right.
Great. State willing to relay that information?
I'd rather not, given the accusations levied by Mr. Brooks. I think it's better we do it in open court.
Very smart call.
Right. Who's your next witness? Will it be Mr. Lozano? Because if it is, I'll just have him come in now and I can put him on the stand and advise him of that.
May I ask who's present right now?
Your mom.
Well, for sure, Mr. Hayes and Mr. Lozano, and I'm not sure the 330 witnesses, I think, are probably on their way.
Oh.
They're on their way.
Right, so Hayes and Lozano are still here.
Yes.
All right. Those are the 2 who are here, sir. I'll tell you what, either way, let's just bring Mr. Lozano in case he's not your first, but then I don't have to deal with the interruption with the jury. You don't have to call him first unless you want to, but I'll just bring him in and advise him. So if someone from victim witness could bring him in, please.
All right, gentlemen. Well, this has been torture, and it's time for me to bounce.
Oh, thanks for stopping in. It's been too
But
long.
I believe it's.
Yes. It has.
Nice to
I
meet
hope
you,
we can do it
Andrea.
again. Yeah,
Well,
nice
I'll
to
be,
meet you too, Stephen.
I'll be hitting you up for shows at some point pretty soon. Now that I've got your contact info again.
Perfect. Sounds awesome.
All right. See you later, Andrea.
See you guys.
Jurisdiction, Your Honor.
Court declines to address that.
Still has yet to be verified and proven for the record.
Your objection's noted for the record.
It's Friday. What are the odds that she goes late?
Oh, I've got to go at about 4:40. So about 40 minutes or so.
Do you want Mr.
Yeah,
Lozano
30
on the
34
stand, or are you
minutes.
going to call Mr. Hayes first? Just so I know what to do when he comes in.
I don't currently have, I can't find paperwork from Mr. Hayes. Can a police report or something be provided in case I want to call
Help
Mr.
me.
Hayes?
Help me.
Could
Yes.
someone please prepare my entire case for me?
Accommodate that request. It'll just take me a minute, Your Honor, to find it.
You know, aside from the lawyers that were appointed for me.
Or Mr. Wichow can run. Thank you, Mr.
I will give
Wichow.
you permission to email it to Teresa and she can print it in the courtroom.
Well,
will assist.
It's part of a 700-page PDF, so I can't just email one page.
I see.
At least I don't know how to do that. Copy and paste it into a Word document.
Just take a picture of your
For
laptop.
God's sakes. If it's Adobe, just print it to PDF as a single current page and then send that.
Mr. Lascano, I'm just going to have you for a moment take a seat. You're not going to testify just yet, but just
It's a courtroom. She's using Windows 3.1.
I want to, everyone can
Tell me I'm wrong, Steve.
No, you're right on the money.
Have a prior record. And so for purposes of testimony, I've made a determination that if asked, have you been convicted of a crime? Your answer should be yes. And then if someone asks the follow-up, how many times? The answer to that is 7. Have you heard me say that?
Yes.
Do you understand that?
Yes.
All right, thank you. I'm not sure that you'll be called next, but I wanted to do that while I didn't have the jury here.
I've had defendants get up there, going through this very procedure. You say 7, yes. And they get up there, and when you say, they go, I don't know, 3.
Yeah, I'm
All
sure.
right, then let's have the jury brought out, please.
It's like how
You're faking.
Yeah, the world is crushing down. He's such a, the world is about him.
Crushing down like a car on your grandmother.
I want him to have a nice self for himself, where he can be, that's actually just perfect. He can have a self just for himself, and he can be a sovereign citizen there, and it makes everyone happy.
He'll be sovereign of his cell.
A little
Sovereign
6x9
himself.
room just for him.
He's going to have a roommate, though.
I don't know about that, because
No, unless he goes into isolation, which he'll probably end up there a lot.
send him to the shoe.
The shoe.
All right.
Well, if he has a cellmate, at least we know his sovereign borders are going to get violated.
Oh, man.
Hey, I'll say Overlord, by the way. Overlord. Nice to meet you.
Yeah, bro,
Does-
good to see you too.
Does being in a cell with him in particular constitute cruel and unusual punishment to me?
Yes.
I mean, there's got to be.
Could you imagine
I would expect so.
how
That's
many
just like-
times you would hear the story of how he didn't get subject matter jurisdiction
Thank you,
on the
everyone.
record
Please
for the
be
rest of
seated.
your life?
Like,
The
I'm
defense
here
may
at
call
one
us next
time.
witness.
I'd hear at one time.
Cute. Not saying you're wrong.
Defense calls, is it Jason Hayes? Jason?
All right. We'll have the witness brought in.
Oh, by the way, guys, everybody follow who's on Twitter. Andrea Burkhart is on Twitter. Her Twitter's great. She is wonderfully insightful. She's funny,
is it
and
Haynes or
she's
Hayes?
got a very thick skin. She does not
no,
like
no, and-
shy away from
Hayes.
jokes and tough
All right.
topics.
Good afternoon, sir.
Yeah, Andrea does great work.
The witness stand, which is on my right. Upper riser. When you get there, please remain standing. Raise your right
And a little
hand.
easier on the eyes than the rest of us.
We'll swear you in.
Speak for yourself there,
The testimony
Brinka.
you're about to give shall be the truth, the whole truth, and nothing but the truth. So help you God.
Thank you, sir. Please have a seat.
Just kidding. She's delightful.
Hey, you got modeled on the Pope. I got modeled on Marlon
Your
Brando.
first and last names
Not
for the
correct.
record and spell each.
Jason, Jason, Hayes, Hays.
Thank you. Go ahead, sir. Your witness.
Just 1 second.
1 sec.
Come on, dude. Little closer to the mic. Pretend it's your boyfriend, okay? Come on.
Oh, he followed you.
Whoa.
He's putting on the Carmex.
I accept for value in return for value this document for the record.
Oh, for God's sake.
I don't know what that
He's
means.
going, what? What's he saying?
Good afternoon, Mr. Hayes. Is that how you pronounce Hayes?
Yep.
What do you do for a living?
I'm a retail sales associate for a food broker, Damon Worldwide.
Been doing that for a long time?
21 years.
That's a long time. It's the second witness he said that to.
Is he cuffed?
The evening of
No, he's got
November
a
21st,
he's got a
2021.
electric ankle shackle that can tase him. But
Are you
that's it.
kidding?
Which
Pretty well.
they've not yet used, unfortunately.
Fairly well, yes.
But he has to stay
what
behind
were
the
you
table, and
doing
so
that
does the
evening?
prosecution, because they don't want to prejudice him by showing the jury's
To the
shackle.
parade.
Oh, so he is shackled. Yeah. Okay.
Did you go to the parade with family, friends?
I went there with my daughter.
Do you recall what time you arrived?
30 minutes before the parade started.
It's amazing that every response is not followed by UMFer.
Were you scheduled to do any marching in the parade itself, or
No.
just spectate?
Dodging vehicles mostly.
Calisthenics.
Just for the record, did you say yes to being a spectator?
Yes,
Thank
that's what
you.
I thought he said.
Yeah.
I just wanted to make sure there was.
He answered. Yes.
She was clarifying what the answer yes was to, because you asked bad questions.
Anything unusual catch your eye that day that you recall?
Yes.
Are you serious?
What a stupid
What did you see?
question.
He looks giddy. That's not a good look for you, Brooks.
Besides the parade,
That was unusual. They caught your eye.
This is very uncomfortable, actually.
where we were,
Yeah.
yes, a red truck.
Was
came
Brooks
through.
better or worse than Elaine Brederhoff?
It honked and swerved.
Oh, hey, honking.
I guess I want to back up a little bit. Where were you positioned at that?
We were all the way at the beginning of the parade.
Okay.
Like it was Main and corner of Main and White Rock.
Okay. And you said you observed this vehicle honked and swerved?
Yes.
What did it swerve from?
I'm sorry.
What did it swerve from?
Where?
Or was it, I guess the correct question would be, why did it swerve?
I don't know. I wasn't driving. I don't know what his intentions were.
Boy, they wouldn't want me on this stand.
In order to kill as many people as possible, that's why it was swerving.
And you stated that the vehicle honked. Was that just a single honk, or was it a beep beep, or
One honk.
One murderous honk.
do you recall stating that it honked several times?
I don't
And
recall.
when you were initially.
I don't recall.
So well, before we get to that, did you see where the vehicle went after it honked and swerved?
Yes, it kept on going straight down Main East, the same route the parade went.
Did you get a description of who was driving the vehicle you saw that day?
I did not.
Did you get a license plate?
I did not.
Do you recall if the vehicle had any tinted windows?
No.
And I'm assuming at some point you either were interviewed by law enforcement or seek to be interviewed by law enforcement.
I did, by a detective.
God.
And do you recall if that was the same evening or?
It was not the same evening.
Like a
So it was
12-hour
A
that
couple
day
days
prior.
after.
Okay. Do you recall in that interview that you had with the detective stating that your kids were playing in the roadway and the operator of the vehicle honked the horn several times and veered to the left around the kids?
Yes.
So in your opinion, it wasn't trying to strike the kids?
Correct, yes.
Hey, there you go. Something on intent.
He was only answering
right.
after Granny's, that's all.
And after it continued, I think you said east.
Yep.
Would that be correct? East.
Yep.
Trying
Did
not
you
to strike the
see,
kids and trying not to strike everybody
the
else
vehicle
who's
strike
different.
anyone?
Yeah, I'm just saying, hey, it's something.
See, he's
Yep.
gone through all the police reports and found anything from any witness that's possibly looks good on him. He's going to say that somehow means he's not guilty.
I mean, it's an idea.
I mean, it's what I would do. What are you going to do?
Do you recall what side of the street the vehicle was traveling on at that
It
time?
was on the right side.
On the right side.
So we were on the north side of the road.
So the right side would be.
Yep.
Okay. Did you see the vehicle stay on the north side of the road for the duration of the time that you observed it?
Yes.
So you never saw it go to the other side of the road, or?
No.
So is he a member of Law Troop now?
Darrell Brooks. Yeah, there's a thinning of the ranks. They have to refill them.
No further questions.
I noticed I stopped getting text messages.
Oh, yes, just briefly. Good afternoon, Mr. Hayes.
Good afternoon.
Thank you for your attendance, sir.
You take it very personally.
Mr. Hayes, do
You
you,
know what?
remember
That was a good witness for
seeing
him.
a police officer at this intersection?
But he did
as
it well. I mean, there's
Don't
not
recall.
much.
Okay. Do you remember writing in your report or telling the police officer that a police officer chased the vehicle on foot?
Objection, leading.
Overruled.
He's allowed to.
May answer.
It's cross.
Can always
I
lead
do
on cross.
remember that I thought I saw a police chasing after the car on foot.
Okay. And do you remember also telling the same officer that the SUV took off down the street and that it accelerated?
Yes.
Objection.
Is that
Hold on, there's been an objection.
Grounds.
I guess the objection to be what officer is being referred to wasn't clear.
Overruled. The statement continue asking the question.
I guess I was asking was that referring to the interview officer?
Your objection is noted. It's overruled. The statement asks the question fully.
Is that your recollection, sir, that the vehicle sped off and accelerated away?
Yes.
Objection speculative.
Overruled.
Do you also recall telling the officer who interviewed you that the driver of the vehicle had a dark complexion and a beard?
Yes.
Is that accurate with your recollection of the driver?
Yes.
But you didn't see a face. You couldn't
No.
identify anybody beyond those descriptions, correct?
Hold on. There's been an objection to leading. It's overruled. The witness may answer.
No.
All right, thank you, sir. Those were all my questions.
Thank you. Any redirect, sir?
Briefly, very briefly.
Ah, you fucking law and crime. Ah, damn it. Come on.
Redirect, sir?
Briefly.
Briefly.
Very briefly.
Better not freeze up again. Damn it.
Oh,
Nick?
I don't know, man. No, it's it happened. Okay. They're having an issue.
no kidding.
Their chats.
The defense may call its next witness, please.
Okay, their chat's having the same thing.
We missed the poignant question though.
Quick question before I do. Who's supposed to be arriving at 3:30? Just so I know.
I'm not sure.
Idiots and Urel will be here at 3:30. Mr. Liscano is here now, Your Honor.
Thank you.
I knew who was here now. Just Just be clear.
God, this guy is an
No one gives a
insufferable
shit.
pile of trash.
He talks a lot of shit for a guy who's going to prison for the rest of his life.
And he may,
Mm-hmm.
defense is calling Abel Lascano, correct?
See how that works for him on cell block C.
The defense is calling
If he makes it that far.
Abel.
Abel Lascano.
When this is all done, the prosecutor should hand him a bar of soap and drop it just before he can grab it. Just for practice.
Yeah, we had a guy who we prosecuted that was kind of like this, and he went to prison and they threw him off the second story.
Yeah, right.
And
Yeah.
then he got brain damage, and then he kept going. They threw him off a second time about 2 months later, and he died after the second time.
Jeez.
And my clerk,
Damn.
Teresa, who will be across from you or is across from you, will swear you in. Thank you.
I mean, just imagine high school bullies, except they're all murderous psychopaths.
Testimony you're about to give shall be the truth, the whole truth, and nothing but the truth, so help you God.
Thank you, sir. Please have a seat. First thing I will have you do is to state your first and last names for the record and spell each.
Abel Lascano, ABEL LAZZANO.
Thank you. Your witness, sir.
Good afternoon, Mr. Lascano. What do you do for a living currently?
I'm a hairdresser.
I'm training to kill you.
No judgment whatsoever on this question. Have you ever been convicted of a crime?
Yes, I have.
And how many times?
7.
Okay. Well, thanks for bringing that up.
Do
How
you
many
recall
tattoos do you
the night of November 21st, 2021 pretty well? I know it's been a minute, but
Best as I can, yeah.
what were you doing that evening, if you recall?
The Christmas parade?
Were you marching in the parade? Or,
No, I was watching it.
who were you there with? Family, friends?
My wife and my daughter.
Do you recall where you were positioned to watch the parade?
I was standing in front of the Corey Insurance on Main Street.
Is that part of Main Street close to like a side street? If you recall,
It's not too far from Maple.
do you recall the side streets being barricaded during the parade?
I don't remember.
I have to say, Brooks has some of the style down.
Yeah,
Can you think of anything I can do with my hair that would help? How about that question?
Do you recall what time you arrived at the parade that evening?
Yeah, it just started. So whatever time that was at.
You recall something other than the parade catching your attention that day?
People getting hurt, yeah.
And what did you see that day, if you recall?
I saw a red SUV plow over a bunch of people.
And did you see the driver of this SUV you're referring to?
Yeah, you're standing right there.
Lol.
Oh shit!
Damn.
It's that fucker.
And how many people did you see in the vehicle?
Just one, the driver.
You
So,
Heavy.
This is your witness?
do you recall flagging down
I hope you
a
get free.
law enforcement vehicle that evening?
I hope they let you go.
And do you recall what you told the officer that evening?
Not very well.
I'm gonna attempt to see if anything brings back some recollection.
I'm gonna
First,
attempt to see if I can
do
get you
you
to say
recall
anything.
the name of the officer you flagged down that evening?
Officer Moss.
Do you recall telling Officer Moss that you observed 3 or 4 people in the SUV as it passed you?
I don't remember that.
This guy's getting the public defenders to root for the prosecution team.
Brooks didn't come to your trial training, Steve?
No, he did not. This is like everything you should do wrong.
So, to your recollection, the SUV that you saw, did it have tinted windows?
I don't remember.
Samir, is even the Wisconsin felons polite?
Well, it's a DWI felony. It's not.
And do you remember what the description was that evening that you gave to law enforcement?
I told him it was a red SUV.
The description of the driver, do you remember that?
Yeah, I know he was a black male.
Your height?
Is that all you recall about your description?
Different hairdo. Amazing.
Has he tried the grandma got run over by a reindeer defense?
Oh, jeez.
After seeing this vehicle, what did you do?
We left. I got my family out of there.
And where did you go?
We headed back to the car.
Do you recall where your vehicle was parked?
I believe it's the Lindholm or building on Maple Street.
And did you see the vehicle stop on Maple Street?
Thanks, buddy.
Which
Yeah.
vehicle?
Who's that character? The SUV.
The hairdresser.
That you claim you saw.
Oh,
Yeah.
no, I didn't see it stop. No.
We don't
Oh,
ask
damn.
questions.
Great.
And speaking with is it Detective Moss? Well, speaking with law enforcement that evening, do you recall advising law enforcement that you observed 3 black subjects running from the vehicle?
No, I don't remember that.
If it pleases the court, I would like to show the witness this.
Como se dice?
For example,
Bathroom?
Is it a statement this witness personally wrote?
I believe it's what I don't think he wrote it himself.
So it's a summary written by another person.
By I don't know if it's Officer Moss or Detective Moss. I'm not sure if what his rank is.
Continue with your questions. I'm going to deny the request that you show the exhibit or the paperwork to the witness.
Do you recall making the statements to Detective Moss that you observed one where it says one was described as running southbound on Maple towards College Avenue? Do you recall that?
No, I don't.
Do you recall stating that the other 2 were described as running in a westerly direction from the rear of 338 Maple Street?
No.
Do you recall stating that one black subject was described as tall, wearing a blue top and blue and black pants, while the other subjects were described as 2 short black males wearing sweatpants?
Barely, a little bit of that.
So, which of these subjects do you minimally recall wearing those items that evening?
No, you asked me if I remember people running, and I said no. I remember describing those people to him. I remember.
So where did you observe those?
Standing by the vehicle, where I found the vehicle, where I spotted it.
Just so we have clarity, describe the subject you saw that evening standing by the vehicle.
I don't remember that good. I mean, you were describing them, so it brought back a little bit, but I can't tell you. That was too long ago.
And how did you come upon the vehicle at the address of 338 Maple Street that evening?
I was walking my family back to the car, trying to get them to safety. So I was keeping an eye out, and I spotted it.
Do you recall stating that you saw the SUV reverse into a driveway?
No.
Do you recall why that would be reported?
No. When I found it, it was parked already.
Do you recall when you initially had the interaction with Detective Moss? Do you recall leading him to where the vehicle was ultimately found?
Yeah.
Do you recall yelling at subjects standing outside of the building where or near where the vehicle was that evening?
I remember asking them. I don't remember yelling at them.
Was my nose whistling into the mic? I'm
Do
sorry.
you recall why?
I hate this trial and this man.
Do you recall why the report
This
says
judge
that
and Wisconsin?
you advised Detective Moss that there are 3 black subjects, specifically black subjects, running from the vehicle?
No.
Racist.
This guy looks like a traditional white supremacist.
He actually looks like the guy who teaches my BJJ class.
I wouldn't mess with him.
Were you yourself injured in this incident that evening?
No.
my god, it's a fucking question.
It's a public service that you're
Man, Nick,
broadcasting.
you
this
got 23,000 people watching this on Rumble. You are the king. This content, holy crap!
this is all day.
Thanks for your
backhanded compliment.
yeah, your loving and tender assessment of what's happening right now. So, Bronca, if a Wisconsin lawyer wanted to hire you to consult on a case, would that be okay, or would you have to get licensed in Wisconsin?
I'd have to ask Natalie
Before
first.
stating that
I'd have to get a permission
Well,
slip from that lawyer chick.
Did you speak with another detective
Yeah,
that
the
evening?
purported lawyer. I'll
Yeah.
take her to word. Who is
And
a very limited.
do you recall if that was
critical thinking
Detective
ability.
Coates?
I don't remember his name.
But I think we'll talk about that later, right? Tomorrow.
So it'd be fair to say that you
tomorrow
spoke
night.
with two different law
11 p.m.
enforcement
Central,
officers
okay
that
with you?
What time?
11 Central.
Yeah.
Perfect.
Bring food and water.
Do you recall in
Okay.
your interview with Detective Coates in reference to the vehicle that you saw that evening?
As long as you don't bring a
Do you
tie.
recall telling Detective Coates
Deal
that it appeared there were 3 or 4 people in the Ford Escape as it passed you?
No, I don't remember that.
That 5.5 hour stream we did, Nick, when it
Do
was like
you
midnight
recall
to 5:30, about killed
in
me.
your interview with Detective Coates that evening, stating that you could not
That's like
provide
my
any
life.
description of the occupants other than that they appeared to
Last
be
time I
out.
was on all night with Nick. It took me 2 days to
No,
recover,
you're saying
and it wasn't even all night. It was like 2 hours.
So it'd be fair to say that you observed
That's what all my
African
dates say.
Americans in this vehicle.
I woke up intubated.
The reason why I came up with 3 or 4 people is because when I was walking by and I saw the car, there was 2 or 3 black males standing by the vehicle. There was at least 3 or 4 more on the porch. So I figured they
And
were
my grandmother's
by the
intestines
vehicle. It
were
must have
wrapped
been
around the
ones
differential.
on the high of the vehicle because they were standing in front of it or real close to it.
In your opinion, did it look like they were nervous or attempting to hide?
Well, everybody was running past them and walking really fast, and they were just standing around there. They were the only ones not doing much. So yeah, they stood out.
They're not going to run. They're too
This is-
cool.
The question actually was in reference to when you spoke with Detective Coates that evening, and it is in reference to seeing the vehicle in the parade as it passed you. Do you recall at that point, while at the parade that evening, do you recall stating to Detective Coates that it appeared that there were 3 or 4 people in the Ford Escape as it passed you during the parade that evening?
No, I don't remember that.
Who do you reckon will get to play the hairdresser in the
You
Lifetime movie?
the Detective Coates will report that that's what you stated to him.
Like I said before, I saw 2 or 3 people by the vehicle, so I assumed they were.
What did you say?
They
I didn't-
were
I
with the
didn't hear you.
vehicle, so they must have been.
Never
in
mind.
the
It was a
vehicle.
bad joke. Never
I
mind.
saw the driver
Oh,
going
okay.
by.
Your mic
because
was
he hit
down low. I
somebody
turned
right
it
in
up.
front of us.
I don't know why it was
Oh.
low.
Well, I think I just sent you a rumble, Nick. Whatever the F that is. I gotta stop clicking buttons.
No, send more.
You recall in your interview with Detective Coates that evening, stating that the 3 individuals, and I'm referring to who you saw next to the vehicle, so some clarification. The 3 individuals who were standing in a line, shoulder to shoulder.
Shoulders.
That's African American males.
Shoulders. That's
Yeah.
his next rap video's beat. Shoulders.
So it's fair to say that's what you observed that evening.
I saw these 2 of them.
Shoulders.
It looked like they were standing in front of it.
Shoulders.
Danny Trejo? Maybe. I can see it.
See Megan's chat.
I don't know. I thought heart attacks took longer than this. Wait, no, that's not right. I've not had enough coffee.
And during that, you with Detective Coates that evening, do you recall stating to Detective Coates that you may be able to recognize the older male? So I'm assuming one of the individuals that you saw standing shoulder to shoulder was a older male.
I don't remember.
There he goes.
Strictly speaking, comments. He doesn't have to prove he's innocent. He just has to raise a reasonable doubt about his guilt. That's the standard. Good luck.
Jackson.
Any reason why multiple? Well, I'm not gonna say multiple. Two. Any reason why the two detectives that you spoke with that night both reported that you stated you saw 3 black subjects running from the vehicle?
No.
No.
No, it was definitely you.
And during the parade incident, were you or anyone you were with injured that evening?
No.
No further questions at this time.
I may recall the witness, Your Honor.
Yes, Your Honor, thank you. Good afternoon, Mr. Lascano.
Good afternoon.
Sir, you said you watched the parade near Curry Insurance, is that correct?
Yeah, right in front.
Okay. Do you remember, you said you saw the SUV strike some people in the parade? Yes. Do you remember what group of people in the parade? Can you remember anything about the name or the banner or the costumes or anything like that?
Objection, leading.
Overruled. It's crossed.
No.
Speculative. Objection.
Would you agree or disagree?
His answer, I believe he said no. His answer was
Yeah, no, I don't remember.
Okay. Do you remember seeing the SUV strike more than one person?
Yeah.
Objection. Speculative.
Nope.
overruled.
About how many people did you see the SUV strike, sir?
Objection. Speculative.
Overruled.
It was crowds. I mean, when it was coming through, because I was standing over my daughter and my wife, they were sitting on the curb. I saw it coming through, and at first it looked like it was just pushing people out of the way, and then it just kept swerving back, and it was just plowing everybody out of the way until it got to in front of us. Then it actually hit somebody, and it just did like a cartwheel in the air.
You remember that?
Yeah, it was
Ooh.
right in front of us.
That's yeah.
Not the kind of testimony you want to elicit.
Right. He
No.
air
Well, that Darrell.
directioning his hand from right to left, describing the vehicle coming from right to left. And then when he said he saw someone go into the air, he was like twirling his fingers as if to say it kind of tumbled in the air. All right, go ahead.
Just a grift. We are 19
So, Mr.
local
Liscano,
supporters
I
away
wanna
from
talk about the moment when you
4,500.
Located this vehicle on Maple, okay?
Damn. Well done.
Ask, Madam Clerk, could you please turn on the AV system? We're gonna put up State's Exhibit 65.
Hey, I got to check out, guys.
Catch you later, Steve. Thanks for joining tonight, man. Or today.
Thank you. It's been
Take care,
fun.
Steve.
Hey, Andrew. Good to see you.
Objection.
Hey, that's the dean down there, man. Andrew.
Exhibit 65.
In the Dean T-shirt.
Yes. Go to
No,
Give my
crimelaw.net.
best to your wife, Steve.
It's been
Thank you.
received. The state may proceed.
All right, this total clip is 36 seconds, but before we begin to play it, sir, do you recognize the area on the screen that's
Yeah.
shown in this picture?
Yeah, I believe that's Central Middle School,
Where?
right at where the stairs is.
Okay, the red brick on the left side of the picture?
Yeah.
Objection.
Okay.
Speculative.
Overruled. His answer stand, he said, I believe.
And would you agree with me, the house where the SUV was found was up in this area here where I just put the green dot on the screen?
Yeah.
Objection leading.
Overruled.
Oh, for fuck's sake.
The answer.
I guess the whole
That
trial.
looks right, correct, sir?
Mm-hmm.
Overruled.
All right, we're gonna clear the screen. And we're
Good
gonna play
question.
the
He
tape
had
for
an objection
36
card
seconds.
he used to hold up. Does the judge have like
Please
an
watch and
overruled
see
card?
if you've seen
She holds
yourself
up,
or any of your
Oh, was that the
family
one in private chat? Yeah, I wasn't sure if I could ask that on stream or not.
Video to this particular.
Yeah, of course you can.
Overruled.
You're comfortable asking it.
Overruled on what grounds, Your Honor?
People can say whatever they want on my show. That's everybody is responsible for their own speech. I'm responsible for mine. And I would never ask that to be any different.
No, I get that. I mean, taking into account race relations in America, I wasn't sure if it was smart for me to say it and take responsibility for it myself.
I'll say it. Given his stance on race, would it be appropriate to ask what race the kids were that he swerved to avoid? Well, depends on what he says on his direct, I guess. If he testifies,
Sir, did you
if
see
that'll open
yourself
the
or
door
your
to that on
family in
cross.
that
But
clip?
Objection.
I'm pretty sure the race issue is
No, I did not.
held out in limine.
Now, you said you did see, by the time you walked past the car, you saw 2 or 3 black males standing near the car, right?
Objection. Mischaracterization of this. He said 3. Specifically said the number.
Overruled.
And you also said you saw 2 or 3 what you thought to be black males on the porch of the residence there, correct?
Objection. Stated it was black males. Asked and answered.
Overruled. The witness may answer.
No.
I'm sorry, go ahead.
No, there was 2 or 3 standing by the vehicle.
Okay.
And then on the porch, there was maybe 3 or 4 or more people. I don't know if they were, I'm sure they were white, but I was trying to not make it obvious at the time. I believe that they were with the vehicle, so I didn't want them to see that I saw them. So I just did what I thought was right at the time.
Sure. Do you happen to know the people that live at this house?
Objection. Speculative.
No, I do not.
Would it be reasonable, do you think, Mr. Lescano, that people living in the house heard the crash and came outside and that's who you saw standing there by the
speculative
vehicle?
to this.
Objection. There was never any crash mentioned.
I'll sustain.
You
calls for speculation.
Thank you.
The judge is filling in the ad libs objection.
Is it possible that the people you
He's
saw
just living in the
standing near
future.
the vehicle were in fact just neighbors that saw the vehicle the same way you did?
Yeah.
You described that at the time you went by on Maple Street, there was a lot of people running around in the area. Is that correct?
Objection. Mischaracterization of testimony.
Overruled.
Yes, it was.
And these are people hurrying away from the parade with their families, trying to get to safety.
The witness is right here to correct
Objection.
this
Speculative.
Overruled. The witness may answer.
Yes.
Sorry, I'm allergic to bullshit.
Anything like that in States Exhibit 65, did you?
No, I did not.
You said on direct examination that you saw the driver of the SUV in the parade. Is that right?
Yes, I did.
And you see that driver present in this courtroom here today, please?
Objection. Speculative.
Yes, he's sitting right over there.
Are you sure about that, sir?
Yes.
Objection. Speculative.
Overruled.
Does not understand what speculative is.
You said
And
that.
mischaracterizes the testimony because that was not testified to before on direct.
Your objections are overruled. I believe the witness already answered. Go ahead.
All right, guys, I'm going to have to sign off.
Notice
Sorry about that,
in
but I'll
Exhibit
talk to you all soon.
65,
Nick, I'll talk to you
red
tomorrow.
SUV, that
See you tomorrow
video
night,
clip
Andrew.
that you watched?
Take care.
Peace.
No.
You didn't see it at
Couldn't
all,
see
did
it.
you?
No.
Okay, just wondered. Mr. Lescano, have you and I ever spoken about this case, sir?
No.
What about Attorney Basie here to my right? You and her ever talk about this case through your testimony?
Objection. Hearsay.
Overruled.
No.
Mr. Witchow on the end, did you ever talk to him about
Objection.
your testimony, sir?
Objection. Hearsay.
Overruled.
No.
All right, thank you, sir. I don't have any other questions.
Thank you. Any redirect?
Yep.
Go ahead.
You stated that you saw the driver, correct? of the SUV that you saw that day, correct?
Yes.
How did the driver look that day you saw him?
Same as today.
Scruffy beard, and he was a black male.
Did you see what the driver was wearing?
No, I don't remember that.
Did you see if the driver had any hair?
I don't remember that either.
Did you see if the driver had anything noticeable about their appearance, tattoos, scars, marks, anything like that?
No. I saw the side, the profile, the side. You were flying fast down that street. The color clothes you were wearing. I knew it was a black male and had a scruffy beard. The first thing I told my wife is he was a black guy driving.
And do you recall how long you were able to get a side view, as you called it, of the alleged driver?
No, I had to be a couple seconds.
And in a couple seconds time, you were able to make out the driver's profile and race just by a couple seconds.
Yeah. It's not hard. I could tell if you were white or if you were black and if you had a beard. No, that's it. I don't know what color shirt you had on. If you had hair, a hat on backwards.
So that leads back to the question of, is that the only person you saw in the vehicle?
From what I remember, yes. I saw the driver. Like I said before, the reason why I thought there was 3 or 4 because I saw 3 or 4 people around the vehicle when I spotted it.
So would it be
That's the only reason.
Would it be fair to say that when you spoke with 2 different detectives that evening, the evening of the parade, both of those officers reported that you stated there were 3 or 4 people in the SUV as it passed you? Is that fair to say?
Oh, wait, can you repeat that again?
Prime ministers haven't lasted as long as this trial.
Mm-hmm. It is brutal.
Just for clarification, you already stated previously in testimony that you spoke with 2 different detectives that evening, correct?
Yes, I did.
Super chat says Nick, or Geralt says
And
Nick.
both detectives.
What
that
would you rather
spoke
be
with
forced
that
to watch
evening,
for
the
all
evening of
eternity?
November 21st,
The Brooks
2021,
trial or She-Hulk?
you stated to both
I choose Brooks.
of those law enforcement officers, detectives,
I have to agree with you on that.
that you observed 3 or 4 people in the SUV.
Like I said before, the reason why I said there must have been 3 or 4 was because they were standing by a vehicle. So I assumed that they were with the vehicle. I don't remember seeing them in the vehicle when you were hitting the people.
You stated this to both detectives, 2 different detectives.
Objection.
The evening of November 21st, 2021.
That's an answer.
And this was in relation to what you saw from the vehicle at the parade, not where the vehicle was later found. Any reason why you stated to both detectives in relation to what you saw at the parade, why both detectives in their reports stated that you told them that you observed 3 or 4 people in the SUV at the time of the parade?
So what's your question?
The question is, why did you report that to 2 different detectives on the same evening?
like I told you before, when I walked past the vehicle, I spotted more than one individual standing in front of the vehicle. So I assumed they were with the vehicle. That's why I said they were inside.
I'm sorry.
That's why I said they were in the vehicle. I said there had to be at least 3 of them in the vehicle. That's the only reason I said that.
So why would you report that you saw this during the parade?
I don't know.
I don't know. That works.
And during both interviews with detectives that evening, the evening of November 21st, 2021, you also stated to both detectives that you observed 3 or 4 black or African American is the word used. 3 or 4 African Americans running from the vehicle. Any reason why both detectives reported that you said that?
No, I don't remember.
No further questions.
Thank you, sir. You may step down.
We're done yet?
Nope.
Do we have additional witnesses here? Yes, Your Honor, they're right.
Kurt, why
There's
not
your
exist
answer.
but to suffer?
There's 2 left.
Okay, so the 2 left on your list, your next witness, sir.
2 left on his list, but his mom was added to the list. I don't think she'll be in today. So
I'm guessing that's
maybe himself and his mom tomorrow. That'd be fucking a terrible.
One quick second, Your Honor.
Sunday.
Answer
Quick
for him.
Go ahead.
What's he going to call his mom for? That he's a good boy? I don't think mom's going to say that.
No, he's going to call his mom because of a jailhouse phone call he had with her that some detective didn't actually talk to her or something.
What is your son's name? How long does he have that name? How long has he gone by that name?
His name is I do not consent to the use of that name. It's very weird. Soundwave TM3, Rekieta Law, do you think if he was a white male with tattoos, he would be getting this many chances as all this shit he brings up is for the appellate court? Yeah. I don't think he's actually getting treated this way because of his race.
Sorry about that, Your Honor.
I really don't. I think it has so much more to do with him just being pro se and the case being so huge. I mean, this is a mass murder of 6 people. These don't happen very often. It's a highly public event. I know a lot of people want like a race narrative involved in the case, and there may be fully a race narrative involved in his motives. That I don't care if they was or not. Like that could be true. I don't know. There's some indication that there might have been, but I think in the treatment of him, I really don't see it that way. But maybe other people have a different opinion. That's fine. Some people might think the judge is concerned about what would happen to her in her house if she treated him differently. I don't know. That could be on her mind. It's not supposed to. We'll never know the answer to that. So you are free to speculate however you want.
So much paperwork.
Okay, great. That'd be great.
Oh, my neck. Talk. Brooks, what are you doing?
Damn it, we need Jeff's Jeopardy music again.
Icanillis says, if Wisconsin had the death penalty, I would say his remains should be encased in asphalt as a speed bump on the spot he ran through the parade. That way people could run him over for the rest of time.
Kathleen, Urel?
That's how I think it is. We'll find out.
Why is my neck sore? What have I been doing? Sitting here staring at this damn trial.
Dude, I had surgery on my back when I was like 13.
All right.
Sitting for long periods causes pain. This guy's literally a pain in my ass.
When you get there, please remain standing. Raise your right hand, and my clerk Teresa, who's on my left, will swear you in. Go ahead and come all the way up. Thank you.
Legendary Racing says Danger Witch is a Russell Wilson Subway commercial that's incredibly cringeworthy.
I do. Thank you. Please have a seat. First thing I will ask you to do is to state your first and last names for the record and then spell each.
Kathleen, Kathleen. Last name Urell, Yourell.
Thank you so much.
The captioning is so weird.
Good afternoon, Miss Urel. Is it Urel?
Urell.
What do you do for a living?
I'm in workforce management for a call center.
Riveting.
November 21st, 2021. Directing your attention there. You recall that evening pretty well?
Off and on, sir.
That's fair. It has been a while. Do you recall what you were doing that evening?
Yes, sir.
And what were you doing that evening?
At what time?
Around 3:30, 4 o'clock-ish.
I was dropping off my children who were participating in the parade.
And did you yourself stay for the parade?
Partial parade, yes.
Partial,
This was a bad call.
Maybe a few minutes.
Until my group of children went by.
Okay.
Yep.
Do you recall where you were positioned during watching your group participate in the parade?
Yes, on north and east, right on the corner there.
North and east.
If you're going parade route, it would be on the right-hand side.
Just so we have clarification, can we pull up the exhibit? I believe it's 15. Thank you.
Go ahead. And thank you.
Can we show it to the witness first?
He doesn't want it published, so just to the witness for now.
Just not yet.
Maybe she was like the coach of the group of kids that he swerved around or something.
Can you see that?
Did I hit your
on
kids
screen
though?
yet?
I do.
And using the touchscreen, it's a touchscreen. Can you point out where
It's
you?
not published. So do you want it published?
I'm sorry. Yeah, publish.
Sorry, I didn't mean to interrupt, but I just wanted to point that
So
out.
just so I know to use the touch.
Stop
it has to be
apologizing.
published.
No, she could use it, but if you're going to have her do it, it should be done in front of the jury.
Fair.
Okay, go ahead.
I think we got to wait on the jury, right?
Thank you.
For the jury, and can you using the touchscreen on your screen? Can you point out exactly where you were positioned?
When I was watching it,
Yes, when you were watching it.
right on the corner. Sorry. Oh, well, if you want to
Can you
reverse
clear
it again, I'll do it
the
again.
arrow?
We'll clear it. You can do it again.
Yeah.
If you don't want, do you want the arrow?
Well, it was to the.
Clear it again.
Okay.
So it's a touch screen, so use your index finger and you can draw a circle.
Okay.
I was gonna say that.
Well, I mean, it was right there, but.
I was gonna say a circle or a little dot if.
Well, I thought I was doing that, but.
Yeah.
Oh.
Heavy hands.
No one gives a shit what you were going to do, Darrell.
Hold while you draw.
Okay.
Sorry, Darrell.
There you go.
And you said that would be approximately East Main and Northeast.
Correct.
And do you recall if those will there's side streets right there that you can see? Is that fair to say?
No,
Correct.
nothing is fair to say.
And
Motherfucker.
those side streets would be Northeast and Buckley, correct?
Correct.
Do you recall if there were barricades at those?
I can't honestly recall. I can't be sure.
We can take Exhibit 15 down.
Thank you. Go ahead.
And you said you stayed at the parade until your group had passed.
Correct.
And
Get him, Karen.
did you leave?
I can't determine the time. It was right after my group of kids went by.
For those who are asking,
And
I'm eating
where'd you go
chicken
from here?
strips from Dairy Queen.
I walked down,
It's
well, I
depressing.
went to go get the car because I had to go pick them up at the end of the parade.
And I'm assuming at some point your attention got drawn to something happening. That'd be fair to say?
Not necessarily.
What do you remember when you went to go get the vehicle to pick up members of your group? Would that be fair to say first? I don't want to assume.
Yeah.
Do you recall anything happening at that point?
A situation did occur before the said big event that took place.
What do you recall happening at that time once you were on your way to get your vehicle?
I think I need more specifics from you to give the details you may be.
I don't need the lecture, guys. I eat fast food once a month, maybe.
While you were getting your vehicle, did you observe anything happening? Did you overhear about anything happening at that point?
Nothing of that nature. Well, all I can say is that I was walking past White Rock.
Did you see anything that may have alerted your attention at that time?
Yes, a car coming through the parade at the beginning on White Rock where the parade was starting. So when I left, I walked down Main to White Rock on the corner there. Then a gentleman, a child who I don't know who they were, and myself walked across the street. And at this time, a car was beeping and weaving around a slight curve that White Rock has, and then continued on.
Did you see did you see where the car went at that point?
Yes, I did. As it came around the slight curve White Rock has, it started to move forward, and then it went straight across when I was thinking it was going to leave the parade route. If you leave the parade route on Main, you're leaving. Sorry, if you turn left, you're leaving the parade route. If you're turning right, you're going right into the parade. And it went right to if you're looking at the parade, it was on the right-hand side. And it's continued on into the parade.
Hold on, just for the record, she was using her hands
Yeah.
during her testimony. I just need, that's okay. I just need to make a
Yeah.
record of it. Usually her right hand just kind of demonstrating the course of travel that she described, the vehicle. And I think that's probably all I need to put on the record. Sure. Go ahead. Next question.
I want to back up a little bit.
How does Drexel feel about them
When
D
you
queens?
first observed
Who do you
this
think picked
car,
this
as
up?
you say, you recall that it was blowing its horn.
Oh, is that what he dropped off to you?
The horn was beeping.
Yeah.
Yeah.
was very nice. Nice bro move. It's the only fast
Do
food
you recall
restaurant
if you
or
saw
easy
who
to
was
get food from
operating
restaurant within
that vehicle?
10 miles of my
Unfortunately,
house.
sir, I can't recall.
Fair enough.
Do you recall if you might have seen multiple people in the vehicle at that time? Or?
You know, unfortunately, due to the time passing, I cannot recall.
That's fair. It has been a while. Do you recall about what time that was that you observed the vehicle?
Again, I can't be sure.
Sorry if I keep asking.
No,
stuff.
I can't be sure. I'm sorry.
Oh, Jesus. I tell you what, if I ever need any image work done, I'm like freelancing, I'm contacting your locals chat. I swear to God.
They're hilarious.
At the time that you observed the vehicle, did you see it strike anyone?
I did not, or at least I don't recall. I'm sorry.
Goddamn, let me think about it, and I'll get back to you.
God, finish your fucking questions. His witnesses have been exceedingly short throughout the day, and they feel eternal.
Mm-hmm.
Because he takes so long to ask the next question.
If he'd been even remotely prepared, this would have been over
vehicle was
hours ago.
speeding at that point that you observed
Yeah,
it?
It wasn't speeding, but it
With the
was
same amount of questions, it would have been
All I can state is it was
all the witnesses done by lunch.
Yeah.
Did you happen to catch the license plate number of the vehicle at that time?
No, not at all.
Do you recall if the vehicle had any tinted windows?
I couldn't recall. I'm
Any
sorry.
windows rolled down or up at the time you observed it?
No, unfortunately, I don't remember.
Summer Stew 6571 on YouTube and 1255 on Rumble.
Do you recall if the vehicle passed close to where you were walking at the time?
Yeah.
Someone asked me how many subs I had.
It could have easily have had clipped me or the two people that were in front of me.
Were you the two people that you referred to in front of you? Were any of you hurt at that time?
No.
No further questions right now.
Thank fuck.
Cross.
Yes, thank you. Good afternoon, Mr. Rell. Thank you for being here. You testified on direct examination that you don't recall whether or not you saw more than one person in that vehicle we're talking about. Remember saying that?
Yes.
You remember meeting on December 2nd, 2021 for an interview with Detective Jay Carpenter from the Waukesha Police Department?
I remember going as to a lot of topic of conversations. I unfortunately can't recall those too clearly.
Do you remember telling Detective Carpenter that you only observed a driver in the vehicle?
Objection, leading news.
Yeah,
It's cross.
I can't be too sure.
It's not hearsay.
Can you say that again? I'm sorry.
I can't be too sure. Again, some of the conversations I might have had that day.
Do you remember what this vehicle looked like?
I do not.
Do you remember telling Detective Carpenter that it was a red truck?
I do not.
Can we please put up for everybody Exhibit 15 again?
Go ahead.
Can we zoom in on the intersection of East and Main?
Go ahead.
All right, thank you. Your testimony is that you were standing here on the northeast corner of Buckley and Main Street. Is that right?
Objection already answered that, asked and answered.
Overruled, you may answer.
You said correct.
Correct.
And after your children walked by in the parade, you walked in this direction towards the intersection of White Rock and Main. Is that correct?
Objection,
Correct.
leading and speculative.
Overruled as to both, you may answer. If there is another objection, just
pause.
Sorry. Thank you. No, that's okay.
Correct, that was.
And then you crossed through the crosswalk on the north side of Main Street. Is that correct?
Yes.
Is that when you saw this vehicle we've been talking about?
Yes,
So you were standing in the crosswalk.
correct.
Do you remember a police officer being in that intersection?
I can't be too sure.
Was it clear to you that this was a parade route?
Yes, it was very clear.
Was it clear to you that traffic from White Rock should not have driven onto Main Street
Yes,
unless they were part of the parade?
yes,
Did it appear to you as though the vehicle we've been talking about was part of the parade?
no.
How many children do you have, Miss Urel?
Objection irrelevant.
Overruled. Man.
Oh no.
4 children.
All 4 of your kids were marching in the parade that day, weren't they?
Yes.
Objection leading.
Sorry.
Your oldest daughter, Charlotte, she was 14 at the time.
Yes,
She was marching with the Extreme Dance Group as an alumni, wasn't she?
she was handing out candy.
There was an objection, it's overruled.
I didn't even state why I was objecting, but okay.
Doesn't matter. There are no grounds. Go away.
15.
Yes, please. You see on that map the 5 points intersection?
Yes,
When you were standing in the crosswalk at White Rock in Maine, could you see the 5 points intersection?
I could not.
You didn't see your kids get hit, did you?
I did not.
Objection leading.
Sorry.
Overruled.
Okay, I'm sorry.
Objection hearsay.
Overruled.
You didn't.
I did not.
Did you see them later that night?
Objection leading.
Overruled. You may answer.
I was only able to see 2 of my children that night.
Oh Jesus.
You the other 2.
Days later, when I was able to leave Children's Hospital.
As their mother, you were directly involved in their medical care and the decisions that were made in that process in the days after the parade?
Objection leading.
Overruled. You may answer.
Yes, my father and I.
Charlotte suffered a chipped vertebrae from being struck, didn't she?
She did.
Objection
Sorry.
leading.
Brooks, shut the fuck up.
You may answer.
She did.
Your daughter Alice, she was 10 at the time, wasn't she?
She was.
She suffered chipped front teeth, is that correct?
Yes.
And facial scarring
Yes.
and road rash
Yes.
and a broken fibula and tibia
Yes.
and broken metatarsal bones.
Yes.
She was observed in a concussion protocol, is that correct?
She was.
Good job calling this
Your
witness,
daughter
Brooks,
Vivian,
you
she was
fucking
marching
idiot.
Mhm.
dance group too, wasn't she?
Yes, she was.
How old was she in November of 21?
She just turned 7.
Vivian suffered a severe concussion, didn't she?
Objection leading.
Overruled. You may answer.
If the
Yes.
jury doesn't want to kill him right now,
And road
I'd be
rash?
shocked.
Mm-hmm.
Extreme road rash.
Permanent
And a lung
scarring.
contusion
Jesus.
Yes.
and facial scarring?
Yes.
And your 7-year-old
Holy
daughter
shit.
suffered a broken tailbone, didn't she?
She did.
Your son, Grayson, he was 8 on November 21st, 2021. Is that correct?
That is
Objection
correct.
leading.
Overruled.
He was walking with the Extreme Dance Group handing out candy. Is that right?
He was.
He went to the hospital after the parade, didn't he?
Yes.
He suffered a compound fracture in his femur. Is that correct?
An open compound fracture.
Meaning the bone came through the skin?
Yes.
Objection hearsay.
That's what that means.
Exactly what it means.
Compound means it breaks more in one place. It means it pierces the skin. Yep.
Was that a yes?
Yes.
A police officer saved Grayson's life by placing a tourniquet on that open leg wound. Is that correct?
Yes.
I don't have any other questions.
Wow, what an idiot.
Yep.
Yeah.
Holy
yeah.
fuck.
No redirect. Are you realizing how fucking dumb that was, you moron? You brought that woman up there, asked her a bunch of pointless ass questions, and that's what happened to her kids. Is your argument, but I didn't kill him, no?
So we're gonna take down these exhibitors. You're gonna stay up on there.
Thank you. We'll take it down.
I need to go check if my 4-year-old's still in the house because otherwise I'm going to let loose.
Okay. By the way, guys, her family has a GoFundMe here.
Just 1 second.
I'll share this in the chats. It's the Waukesha Parade tragedy, the Y family. So, yeah, I'm going to share it in all 3 chats in case anybody feels like it. You can actually, help them out. In fact, I'm making a donation right now.
So you one more person here, right?
It's my understanding, sir.
Well, then, I guess.
Would that be correct, Attorney Upper?
Could call himself.
That's true. He could call himself. That's true.
Okay, so my daughter is still within earshot, so the fact that this cunt is a massive flaming pile of trash that I would love to see under a steamroller, I'm going to have to keep it a little bit quiet.
I love that. You're like, I love Australia because you're like, despite the fact that this cunt is a pile of trash. Like that's fine. Just let everybody know, guys. On behalf of the show, I just dropped $500 to the family GoFundMe.
I don't know how to say the last name.
So if you guys feel compelled to donate to that,
Can you
you
give me
can
the
too.
spelling that you have?
Obviously.
VABIASZ.
Like it's babies.
Having to
What's
sit
your
on the
last
witness stand and go through that is
Fabias. All right. Thank you. You are at the witness stand. Would you
Awful.
please raise your right hand? My clerk Teresa will swear you in.
Do you
Hello?
the testimony
Who is this?
I knew it was coming.
Thank you, ma'am. Please have a seat. First thing I will ask you to do is to state your first and last names for the record and then spell each.
Catrice Babias, Katrice.
Would you like a different last name?
Babiasz.
Thank you. My apologies for pronouncing that earlier. Go ahead, your witness.
It's 2022. She may want to keep her own surname.
Good afternoon, Miss Fabias. I'm surprised I got it right. What do you do for a living?
I am a law enforcement dispatch supervisor.
Oh, fuck. She took the calls.
And how long have you been doing that now?
I've been in law enforcement
Go
for
well.
16 years.
Mm-hmm.
The evening of November 21st, 2021. Were you on duty that evening?
I was not.
What were you doing that evening?
I was attending the Waukesha Christmas parade with my family.
Oh, I stand corrected.
And do you recall what time you arrived there with your family that evening?
I arrived to the parade shortly after it started, so it was right after 4 p.m.
And do you recall where you were positioned at with your family when you arrived at the parade that evening?
Yes.
And where were you positioned at?
I was towards the beginning of the parade. I was on Main Street where it connects with White Rock Avenue.
Did anything catch your eye that evening when you were positioned watching the parade with your family?
Yes.
What did you see?
I saw a red SUV coming from White Rock Avenue. The vehicle caught my attention because people started yelling, and the driver was honking the horn.
And do you recall, to the best of your knowledge, it's been a little bit, the driver of the vehicle you observed was honking his horn. Was it gesturing to people?
Yes.
And what do you see? What did you see the gesturing as?
I'm sorry, I don't understand the question.
What was the gesturing?
What was the driver gesturing?
Yes.
Objection.
I'm sorry.
Speculation.
It's okay. So he was taking his hand and going like this, really rapidly, aggressively.
Oh, he was listening to his song.
For the record, the witness had her right hand up above, probably above her, I wouldn't say at a 90-degree angle, but somewhere maybe at a 45
Jeff's like having a wet dream and he has no idea why.
Back and forth,
Maybe.
back and forth multiple times in a rapid motion. Go ahead.
You yourself being in law enforcement and just based on what you were observing, the driver of the vehicle you observed was honking his horn and gesturing with this motion. Would you take that motion as trying to alert people to move out of the way?
Oh, someone please clip that.
Grounds.
Sustain us to the form of the question, please rephrase.
How did you yourself take that gesturing?
I took that gesturing as the driver was telling people to get out of his way.
Let me back up. Did the vehicle pass pretty close to where you were positioned?
Yes, the vehicle almost struck my daughter.
Do you recall seeing the driver?
I looked the driver right in the eyes.
And how did the driver look?
Like you.
The driver looked like through me.
What do you mean through you? Describe what you mean by through you.
That's true.
I feel that it is very hard to explain that look, but it was very frightening.
That was your stare? Looking past you?
So is he going to use this
You recall
one
what the driver was wearing?
witness to try and prove insanity?
The
Because he's not in a
driver
right state of
had
mind?
a like hoodie sweatshirt or sweatshirt on, and something on his head. I wasn't sure if it was the hood of the sweater or maybe a beanie hat. It was winter. I'm not 100% sure.
Were you able to see any hair?
I did see hair, yes.
How would you describe the hair?
The hair on the head was in front, like dreads down here from what I could see underneath the hood or the hat. And then there was facial hair, beard and mustache.
Did the
Hold
vehicle?
on, I just need to make a record of, she was also using her hands, that's okay, to indicate at the neck, like under the chin, neck area, with her hands coming down a few inches to indicate what she was describing as hair being seen from the driver. Thank you. Go ahead, sir.
When you observed the vehicle approaching, was the vehicle speeding?
When the vehicle was approaching from White Rock, the vehicle was not speeding at that time.
I would argue that if you're approaching a parade, any speed is speeding, irrespective
To
of
the
the
best
posted
of your
speed limit.
knowledge, do you recall there being any barriers
A
present where
no
you were
car
positioned at?
zone.
Exactly.
Do you recall if the vehicle you observed had any tinted windows?
I do not recall.
Guys, I think we just raised like
Were you
$5,000
able to make
for
out a
that
license
GoFundMe.
plate number of the vehicle, being that
Well done, chat.
it had
Good
passed
work,
so
chat.
closely by you?
No, once the vehicle continued past my position, I was more concerned about my children that were with me.
About 150 new donations, give or take.
I'm assuming at some point you spoke with the law enforcement about what you saw that evening. Would that be fair to say?
Yes,
And do you recall what agency that was?
I do.
And what agency was that?
The FBI.
Dirty Ezio says, Mom, can we have Britney Spears? Mom, we have Britney Spears at home. The witness, Britney Spears at home. Come on. Now.
That's a bit harsh.
I'll take it.
At what point were you not able to see the SUV once it passed you?
I lost sight of the SUV once it went into a bunch of people.
Do you recall what date it was that you spoke with the FBI agents on? Was that the same evening or a few days after?
It was not the same evening of the parade, but it was that week. It was within the next
Holy
few
shit.
days.
Guys, they're just that GoFundMe is now just under 6,000 shy of the goal. That means we've raised over $8,000 on the GoFundMe there. So I'll share it one
The
more
day
time
you spoke
in
with
case anybody else wants to help
FBI
contribute.
agents,
No pressure, obviously, but if you
do you
feel
recall
like it's
stating the driver was wearing a
good
red
cause.
top that appeared to be made out of a sweatshirt-like material?
I don't recall exactly what was said to the agent, but I do remember the sweatshirt, yes.
A red sweatshirt?
It's possible.
Just a little bit ago, you said that, well, when asked the question of did you recall hair for the driver, you stated and made the gesture that the hair was in front. Do you recall saying that?
Yes, sir.
Do you recall when speaking with FBI agents stating that the hair was pulled back?
The hair appeared to be like possibly in a ponytail, but it was so full that it was coming forward.
Solly Walnut says, is it fair to say that he is acting especially like an asshole because he doesn't respect women? Maybe.
It's always a possibility.
Sure, he respects
Do you
anybody.
recall?
He might just want to respect him with his fists.
Well, let me back up. Did you leave the parade at that point?
At what point?
After seeing the vehicle.
Hang on. After seeing the vehicle, what? I want to hear the words come out of his fucking mouth.
Yeah. After he's seen it. Raynote says the judge needs to repeat his questions back to him verbatim. This will cognitively resolve the conflict in his head, and he will just switch into listening mode. Freighter
Were you
J.
injured the evening of the incident?
Yes.
You were injured?
Yes, I was.
Any reason
thank
why
you,
that's
Band on the Run.
not reported?
Probably because I didn't tell anyone else.
If you were injured, why not tell anyone?
Less than $500 from their goal, guys.
Because I haven't wanted to talk about the traumatic
Holy
experience that I went through for
$14,000.
still reliving the weeks and days after the incident.
Yep. Were you injured? Yes. I
Doesn't
didn't
make
want to
any
talk
sense.
about it.
Talk to
Thanks for bringing that up again.
FBI agents a few days where you said you didn't. To be fair, you said you didn't know. You said it was
They
that week,
apparently just hit the goal, guys. You guys are fucking crazy cool.
the same week. You spoke with
Wow, that's
FBI
awesome.
agents.
That's
Reported no
incredible.
injury.
They didn't ask me about injuries.
Well, would it be fair to say that kind of information would come up when talking to law enforcement, seeing as how you yourself work in law enforcement? It just seems odd, don't you think?
I do not. I was not physically injured.
Oh.
Oh, fuck you.
I'm glad we cleared that up.
Mm.
But you didn't report this at any time whatsoever. Grounds.
Sustained. Already answered.
So did you speak to anyone about this in law enforcement?
Objection made.
Grounds.
Overruled. She may answer. He clarified law enforcement. Did she speak to anyone about this in law enforcement? I interpreted this as the injury.
Right.
So go ahead.
I feel like, no, I did not.
But now all my coworkers know that I felt emotionally traumatized. So thanks for bringing it up.
Yeah.
Did you
Excellent.
file any claims related to the incident?
Oh.
No, I did not.
Do you know the plaintiff?
Because she's a dispatcher, so theoretically, if she had mental trauma as a result of it, that could potentially impact her work, couldn't it? I don't know how it works in the US.
Theoretically, yeah.
Mm. She had a very specific reason for not mentioning that. So thank you, Darrell, for prompting that to the entire world, literally. Fuckwit.
You wanted to keep that private affair.
Mm.
Robbed her of that little bit of dignity, didn't you?
So today, your first time bringing up your alleged injury?
No, it is not.
Oh, there you go. WM Trekker says, yes, it can. I work with dispatchers. So, yeah, she specifically would have been trying to keep this to herself.
Again, it's the testimony isn't
At some
helping
point,
him.
you were subpoenaed by the district attorney's office to testify here.
He didn't ask the follow-up question.
Testify in
He
this
asked,
trial. Would that be fair to
did
say?
you ever talk about it?
Yes, it is.
She said yes.
Do you
He
recall
didn't
when
ask
you
with
received
whom.
that subpoena?
From the district attorney's office, it was in July.
And do you recall whom you spoke with about the information regarding the subpoena?
I contacted the victim witness advocate, Carrie Peterson.
You contacted the Ms. Peterson after receiving the subpoena.
Correct. The instructions told me to.
That's true. She may have felt survivor's guilt as well.
You ever spoke with anyone directly at the district attorney's office?
No, correction. Yes, when I walked in today, I met there and let them know I was here, and then they walked me into a room, and I waited until I was called.
So before today, you had no interactions with anyone related to the district attorney's office besides I think you said victim advocate?
So the victim advocates who I've been in connection with and letting me know when to come and all of that.
You guys rock in the chat, by the
Three
way. For all your
district attorneys
donations.
seated to my left at this table.
Well done.
Have you had any interactions of any kind with any of those three district attorneys?
I have not.
And I believe, just for the record, when you asked that, Attorney Basie was just pointing to herself and the two people next to her, so it's clear, because since there's two tables.
What would be the reason for that?
Since there's two tables of individuals, I think she wanted to make the witness aware. And I just wanted to point it out for the record since it happened.
Working in law enforcement for 16 years, I'm sure this isn't your first time being involved in a trial. Would that be fair to say?
With Debbie Farrah's Day? What the?
I have not been in a trial for law enforcement. No, I have not.
You've never
She's a dispatcher, dude.
She's a dispatcher.
witnessed a trial, sat at a trial, been in a trial?
I have not.
Thanks for making this a first experience, Darrell. It's going great.
Something she'll remember for the rest of her fucking life, you prick.
In any way before today?
That's your all this.
Rounds.
Overruled, you may answer.
I have testified before, yes.
So it would be fair to say that you would have knowledge of where an alleged defendant and the district attorney would sit in the courtroom, correct?
I know where they're sitting, yes.
So does anyone that's ever watched any sort of criminal trial. That is not a basis for bias
by
against you.
process of elimination, there are two sets of tables. One of them is you. What must the other table be?
It's a good point.
Want to back up a little bit to
You want to back up to
observation
before
of
you
the
called
vehicle,
any of these witnesses, is what you
evening
want to
of
do.
November 21st, 2021.
I wish we could back up to the point where his father withdrew.
While you observed the vehicle approaching your position, did you see it strike anyone?
I did not see the vehicle strike anyone, no.
All right, wrap it up, Darrell. Time to be a big boy and go to the big boy house. You earned your treat.
Opinion, observing the vehicle approaching your position, did it appear that the vehicle attempted to strike anyone?
Yes,
And why would you come to that conclusion?
because I saw an officer have to jump out of the way in order for
When
the,
it was approaching,
when it was,
question was when it was approaching.
I'm
Hold on,
confused.
hold on, everyone. The question was asked, this witness is going to be allowed to answer the question fully without interruption. Go ahead and answer the question.
Thank you. I misunderstood his question, I guess.
Answer the question that as you understood it.
Yeah, so I saw that an officer had to get out of the way. And he was attempting to stop Mr. Brooks from driving through the parade, and he was at the last minute jumped out of the way from the vehicle. Otherwise, he would have been struck.
You just used the name Mr. Brooks for the first time that you've been testifying.
Fuck
Would that be fair to say?
I don't understand your question.
You just used the name Mr. Brooks for the first time since you've been testifying. Is that fair to say?
That's fair to say, yes.
Why haven't you used that name before? You've been up there for quite some time.
Because that hasn't been necessary in the context.
I didn't need to.
There you go.
That works.
So what changed for the last question that you needed to?
I don't
Phrasing of the fucking answer, you moron.
You just stated that you didn't mention the name before because you didn't need to. So what about the last question that you answered made you feel like you needed to use the name for that question and no question before that?
Can we get his fucking mother up there already so he can answer what name is on his birth certificate?
There's no answer to this question. He's just trying to confuse you.
Mm-hmm.
I don't know is the right answer. Let her go, Darrell.
Yeah, you guys have raised over $20,000.
Out of curiosity,
for this
how did
family.
you come to the knowledge of that name?
Blown away, guys. Crazy.
It was on the subpoena I received last week.
You just stated a little bit earlier in your testimony that you received your subpoena in July. Now you said last week.
Those are both correct.
So you received two separate subpoenas?
Correct.
What was the difference between the two?
One was from the district attorney's office and one was from you.
There you go.
So
That's the right answer,
one that you
'cause it's
received
your
from
witness.
the district attorney's office in July
Who is the plaintiff?
didn't have a case caption on it?
Oh my God.
Okay, what's a case caption?
Good answer. He doesn't know either, sweetie. It's okay.
Just 1 second. 1 second, Your Honor. if I may
I just
have.
have that first line of questioning. I really don't know what the relevance is for
You know exactly where he's going.
purposes of this trial.
There was no objection at first.
There's that.
There is one now.
I'm going to sustain the objection under 906-11. I don't believe it advances.
I think
trial.
I think you know where I was getting at with the question.
Then you need to ask your question directly, sir.
Hurry up and fucking get to it.
I'm sustaining it as to the form of the question.
When you were subpoenaed in July by the district attorney's office, the subpoena didn't contain information to the case you were being subpoenaed for?
Objection to relevance.
Grounds.
Sustained, you don't have to answer that. I sustained the objection on that, those grounds. Ask the question I believe that you're trying to ask, not that one.
Was the name that you mentioned, Mr. Brooks, anywhere on the subpoena that you received from the district attorney's office in July?
Objection, relevance.
Grounds.
Oh, sustained.
You're lucky Mr. Brooks isn't around.
Grounds for the sustained.
Not relevant.
Wasn't that a Liam Neeson movie where he was a hired murderer?
Is it? Is it mind-boggling? Is it, Darrell? Is
Probably
it?
for him. I mean, he's operating with a brain the size of a pea.
Sir,
Yeah, when his head
in
moves, it
July,
does
when you
boggle.
received your subpoena from the district attorney's office, were you even aware what you were being subpoenaed for?
Objection.
Objection, relevance.
Relevance.
Sustained. Not relevant.
Grounds.
She's testifying in the trial and it's not relevant that she got subpoenaed?
Mr. Brooks, she's here under your subpoena.
What?
You subpoenaed her, you
called her
idiot.
as a witness. It's
The
your
subpoena that you...
She's
the
there as
subpoena-
your witness under your subpoena.
It's
The
relevant.
details of your case.
Under 90611, please ask the witness a
This is
relevant
mind-boggling.
and probative question.
This is mind-boggling.
It's not mind-boggling if you know anything about what you're doing, or if you had a
Remind
lawyer.
the jury that the statements of the parties or the attorneys are not evidence.
Don't give in, Judge. Don't humor him. Just let him say his stupid thing and move on.
So were you aware that it was a chance you would be possibly testifying in this trial?
Yes.
Yes.
Generally,
And
what a
did you
subpoena
know what
means.
the trial was for?
Objection.
Grounds.
Sustained.
Grounds for the
relevant.
sustained.
It's not
I've
relevant.
never heard of nobody testifying in a trial that they didn't know who the trial was for.
What does that matter?
Mr.
I mean,
Brooks,
obviously that's
I'm
It's
sustaining
relevant.
the objection under 90611, and I'm asking you to move on.
Y'all, this ridiculous, man.
Although I will say, I
Oh, the
agree.
court knows all about it. I'm sure they'll love hearing from you, Darrell.
I agree the objection is fine and the judge is ruling correctly on it, but like, why not just let her
Seems
answer?
to me like a like a lot of your answers are coached. Is that fair to say?
Look at the GA's.
So the subpoena that you got last week, is that how you learned the name that you used?
Objection,
Grounds.
relevance for the same reason I argued. before.
Grounds.
Asked and answered. She's indicated the answer already. 90611, sir. Next question.
The question
Different
was,
topic.
is that the first time that she saw the name?
It's not relevant.
That
Next
was not
question.
asked and answered. That was not asked nor answered.
Under 90611, please ask a question, sir.
Man, what is y'all people trying to pull up, man? This is ridiculous.
Mr.
Very
Brooks,
nice.
if you don't
Lovely
understand
with
the
these
question
questions.
is
Thank you for the
relevant,
witness's
probative,
time. Bye.
90611, then I will turn the witness over to the state for their cross-examination.
And then I should be able to get redirect, right?
The state's thinking themselves no, because I'm not going to cross-examine.
That would be hilarious.
Your Honor.
Ask a question, or I will declare the examination by you to be ended.
It's not an examination, it's direct.
It's a direct examination, sir. Under 90611, you are directed to ask a question, or I will
I
ask
heard,
the
I heard
state
you.
if they
I
have
heard
any
you, Your Honor.
questions.
I heard you. I heard you.
Thank you. Next question, please.
Don't you stare her down, you piece of shit. I haven't agreed with everything that this judge has done throughout this trial, but at this point,
The judge is just
No,
being
the
too
plaintiff
differential.
is
I mean, that's
in this
really your criticism you can be. It's
Yeah.
just too differential
Who's the
and not
plaintiff?
authoritative
The
enough.
state of Wisconsin.
Is that an entity or a living human being?
Objection.
Grounds.
relevance.
Not relevant, sustained. Next question.
Have you ever had any interaction with the plaintiff?
Objection, vague.
Sustained.
Vague.
As to the form of the
Have
question,
you ever had any interaction with the state of Wisconsin?
do not answer that question. Next question, sir. Under 90611.
Was there an objection or was that just a ruling? I'm not sure.
The sua sponte objection. She can make objections herself.
Under 90611.
She
I
doesn't
direct
need the
witness
parties to
not
object. She
answer
can do
that
it.
Relevant question. Ask your next question, sir.
Let's not tell him that though. Sorry. Because he might bring up a whole other shit
Look at
about
that
the
mean
being.
mug. I love it. I love his mean look. It's like me giving someone a mean look because he's got
Mr.
bitch
Brooks?
shoulders like I do.
Ask your next question.
I'm gonna get to it.
Thank you.
I'm sure you are. Oh. You see what he did with his lip there?
I'm gonna get to it.
So when did you first report your alleged injury?
You do not have to answer that question. Next question, sir.
Jesus Christ.
Grounds for
90611. Sub 1, sub A, sub B, and sub C.
She's had enough.
It's lawful
All
law,
right.
yes.
You may sit down. Does the state have any questions for this witness?
The judge actually pulled the trigger on something finally.
Right now,
Amazing.
they're saying, do we bother or
fucking
do we
time.
just screw him out of his redirect?
Ma'am, that day on November 21st of last year.
The
you
state
were there
has
with
questions
two
for her.
kids?
They had subpoenaed her. They
I
just
was,
weren't going
yes.
to call her
What
because
were
they
their
didn't need
ages on
to.
that date?
objection?
3
relevancy?
and
Overrule, the witness may answer.
Of course, it's gonna be overruled.
It's because it wasn't a valid objection.
3 and 6.
Gotcha, bitch.
And I don't know. Don't pick this out. I'm asking the question. Shirley.
Mr. Brooks, please sit down.
Sit down or you're going to get removed.
Mr. Brooks, you're not asking the questions.
I'm not saying
I would
anything.
ask you to sit down, please,
Stop saying please.
to this witness
Just order him.
and to the court.
No, it's not. Not doing anything wrong. I'm merely standing here.
You don't get to stand right now.
Shit. Here we go again.
And when you were at the parade on November 21st of last year, approximately where were you watching the parade from?
Asked and answered objection.
Mr. Brooks, it's cross-examination. Just because you asked the question initially and she answered does not mean the state doesn't get to follow up on it.
So they can ask the same question I
The
asked.
state can ask.
Yes, they can.
Yes.
As a matter of fact.
And I did that.
Overrule,
It was
the witness may
the
answer.
same.
I was on Main Street, but right by where the intersection of White Rock, and I was in the roadway.
I'm going to show you what's been marked and previously admitted into evidence as State's Exhibit 15.
Go ahead.
And I ask that the screen be cleared. And ma'am, does this show?
Wait until it's in the jury
Oh,
box.
sorry.
I'm sorry. The jury would let me know when it's there.
Wait, what's happened to the jury?
Thank you. It's there now. Go ahead.
They're
Yeah,
waiting
just
for it to
get the
publish
full
to them.
Yeah.
line, on that would indicate the parade route going from White Rock Avenue down Main Street.
Yes, I do.
And can you approximate where you and your kids were watching the parade?
Yes. Do you want?
If you, I'm sorry, it's a touch screen. I keep forgetting to say that. Touch screens, just put a dot right where it is.
It's not the
Maybe on the other
clearest
side of
I've
that
ever
red
seen.
line?
So, okay, can we clear the screen and maybe just put a dot? I think that, or a circle. I think a circle would be good. Okay, thank you. Would be fair to say is to your left would have been Pleasant Street?
That is correct.
Were there barricades blocking Pleasant Street?
Yes.
There were
Objection, asked
ba-
and answered.
I'm pretty sure she.
There were
Didn't she already say that she
barricades
couldn't record?
that were partially block. They were on Main Street, but partially blocking Pleasant Street as well.
Could a car have gone down Pleasant Street?
Yes.
Objection.
Overruled. The
Hearsay.
witness may answer. Not
Abstain.
hearsay.
So when the red
Hearsay.
SUV came down White Rock Avenue and was making its turn onto East Main Street, as you testified, it could have just gone straight onto Pleasant Street, correct?
That is
Objection.
correct.
It's hearsay. She's speaking as a
Hold
person.
on.
I
Not
would-
There's
hearsay.
no
She's asking
objection.
what she observed. That's not hearsay.
Mr. Brooks, your
What did you
objection is
see
noted.
is not
It's
hearsay.
overruled. The
See,
witness may
usual.
answer.
hear.
It's always overruled.
Yeah, because you're always fucking stupid with them.
Sorry, there's a lot of talking. Your question was, just to clarify, could the vehicle have gone straight onto Pleasant Street? Is that right?
Yes,
Okay, yes.
thank you. And where you stated that you and your kids were partially in the roadway when the red SUV came through?
Yes, we were.
Objection. That's mischaracterization of what was testified to.
Overruled. The witness may answer. Go ahead.
Give me an answer.
Can you repeat it?
Sure. Were you and your kids all in the roadway when the red SUV went through?
Yes, we were.
Okay. You weren't part of the parade, correct?
We were not.
Okay. So were you standing with other people that were in the roadway?
Yes, we were.
And was one of your kids going to get candy when the red SUV came through?
Yes, my
Objection.
daughter.
Speaking as a first-hand eyewitness.
Because she is a
No, I'm talking about you.
The objection is noted. It's overruled. The question is proper, and the witness may answer.
Yes, my daughter was further in the roadway. We were all on the road, but she was further in the roadway, reaching to grab candy.
At any other time, you said that this was towards the end of the parade. Is that correct?
Yeah, we saw Santa, and he's always like the end of the parade.
And had your daughter gone to get candy at other times?
The entire time.
Had she, during the time preceding the red SUV coming through, had she almost been struck by any other participants in the parade?
No, she was nowhere near like where the vehicles were driving through the parade. She was no.
So she's going out to get some candy that had been thrown, I assume, correct?
Yes.
And
Overruled. The witness's answer may stand.
Fundraiser's now at
this red SUV
$85,000.
coming, is it coming from your right or from your
You
left?
guys so very, very much.
The red SUV was coming from my right side, which was White Rock.
Okay. And how close did it come to your daughter?
It was, I wouldn't be able to give an accurate judgment, but it felt very, very close.
Had you not pulled your daughter away, would that car have hit your daughter?
Objection. Speculative.
Overruled.
It's very possible.
So you say that you saw a police officer have some contact with the red SUV. Do you recall that?
Yes.
Can you describe that for the jury?
Well, there was a few times that police officers attempted to stop the red SUV. The first one was Ben, where we were on Main and White Rock. And then there were also other people trying to stop it too. And then again, as it drove, once it turned onto Main, the next road, I believe is Buckley. And there was another officer who tried to stop that red SUV again.
And which is the officer who had to step out of the way in order to not get hit by the red SUV?
What was the question?
Where was the officer located who had to step out of the way to avoid being struck by the red SUV?
I believe that was the officer around Buckley and Main.
And ma'am, as the car passed your location, did it increase its speed?
Yes.
Do you know where in the roadway it traveled down?
Objection. Speculation.
Overruled. The witness may answer.
You watched it go. It's not
The direction of
speculating.
travel?
Where in the road? Was it on the left-hand side, the right-hand side, or in the middle?
It was all over the road.
You saw it all over the road?
Yes.
So going, and why don't you
Yeah.
describe for the jury what you saw?
Driving the vehicle, once it turned onto Main, it drove side to side, and then I lost sight when there were through the people as it got down the hill.
Nothing further.
Thank you.
Oh, go ahead and redirect that. That'll be great.
Been standing this whole time. Lol. What a jackass.
She should have removed him. She
Mhm.
ordered him to sit, and he didn't do it. Remove him.
She asked.
You said you observed multiple officers try to stop the vehicle. Is that correct?
Yes.
You described one that I think you said it was Buckley, right?
Yes.
Why didn't you report the other officers that you allegedly saw attempt to stop the vehicle?
I don't know what you're asking.
The report that the interview that was conducted with the FBI. That was who did your interview, correct?
Yes.
Why is it not in the report about the multiple officers that you say you saw attempted to stop the?
I don't know is the right answer. I didn't write the report.
I don't know why that wasn't put in the report.
Amazing.
You call if you told the FBI agents.
It's been a year. I believe so, but it's been a year.
When you say it's been a year, I'm assuming that means that there's some details you don't quite recall all the way. That be fair to say?
Yes.
So it'd be fair to say that if there's details you don't recall, how can you recall path of travel of the SUV that you claim you saw?
I watched it.
Can you rephrase the question? I'm not understanding.
Not understanding because it's a dumb fucking question.
Clear, but I'll ask you.
It doesn't really matter what you think. She's the one that asked.
Acknowledge that
As long as you don't drive again, we're fine.
there may be some details that you don't quite recall.
Right.
So would it be fair to say that you don't quite recall the path of travel of the vehicle?
No, that is not correct.
Judging by what you just stated, would it be fair to say that that's a possibility?
Nope. I remember that.
She just
pretty
said
well.
no.
So you recall all the details of what you observed that evening, November 24th?
No, that's not what she said. She said she
No.
removed the path of the vehicle. You're not very good at listening to women, are you, Darrell?
No, he's really not.
So what other details do you not recall?
I'm not sure.
Oh,
How did someone recall the details that they don't recall?
Yeah, that's what I wanted.
Sustained is to the form of the
Some
question.
details, not others. Seems very funny.
It is funny.
It
because
was
it's an
worth laughing
insane
at.
question.
Seems
How do you know
almost
what you don't know? I mean, it's possible under some circumstances,
Want to
but
recall and purposely not recall.
Objection.
Don't.
Badgering the witness.
Yes, sustained. You do not have to answer that, and you are warned. You may not badger or argue with this witness. Next question.
Badger or argue.
ooh, Judge Mommy is a little bit peeved.
Next question.
About fucking
She's-
time.
One of the things courts take really
Don't
seriously
intimidate the
is
witness,
not
is what I mean.
re-traumatizing people
Badgering the
unnecessarily.
witness by eye rolling, by pursing your lips, by making facial movements regarding
That's
her
Does she
answers
feel intimidated?
is badgering the witness.
Are you kidding me?
8 to 11.
Your
Close it out.
90611,
Call it a day.
please ask your next question.
You can't be serious right now. Intimidating the witness. What have I done to intimidate the witness?
The last question was badgering, which is a form can
But you
be.
said
Mr. Brooks, I've made my ruling under 90611. Please ask a question or I will stop the questioning.
How did I intimidate?
Stop the question.
Under 90611, sub 1, sub A, sub B, and sub C, ask your next question or the questioning of this
How are
witness
you
will
even a
end.
judge? How are you even a judge?
All right, you may.
Question's over. Thank you. Bye.
How are you even?
Yep, done for the day.
Come on, man.
Ooh, bailiff's up and ready.
Q trust, right? That you want to be the beneficiary of.
I'm going to give the jury their closing instruction. We are done with testimony for today. Please do not begin your deliberations and discussion of the case until all the evidence is presented. And I have instructed you on the law. Do not discuss this case among yourselves or with anyone else until your final deliberations in the jury room. This order is not limited to face-to-face conversations.
You guys have met people
It
who
also
do that
extends
they'll like
to all
mutter
forms of
under their
electronic
breath.
communications.
You ever
Do not use
seen
any
anyone,
electronic
even
devices
outside of
such as
court,
a mobile
where that has
phone or
worked out
computer,
in their
text, or
benefit?
instant messaging or social networking sites
Fuck no.
to send or receive any information about this case or your experience
Such
as a
petulant
juror.
behavior.
If you come in contact with the parties, lawyers, interpreters, or witnesses, do not speak with them. For their part, the parties, lawyers, interpreters, and witnesses will
Think
not
the judge is going to
contact or
spank
speak
him or
with the
just end
jurors.
it?
Do not listen to any conversation
I
about
hope she spanks him. I
not
really do.
research any information that you personally think might be helpful to you in understanding the issues presented. Do not investigate this case on your own or visit the scene either in person or by any electronic means. Do not read any newspaper reports or listen to any news reports on radio, television, over the internet, or any other electronic application or tool about this trial.
I'm gonna stare her down.
Dictionaries, computers, electronic applications, social media, the internet, or other reference materials for additional information. Do not seek information regarding the public records of any party or witness in this case. Any information you obtain outside the courtroom could be misleading, inaccurate, or incomplete. Relying on this information is unfair because the parties would not have the opportunity to refute, explain, or correct it. Do not communicate with anyone about this trial or your experience as a juror while you are serving on this jury. Do not use a computer, cell phone, or other electronic device, including personal wearable electronics applications or tools with communication capabilities, to share any information about this case. For example, do not communicate by telephone, blog post, email, text message, instant message, social media post, or in any other way on or off the computer. Do not permit anyone to communicate with you about this matter, either in person, electronically, or by any other means. If anyone does so, despite you telling them not to, you should report that to me. I appreciate that it's tempting when you go home in the evening to discuss this case with another member of your household, but you may not do so. This case must be decided by you, the jurors, based on the evidence presented in the courtroom. People not serving on this jury have not heard the evidence, and it is improper for them to influence your deliberations and decision in this case. After this trial is completed, you are free to communicate with anyone in any manner. These rules are intended to assure
We'll see what the
that
court
jurors
does and then
remain
read the
impartial
chats in
throughout the
a
trial.
minute, guys.
If any juror has reason to believe that another juror has violated these rules, you should report that to me. If jurors do not comply with these
Staring down didn't work.
in a new trial
Gave up.
involving additional time and significant expense to the parties and the taxpayers, you are to decide the case solely on the evidence offered and received at trial. I'll have the jurors report on Monday at 9 a.m. Thank you. You are excused. Please rise for the jury.
Call yourself a judge as much as bias you put.
Shut the fuck up.
Tell the jury the truth.
Don't tell the jury the truth.
Got no integrity whatsoever. None.
Who's the softball player they brought in to beat him up?
None.
Uh-huh.
Thank you, everyone. Please be seated.
Oh, here we go.
I would like an update on whether Mr. Brooks filled out a subpoena for Don Woods and provided that to the state. Has that been done?
Nope.
No, we haven't received anything, Your Honor, and obviously, she can appear here voluntarily if Mr. Brooks wants to arrange that. I don't believe a subpoena is necessary. We had subpoenaed her, and she was under state subpoena. So I know that at least some point she had notice, but our position would be, Your Honor, that we will not be responsible in any fashion for producing Miss Woods. Mr. Brooks talks to her on a daily basis. If he wants her here, he can produce her on Monday.
Yeah, they ain't got to worry about that.
So I just wanted to know, because I know a subpoena form was filled out.
If I want her to be here, she gonna be here.
I agree with
So
the
just
state that.
know that.
Just know that.
She could certainly appear.
It ain't even got to be no arrangement. All I got to say is come. She gonna come.
Jeez, what a pile of trash.
That simple.
Mr. Brooks, do you intend to call her as a witness? Because I'm directing you
We
to
said-
have her
we
here
said
at
all
9
that- We said all that at the beginning, man. Like, I don't even want to be in here that much longer. Just do what you got to do so I can get up out of here. I'm tired of being in the courtroom that has no integrity whatsoever. How can you even call yourself a
Mr.
judge?
Brooks, I need to make a record of
I need to make a record too.
You don't.
When
need
am
to-
I gonna get the chance to do that?
You've
All
been
right,
making
I
a
need to
record
make
the
a
entire
record. He's being
time.
removed to the other courtroom. He is yelling at me. He's not going to let me make a statement or make the record that I need to make.
I'm finna
He
lose
hasn't
anyway,
sat
so
down
we'll do it
for
now. You
the
can
better
hold
part
me
of
in
2
contempt all
hours.
you want. You can
At least
hold
you
me
know.
in contempt all you want.
I'm not
All
holding
you
you in
gotta do is tell me
contempt.
if it's criminal or
Tase
civil, so I can hit
Right.
you with you.
I need to
with
clear
what you
the
know is
courtroom because
coming.
I do need
I'ma
to
give
make.
you
One
what
little
you
button. You can do it.
I need him to go to the
If
other
it's civil-
courtroom because I do need to put some things
If
on the
it's civil,
record. The record should
where's the
reflect
contract between you and
that
I?
Mr. Brooks
If it's
is
criminal,
yelling at me.
what is the
Just do it.
crime?
He is.
Who makes the claim?
What is the crime?
And what
There's
is-
70 of
I
them.
will make the record when we get back. I will step off, but Mr. Brooks,
Stop.
you're being
It ain't
taken
no
to the
Mr.
next
Ain't no Mr.
courtroom.
Brooks. Don't try to address me
Thank
like
you.
that, like we cool. You don't have no integrity. How can you even call yourself a judge? Making
He's not your
executive
friend,
agreements,
pal.
being biased, judicial misconduct, trying to steal somebody's system.
Well, it's going well for Darrell Brooks today.
Hmm.
He's doing fine. What do you guys think? He's gonna win? Gonna pull this one out?
I think
just
the
like
jury looks like they're getting this on Monday or Tuesday, and I think the jury is returning this on Monday or Tuesday.
Yeah.
And I think he's going to prison.
Kurt, if the jury gets this on Tuesday, they may return it Monday.
That's a strong possibility, Dick. This is
this-
infuriating on every possible level.
Yeah, this guy was such a pile of garbage. Absolutely. Look, it is hard to suggest that someone who's about to be put away for their entire life have like a bit of respect for the system that's doing it. Like, I get being frustrated with the system, but there's also just a way to act that is completely non-beneficial to you, and he is checking all of those boxes.
Yeah.
Like, if this, maybe it's a 4D chess move. Maybe he thinks that by being ridiculous, the judge will be afraid of over sentencing him due
I
to
don't
bias
think so.
and will mitigate it. I don't think so either. It's a gamble, Kurt.
I'm not
It's-
sure what the sentencing possibilities are, but the judge could max this out and go consecutive, and no one's going to care.
Yeah.
So I think there's like 1,000 years or something. Like if you put this all sequentially, and I don't think the Court of Appeals will care about that either.
Right. And if he gets even one intentional murder, even one where they say, yeah, you were accelerating into that crowd of people, driving a car, and you intended for that to cause death.
Yeah.
Or, then you're done forever. And, it was really interesting today that he elicited a piece of testimony that stuck with me. I don't know if it would stick with the jury, but part of the, establishing intent is kind of difficult sometimes. And there was a piece of testimony that came today from one of his witnesses, who was the dispatcher, where she said she looked him in the eyes and he looked through her.
Mhm.
Like, to me, it's not tangible, but that's the type of intangible detail where a juror goes, oh, like this is someone who did not regard a human as alive and was just an object in their way type thing. And that would be, for me, that would be one of those things that would be like, that might seal the deal on intent. Where otherwise there could be theoretically some ambiguity.
Maybe
I don't
for
think
the
there is,
first
but
one, but somewhere around number 6, I'm sure you kind of lose that argument a little bit.
yeah, especially when number 6 is like half mile up the road
Yeah.
from number 1. But man, he's a monster. God. Holy shit. Okay. Oh, we coming back, Judge?
That's what
Soundwave
she
TM.
said. She wanted to put some stuff on the record. So yeah.
Yeah. I just was hoping she was actually back already. Soundwave TM3 says, Rekieta Law, I gave 50, but wanted to say this is why I watch you. Not only do I get the best law education with a side of grift, but you have honor and strong family values. Take pride in the fact there's no other law tuber like yourself. Well, there can't be. I'm not in law tube. Appreciate that. Thank you very much. It's very, very kind.
At this, well, I've already made a video saying that LawTube isn't a thing, so
it can't be. It's if it is, it's a disaster. So it just shouldn't ever be.
I think was it Joe who said it's a genre?
Yeah, I think
concept or something along those lines.
Said it was a genre. LawTuber's a genre. That's probably the best way of thinking about it. Instead of it being a group, it's a genre.
Yeah. It definitely should not be a group ever. That it just definitely should not, in my opinion. Of course, I said this back in May. I think it was.
Yeah, you were smarter than the rest of us.
No, Kurt, don't give me that. It was just experience. I've been through this in several previous groups on the internet, and I saw how all of them worked. They all went the same way, and it always happens. So
we're professionals. We're better than that.
Oh, Kurt, you're killing me. You're killing me. I love lawyers. Exeter says, "Hey Nick, first Rumble super chat. Hey, thanks, buddy. How you been?"
To reflect that Mr. Brooks is in the adjacent
we'll get this in a
courtroom.
minute.
I have verified the audio and video are working appropriately. I need to address some scheduling issues, but before I do that, I need to make a record that at the very end of, after I read the closing instructions, Mr. Brooks started to make disparaging remarks about the court in the presence of the jury. I did not respond to those. And once that jury left, he got incredibly loud. He was yelling at me. He, I think, had been standing for the better part of the last couple of hours, even though at one point I directed him to sit down after the direct examination of the last witness. It was apparent to me that he was not pleased with some of the rulings that I had been making regarding objections. I would just remind him that this was a witness he called. Therefore, it's proper and allowable under the law, under 906.11, sub 3 to be exact, for the state to ask leading questions.
We know.
Which they did. And at the very end of that, there was an objection based on badgering, which, as the record reflects, I sustained. His voice got louder. He continued to stand. He was being very argumentative with that witness who, again, he called. Given his posture, given his staring, given his pursing of his lips, given the way that he kept asking the same question in different ways, but over and over, not satisfied with the responses that had been given or the court sustaining the objections, that is why I made a finding at that time and sustained the objection for badgering. It was Mr. Brooks who asked me what that meant, and I indicated it's a form of intimidating a witness. I don't mean that in the sense of there's a charge of intimidating a witness. That's not certainly what I meant, but really in the common everyday usage, it's another word. It's a synonym for badgering. Clearly, he was displeased with the court. After that, I cut off the examination, which I had given a number of warnings that I would do if he didn't ask an appropriate, a probative, a relevant question. During that time of both the, frankly, even during his direct examination, definitely during the state's cross-examination and then redirect, it was very apparent to this court, and I think to anyone who was watching, that Mr. Brooks was not pleased with the witness's answers and would roll his eyes at her, or just to himself, I guess, but and purse his lips and make other
Reading the
gestures
Bible.
that
Lol.
he did. That it was apparent to this court he did not like her testimony. And again, I'd remind everyone that it was his witness, and he had the police reports for this witness, and obviously was fully aware of her statements to the investigators in this case. So I just wanted to make a record of that. It's in part why at the very end, and given the history of today and his conduct and being removed previously, I thought it important that the court remove him at the end of the hearing outside the presence of the jury so that I could get through a couple of things. We have gotten through the witnesses for which Mr. Brooks issued subpoenas that the state assisted with. I did provide permission to him earlier today, if he so chooses, to call Dawn Woods as a witness. The only other witness at this point that I can identify that's been, for which the court and the state has been put on notice, of course, would be Mr. Brooks himself. I'm not looking for an answer today, but what I wanted to put on the record and what I will put on the record are certain advisements that he can certainly contemplate over the weekend, so that when I do the colloquy with him on Monday morning, he's had a sufficient opportunity to think about his decision to testify or not to testify. The advisements that I will give Mr. Brooks at the moment are as follows. Mr. Brooks has a constitutional right to testify. If he chooses to testify, I'm further advising him that the state has the right to ask questions of him, what is referred to as cross-examination. That may include reference to whether he's been convicted of crimes in the past. I still need to make a ruling on that, and I will do that first thing Monday morning. I will also advise him that he has a constitutional right not to testify, and that a decision not to testify, that a jury will be so instructed, not for that, they will be instructed that that cannot be used against him in any way, and there's an appropriate jury instruction on that. If he chooses to testify, the other jury instruction that is typically read simply advises the jury to assess credibility no differently than how they would assess the credibility of any other witness. There's the added paragraph to jury instruction 300. I would further advise him that it is his decision and his decision alone on whether to testify. I will ask him whether anyone has made any threats to influence his decision on whether or not to testify. I will ask him whether anyone has made any promises to him to influence his decision.
You don't have to tell the record what you're going to do for the colloquy. Just have the colloquy.
Will rely upon my
He's also telling
upon the record, specifically the record made during the waiver of attorney regarding his education. I will ask him whether he's had any medication, alcohol, or drugs within the last 24 hours prior to the colloquy. And I may also confirm that he's able to read, write English. Again, I may also refer back to the colloquy I had during the waiver of attorney hearings. I will then ask him whether he's made a decision, and then ask what that decision is. And then based upon his decision, I, of course, will make an appropriate finding. Given how this trial has progressed and the disruptions and some of the issues with, excuse me, consent or lack of consent, or that Mr. Brooks sometimes raises, I'm also going to advise him today that failure to answer the question on what is your decision, a failure to answer, this court will interpret as a no, meaning he will be choosing not to testify, and the jury will be so instructed. And I may ask that question more than once, depending on the circumstances. I'm also going to direct the parties to some cases that I think may become relevant about potential testimony, the scope of it. Chambers versus Mississippi. It's a U.S. Supreme Court case from 1973, found at 410 U.S. 284. Rock versus Arkansas, also a U.S. Supreme Court case, 483 U.S. 44. State versus Anthony, which is a Wisconsin case, 2015 Wisconsin 20. These cases, of course, recognize that a defendant in a criminal case has a fundamental constitutional right to testify in his or her own defense. Of course, that right stems from various constitutional provisions, including the 14th Amendment, which protects a defendant's due process rights to be heard and offer testimony, the 6th Amendment, which protects a defendant's right to call witnesses in their favor, and the 5th Amendment, which protects a defendant's right against compelled testimony unless he chooses to speak on his or her own behalf. I'd also point the parties to State versus McDowell, 2004 Wisconsin 70. Although the right to testify is a fundamental constitutional right grounded in personal autonomy, it is not absolute. There is no constitutional right to present irrelevant evidence. State versus Robinson, 146 Wisconsin 2nd 315. Moreover, a criminal defendant's right to present relevant testimony is subject to reasonable restrictions. Citing to Rock versus Arkansas, there's a balancing test that if and when this court is faced with any of these situations that I will be prepared to go through.
You're going to go through them.
Illinois versus Allen is also important, and all of the other cases that I've cited along the way. State versus Anthony is also important, as I've noted previously. I've relied heavily, of course, during the course of this trial on 906.11. And the primary purpose of a criminal trial is to develop relevant facts on which a determination of guilt or innocence can be made. Efficiency is a secondary objective of trial. And of course, it is the circuit courts and the judges assigned to those circuit courts that are charged with administering the trial and serving these two purposes. So just tying up, I guess, the last loose end. I've referenced it already, but I think it's worth repeating again. If the defendant wishes to call Ms. Dawn Woods to the stand, I expect her to be here. I expect one of two things to happen. Either he testifies first or he doesn't, or he calls. He can certainly call her after he testifies, but if she is not here at 9 o'clock, when I've advised the jury to be here, I will, of course, have gone through the colloquy with Mr. Brooks. And I expect people to be on time and to be ready to go, to be fully prepared. And then, of course, the state, if it so chooses, does have the option to call rebuttal witnesses and offer rebuttal testimony.
We would not anticipate that as of right now, Your Honor, just so you know for timing.
Thank you. I appreciate that. Because once the evidentiary phase of the trial is closed, of course, I will be sending the jury home because I do anticipate a very lengthy jury instruction conference
God, it's going to be brutal.
It's my hope that that is something we can get done by the end of the day on Monday. But since it's
like
just
4
the parties
hours
and
to
not
read them at the beginning, right?
a jury here, I will go as late as it takes, with the hope of and with the plan
Good.
of
Look for a
again,
long day
when
Monday.
the state doesn't call any rebuttal witnesses, to
Oh, man,
start
it's too bad I'm gonna be out
instructing
of
the
town on
jury on Tuesday morning. I anticipate that is going to be an incredibly lengthy process.
Oh shit! No,
We have been
Tuesdays.
working.
No,
Madam Clerk has been working
Busy?
very hard.
Monday's going to
on,
be his testimony
pulling
day. That'd be a
together,
good day.
just from what we have thus far, the
Yeah.
jury instructions.
You're not
think
available
it's
Monday?
well over 100 pages. Yes, with my advanced eyes, I need 14-point font. So with that caveat, but the preliminary instructions were 69 pages with the 14-point font.
Oh, joy.
So I know it's going to take some time.
69.
I know
Nice.
I'm going to need some breaks. I do not anticipate getting done with, sorry, I keep saying preliminary, but I don't anticipate getting done with the advisement of the jury instructions before the lunch hour. I can't tell you how long it's going to take. It may take the whole day, but the party should, well, the state would go first. So the state should be prepared, perhaps to start closing arguments.
9 hours with that monitor.
I'll ask you on at a later point, probably sometime on Monday, if you have an idea of how long that will be, because that will frankly dictate in part like where we are with how long it takes for me to go through the instructions, and whether I just instruct and then bring the jury back the next day for closing arguments. But that's generally the framework that I intend to follow.
Yeah, so the jury's getting this on Tuesday or
Any
Wednesday,
questions
basically.
about
is what
any
we're
of
learning.
that from the state?
Nothing about any of that, Your Honor.
Anything you think I need to address before I turn to Mr. Brooks?
We do have two things to clear a record about.
Go ahead.
Do that now.
Yep.
The first is for the testimony of two different witnesses. We provided Mr. Brooks with summaries of those witnesses' statements as recorded in the police reports. First was Deanna Aldrich. That included a piece of paper containing 3 paragraphs, which summarized Ms. Aldrich's statement to the Waukesha County Sheriff's Department as they were memorialized in supplement number 55 under an incident report number of W21087731. The second of those was a 1-paragraph summary of the statement provided by Jason Hayes to the City of Waukesha Police Department, memorialized in supplement number 28 under incident report number 21047493. These were, again, documents that were provided to Mr. Brooks in the discovery process, but we sought to be helpful in his presentation of evidence here at the trial today. The second issue that we'd like to make a record about relates to the testimony of Erica Patterson. So for the record, I think it's important to note that the 2 photographs the defendant attempted to show that witness and presumably put into evidence depicted what I believe to be the defendant and Ms. Patterson's 15-year-old daughter, as well as their new grandchild, the daughter's child, who was born
15-year-old child?
May 1st of 2022.
Apparently.
Looks like
I think that
mother,
there was
like
ample
daughter.
grounds for the court to end Ms. Patterson's testimony when it did, but for just in case that becomes an issue going forward, I'll make an offer of proof that Ms. Patterson, if asked about those pictures, would have testified that she did not provide them to Mr. Brooks. She provided them to a person named Michelle, who I believe is a mutual friend, who in turn provided them to John Woods, the defendant's mother, long day, who then, that was the person who provided them to Mr. Brooks. If she were forced to answer questions about this supposed letter that Mr. Brooks was claiming to exist, she would have testified that she has not written a letter to Mr. Brooks since he came into our jail on November 22nd. She didn't write one on November 21st either. At any point between his being taken into custody and today. It's my understanding that he has tried to call her from the Waukesha County Jail on 37 occasions. She has
has a
never
restraining
accepted
order
a
against
single
him.
one of those phone calls.
Lovely.
And finally, during the early lunch break, I was informed by the bailiff staff that the defendant was twice offered to go to his cell to retrieve that letter that he talked about. He declined both times.
Thank you. I appreciate the record being made. I will now unmute Mr. Brooks and ask him if
Why y'all be
there's
lying on the
anything
record? Why y'all be
he
lying
needs
on the
to make a
record?
record of at this point on the topics that have been raised.
He hadn't been listening to the topics raised.
No, of course not.
Nope.
He got cuffed.
So this, anything you wish to address before we break for the day?
Yeah, I wasn't really hearing everything that was just said good, but
And you have your headphones on.
why haven't I been given the chance to offer all my filings and the evidence when I already stated that before?
You have to
I
introduce
would
them
like
to
all my filings. I would like every single filing that I filed placed into evidence. Every last one of them.
No.
That has yet to be done. I put you on notice and I've stated it on the record. Even before I even had a chance to start calling witnesses and put on the defense that I
Put it
had
on the record for the Court of
absolutely
Appeals if you
unable to
like,
do.
for all the fucking care they'll give.
So this is something that's been stated on the record numerous times.
Doesn't matter, dude.
I did hear a reference to
Don't lie. You heard every word. You heard
whatever
every
he
single
was
word.
just talking about.
You're so performative. It's pathetic.
Whatever he was just talking about is in regards to me going to get the letter or whatever the case may be. First of all, it's not just one letter. Like I stated before, it's multiple letters.
Multiple.
And for somebody that don't even know to try to tell me what I got, like you need to cut it out, man.
Well, you had a duty to produce that to the state.
Seriously. Stop it. It seems to me that all y'all been wanting to do is gang up. Be biased, be prejudiced, and gang up.
They're just doing her nails right about now, maybe.
It takes a lot to make me be on the side of the state as a default. Yeah. But Darrell Brooks has done it.
Earlier made a record before the lunch. You sit up there and made a record about all this stuff that happened in Nevada. That's other acts of evidence, ain't it? How was you allowed to put that on record and not even be truthful about everything that you said? But not one time did somebody say, no, we're going to strike that. Not one time. But if it had been me, it would have got struck. Or if it had been me, it would have been a problem. If it had been me, I'd have been held in contempt.
You've never been held in contempt.
Why was the bond not addressed? Why was the statement of particulars not addressed?
Statement
No filings that I seem to file need to be addressed.
Your statement of particulars was a criminal complaint
After you
that alleged
sat
every
there
single
and
count
told me
against
that
you and the
that's
basis
what I
for
needed
it.
to do. Do you want to refer to the waiver of
You had every opportunity to challenge it.
counsel, which, again, for
And
the
your public
record,
defenders probably
you
did.
accepted it the way that I gave it to you, which clearly states on there, I do not waive my right to assistance of counsel. And you accepted that. But you still turn around and continue to violate my Sixth Amendment rights.
What assistant attorney did you hire?
Violate my First Amendment rights by telling me what I can and can't say. Which I have the right to say whatever I want to say and to be heard. That's the First Amendment.
I mean, not really.
You sit up here and talking about a fourth option that you came with out of the blue for Illinois versus Allen when there is no fourth option.
But the fourth option is actually a hybrid of the first and the third.
Yeah.
Then you try to sneak some other case laws in that you
It's
just came up
less
with
restrictive
today.
than both of those.
I don't know if you came up with that when you was on one of your breaks that you take, but it's awful funny that it never got mentioned before. You've repeatedly made a false record.
Fuss of false.
You want to sit up here and perpetuate all this disruptive behavior and this, that, and the third, when you knew
disruptuate
from the point of the start of this trial, one, that I wasn't prepared, two, that I did not understand the proceeding. But yet still you choose to find a way to get around it. Just like you found a way to get around answering what your name
Nobody
was.
cares.
You're a public servant. The name that you have on file with the Secretary of Treasury and State, however you want to put it.
Get that secretary.
You were asked for a certified copy of your oath of office, which you stated on the record you would not provide. Didn't give any case law why you don't have to provide that.
Office, take the oath.
There's no case law that says he does.
Jurisdiction,
public servant.
For the record, have yet to show that you even have a license to practice law.
You don't need one.
Haven't proven that yet. And neither has the prosecution. Where's the
prosecution's license practice?
Why can't I place your oath of office into the record? Why can't I make that part of evidence? The oath that you haven't even honored, not one bit. Doing enough to keep your face clean doesn't constitute
your face clean.
Being fair.
Do you reckon she's taking notes at this point or just planning it a weekend?
Look at the man behind him.
When the jury was selected,
Man's a pile of eggs.
That never got addressed in any way, shape, or form. When you were informed way before that I was striking the whole jury. So how can you go over that constitutional right, which I have the right
You can't strike the whole
to
jury.
not pass the jury?
Mr. Brooks, I'm muting you. And the reason I'm muting him is because he has not addressed a single
Actually, in
issue
Texas,
that was
you
raised at the
can.
end of this hearing today.
shuffling.
He is simply rehashing previous determinations of this court. I would describe it as a rant. He continues to impugn the integrity of this
Maybe he could
court
be on Alex Jones.
process. Again, he did not address any of the issues that I raised at the
Call him
end
from
of this
prison.
hearing. From my perspective, the issues that he is raising are all related to claims that a sovereign would make, someone who claims to be a sovereign citizen, claims that have no base, that are baseless in law and in fact. I'm not going to address them any further. Again, they are simply baseless. And with that, I'm
Can't
going
prove
to
it on
end
the
for
record.
the day. I'll see the parties.
Can't prove it on the record.
8:30 a.m. on Monday. Thank you, everyone. We are in recess.
You still ain't giving me verified proof.
Oh God, it's over for the day.
You ain't giving me verified proof. Record. Nice. I like that. That was good.
Yep, that was good.
Let's see. We can remove that for now. Oh my God, that was terrible. just 9 hours of terrible, though. That's fine. That's fine. Well, gentlemen, any closing thoughts? Verified proof. Verified proof on that record. On that record.
You remember when we used to discuss law? It was nice.
Well, Kurt, tell me about why the plaintiff cannot be the state of Wisconsin.
I got nothing.
Have you met the state of Wisconsin?
I've never been to Wisconsin.
You've never seen the
No,
plaintiff?
that's not true. I flew through Green Bay once.
You flew through it? Like you
Yeah,
landed in
as a
Green
layover.
Bay?
I had a
Or you
layover- I
just
had a
like,
layover in Green Bay once.
I just didn't know if you were talking about like elevation rights or whatever over the city of Green Bay.
Yeah, no. Yeah, so I guess I have met the state of Wisconsin. It had nice
Okay.
cheese hats.
Given the state of Wisconsin is an entity, can either explain to me why the court couldn't just say it's an entity, the representatives are sitting right there as the prosecutors, have at it. Like, I don't understand why you can just say that, or that set
Okay.
a precedent that you don't want.
Well, first, there isn't a plaintiff in a criminal case. That's
No, obviously.
artifact of civil law, and so I think they're hesitant to just engage that at all. But the
Mhm.
other reason I think that they don't is because the inevitable follow-up argument of the sovereign citizen is that entities cannot be persons, therefore cannot have rights. You guys, we all know that corporate personhood has existed for a very, very long time, is well-established law, is respected basically in all Western countries, and Western systems of law that we would be with the common law system. So we're all fine with it. Sovereign citizens will just deny that that is a thing that is okay. And so you're just pushing. It's like if the football is on the 50-yard line, you're just pushing it to the 51 by saying there's the representatives of the entity. Because if we went with entity law, you don't even have to have a corporate representative present in the courtroom most of the time. You would just have, if this were a civil case with a plaintiff, they could just be represented by counsel. They wouldn't actually have to be present. You wouldn't have to have anyone. So, I mean, your argument is sound, but the party you're engaging is irrational. And that's the issue. I think that they're just trying to just move past it. Because the court and so many courts have held that there is no merit to any sovereign citizen argument, that it's almost absurd that it is as popular as it is. Not that it is that popular, but even that there's any inkling that, no, bro, your case is going to go great though. Like everybody else loses always, but yours is definitely going to be, you've got the magic word this time. So I think they just don't want to engage the argument at all. They're well grounded on well-reasoned precedent to just ignore it completely. So that's my thought on it. I don't know, Kurt, anything different in that?
No, you're asking the question like the answer would in any way satisfy him. That's the problem. Like, yeah, that's the right answer legally, right? It's an entity and that's their representatives. Of course, that's the right answer. But it's like it doesn't satisfy him because there's always one more thing. Like only a person can be harmed. Only a person can bring a complaint. Only a person has rights. And then this idea of lawful law, which I still don't know what that even is supposed to mean. Even in soft sit speak, I'm not sure what that's supposed to mean.
No, he has this. He has adapted or adopted or misunderstood even sovereign citizen stuff, like the lawful law. He accepts for value, but then returns for value, which I have not done the most research on, but I cannot find what returns for value means at all.
No, nor can I.
Yeah, and
Makes
so
no
it's
sense
like
whatsoever.
he's like adding some of his own math boy fly flair to it.
Yeah.
I hope he.
And then like the stuff like I need a certified copy is like I need the original with the office. I mean, no, there's no satisfying it.
Yeah,
like you can produce all these things, it wouldn't matter. And the judge has to some degree. She's written an order. It's like, what's the law? It's like, well, here's the statute that creates the courts. I mean,
Do you
there's
know
that.
what would satisfy me, Kurt?
Probably roughly the same thing that would satisfy me.
A jailhouse rap album from Math Boy Fly with only sovereign citizen raps. Except for value, verified copy, oath of office. Listen to the tracks that this man could create.
You can call them in from the jail cell to the recording studio.
Subject matter jurisdiction.
Yep.
Gives a certain level of authenticity if it's got that crackling on the phone line and they have to have the you have a collect call from such and such prison. Do you accept? And then he just starts rapping.
Yeah, that analog that
Yep.
That'd be great. Oh, that'd be fantastic. God, I'm gonna call him up. We can guys. We can go fund me this. We'll give him some commissary money as part of the
We're gonna go visit
GoFundMe.
him in jail. We'll go visit him on Visitor Day. How's it going, Darrell?
Oh my gosh. let's see. Just an update on that GoFundMe, guys. Have raised over $25,000. $25,554 is the current number. You guys seriously blew me away with that. It's crazy town. I took a gander at the comments, and it's just like from Rekieta Law, which none of you should have done, but I'm really glad that you all did. Thank you. But that was just awesome. It's just a huge show of support. And you know, if the mom of that family reaches out, I will pass on the deepest prayers and hopes for their family from you guys. Okay. So, and I'll let you guys know if she reaches out, and because a lot of times when we do stuff like this, people will actually, you know, come out and say thank you and give me updates and stuff. So I will keep the chat informed on that. That was just way too fucking cool that you guys did that. So Exenter says, hey Nick, first Rumble super chat. As a lifelong Wisconsin resident, I can definitely say that the accents are way thicker down in the Milwaukee area. Holy hell. They're pretty brutal. Hail to Skin says, for Andrew, I have 0 followers here, but Nick has $20. I still love you. Thanks. Aunt Debbie, you know how he picked most of his witnesses, right? He took the state's list and called all the witnesses that they decided not to call. Damn. Hey Steve, what's up, man?
Hey.
Did you happen to catch the end there?
Oh, wait.
Yeah, get your headphones on. Who is this boomer and how can he be like this? The bonus track on the Jailhouse album is Stephen Gosney. Steve, you with us?
Hey, how are you?
Good, man. Did you happen to catch the end of the proceedings today?
I just, hold on a second here. I got to get, okay, here we are. Can you hear me?
Yeah, we got you.
Yeah, no, I just got, man, you guys are insane. I just went, picked up my wife. We went out to dinner, had sushi, and drove back home the slow way. And I come back and you guys are still punishing yourselves on this trial.
Steve, how do you come back into it? How do I like you when you leave the stream, but shortly after you come back, I hate you?
I have that effect on people.
Okay, well, the ending was pretty dramatic.
What happened? Tell me, fill me in.
Oh, I mean, he got removed. He blew up at one of the witnesses. All of the witnesses were terrible for him. Pretty much. Especially once Cross was done. We had a mom who had 4 children hit by him. That he called to the stand. That was probably not the best move. Her children all lived but had severe injuries. Then we had like a police dispatcher who the state elicited the testimony that, or he did. No, he elicited the testimony that she's been suffering like from trauma from witnessing what she witnessed that day and stuff like that. So it was all terrible. He got really mad about everything. She kicked him out of the room, made a record. She finally was just muting him and just making the record. And then she let him speak for a while. He addressed nothing for about 5 straight minutes. And then she cut him off and he was just having a hissy fit the rest of the time. He did get shackled when he got removed, but that was outside of the presence of the jury. They were dismissed for the day. And then when they removed him from the courtroom, when he showed up on the other thing, he was in full wrist chains.
Insane. So. This guy, oh, what a pathology he has, huh?
Yeah. So now what we're doing is just reading through the super chats. And by the way, guys, if you're still listening or if you're on your way out, before you go, click that Rumble Plus button, click the thumbs up, let Rumble know about this channel, let Rumble know that we're here. We're going straight to the top of the damn list. I'm going to take the charts over. I'm going to make Dan Bongino cry. I'm going to do everything, okay? But I need your help to do it because this is meritocracy. Thumbs up means up the ladder, and I want to always be on the top rung. So with your help, we can do it. Okay, Surveyor 8587 says, DB's strategy will make sense when he says the prosecution rests, Your Honor. Corpus Delect Says, I mean, Nick has a big nose and this chick has a stacked rack, but her nose looks like a dong when she looks forward.
I came back for this.
That's rude. You did. I don't know why you would do that.
Well, it was playing in the background. My wife says, "Who's talking in the house?" And I'm like, "I don't know. Is Nick still on?" It's like,
yeah, we gotta get done here. Team Ruby says his closing argument is going to be David Brooks standing up and saying everything they said is bullshit, not lawfully lawful. Very good. Very good. My cousin Vinny, if it were David Brooks. Freighter J, this case is making my pee-pee soft. Genkin, he brought in the ex in just to abuse her one more time. Yates Networks, what up, you sexy beast? That's for Rackets. He loves when the chat talks dirty to him. Gay. Well, all of that was true. Genkin says, we have a pedo that committed murder. Where is Kyle Rittenhouse when you need him? You can find him
I feel it.
You can find him on YouTube. You can find Kyle on YouTube. He's got a YouTube channel now. He announced it with Brandon Herrera, and it's growing. So go check it out. He does gun stuff. You know, it's almost like there was some YouTuber who said during the trial, like right at the end, something like that. He said, Kyle Rittenhouse, if you just reach out to me, I will make you a millionaire on YouTube right away. And instead, he listened to people that dragged him to like Fox News and CPAC and a bunch of bullshit and didn't capitalize on a year of the hottest publicity he would have ever had. And it drives me fucking crazy that that's how that went down. Kyle could have. The Dragon's Treasure says, imagine how mad the jury must be. They leave, sat in silence for 45 minutes, get called in, they sit and are immediately told to leave again. Yates Networks, order in the courtroom, you angry knitter. Jackass rumble censor. Wow. You know where you're not censored? Locals. Macam 75, he should have stuck to finger blasting. Phil Booty, Steve, I don't think she is afraid of the appellate court. She's afraid of the cameras and being called an istophobe.
actually, that there's a lot to that. I mean, when I was watching her at one point, I was thinking, she's not really protecting the record here. She's playing to the she's so very aware that she's on camera. So that's interesting because that has an effect on people when they're in trial. It shouldn't, but it does.
And even if she may not be concerned for herself, it's very possible she's concerned for the city of Waukesha. And the potential. I don't think Darrell Brooks is that sympathetic with even some of the most radical elements of race baiters.
Yeah, the Black Lives Matter people are like, wait, I don't know about this guy.
Yeah, I think he lost most of that as the evidence really came out, but that doesn't necessarily matter, and the judge might be cognizant of the risk to Waukesha if there's a perception of impropriety. Carts 312 says she's worried about the race card being thrown about. Sejong the Great, this comes across as a judge being unable to speak as a figure of authority to a person in a minority. It comes off cucky, like she's got a social justice slant. Warrior Biatch, Steve, come to Wisconsin Dells, water park capital of the world. We would gladly meet you for dinner or drinks. There you go.
I've had a lot of nice comments of course, I've been nice to Wisconsin, I guess, but I mean, aren't the witnesses and everybody there just the sweetest people? I mean, this is typical American flyover country that gets ridiculed. And here, these are the best people in the world. I mean, these are great people. And I'm just blown away. I mean, we have Florida Man here, but I mean, the people this is the people that make the country run and make the country great. And I'm just impressed with all the witnesses. Even their felons and thugs are polite and kind. I mean, it's amazing. They're like, well, maybe.
Except for Darrell Brooks. No, but the state of Wisconsin.
Minnesota, right?
No, I think. Oh, he could be.
Where's he?
Makes sense. I thought he's from. No, he's from Milk. I don't know. No. All I know is that the state of Wisconsin runs on beer. Royal Plague 45. Show the hot Downs woman from the Jack Show. Lol. No. Not. We'll do that tonight or something. Fry Dog. Hey, Nick, YouTube is effing us over by raising their family premium costs. They got to make up the money they are losing by trying to cancel you. Oh, and by the way, I'm unsuspended on YouTube officially now. So I have put up my first community post, and you can expect a YouTube video. I don't know if I'll get it out today, but it'll come out today or tomorrow. Ellie Fan.
One thing we should the discussion that Uncivil Law and I had on the death penalty, I thought was I watched it back, and do you mind if I clip that and put it on my Rumble? Because
Go for it.
Because I think it was a very good discussion. I really enjoy. I mean, like I said, he's an intimidating guy over here. He's a very smart and he knows what he's talking about. So it's fun to go against somebody like that who does know what they're talking about. And we have a debate. I think it's a pretty elevated debate, and I really enjoyed that. And I think that was something that people should go back and watch. And I'd like, maybe I'll just clip out that half hour and put it up. If you don't mind,
You have my full permission to clip anything from my show. Go for it.
Well, Kurt was on there too. Is that okay, Kurt?
It's not his, it's mine.
Oh, is it yours? Well, but I wouldn't want to get on his bad side.
I'd say I'm shocked, but that community post you mentioned went out an hour ago. I didn't receive any notification.
Yeah, no.
So.
It's gonna take some time for those notifications to do anything. Elifant says, my grift in November, there will be an interview on my Substack with Megan Fox. Sign up. Elifant, ELIEPHANT.substack.com. Also, she's going to have an interview with me very soon too. CF Herman says, Rackets, today is my 16th wedding anniversary. Can you toast to my wife, putting up with me for the last 16 years and giving me the best 3 daughters a father can ask for?
I told him to go for 4. The first 3 were great,
I have 3 daughters, Kurt.
Yeah.
I don't have 4. They're the greatest 3 daughters that a man could ask for. And if that answer were 4, that might change. I'm sorry. What was the CF Herman? Happy wedding anniversary and a massive toast to your wife. Since you're here on this channel, I can only imagine she's a saint for putting up with you. May God bless you and your family. And may those 3 daughters keep the hair in your head as long as possible, though it may gray. And may they bring you nothing but joy and satisfaction and pride. Cheers, buddy, to 16 more years and 16 after that. AV Tamata, I formally request that in one unbreaded reading you replace Binger with Grounds. We'll think about it. Dreader62, I'm way behind here, but remember that he had Erica Patterson's Georgia EBT card with him, plus he was trying to shake her down for $350 cash. Yeah, he's a monster. Blackjack21, the only thing that changed is the stream audio is playing. The most banned queen, hey, you bingers with a hard B, how do we have 20,000 watchers with less than 10,000 rumbles? Give Nikki some love. It's a good question. Jacob McQuaid, Brooks has single-handedly made me pro-death penalty. People like him do not deserve the gift of life. Something awesome. If I'm his appellate attorney, I'm arguing she abused her discretion in not removing him and allowing the jury to see this prejudicial mess.
Now, that's kind of like ineffective assistance of counsel on yourself.
Yeah. The other thing is, most of the stuff that happened, even though he wasn't removed, was outside the presence of the jury.
Yeah.
So most of his outbursts, I mean, he had a couple mouthy things and back and forths with the judge, but usually once it got past about a minute to 2 minutes in front of the jury was dismissed, even if he wasn't ultimately removed. But at the end of the day, there's no way to prevent someone from prejudicing themselves. Because even if you had to remove the jury with every single time or remove him every single time, that would also prejudice him. This guy is such a bad actor that we have to be shuffled out. Every time he raises his voice, we got to be shuffled out. So I think the judges made a fairly happy medium with her removing the jury. I think she should just be more direct with him, put him in the other courtroom, tell him you will come back in at this time and no sooner, and you'll work from there. Not this, you go over there and immediately can apologize and come right back. That's way too disruptive.
And now catch me up on this. Is he done with his witnesses or are there more on Monday?
There should be, his mother is a potential witness, although he didn't file a subpoena for her. So she'll have to show voluntarily, which I think she'd indicated prior that she would not show up to testify for him, but that may have changed. And then he, I think, is his last potential witness. So, and they'll
right. He may testify on his own behalf. That's going to be a show.
Yeah. Monday, there will be a colloquy with the judge about his testimony. It seems she indicated that today. And yeah, so his mom. I think that's the only two witnesses that would be left.
And then
Yep.
what's going to
And
happen is
the state said no rebuttal case today.
okay, good. Well, and then there's going to be a
So,
jury instruction charging conference, right? And
That's
gonna be
yeah,
fun.
Monday,
No,
and that's it.
I thought it was Tuesday
Well-
for the. No, the conference was Monday. You're right. Yeah.
Right.
And
Yeah.
then Tuesday would be the actual jury instructions. Both of those are going to be long. She said the conference, she will stay as long as is required. And then reading the jury instructions is going to take 3-4 hours, I think, on Tuesday.
It just so people know, every crime that's charged, and I think there's like 70 something crimes here, every one is going to have a page of instructions, and it's going to repeat over and over. And it's going to say aggravated battery on John Doe 1, and aggravated battery on Jane Smith 2, right? And she's going to have to read through that whole thing. And they got a degree on that. So she's going to be going through those pages with him, asking him, what do you think about this? What do you think about this? Oh my gosh.
Yep.
And some of those probably have lesser included and alternatives and all kinds
gonna
of
be
things.
a
So yeah, it'll take
mess.
some time. But we're looking at the jury getting this Tuesday afternoon, and we're looking at being convicted Tuesday afternoon.
That's right.
So,
I can't imagine. Like I think the jury may put some sort of show into it, but I think it'll really be as fast as they can sign the documents. I mean, couple hours to like give a perfunctory read through of everything as they sign it and determine if it's all just straight guilty. But why that first of all, it's going to be hard for the jury to sift through 72 different crimes specifically. So I think they'll just think of them as a group. Like, did he do these things? And I think it's really going to come down to, did he do it with intent or not on any of the questions where there's either intent or just like knowledge or whatever.
They're going to go
recklessness.
through that as quick as they can. But you know, another thing is that are they going to sentence him immediately because these are all min-mans, or are they going to set it off for a month?
I don't know. That'll be in Minnesota, they'd set it off. But there's discretion.
it probably matters whether or not if Wisconsin has some sort of right to victims' right portion where they have the right to.
Right. Oh, that's good. Right. You're right.
Right
about
to
that.
address the court.
Yeah, and the
which
state
would
will
delay
probably-
sentencing.
Yeah. That's where I forgot about that. You're right.
Yeah.
So
the other thing
is that a state by state thing in the US? It's not an automatic thing.
Yeah.
It's a state by state thing.
Wow. Okay.
But a lot of times, if you get like somebody convicted of life in prison on it's one count and it was a murder or something, a lot of times the state will already communicate the victims, and then they go right into it. And it's like, okay. And as soon as the jury goes out, they go right. Okay, we're going to go into sentencing, and they go life in prison. Boom, you're gone.
Yeah. The thing that would make me think that there's going to be a delay, though, is all of the lesser charges that don't have life in prison as an option. He's going to have a pre-sentencing investigation.
Well, no, she's not entitled to that. In Florida, they're not entitled to that if they have prior felonies.
Okay,
they're only
yeah,
entitled to that on
that's
their first
possible.
go round. But they'll probably do it because she's going to want to write up the order so that she can pronounce it.
Yeah.
Yeah.
Manders 13, the most frightening thing is she's mirroring his for the record BS, true sign that she's lost control. Xander Shade. So we've seen a bad prosecutor in Rittenhouse, a bad defense attorney in Edgecombe, and now at least an ineffective judge in this trial. Oh, if you wanted an ineffective judge, you would just look no further than Curtis Reeves. That judge was terrible.
Mhm. Oh, she was, yeah. And she had good she had attorneys in front of her. See, this is probably a good judge, but she's over her head, and I don't think, she's unused to this type of situation. If you were a public defender and a prosecutor in her courtroom, I'll bet you she's great. But this is such an unusual case, and she's not handling it well. So we're getting a bad impression of her from the, through the eye hole, right?
At least we're not getting an impression of her through the pee hole.
I kind of saw that one coming, actually.
Good. Well, you're being
I
corrupted.
feel sorry for you then.
I
Bald
knew there
Eagle,
was something up there. I didn't know. It's like, oh no.
Bald Eagle 1787 says, how much you want to bet that during the lunch, the judge is told by other judges that she can shut him down to go after him and the appeals court will side with her? No, she knows. Engineer says, one last time, 80 times later. Noah R. Klein, what would happen if a lawyer behaved like this to a judge? They'd be arrested. They'd be arrested, possibly sanctioned. You would
the bar
not
would
want
have words, I'm sure, at this point.
you would not want to be that lawyer.
We're so far down the line. I mean, the first thing that he was just the rolling the eyes thing. Contempt immediately. But see, we all have something to lose. He has nothing to lose.
Right. Doogie Hauser says either he gets turned on by his woman being mad, he can fantasize it with the homies in Big D Block, or she hates one of the prosecutors, so this is her spite for them. Okay. Touch the Riot says, does anybody else have a problem where to see the Rumble rant field, you have to chop Rekieta's head off? Wait, maybe that's a good thing. I keyed. Outcast. Yeah, I'm going to be talking again. I'm in talks with Rumble as they will talk with me. I've proposed a bunch of changes through the chat. They listen to some of the stuff that we say in here and they see it in the chat. So they're implementing changes. So hopefully it gets better soon. Outcast 77, thanks for showing up. You're the best. Oh, hey, you're welcome.
How are they just not paying you as a like sponsored person at this point? Okay.
DZYDVL1776. Oh my God, my friends have to be losing their shit. This motherfucker severely injured their son, a member of the South MB. My God, I need a drink. Damn. Tell your friends that we hope their son gets better, and makes a full recovery and gets over the trauma that they probably have from this. Engineer, if the jurors are Catholic, it's just another Sunday in court. Stand up, sit down, stand up, sit down. Knife and Lantern, if Brooks does go up as his own witness, how does that work? I assume he can't ask himself questions. It kind of depends on how the judge wants him to do it. I think she'll allow him to make a statement, just sort of a narrative statement for about 15 minutes or something like that. Give him some time limit. Say, here you go. Here's your testimony. And the state can object while he does it. They probably wouldn't bother. And then, unless he goes off into the weeds, and then the state will do cross, and that's how that will work. And it'll be a terrible decision for him to do that.
Doesn't matter.
Yeah. I mean, Touch the Riot says, dang, I was so hoping he was going to start questioning when I get out of the red SUV, did you see the other red SUV that hit those people? Blackjack 21, that's teenage dirtbag era Nick. Why is he dressed like Drex? Look, I don't know. Glib facsimile, Your Honor, I request a motion to Sneed, where previously the court had determined ownership of said article by Chuck on the grounds that we feed and Sneed. Country Girl Charm 13 says, first Rumble rant. Just wanted to say how much I've enjoyed your coverage with various guests. Hey, thank you. I think I responded to you in the chat, but thank you again if you're still here. Glib facsimile. Alexa, play the Jeopardy theme song every time I do not consent to being called that. Stares at his notes. Fake name. How'd I've done it if I was a Kang? No, I'm saying, Your Honor, it wasn't me, because grounds, whites be bad, females is hoes. Polyfrog 64. Hey, Nick, just want to say, please keep streaming on both Odyssey and Rumble. It's worth it to have it as a backup. Wishing you all the best. I don't intend to change anytime soon, but well, we'll see. Blackjack 21. Would a count be added to Brooks's trial? I don't think at this point they would bother adding a count to anything. They wouldn't have any reason to. Polyfrog, Darrell Brooks drinking game. Take a shot every time you hear grounds, objection, sustained. You'd be dead. Takul says, I'm far from an idiot, Your Honor. Object, fact, assumes facts and not in evidence. Dreader 62, I spent 20 years in the Army. His behavior earns a blanket party. Oh, shit. Andrew War Snowboard, Eurovita is unironically the best tea on Dragon's Treasure. Iceman, finally made the YouTube jump. My life is much less breaded now. Manders 13, would her leaving the bench in reaction to his behavior give grounds to the judge no longer being impartial? No. Iceman, that is purely my interpretation of a stylistic choice where I think the judge just looks better if she stands up at the bench while he's taken away, mainly because I think she's losing control of the courtroom because he's given control of it so much. That's just my personal opinion on how to handle it. Iceman 1014 in Richard's voice, Your Honor, I want it on the record that I do think the opposing counsel is an idiot. Thank you. Xander Shade, in cell block A, he'll be assaulted. In cell block B, he'll be battered. And in cell block C, he'll take many big C's. Kate says, I figured it out, guys. He was so offended that these people were celebrating Christmas before Thanksgiving had passed, he had to stop the parade at all costs. Talking trash and truths, hit that plus button. Malapropist Says no chat on mobile is bullshit and breaded. Also, no dark mode. Take my dollar and complain to Rumble headquarters. You shyster strip mall liar. Okay. Il Sarto, why not call his father as well? Rude. Shot glass philosophy. Can anyone confirm that the court stenographer has the Ebonics keyboard option? Talking trash and truths. This is the type of male that lives in my town and surrounding areas. It's horrible, abusive, ignorant, and immature with such entitlement and anger that there's no reasoning with them. Fenray Wolf or Fenris WF. I have a brand new set of dental tools. I'm willing to offer my services on Darrell. Eric the Red says, according to Stacey Abrams, Darrell Brooks was merely trying to combat inflation when he drove through that parade. Damn. Corn Pop for president. Don't read this. And then he sent another one, just emptying out a gift card. Thank you for both of those. 100-star chili. Love you, Nick. Will support you no matter where you go. Thank you. You guys make it possible to move. I mean, literally, before getting banned from YouTube, when I was merely suspended and streaming on Rumble, did not look possible to move to Rumble. After getting banned from YouTube, you guys showed up in full-on support, and it looks very possible.
You know, you should really like promote the fact that you're like banned on YouTube. You know, like you're a criminal, you're a bad guy. You know, that seems like a mark of coolness.
You got
Isn't it?
3 strikes, man, and everything.
Yeah,
and rose from the dead.
So dangerous.
Baron Von Meow, Wisconsin. Rekieta, God bless you for showing the GoFundMe link. You're an absolute baller. Hey, you're welcome. Thank you. Touch the Riot says maybe if he asked and his subpoenas was better than the subpoena from the state, maybe he'd feel free to move on with face saved. Danconia Copper, Brooks was damned from the womb. His potential for psychopathy depended on his upbringing and exposure. The world produced this 12-year-old child without the intellect to control his demons. We're not equal. Sadie Girl's mom, he is lucky the judge didn't have the remote for his shock shackles. She's in the mood to push the button and let him fry. One little red hen. K. Pendejo, Kingslayer Damocles. Just remember this judge told Brooks earlier in the trial that the state is allowed to lead on cross, but he is not allowed to. Brooks is a piece of garbage, but that makes her untrustworthy, in my opinion. No, you misunderstand.
He's allowed to lead on cross and has been leading on cross.
Yes, absolutely. Cross exam, everyone can lead on cross. That's the rule of cross exam.
Yeah, and there's been no state objections on cross for leading, has there?
Nope.
I've not seen the state make a leading objection on cross. I don't think I've seen them make one on direct, but maybe they have. I think they're really letting him kind of conduct his direct outside of the questions around the jurisdiction or what is it? The other thing, the plaintiff. Project Calm, this was his strategy such that it is. He wants it on record that she cut off his witnesses and kept probing to find the minimum way to get it done. Glib facsimile. I do not consent to being called that. How can you call yourself a lawyer, Rekieta? You have no integrity. Your comments are law misconduct. I'm finna rumble up out of here because I can't get no sovereignty. Vinny D95 just saw a commercial watching F1. It was a couple that were homeowners. The wife got pregnant and said they had to sell their house, implying that if you want to be a parent, you can't be a homeowner. No, if you want... I won't finish that joke. Project Calm. Why have you not gotten it done, slackers? And then sent the GoFundMe link. We did get it done. We got it done. Guys, so when we started, it was $61,000 in their GoFundMe. They had a $75,000 goal. It's at $88,210. Okay?
What is this
We got
for?
it. We
What
got
is
it
it?
done. One of the witnesses who testified is the mother of 4 children who were struck at the parade. They all lived, but had some of them, 2 of them at least, had very
Horrific
severe
injuries.
injuries. And someone sent me their GoFundMe link, and I shared it, and the chat has raised $27,000.
I believe there were 951 donations when we started, and there are now 1,700.
Yes, it's been amazing.
Oh.
Amazing.
Somebody says it's 88,000.
88,210, yeah, is what they're at. But they started at 61. So about 27,000 has been raised, which is it's insane. Insane. Prep Boy Rick, chimping out at Popeyes is a generational thing, you bigot. Redone 77, this motherfucker has a jaw of a Tyrannosaurus Rex, but sounds like Snoop Dogg. Shit, here we go again. On Veray says the new unbreaded. DJ Mass 66, those Wisconsin accents are as irritating as lawyers. It's all good, man. Lose Cunt 79. Kurt, I gained a lot of respect for you during the last few weeks. You're an infinitely intelligent man with principles, and I appreciate that. God bless you, Nick, and everyone here. Thanks. Thanks, Loose Cunt 79.
Thank you as well.
I love the internet. I really do. It's the funniest place.
And it adds irony to that one, doesn't it?
Engineer says, I would love to see one of your clipping fans make a compilation of every time the judge says one last time or one more chance. Blue-Eyed Roof Korean. Steve, a simple clip of the death penalty debate will not suffice. Please collaborate with other panelists for a longer form debate. I listen at work. This stuff keeps me busy. Thanks for covering, Nick. There you go.
Well,
I think both and would work.
Yeah, we can do both. Well, I'm working on a long form article on the death penalty. Really, I have a death penalty module in the law of self-defense class, so Braca's doing, and it's a lot of work. I mean, it's such a complex issue, and I really want to do like a arguments pro and con, and then weaknesses of each, and make a very kind of working document where we all can kind of work off of. So, if anybody has ideas, well, I'm working on it. I'll just put it that way. But thank you for that. And we did have an interesting debate. I thought 30 minutes of enlightened death penalty debate was good compared to what we usually see in the media, where people just yell at each other.
We could do that too.
Yeah, but not always.
DJ Mass 66, go to Sleazy P Martini or Sticks Hexenhammer 666. November 8th will be epic. Potentially criminal. No judge would be ready to handle this case. Lugmeister, maybe the GoFundMe passes 90,000. It might. Tankrat.
For what it's worth, Steve, I'm not maybe as strongly pro as our conversation might have indicated. I think Darrell Brooks, as I'm sure you can appreciate, is bringing out my more primal side and might have led to a more aggressive posture than otherwise.
I'm with you. I'm feeling
with
it.
a more nuanced position.
I agree. I understand. I'm with you.
Tankrat says Ethan Klein was banned from YouTube. And then he said, actually, he was suspended for a week. Let me say this about Ethan Klein. I know nothing of the circumstance other than I think it was some dig at Ben Shapiro that may have been quote unquote anti-Semitic. And I'll say this very, very clearly. I think Ethan Klein is an unfunny, sad pile of garbage who supports the deplatforming of a whole bunch of people. And that is a shit fucking position for him to have. And I still don't think he should be struck for making a joke or even a statement that people may disagree with, because that's the principle I adhere to. But maybe he'll learn.
No,
he won't. But maybe somebody will learn. Oh, wait, maybe striking people for a joke or a different opinion isn't a good thing.
But you said a dirty word. I never hear dirty words.
Yeah.
Yeah.
I look at Ethan Klein, I think dirty words. Barb loves mostly fat jokes. Barb loves Alaska says, whichever prison he may go to, can they reject having him there? No. Well, the inmates can. M. Nordquist 56. How long do you think the jury will take to deliberate? Over under 30 minutes. Deliberate or return a verdict? Because they have to fill out 70, however many verdict forms. And just doing that takes time. They have to go through, check off the elements. They have to probably answer a couple questions about it. And then
reading the verdict's going to take forever.
Right. And if there's enhancers, they've got to read through like whether those
We're going
enhancers
to
apply.
bind and gag him during the reading of the verdict because it's the only way he's going to shut up.
Yeah, I can't believe you punishing me. You didn't even let me get on the record. Okay, Soundwave TM3 says, Rekieta Law, have you ever thought about starting courses on teaching certain topics of law? I have briefly thought about it, but someone who's actually doing it is Andrew Branca, Law of Self-Defense, and Steve Gosney is the first professor of criminal law. So you can actually check that out. I think there are more courses coming.
Yeah, we're in the middle of it. He's going to do
I
a
asked him
con
to
law.
teach. I asked him if I could teach a con law segment, and he said they were good. So I was like, well,
I think he's
screw
got
you
somebody
guys.
in mind. I'm not sure, but he's got somebody, because I'm just pouring everything I have into this criminal law class. But I'm not sure what his plans are going forward. But I think he's going to do like a whole sequence of law school type classes, and then he's going to bundle them, because we're in it doing it live now. But then I think he's going to do it on like a DVD bundle or something. But it's his. I'm just the employee. He's the one that's in charge of that.
Yeah, because I think you can pre-buy multiple modules as a bundle or something. I'd heard about that. I don't know if that's actually live, but I would pay for that type of understanding of your thoughts on how you look at issues and how to properly defend them. Again, bro, thanks for everything you do. And my bad from before. You are the best law splainer. Lol. Oh, thank you, no, I've talked about, or I had talked about this, and I have a kind of an idea for something like it, but not something as thorough as a class. There are people who are better at teaching that than I would be, but if I were to do like a class segment, it would be more like a homeschool supplemental module or something where like it'd be aimed at a high level discussions for teenage kids, basically to get introduced to constitutional law or criminal law or something like that in a really like more fun and high level way, rather than really getting down into a law school level course. That's kind of more my avenue of teaching. But I do have some ideas for some other stuff as well. So just stay tuned. He also says, I also help out with Timcast. So if you want help with setting up anything with your platforms, let me know. Thank you very much, Soundwave. I appreciate that. Del Morte, Nick, you don't need to read this, but feedback for Rumble. With the Roku app, you can't hit the plus or Rumble button, but I bet it goes towards watchers. Maybe Rumble should add a plus icon to streaming apps on TVs. Yes, they should. Absolutely. Matt himself says Johnny Depp is going to be Beetlejuice in Beetlejuice 2. Really? Cold Frost says, after that, I hope he dies of blood loss from all the asswage in prison. Jesus fucking Christ, he's a monster. C. Mason says he is calling his mom so he can see her one last time before Hung Harry gets a hold of his ass in person. Also says, I would love to see the Edgecombe judge with this dumbass. Borowski would. I actually am curious how Borowski would handle it, because I think this judge is acting very cautiously, but his demeanor was just so much different. And him just being like, no, get out. OUK 86. Any of the panel have advice on staying calm while testifying? After testifying a very emotional topic involving a child close to me, any tips would be appreciated. Thank you. Do you do any meditation or yoga? Because you want to do that first. Get into a very good place. Remain calm. But it depends on how you testify, who you're testifying for. Your emotions may not be a negative thing, depending on how that's supposed to go.
Yeah, I think be honest and be yourself and answer the questions, listen to the questions, be truthful. If you don't know what's being said, don't know the question. If you need a break, ask for a break. I mean, it's not really difficult if you were there and you have insights and you have truth to offer, then be truthful. That's the key.
Yeah, the most just important thing is tell the truth.
I was just going to say, take deep breaths, and if you feel the need to throw up beforehand, don't fight the urge. Get it all out there. Just go and do what you need to.
Yeah, absolutely. Spatula guy, sexual tension between Brooks and this judge. Wow. Hold on. Next, we've got Chininator. How many more witnesses does he have to call? Well, 2 now, maybe. His mom and himself. I think that's the last 2. Jensen Zeiger says they just need to tape down the taser button. Just running out of batteries. The real CH3. Be right back. Hugging my kid. Yeah. A lot of people were talking about that when the mom was testifying. That was rough testimony, man. Kathleen K. was, can you do a toast? Had to put to sleep Bosco, my Maltese Shih Tzu. The day before Ian hit us, he was 18 years, 4 months, and he was the bestest good boy every minute of that time. Sure. Real quick, I can do that. If I have to go anywhere, I'll just find Joe's wife and have her drive me. Let's see. We got, yes, Tabasco, and 18 years of companionship, of friendship, of family. People's pets become more than pets pretty quickly, and their loss is much more than merely losing an object that you own. And so, Tabasco, and to that family, cheers to you. Cheers to the memory of your loved pet. Okay. Hey, bail threesome. I do not consent to this verdict. You've still not shown subject matter jurisdiction, nor as the plaintiff. The state of Wisconsin appeared via subpoena. I demand this case be thrown out and that the alleged defendant be set free. Okay. And then we've got Diz Guy says, buy that tea. My favorite teas is teas nuts. Oh, God. Obshart says, Nick, I've seen many people be able to cope with ODD and go on to be a part of society. I've seen this severe of ODD rarely, but I would say that's what he has. I would say without being able to meet him, lol, he is untreated ODD, just not antisocial, which unfortunately fits with sovereign citizenship in a horribly perfect way. Well, apparently he was diagnosed with antisocial personality disorder is what the report was.
And you're saying that like when he was arrested, he didn't have any of this stuff. That all the sovereign citizen stuff is stuff he's developed since he's been in jail to now, right?
I have no idea. I was exploring, like, is he a true believer, or did he say this is my one best hope? Like, if I can just do the magic, then I'll be there. But some people have said that he's been like this forever. There are reports that he's been like this forever. I don't know. So
Let me sign off for now, okay?
Yeah, buddy. Thanks for hanging out.
Talk to you guys later. Bye.
See you, man. And if either of you need to go, feel free. Also,
I just got back on. I missed all the fun.
Yeah, I'm just trying to. I'm going to wrap up as fast as possible because it's fucking late. Obshart says, I agree with Andrea. These sort of people are impossible to work with. I've worked with youth with ODD and other personality disorders. I've seen so many staff make the same mistakes as this judge. This judge thought she could reason with an impossibly unreasonable person. Not everyone has experience with these sorts of people. I still think the judge deserves respect, and she has done her best. I should clarify when I say I have ODD, I'm joking. I am undiagnosed. I just have severe problems with any authority, but that probably came later in life. No, actually, I don't know about that. But I was able to navigate fairly well anyways. I could stay out of trouble despite the fact that I did not give a shit about anybody's orders. Horror Amarata, I have to say, at least the jury doesn't have the chance to fall asleep, but with all the in and out they have to do. Has Knuckles, hey Rackets, I was lucky enough to be one of the limited edition Glenfiddich and Mr. Porter collaboration bottles of 20-year-old single malt. Only 1,500 bottles were made, and I'm saving it for when my wife and I have our first child. Whoa, that's cool, man. Enjoy that. That'll be a treasure. Jaime Scheckelberg, I know a lot about Wisconsin prisons if you have any questions. They're not the same as California or Florida prisons. I can even tell you where he will land, and I can virtually guarantee it.
Interesting. Well, actually, that would be kind of interesting as a follow-up, just for the pleasure of knowing. You said you had a family member who was a prison guard?
Yeah, in Minnesota.
Oh, in Minnesota? Okay.
Up at St. Cloud, yeah. My father-in-law, 20 years at the St. Cloud prison. He was at the mental institute here in Wilmer before that, but then this is back in the, I guess, the 80s or whatever, when like Reagan closed all of those down.
Right. Yeah, it's fascinating because when I was a prosecutor, I used to make a point of going out and seeing where we were sending people. I'd go to commitment facilities, and I'd just take one day out of every month as my out of office, because you can get kind of tunnel vision in an office. And so I visited the prison, the local prison here, I think 3 or maybe 4 times, going through and getting private tours by the prison guards. And it was very interesting. And most people have no clue what it's like. It was a very educational topic, and that might be cool to get a guest from somebody like the Wisconsin prison system to talk about that.
Well, Jaime, if you want to email me, let me know. Or if you want to email me, and then we'll take a look. Jay Hudler, she needs to read that Sovereign Citizen PDF because all these tactics are in there. Bad Weather Biker, this is one of the reasons the media is suppressing the story. The Milwaukee DA is a Soros-backed, no cash bail DA. Eric Kahn, Brooks's whole point with Erica today, Bish, who are you sleeping with? Alto Patones, he ain't trying to control the court. He is controlling it. Jaime Scheckelberg, Nick, how would Judge Borowski deal with this one? I'm genuinely curious, although I think it would be funnier, however it turned out. Reformed Convict, Nick, the name for your supporters should be Racketeers. Take votes if you want, but you're the firm. Fuck YouTube. Fuck LawTube. Mo Zamboni, this judge's children, should she have any, have to be gigantic fucking problem. As a parent who actually tries, I am gritting my teeth listening to this. The consultant says obvious. Cool. Oh, are you talking
Oh
about the
fuck!
song?
Now I just realized I have to change my Discord name.
What is your Discord name?
The firm.
Roxif says, I'd make so many jokes at you. Roxif says, if he rests before he submits evidence, will the jury get anything from him, and can he still submit evidence? In theory, you can submit evidence at any part of the evidentiary hearing if you can bring it in. Typically, you do that through a witness. So if you can get on cross-examination a witness to authenticate some document or some piece of video, then yeah, you could bring it in. Problem is if they're hostile witnesses, they may not want to.
One thing that everybody misunderstands is that witness testimony is evidence. And like, he's like, where's the evidence? Well, you just had 20 people pointing to you and saying you're the one driving the car. All of those witness testimonies are evidence. Now, there's documentary evidence, there's scientific evidence, there's different types of evidence, but witness testimony is evidence. So, he's sorely confused about what's going on in this court. Like, we know that, but it's like he doesn't have to understand. He can be an idiot and he can still get convicted.
Yes, Soundwave TM. Rekieta law, can folks sue Ford like the Connecticut parents sued Remington? Yeah, sure, they can. But Remington wasn't actually liable for the Sandy Hook shooting. They made a PR decision to pay out $79 million. I think that was a poor decision, but it also saved the possibility of a precedent-setting case that would allow liability for gun manufacturers. You could certainly, you can sue anybody for anything ever, and you could come up with a products liability or a theory that the Ford vehicle was somehow a partial cause of this tragedy. You would need to look for some sort of defect in the design or production that would lead to foreseeable injury. That would be kind of the best way to go in bringing the case, but it ultimately would probably lose. That would probably just be a loser of a case. Again, the difference there being the politics that the gun company wanted to push in that settlement. And you can agree or disagree. I disagree with their decision to settle with the Sandy Hook families based on the theory of liability, but they agreed to settle most likely on the theory of PR. Savvy Sue says, Nick, did you see the judge say Brooks scared her today? Yes. It was kind of at the end when she was talking about him raising his voice and staring at her and threatening. I think the bailiff should tase him. I think if he does that again, if he stands up in that aggressive manner or makes that face or leans in, I think they should be ready to zap him. Matt himself says, never mind, it's just a rumor. I don't know what the rumor was. T-Man, what the fuck is this shit? Oh, yeah, Washington Post or USA Today articles about crying on the sand. Yeah. Johnny K 198, did he get vaccinated and boosters? Yes, because that myocarditis thing or SADS might actually have one benefit from the vaccine. Not a robot. Nikki Rackets going to do that possum like he did that skunk. That skunk deserved it. Mary Pari 98, best Bryan Adams music is his entire soundtrack to Spirit, Stallion of the Cimarron. Oh, I'm not familiar with any songs in particular on that one. Sheep City, and I feel bad for the janitor that has to clean his room every day. You Bring the Smoke says, please pass this off to Jeff. It's the Law Racks. We'll have to see that later. Johnny K 198, she doesn't follow through. How many fucking last times is the most deference anyone has ever gotten in the history of civilization? She looks weak and people are going to test her even more in the future. Sheep City and Brooks is over there like, you acting like a hoe and you fitting to get no dick if you keep acting like this. Torgo the White, I hate this judge as much as Brooks at this point. We should not have people this weak serving as judges. Stephanie Tam, is there any way that all parents be forced to take foster parenting classes? It would be better for the whole world. No, because forcing parents to take parenting classes is tyrannical oppression, in my opinion. Maybe they should consider it, but I don't believe in forcing that on anybody. Johnny K1, a lot of parents in the foster parenting classes were not there for foster parenting, but were there as sentenced to sort of a rehabilitation in their own CPS cases as well. They're really good classes. They really were, But I just don't believe in forcing people to be educated.
It's always the people that actually go to those classes or the people that actually don't need it. You know, I remember I used to do the education for my police departments, and we had a kind of a rogue police department with like 4 officers that were really needed to get their act together. So
Yeah.
I did a special education just for that police department. And of course, who are the 4 that don't show up? Everybody shows up except the 4 that needed to hear it.
Right. Johnny K198, she's going to make future cases worse for her if people perceive her as weak. Fire PA 498, Brooks is totally going to end up being someone's punk in jail. Legardicus, the court is not holding Brooks in contempt, but I certainly am. Just activate the damn shock shackles already so we can laugh at his ass. Teabag 98, rate my gimmick bottle of whiskey, Mr. Rackets. I've never had that or seen it, so I'll rate it meme. Sheep City, and she's enjoying this courtroom abuse. Oh, it's cold. Widow Son 16, you're too nice to new guests. This isn't the you show. Wait, what? The newest guest is Aussie. Hey, Aussie.
I've been copping some shit in the chat. I've been ignoring him.
You're a piece of
Shut the
shit.
fuck up. Oh, I know. Fuck you too.
There you go. Yeah. Oh my God. What is this? What is this shit? Why did you? The first what? The fuck is this? Royal Plague just sent a picture of a, I think that's a woman in a bikini. I'm hesitant because it's the internet. Sophia Giroux? Who the fuck is this? Why are you sending me this? Puerto Rican model with Down syndrome. Oh, okay. It's the that's that girl. Gotcha. Now I understand what happened. And then another one. Okay. Those are for the night show. Not a robot, says Rekieta. Can you ask Steven? Sorry, I keep asking this. Hypothetically, with this is a long question. So I don't know if we want to address it. No, correction. I don't want to address it today.
Okay.
Hypothetically,
I'll be back for the closing arguments on that one. So
hypothetically, with medicine that extends life indefinitely, how death penalty versus life in prison would work for morality.
Ooh, let me think on that and come back to me on closing arguments when we're going to cover the closing arguments. And maybe in a break, we could cover that. And let me think on that one, because that's not a knee-jerk reaction kind of question, is it?
No. It raises various ethical issues that I have. Sheep City, and this Binger is trying to air out his baby mama drama during a fucking murder trial, and Darrell is so starved of conflict that everyone else has to suffer through this. I wish you were going to Orlando so that you could enact an Emmett Till on me. Oh man, I would love to go to Orlando. I would have a ton of fun, but it's not in the cards this time of year. Sorry. Johnny K198. Hopefully his cellmate is Chandler. And he's in the mood for long pork sashimi. Chininator, wait, so what are your thoughts on gun control classes? As a gun owner, my biggest fear is another idiot who doesn't know how to use a gun or is oblivious to gun safety. My thoughts are I don't believe in gun control classes being mandated.
Not only that, you know what they need to do is they need to the Republicans take over Congress, pass a law where every gun store has to shred any records they have of identity of who bought those guns and bury that gun control tyranny once and for all. Aussies know about this.
Yeah.
But let's not get started down that road.
Royal Plague says, where is Baldo? Well, I've got good news. I think it was last night. One of the lovely chat members ordered me a Baldo. So that's coming. Not a robot, says Steve. Take your time. I watch all of Rackets. So I'll definitely see your thoughts. Oh, and Nick's too, I guess. Ken Jennings says, I was going to Photoshop Lady Rackets in this, but I started to feel bad because she was nice to me at Road Rage Tampa. McJuggernuggets 69 for 69 and McJuggernuggets $2 for $4.99. I don't know why she showed up under McJuggernuggets, but I told her I was looking for some McJuggernuggets myself. Royal Plague says Nick Wick, thank you. You okay there, Aussie?
That one batted him out. He's down.
Oh man, Royal Plague says I sent all these pictures after I watched the Jack show from 3:30 a.m. to finish. You okay?
I'm fine. Sorry, I'm tired. Let's face it. That one just knocked me around. That's all good.
These are just a bunch of memes of me. Indiana Jones, James Bond, Elvira. I got a nice rack. Nelvis. Okay. Let's see. Oh, me is Ariel from Little Mermaid. That's right. That's good. Captain America. That's a fun one. Oh, me as Doc Brown. Tip from locals chat, 1.21 gigawatts. Okay, Johnny Case says bring back gladiators in the Coliseum, SUV and Brooks versus poor shot cop. If Brooks wins, keep going till the SUV runs out of gas. Then bring in Rittenhouse to finish what the trained officers couldn't. Johnny Case says put him in an SUV, give the cop that missed an opportunity for redemption. And then finally, Angry Medic 5 says, holy shit, this dude here. I assume talking about Brooks. And I think that's about it. Yeah. Oh, real quick. No One Leaves says drunk lesbians would be domestic violence, not consent. Seed and Feed says, good afternoon, Rekieta Law. Here's some funny money. Lol, God bless. Nazcat, the Lord's name is not a curse. Rackets. Pleb Life, just another rando. She is being an idiot. She rewards his behavior every time she fails to follow through with her threats. This is basic toddler parenting 101. And Retro Gamer says, this is we in the black community calls an N-word moment. Redone. Nick, how would a competent judge would have handled Brooks in court without risking an appeal or mistrial? This one did it. She's not risking an appeal or mistrial the way she handled Brooks. She's just kind of lost control of the courtroom. That's just annoying for her and for us. Also, will a certain toe fucker join the stream again soon? Lol. Yeah, Drex will be on tonight. Tonight is a big panel show. Very laid back, very relaxed, lots of fun. I say big panel show. Adam Krigler, Nina Infinity for sure. I got to talk to some more people, but some invites are going out. Tor Theo, USA Today with a sympathetic headline about Brooks's pathetic self-pity opening statement. Yes, they did. Blue-Eyed Roof Korean says Aussie seems legit, even if Australia isn't. And Lugmeister says maybe Darrell should be put in the same cell as Seinfeld, Kramer, and Elaine. There you go. Okay, gentlemen, that's it. That's everything. Thank God. It's almost 7 o'clock. I got to go. Anything you want to say before we take off?
Amazing. Crimelaw.net. How about that?
There you go.
Go there, check it out. I got a music video on there, or no, I should say my music video. Iron Maiden, Flight of Icarus, played by me, because nobody believes that I actually play the guitar. And of course, really what I want you to do is go to crimelaw.net and buy my book. That's the way to support me. And I thank Mr. Rekieta for actually making my book sell, because they wouldn't sell otherwise.
Well, thank you, Steve. Guys, check him out. And Aussie is on YouTube. What were you going to say, buddy?
I'll chuck my link tree in the chat. I'm on YouTube, Rumble simultaneously. Got the locals up. Finally got that working. And if Nick's is not available on Monday, I'll talk to some people, try and work out exactly who's going to cover this on Monday. So, yeah, I'm definitely not available on Monday. But you should look me up for a Sunday show. Oh, yes, I will send you a link for... Oh, I should qualify. Yes, Sunday, guys, 5 p.m. Eastern, 2 p.m. Pacific. Don't know how it works with Central. I got to add it to the clock. Sunday show, we go through the normal news, and then we do Kinky Corner. Everything news and sex related for at least an hour of absolute degeneracy.
I remember. That's right. That's your gig on Sunday, right?
That's so exciting to me. Okay, 2 more chats have come in. Roxf says, wait, one more. And 40 Mike says, what are the odds of Brooks showing up in a skirt and pigtails for sentencing? Who knows? All right, guys. Thanks to my guests. Guys, check out Aussie Overlord on YouTube and Rumble. Check out Crime Law, Steve Gosney, crimelaw.net. Also, Crime Law on Rumble. And I'll see you guys soon. To the chat, y'all have a great night. Peace. I'll see you at 11 p.m. Peace.
Oh, he drinks a fair bit, but you realize that it just helps get his noggin jogging along. With his glass by his side and his kids asleep tight, we'll hear some lost-plaining tonight. With his microphone muted, we'll laugh at this boomer until he explains it's all part of the plan. Watch his face become redder as he becomes meta, raging at idiots from Twitterland. From the white shores of Maine to the hills of Glenlivet, there's no one who explains the law better than Nick. So pour out a glass for the ones who have passed, to make the law what we have now. Oh, his lady is fair, and she handles herself with the grace of one who has borne many children. As the wife of a lawman, she makes sure that he has the time and the place to provide for them there. So pour out an ardbeg, a bow, more of the frog. The spirits flow as the ones who get unemployed. So pour out a glass for the tea post on Twitter, as we hear lost-plaining tonight. From the white shores of Nairn to the hills of Glenlivet, there's no one who explains the law better than Nick. So pour out a glass for the ones who have passed, to make the law what we have now. Oh, the guests are all plentiful, from Doug T to Drexel. They bring their perspective and spice to the mix. But the reason we're here and the one that we cheer is the one who is showcasing us his career. Get unemployed. So pour out a glass for the tea post on Twitter, as we hear lost-plaining tonight. From the white shores of Nairn to the hills of Glenlivet, there's no one who explains the law better than Nick. So pour out a glass for the one